Good morning, everyone. I would like to call to order this public hearing of the Committee on the Judiciary and Public Safety. It is 9:38 a.m. on Wednesday, November 29th, and we are convening this hearing in person at the John A. Wilson Building in room 500. We are also streaming live on the Office of Cable Television website, Council Channel 13, the DC Council website, and YouTube at @CM Brooke Pinto. I'm Councilmember Brooke Pinto, representing Ward 2 and chairwoman of the committee. We have one bill on the agenda today, Bill 25-555, the Addressing Crime Trends, or ACT Now Amendment Act of 2023. This bill was introduced by Chairman Mendelson at the request of Mayor Bowser on November 2nd, 2023. We are experiencing a crime crisis in the district. Compared to last year, violent crime is up 40% and property crime is up 25%. This crime surge has affected residents, visitors, and businesses they support. Many are fearful and their day-to-day lives have changed in a myriad of ways as a result. As chairwoman of the Committee on the Judiciary and Public Safety, developing solutions to improve public safety in the district continues to be my number one priority. I've spent the past several months working to identify creative solutions and fill needed gaps in our legal system in order to make all communities across the district more safe and more secure. My staff and I have met regularly with our public safety cluster, the agencies who do this work, and the residents they serve about these issues. We've spoken with experts and we've engaged directly with communities in all 8 wards through public safety walks and other events, meetings, and conversations. This fall, I've advanced my Secure DC plan by holding hearings and roundtables on legislation I've introduced that will make a meaningful impact to make our communities safer and more secure. I will continue to stay focused on what we can do on this committee to move forward changes that will help improve public safety for our entire city. I'm confident that we can work together to create tools that will effectively address these issues and ensure the district continues to support the livelihoods of our residents and to keep residents, visitors, and businesses safe. We will continue to be deliberate, thoughtful, and comprehensive in the approaches we advance. But what is clear is that we have to act to stem the tide of this violence, and time is of the essence. Lives are being lost. With that, I'm going to walk through some of the issues facing the district and some of the mayor's proposed solutions in the Act Now bill. First, the bill allows MPD to declare drug-free zones for up to 120 hours in locations experiencing disproportionate drug use and crimes of violence as another tool to hopefully disrupt drug sales and help combat the district's opioid crisis. This proposal is aimed at an issue we've heard about consistently from residents, real concerns about safety around certain pockets where there is a lot of drug activity. I'm looking forward to hearing from witnesses about these issues and whether they believe that this will be an effective proposal. I'm also interested to hear from MPD about how they plan to deploy this strategy in practice most effectively to really finally address the concerns that we've been hearing from residents for many months. Second, in an effort to address retail theft, Act Now would establish a new offense of organized retail theft, allowing MPD and prosecutors to target individuals who direct others to repeatedly engage in retail theft. Retail theft has increased dramatically in the district and is another issue that many people and businesses across the district have seen over and over again with little consequence and sometimes no recourse at all. Not only is it unacceptable for businesses to have their items stolen repeatedly, but it is also creating an environment of fear and lawlessness for many in our communities. Many stores have begun locking common household items like deodorant, laundry detergent behind glass to decrease the risk of shoplifting, making the shopping experience longer, more difficult. Some larger retailers have shared that the retail theft losses from their locations in the district have quadrupled in recent years. Even worse, some businesses have closed their doors in the district, citing these repeated theft issues. Beyond the lost revenue, chronic retail theft has left many residents frustrated with a shopping experience that threatens the safety of both shoppers and our retail employees. Again, I'll be listening today to hear whether the Act Now proposal on retail theft would provide the right tools to address this pressing issue, and if there are other interventions around retail theft that we need to be adding here. Next, the Act Now bill would reinstate the district's anti-mask law. This aims to address individuals who are wearing masks while committing property crimes, as well as serious violent crimes like carjackings. Ski masks, which have grown prevalent in usage during the commission of crimes this year, can prevent law enforcement and does prevent law enforcement often from identifying suspects, even when we have video footage. I will say the one thing I'll be listening for today as well is whether people have concerns about this proposal being overly broad and potentially sweeping up too many people who are just wearing ski masks for warmth, health, religious reasons, or personal choice. And I want to understand how we could avoid that while still addressing this important issue. Lastly, as we have heard in prior hearings and from MPD officials, MPD is facing serious hiring and retention challenges. These issues have a variety of causes, but I've heard concerns from officers about feeling unsupported and overworked without adequate tools to do their jobs safely and most effectively. Mayor Bowser's bill proposes several changes to provisions related to MPD policies. These changes would clarify the neck restraint and vehicular pursuit policies previously passed by the council, as well as limit when officers' names and badge numbers can be released to the public. These changes may be important to provide clarifying policies that allow officers to perform their jobs safely while also ensuring accountability through public and accurate access to important information. As crime increases and MPD faces staffing shortages, officers need to be supported so they can continue to serve our communities here in the district. This is important not only in employment, but also in responding to what we are hearing every day from officers about the practical limitations that they are experiencing due to some of the restrictive language that they have been abiding by. Before we begin, I think it's important to re-emphasize the need to find informed and effective solutions. As I evaluate each one of these proposals with my colleagues, I want to keep in mind all of the different goals that we share. The importance of having a criminal justice system that effectively deters crime and ensures accountability, the need to respect individuals' rights and ensure that everybody feels respected and safe, the need for transparency and accountability within law enforcement, the need to ensure that our police officers have the support they need to do their jobs, and the overarching right and fair expectation that our residents should be able to live safely in their communities without constant fear of being victimized. I believe there is no greater responsibility or obligation for our government than to provide for the safety and well-being of our residents. And we have to keep working together so we can live up to that promise. I'm looking forward to hearing from both public and government witnesses on these issues today. I ask my colleagues and all watching today to keep an open mind, to speak to one another with respect, and keep working together on what I know are many shared goals. These are complicated issues with a lot of strong perspectives, but let's remember that we are all on the same team. We all want a safer city. With that, before we begin with public witness testimony, I'm going to turn to my fellow council members in attendance if they would like to make an opening statement. I'm going to first turn to Council Member Anita Bonds, who's also a member of the Judiciary Committee, for any opening statement that you may have.
Well, good morning, everyone, and it's a pleasure to be here with you because we are so very anxious to hear from you. We have experts at the technical level, and we have experts from the community. And I am so delighted to see that we're coming together. These issues before us are very important, and it is about our community and how we're going to move forward. And so I'm very happy to join my colleague, chair of this very significant committee, to hear from you today. I'm here with ears. I don't have a lot of talk, but I will take what you share with us certainly under advisement, and hopefully we can move forward on this issue. Thank you very much, Chairwoman.
Thank you very much, Councilmember Bonds. Next, I'll turn to my Ward 3 colleague, Councilmember Matt Fruman, for any opening statement you may have.
Thank you very much, Chair Pinto. I'm happy to be here today. I want to thank you for your leadership on these issues. This is a really tricky terrain that we're dealing with. Every day, literally every day, I get a half a dozen emails from constituents who frame the issues around public safety as being about the future of our city. And they're right. And we need to grapple with these issues and figure out how to respond so we address the short-term issues, and how do we respond in a way that don't make the long-term issues even more difficult. This is going to be very difficult terrain. As Chair Pinto talked about, there are very strong feelings in all directions on these issues. We need to hear from all of you and try to figure out what's the path that can, frankly, save the city. Because if we go down the path that we're on now with the momentum of violence and crime, we're in trouble. We need to figure out how to turn that around. We need to figure out how to make sure more of our residents have a sense of opportunity so they're not choosing a path of crime. We need to figure out how to respond to the immediacies of the moment. And that's what this today is all about. And I look forward to hearing from our witnesses. I will, in candor, be in and out, have other hearings, but also will at some points be watching online, but look forward to hearing from our witnesses today. Thank you very much.
Thank you very much, Councilmember Fruman. Next, I will turn to our Ward 1 colleague, Councilmember Brianne Nadeau, for an opening statement.
Thank you very much, Madam Chair. We all deserve to live in a community where we feel safe. All Ward 1 families need to be able to enjoy our public spaces and community amenities without fear. I am raising a family here myself, and like many of you, my family's safety means everything to me. And that's why I've been so concerned about the ongoing violence in the district and in our ward. I've taken a comprehensive approach to public safety with 3 areas of focus: prevention, policing, and prosecution. As council member, I voted for a police budget of around $500 million each year, and I've brought millions of dollars for violence prevention to neighborhoods like LaDroit Park, Columbia Heights, Parkview, and across Ward 1. And I've supported similar investments across the district. I've long focused on the root causes of crime and how to prevent it with programs and services that support people who are struggling with mental health and substance use disorder issues and homelessness, and children and adults at risk of falling into illegal activities. When it comes to the second and third components of this comprehensive approach, policing and prosecution, I work closely with MPD to advocate for prioritizing police resources to high crime parts of the ward and to hear what tools they need from the government to effectively address crime. We had a robust conversation with Police Chief Smith about this last night in a town hall that I convened for Ward 1 residents. And while the chief and I are not in agreement on all the details, we are on the same page when it comes to giving MPD the tools they need to do their jobs. I believe it's a problem that the crime lab hasn't been accredited for several years. That's a problem for every case. And it's a tool that's not working as it should in support of policing. It's also a problem that the U.S. Attorney's Office is still declining the majority of cases. And that's a tool that exists and is not working as it should in support of policing. We're going to continue the conversation today. We're going to discuss and think critically together about aspects of the bill and effects it will have on our communities. For example, if MPD declares a drug-free zone for 5 days, how will that impact the services we're providing to people struggling with addiction who tend to return to the same spots to receive drug treatment and counseling? It's something I've discussed already with the chief, and we're going back and forth with questions and answers to work through that. I am here today to listen. We have a lengthy list of people prepared to give testimony, and I want to hear what they have to say. As I mentioned, I have concerns, but we all have the same goal: There are aspects of this legislation that can work for Ward 1 and for the district if we work together to ensure that we take account of concerns and unintended consequences and address them in the legislation. One final note, there are other important public safety measures before the council that we are considering. Let's make sure we're not putting all of our hopes into one piece of legislation. We have Councilmember Pinto's bill, Councilmember Robert White's bill. I've introduced 3 bills on public safety that address recruitment, the failing dispatch center at 911, and helping police close more homicide cases by increasing support and protection for witnesses. This is an all hands on deck moment. It's not just about the police. There are a lot of government agencies that are a part of this, and council plays a role as well. We want to make sure the mayor and law enforcement agencies can use the tools they have already. Passing bills and passing bills and passing bills is not going to get us out of this situation. Passing bills without critically thinking about the short-term and long-term effects they will have on prevention, policing, prosecution, and people's lives isn't going to get us out of this situation. We must do all of the work. Let's talk about these things. Let's not just talk about one bill as the magic solution. That's not realistic. Let's acknowledge that we all want the same thing. And if we work together with integrity and respect, we can accomplish what needs to get done. Thank you, Madam Chair. I look forward to hearing from our witnesses today. I too will be back and forth to the education hearing, and I look forward to returning and talking more with folks in a little while.
Thank you very much, Councilmember Nadeau. Next, we will turn to our at-large colleague, Councilmember Christina Henderson, who's also a member of the committee.
Thank you, Chair Pinto, and good morning. I actually don't have a prepared statement because I didn't know if I would make it on time, multiple different things, and I actually am chairing a health committee hearing in a couple of minutes. But I did want to say that I appreciate all of the public witnesses who are here to testify today and will be monitoring throughout the day. As I've talked to neighbors, I share in the frustration that folks feel about what has been happening across the city, not just today or recently, but progressing over the last couple of years. And some of that frustration comes out of the fact that we have voted on quite a few pieces of emergency and temporary legislation, but we haven't seen them be able to penetrate in terms of a downturn, especially over the summer and as we lead into the fall. As Councilmember Nadeau mentioned, we have several more legislative proposals. Councilmember Pinto has introduced several bills. Today, we're considering a proposal from the mayor. And as a member of the committee, as we look to how we put together whatever the package is, I'm looking for not just what it looks like on paper, but what can actually be implemented in a way that with fidelity to show the outcomes that we all desire and that we all hope for. Some of the questions, though, I have for some of the government witnesses, I'm going to foreshadow because I'll be back for that, is around that everything that we have dealt with thus far have dealt with adults. We have not had any pieces of legislation in particular that have dealt with young people and what we're seeing happening on that front. And so I have questions about that for later today, but I know you all want to get to the public witness testimony. So thank you so much for the opportunity to provide a few comments. Thank you, Councilmember Pinto.
Thank you very much, Councilmember Henderson, and thank you to all of my colleagues for being here. I know others will be joining throughout the day, and I know that this issue is top of mind and important to all of us, so I really appreciate all of your continued partnership. So for today's hearing, we're going to first hear from public witnesses to discuss the legislation before us, and then from our government witnesses on this bill. As a procedural note, given the number of witnesses we have today, all public witnesses are going to be given 3 minutes to present their testimony, which includes individuals and those representing organizations. Everyone is still able to submit written testimony to supplement their live testimony if they would like, and the record will close on December 13th. I will now invite our first panel of public witnesses to come up. I'll ask the first person to sit in the seat farthest to my right, to your left, and then, 1, 2, 3, 4. So first, we will start with William Lightfoot, former DC Council member at large, and former chair of this committee. Dennis Corkery, Washington Lawyers Committee for Civil Rights and Urban Affairs. Salim Adolfo, public witness. Salim here. Joshua Miller, Open City Advocates. And Rondell Jordan, Open City Advocates. All right, and Councilmember, please begin whenever you're ready.
Good morning, Chair Pinto, Councilmembers Bond, Henderson, and Fruman. My name is William Lightfoot. I'm a former DC Councilmember at large from 1988 to 1996. I'm a sponsor of numerous criminal justice reforms passed during those years. One reform was the anti-loitering law. Mayor Bowser's proposed criminal justice reforms, called Addressing Crime Trends Now Act, contains a section substantially similar to the anti-loitering law that we passed. My testimony will focus on that part of ACT. That authorizes the Metropolitan Police Department, MPD, to declare temporary drug-free zones, which would allow MPD to limit loitering in those zones. The purpose of my testimony is to place current circumstances in an historical perspective and to make recommendations for improvements. I testify in support of ACT Now. Parts of our city are plagued by criminal activity on public spaces. Innocent people are being shot. Homeowners are afraid to walk on their sidewalks. Similar conditions existed when the council passed the anti-loitering law. Posting no loitering zones causes disruption and confusion in criminal activity. This confusion is an effective tool for police to prevent street crimes. ACT provides MPD with tools to hold criminals accountable and to keep our neighborhoods safe. In 1996, when the council passed an anti-loitering law, we were reacting to criminal behavior on the streets. People demanded that changes be made to clean up the neighborhoods. Similarly, today, the council and mayor are reacting to criminal behavior on the streets. The government reaction expresses a policy that the beatings will continue until the attitude improves. Such a policy may be appropriate for some criminals, but the council must also act to prevent criminal behavior before it occurs. We need to adopt proactive policies as well as reactive policies. I recommend two proactive policies that are based on educating people to change their behavior. First, I recommend that all people who are arrested for possession of an illegal weapon must successfully complete a mandatory gun safety course. Secondly, when the council first passed the anti-loitering law, we also created a Judiciary Committee working group to improve truancy. We believe that increasing student school attendance while decreasing student absenteeism will cause a decrease in juvenile crime. Today, an effective truancy plan will cause a decrease in juvenile carjackings. The working group of truancy stakeholders met monthly to review statistics describing student attendance. The working group included schools, courts, police, independent agencies, and others. Regular meetings with a council member help coordinate information sharing among disparate government agencies. I strongly encourage every council member to exercise meaningful oversight of truancy. Please, council members, conduct oversight of the implementation of the truancy plan. On paper, the plan is good, but the number of truants is unacceptable. Strong council oversight will result in more students attending class and less juvenile crime. We ask the council to make and keep a promise that every child will be accounted for in DCPS. Thank you.
Thank you very much. Dennis Corkery, Washington Lawyers Committee for Civil Rights and Urban Affairs.
Chairwoman Pinto and members here today. Oh, sure. Thank you. Chairwoman Pinto and members here today. At a time where there's an urgent crisis of violence that the district needs to face head on, rolling back hard-fought police reforms is an unnecessary and dangerous distraction. Following our 2020 national reckoning on the persistent reality of racism, especially in policing, the DC Council became national leaders by immediately acting to create new systems of transparency and accountability for MPD and placing firmer restrictions on the deadly use of force. These reforms made the district safer by promoting responsible and constitutional policing. Now the mayor is calling for dismantling these reforms in the name of public safety. But unsafe policing by unaccountable officers will lead to more state violence and do nothing to stem the crisis. My name is Dennis Corkery. I'm interim supervisory counsel of the Police Abuse Project at the Washington Lawyers Committee for Civil Rights and Urban Affairs. I am also a Ward 1 resident. On behalf of the committee, I urge this council to reject the Act Now Act in its entirety. I respectfully refer you to my written testimony that spells out all of the committee's objections to this unnecessary, dangerous, and anti-democratic bill. I also point out how this law is an affront to the memory of Kayron Hilton Brown, who was murdered by MPD officers during a police chase. With my time today, I would like to focus on 2 key points. First, this bill legalizes chokeholds, period, full stop. If there was an actual concern that MPD officers were being prosecuted because of incidental contact with the neck of a suspect, then the bill could have been written that way. Instead, it allows officers to restrain an individual's movement, even if that restraint has the unintended effect of restricting that person's airway or breathing. 3 short years after our nation watched George Floyd die, while a police officer kneeled on him to restrict his movement, there's no reason for any MPD officer to put any person at risk of suffocation in order to restrain them. The council has already heeded the Police Reform Commission's warnings about the proven medical dangers of even a light restriction, such as the weight of a house cat on a person's airway, and there's no reason to go back. Chokeholds are violent, and permitting them cannot be the way to end violence in DC. Second, this act's provision allowing officers to review their body-worn camera recordings before writing the reports will hurt race equity, the original impetus for the reforms. MPD officers already stop and frisk Black people at a highly disproportionate rate. But officers may only stop them if they have reasonable suspicion based on facts that they know at the time of the stop. And allowing officers to review their footage before writing reports gives them the chance to add details that never justified the stop to begin with, making it difficult for innocent folks to challenge unlawful stops. Indeed, it's these less high-profile stops that need this restriction and not just the serious ones that the bill already contemplates. This council must reject this bill. I'm happy to answer any questions.
Thank you. Joshua Miller, Open City Advocates.
Good morning. I'm a resident of Ward 4 and Research and Advocacy Director for Open City Advocates, which provides legal representation and holistic advocacy to youth who have been committed to DYRS. I'm here today to provide information regarding provisions in the Addressing Crime Trends Now Act of 2023 that may be useful to this committee's work. I've been teaching at the university level for 2 decades and worked extensively in prisons for more than 10 years. However, my first job out of college was as a civilian investigator of police misconduct in New York City. I learned a lot then about policing that I'd like to share today. To summarize, highly professional police departments have low levels of unprofessional and unprincipled misconduct. Officers in departments like MPD and the NYPD will perform according to their training standards. Nonetheless, when given discretion, officers will use superior force up to and including deadly force to effectuate an arrest. They will chase a fleeing suspect at almost any speed and use maneuvers that cause car crashes and significant damage. So training and policy matters, and it's going to be built on the council's legislation. If trained to do so, police officers will use potentially deadly chokeholds. They'll fire their service weapons even when there are de-escalation alternatives available. If properly trained and supported with alternative measures, they will not do these things. So like the MPD, the NYPD is a highly professional and fundamentally principled police department. Out of almost 40,000 sworn officers at the time that I worked for the department, the Civilian Complaint Review Board received a little more than 4,000 complaints each year. And we were able to substantiate only about 400. Because of duplications, more than 95% of officers never received a single complaint. And of the complaints received, we only had a 10% substantiation rate. This is roughly similar to the rate of misconduct complaints substantiated here in the district. Those proportions have stayed roughly similar as the NYPD's sworn officer numbers have decreased, which we know because all of the NYPD's substantiated misconduct records from 1985 until today were made available for review first through ProPublica and since then through the City of New York. This is the same kind of reporting that we need in DC. It's not that all the complaints were without foundation. They were simply unsubstantiated with conflicting testimony and no way for investigators to decide. I believe that DC needs a database of police misconduct like the one operated by the NYPD. DC spent $91 million settling police misconduct suits between 2010 and 2020, including for 65 officers who had multiple complaints against them. Police departments don't tend to have a large proportion of bad actors, but a database that discloses both substantiated and unsubstantiated cases can help identify trends before the worst excesses occur. We've repeatedly heard that these provisions are about staffing levels, but I I would just say that workplace conditions for police officers are our civil rights, and we cannot negotiate those away without consequence. Thank you.
Thank you very much. Rondell Jordan, Open City Advocates.
Good morning. My name is Rondell Magic Jordan, and I'm a resident of Ward 2 and community defender for Open City Advocates, which provides legal representation and holistic advocacy to youth who have been committed to DORS. I'm here today to provide testimony regarding provisions in the Addressing Crime Trends Amendment Act of 2023 that I hope will be helpful to the committee's work. So I applaud the committee's sense of urgency in seeking to enact legislation that makes our city safer. I think we can all agree that something must be done to address the trends in violent crime currently plaguing our city. But we must also agree that that something has to be something that actually works. You know, my mom has this saying that she likes to share with me whenever I sit still long enough to listen. She says, magic, time tells stories. Usually, I have absolutely no idea what that means. Today, I do. At least 3 of this bill's provisions seek to revive unjust law enforcement practices that were rightfully abandoned by this council years ago. Time has told us all we need to know about them. They do not make our city safer. Yesterday's wickedness is not today's righteousness. In fact, these provisions appear to be aimed at making policing easier for MPD officers. The assumptions being that our city is safer when officers are free to restrain people with chokeholds, engage in high-speed car chases, and arrest people for lingering in public spaces that have been temporarily anointed drug-free. Time has proven each of these assumptions to be untrue. Thankfully, I've never been restrained in a chokehold by any police officer, but I've not forgotten about Eric Garner, who in 2014 was strangled to death by an NYPD officer who used a chokehold to restrain his movement. In May of this year, a former MPD officer was convicted of 2 counts of violating the civil rights of 2 young people when he engaged in the very behavior that this bill seeks to legitimize. Another misguided provision in this bill mistakes our city for some kind of theatrical production, one in which our police officers become stunt drivers, our residents become background extras, and our streets become a movie set. You do not need to be a driving expert to understand that, with few exceptions, engaging in high-speed car chases makes potentially dangerous situations even worse. Washington, D.C. is not Hollywood. And as good as it sounds, the provision in this bill that resurrects the MPD's ability to designate public spaces as drug-free zones is not going to make our city safer. What it will do, though, is permit officers to target mostly young Black men and boys who are lingering in public spaces, which will further erode an officer's most valuable resource, the trust of a community, thus making us all less safe. Our city is facing a crisis, and people in crisis tend to believe that taking any action or acting now is always better than taking no action at all. But to believe this is to mistake desperate acts for good ones. Only time will tell whether the committee chooses to enact legislation out of desperation. Thank you.
Thank you. Thank you all very much. Councilmember Lightfoot, I'm interested in the truancy task force that you talked about. Can you identify what some of the gaps that you saw during that work? Because we may be able to revisit some of those as continued efforts.
I'm sorry. I would encourage you to revisit it. This was 27 years ago that I was engaged in a truancy task force. But one of the things that I recall, what gave us difficulty were the independent agencies. You know, the courts play a major role in what's happening with truants. Likewise, now the Office of the Attorney General plays a major role. That's an independent agency. And back then, the schools were basically an independent agency. We didn't have mayoral control. So you have these independent agencies that need to be coordinated. That wasn't happening. That was one. The second thing was actually, it was the data itself. And I'm not going to say, I'll use the phrase, you know, what is it? Figures don't lie, liars can figure. I'm not ascribing an improper motive, but the statistics on truancy, when someone's counted as truant, when they're absent with an excuse, when they're not, how many days, is really quite overwhelming. But it gets to the heart of how many children are not actually in class. So that statistical element's important. And then lastly, when we did our truancy working group, the police were very confused, or maybe the law wasn't clear about the extent of their authority with a truant. They're not locking up a child who's truant. They're picking up a child and taking them to a center where they can get assistance, where we can find out why they're not in school, et cetera. So those are some of the major issues we faced. I will lastly in this, I was shocked at the numbers of the truants. You're going to get a number tomorrow on the truancy for the city. I don't know what it's going to be, but whatever it's going to be too high.
Okay, thank you very much.
Certainly.
And then three of you talked about chokeholds. So I'm curious in this distinction because chokeholds are banned in the city. They have been banned for many decades. They continue to be banned under this proposal. The language that the mayor puts forward seeks to remove the definition of neck restraint so it would still restrict any restraint of blood flow or breathing in any way, but it allows for something that could restrict movement. And so is there a different type of definition that you think that would get this balance better to make sure that asphyxiation is still banned completely?
Chairwoman Pinto, my understanding is the concern is that officers could be charged for, say, hitting someone's neck during a melee or something where they never were having any risk of putting someone at the risk of suffocation. And I think that there are ways to write the law where you could just say that these definitions do not include certain things, such as, touching, as that exact phrase, incidental contact with the neck. But I think what's important is to keep in place the chokehold provisions that make clear that restricting someone's airway for the purpose of movement, restricting their movement is unlawful, and that officers need to be mindful of the effect of suffocating someone when they're putting someone in a position.
Thank you.
I would say roughly the same thing. I would just add that as the law was written, contact with the carotid artery, the trachea were banned for any purpose, including for controlling suspects' movement. By removing movement from that phrase, it's now possible to make contact with, to restrain someone's jugular, their carotid, their trachea, to control their movement. These are things that would be banned in, like, I don't know, high school wrestling, right? That they're potentially dangerous chokeholds. There's a way to include a provision that says incidental contact is not covered under this, and not to say you can kneel on someone's upper back and neck in order to restrain their movement, because that's exactly what Chauvin was doing to George Floyd.
Okay, thank you. Thank you all very much. Councilmember Bonds?
Yes, thank you very much. And thank you all for your testimony. I wanted to ask, I believe it's Mr. Miller and Mr. Jordan and Mr. Corkery a little bit about this neck restraint. I too have concerns about that. And my concern is what solution do you have for a situation where an individual we're trying to restrain them and they're banging their head against the wall? Just what should we do? What should an officer do, or an individual citizen on the scene trying to prevent that, thinking you're going to knock your brains out, so to speak? You have some thoughts about that?
Yeah, I'm not entirely sure that well, thank you, council member. I'm not entirely sure that banging your head is a criminal offense, but I think if you're concerned about a police officer responding in that situation, I mean, arms, people have arms. I think anytime you go off somebody's neck is just inherently dangerous. I don't know if anyone in here has ever been placed in a chokehold, but yeah, I think there's other ways to restrain folks without going at the neck. Yeah.
All right, well, let me give you a better picture. The idea is that they're being restrained, arms naturally, maybe even the legs, but now they're just trying to, they're upset. They're having something is going on with them where they can't and do not wish to control their actions. So and the officer is on the scene. what do you think the officer should do? I'm really seriously wondering, because I saw a tape of that situation and wondered, and I said, they should not touch the neck. Okay, but your natural instinct, you're watching this bang, bang. What do you do? What are your solutions?
I mean, again, I'm not an officer, but in that situation, I'm pretty sure they have training to help someone it sounds like a mental health crisis. I don't think responding to a mental health crisis with a potentially deadly maneuver would be the best solution, or even a solution. Possibly there are mental health providers that can accompany law enforcement in those particular situations, which I think are probably few and far between. That might be a remedy for that particular situation.
Mr. Miller.
Thank you for the question. I think it's really important to get to this, and it might not be that council is well equipped to sort of resolve which holds work in which cases, right? When you all banned chokeholds of this sort, you said that they were antithetical to the values of the district. And that really spoke to me, I have to say. If our concern is somebody in a mental health crisis, then what Mr. Jordan described as co-response, right? So a behavioral health professional alongside an officer might be the better way to respond. If you think that somebody's basically injuring themselves, and that the only way to control them is to injure them instead, I think that we've made a sort of mistake, right? Just the other day, there was a report that there's an officer going around using people, mostly African-American women's hair to control them. Can't use a neck restraint, so I use a hair restraint instead. And I would suggest that it's a mistake for us to sort of legitimize that behavior. That's where I would end. And we can bring in the wrestling coaches later.
Councilmember Bonds, the only thing I would add is I think that this is something where the medical community can provide a lot of good insight. And that was, they provided insight to the Police Reform Commission that cited studies about the dangers of chokeholds. And I think that there are a lot of medical professionals in the district who would be able to work with MPD about what are ways to have the least amount of harm that can be done for a situation like that.
I thank you all for your answers. And I recognize that the medical community can better answer these questions, but you provided testimony today. And so I am doing diligence to examine your testimony, because you have said that this is harmful. And I am saying there are situations, as I described, that happen. And it is not clear that perhaps it's a medical situation. So an officer shows up because they got a call from the community, that this person, we're trying to restrain it. Maybe it's a family member trying to restrain another member of the family. I'm just simply trying to understand what situations that are before us that we can begin to think about how do we manage them, because they do happen. So I thank you very much. And I think I'm over my time. Thank you, Chairwoman.
Thank you, Councilmember Bonds. Councilmember Fruman.
Thank you very much, Chair Pinto. I'm going to stay on this a little bit, less with a question for the moment, but maybe a question that you can respond tomorrow or in the coming time. I participated in the MPD Community Engagement Academy, which was really useful this summer. And I spoke with lots of officers, and one day an officer came in and she had a bandage on her hand, and I asked what that was about. And they had somebody who was thrashing around in the kind of way that's been described, and that person bit her, injured a couple of other people, and they all felt like, we don't know what to do here, because we could misstep and then be in trouble. And I think that's real. I think that feeling inside of MPD that they're not sure what can make them vulnerable is real. I heard that the mayor's legislation was going to address this issue. I was really glad to hear that. I read it and I thought, whoa, is this the way you do it? So what I would invite people who are concerned about chokeholds, but also recognize that there's an issue, come forward with like specific alternatives that we can grapple with. You, Mr. Corkery, you sort of got at it a little bit, taking into account what Councilmember Bonds was saying. The most useful thing would be to get at the root problem, which I think is a problem, and crosses sides in the debate. Let's sort that out. Councilmember Lightfoot, when you talk, thank you very much for your service to the city. Thank you very much for the points you made on truancy. I think getting at root causes, preemptive action, super, super important. In terms of the drug-free zones, how do you see them differ from the anti-loitering law that you did 20-some years ago?
Other than the name change, I'm not aware of any substantial difference other than they may have tinkered with the language. There was some concern about a legal challenge. When I drafted that law, was it 27 years ago? It had just been struck down by a court, so then I revised it to meet the court's concerns. I understand what is now in this proposal by the mayor has just tinkered with the language slightly. Essentially, it's the same.
So I guess two questions in one. To what extent do you think that it had a positive impact at the time that you did it, but also recognizing all of the controversy around these things over time? Were there any negative consequences? One of the things that I think many of us really hope for is a stronger connection between MPD and the community, and the most affected communities. And what are the risks that doing this makes that a more difficult project, because that connection between MPD and the communities might be the most important thing in solving crime. So you may be for it, but do you recognize any downside to it?
Let me say, you've hit on a very important concern, and that is the relationship between the police officer and the citizens. And does this anti-loitering zone somehow break that bond of trust and caring? That's a risk, obviously. But I will share with you that back then, before we had it, I used to ride along with the police in what's called jump out squads. Jump out squads. Literally, we would ride in a police car up on a corner, and the police would jump out of the car and chase people off the corner, okay? We stopped the jump out squads after we passed the anti-loitering law. We didn't feel that was necessary. We also know statistically that the number of open air drug markets and open air areas where they were selling drugs and doing criminal behavior substantially reduced after we passed the anti-loitering bill. My recollection is it wasn't widely used throughout the entire city. It's used for a few targeted corners to disrupt where major trafficking was occurring. And all it does is disrupt the criminal activity, makes it go somewhere else, makes it go underground, but it moves them off of that particular corner or that block, which then gave the people who live in that neighborhood a sense of safety, and they felt they could go to the store safely. So that was important. With respect to the relationships between the police and the community, a lot of that's got to do with training. I don't believe that the anti-loitering bill affected that adversely. What does help with the police and the community is to train the police officers properly so that they relate to the community. They're caring, they're open-minded, they've got they reach out. And I think MPD has done a very good job in that. I think we are one of the best trained police forces in the nation.
All right, my time has run out. Thank you very much.
Thank you, Councilmember Fruman. Councilmember Nadeau?
Thank you so much, Madam Chair, and thank you to these witnesses. I'm going to pick up where Councilmember Fruman left off with Mr. Lightfoot for a few minutes. I was listening very intently to your response. And you said something that sort of gave me some alarm in terms of the disruption piece, which was people go somewhere else. And I'm with you on the disruption, because we have a number of areas in Ward 1 that I think if we could disrupt the drug activity, we would make a lot of progress. But I am worried about the people just go somewhere else, because what I've been really pushing on is actually getting those arrests made and working up the chain. And I want to get your take from the time you were here about that piece that I'm worried about here, which is they just go somewhere else, because that's not going to help me that much.
Understood. That was a concern that we had. Would they go somewhere else? And candidly, where would they go?
Right.
Yeah. My recollection is we didn't see them moving these drug corners anyplace substantial. What they did move to was where we had payphones, believe it or not. Payphones were a big part of the corner drug trade back then. We know we banned payphones, so we no longer have it. So I think theoretically, the concern of the drug dealers moving to a different corner, it's real. I think it probably happens to some small extent. But in my years when I monitored it, I'm not aware of these open air drug markets moving someplace else simply because we had posted one of the corners as anti-loitering.
Can I ask you a follow-up too? Because I'm curious if this was something you had then or if it's newer. So I've been funding various interventions in these areas for the drug users, the people who are experiencing substance use disorder, because of course we know, like, there's a supply and demand issue here, right? And the people who are consuming are certainly hurting themselves. We've made a lot of progress in the areas where I have dedicated resources for these services, and we put them in a place where people are. We've seen a real challenge, for example, with the policy that dispersed encampments that has been implemented over the past couple of years. We're making progress on the casework and getting people connected to services, and then all of a sudden the encampment's dispersed and the people are dispersed and caseworkers can't find their people. And I get that this is a 5-day thing, but I am worried about that aspect of it. And I've been talking to the chief about it, and I'm hoping we can work through this piece. But I am curious, Mr. Lightfoot, in your experience, did we have that then? Did we have people sort of on location providing outreach and services that were also kind of disrupted by the no loitering zones?
I'm going to say no, but the reason I'm going to say no is I don't recall us having big homeless areas. You know, we now have homeless encampments all over the city on streets and corners and whatnot. We did not have homeless people.
Well, I'm talking about, I use the homelessness as an example, but we actually have these services for drugs specifically now.
Then let me comment on it, and I'll be forward looking, and I'm trying to answer this as best I can. I'm working with a group now that's trying to present an application for opioid abatement money. And one of the things we're looking at is a program in Kansas City that they call Combat. And Combat uses data to put overlays over neighborhoods where there is a lot of drug activity and there are people that need some assistance. And then by using these overlays, this GIS system, we can better target where services need to be provided. So therefore, if we are even disrupting an encampment, as you just put it, I think we'll have some sense of where the people go or where they are. But candidly, that's a work in progress that we're working our way through right now.
Okay, well, keep me posted on that, because the programs I'm implementing are already on the ground. And my big concern is it takes a really long time to build up trust between someone with substance use disorder and the people that I've funded to be there on the street. And when the police show up and disperse everybody, that really does break down that trust. And public needs these programs to work just as much as they need the law enforcement side to work. So this is really my big hang up in addition to some of the other concerns that have been raised today. And so I'm really trying to figure out how this could possibly work at the same time. And I'm not there yet. So I'm hoping we'll hear more testimony today or from the government witnesses about that. So I think my time is up now. Thank you, Madam Chair.
Thank you, Councilmember Nadeau. Councilmember Henderson?
Thank you, Councilmember Pinto, and thanks so much for these witnesses. I'm going to go real fast because I'm supposed to be chairing my own hearing right now. I just want to follow up on a couple of things. Mr. Lightfoot, so the anti-loitering legislation, language that was in the code around drug-free zones. I was a staffer on the council when it was repealed. And part of it was because it was exactly the same language as prostitution-free zones, which the concern there was that police officers were literally suggesting that because of someone's appearance, you are engaging in said activity, even though you're just standing on the corner in this particular zone and area. And so I even remember former Chief Lanier talking about how there used to get calls sometimes in certain neighborhoods from people, new residents, who would say, I don't know who that is who's standing on my corner, but they're standing on my corner and that is making me uncomfortable. How do we ensure that if we were to do this, that you're not getting back to, as some of the others suggested here, harassment for literally just existing because you look suspicious?
I think that's a very legitimate concern. We've talked about it for decades. It's going to be something that happens. It's a human behavior reaction, I believe, but it shouldn't happen. But I think it stems, one, from those of us in the neighborhoods that are concerned about this problem, reporting it to the police, but it also relates to police training. I mean, there's so much and there's so many problems that can be abated if we have proper training for our police force. And I will go back and repeat, and I'll stand by it. I think we have one of the best trained police forces in the nation. When you look at the training they go through, the things they have to do, the things they are taught. So to answer your question, I think the best way I can tell you, I think the law is necessary because we know that these corners or neighborhoods exist and they disrupt the peace and tranquility of the people who live there. So it's necessary. But what we want to prevent is this kind of harassment that you've talked about. But that's going to come from training. We have to train the police officers to recognize what is harmful or illegal conduct and which is still free speech and should not be bothered at all.
Yeah, this is the rub and tension, right, around the harassment piece. But I also hear from several business owners who, the folks who sit on the planters outside of the business, and now you're not legally, I can't ask you to move, but you're also now blocking the ability of patrons to come in and out of my business, et cetera. I thought what you said around truancy is super important. The only, and I look forward to sort of the numbers. They're not going to be great. We already know that. What is, I think, to the point around solutions and really addressing the problem, what we've heard from MPD is that we see a spike in terms of criminal activity between the hours of 3:15 and 7, not during the school hours. It's immediately after school. And so I think there's a question of what's happening there as opposed to what could be happening in the school day. But to your point, if you're able to engage a young person in the school day, and then be able to continue to engage them in after school activities. Yes. Yeah. I wanted to go really quickly to Mr. Corkery. Was also a staffer when we introduced body worn cameras. And I feel like we have been through this over and over and over again. But what would you say to prosecutors who suggest that the original intent around some of our restrictions on body worn cameras, particularly if an officer was involved in an officer involved shooting, or there was a complaint around excessive use of force, is different than what is essentially becoming a memory test for officers in just describing a regular, not regular, shouldn't use that, but you know what I mean? Like not one of those particular categories, but just an incident that occurred.
I'd say that this was how policing developed long before body-worn camera footage, and that officers always had to exactly say the reason for their reasonable suspicion for a stop and a frisk. And the body-worn camera footage is still going to exist. So if it's a minor discrepancy between what the officer put and what the body-worn camera footage shows, then I don't see how that would disrupt prosecution. I think what the issue is really for people who are being stopped and frisked and found nothing, let go. It's not really getting all the way to the court system for them to be able to hold these officers accountable, and for MPD to be able to work with their officers to hold them accountable for when they aren't stopping people constitutionally.
Thank you. Thank you, Chair Pinto. Thank you.
Thank you, Councilmember Henderson. Thank you all very much. We'll now call our next panel of in-person public witnesses. Lisa Burton, Moms of Black Boys United Incorporated. And again, if I can ask you to sit in this first chair. Robert Becker, DC Open Government Coalition. Anita Bellamy Shelton, DC Women in Politics. Rebecca Strauss, Federal City Council. Ashley Ruff, ANC 7F02. Ashley Ruff comes in this third chair, and Kevin Rapp, ANC 5E05. He's here. Oh, okay. I think we'll put on the next panel. Okay. All right. Lisa Burton, Moms of Black Boys United Incorporated.
On behalf of Moms of Black Boys, Mob United Incorporated, I come before you as the DC chapter lead for Mob United and Mob United for Social Change. We are a movement of concerned mothers who have joined together to uplift and protect Black boys and men. We represent every race, age, socioeconomic background, marital status, and education level. Mob United was founded in July of 2016 after the back-to-back murders of Alton Sterling and Philando Castile on July 5th and 6th. Philando Castile was murdered during a traffic stop on a Facebook live feed while many of us watched in horror as the passenger in the car went live to record the aftermath. It was the cell phone video, the advocacy of the Castile family, and the community unity that ultimately led to the release of the police dash cam video. Both videos were paramount in unearthing the facts throughout the investigation. I am here today also as a Black and Blue mom who has a unique multidimensional perspective as it relates to body-worn cameras, community unity, and fostering a proactive dialogue as we strive to serve our DC residents. Transparency and accountability are non-negotiable. The body-worn camera is critical in this process. In order to maintain the integrity of internal affairs investigation and any investigation as they relate to one's professional responsibilities as a public servant, it is our belief as Mob United that the body-worn camera footage for targeted police officers who are under investigation must be withheld until after the officer provides his or her initial statement. To give said officers the opportunity to review their body-worn camera prior to giving any statement is likened to handing out the answers to the captain's exam as the members walk in to take the test. If I am proctoring the test, I am not going to hand out the answer key as the exam begins. Likewise, investigations into police misconduct or serious use of force matters must not be an open book test either. The officer needs to provide his initial statement from his recollection, not from the images of the body-worn camera he just observed. To view the incident first totally negates the purpose of learning what our officers were thinking in the moment that they made a decision to use force. The stated goal of any police department is to protect and serve. In doing so, the police officers have taken an oath to uphold an ethical standard with integrity, which mandates honesty. This includes being truthful, regardless of the totality of the circumstances. Throughout any investigation, there may be discrepancies that need further clarification, but at no time should this statement from the officers completely miss the mark. When that happens, more likely than not, lies have been told. The community has an absolute right to know and a need to know about any police officer that knowingly has lied. Why? Officers who lie may not be guilty of a crime, but it is disturbing and unethical. It erodes what little trust has been built and completely undermines all the progress that some stakeholders have worked tirelessly to achieve through community engagement activities. More importantly, in some cases, the police officers' misconduct may indeed constitute a crime. If that is the case, that bad actor needs to be swiftly held accountable, publicly and with transparency.
Thank you very much. Robert Becker, DC Open Government Coalition.
Thank you, Madam Chair. On behalf of the coalition, thank you for giving us the opportunity to tell you the very negative consequences of this bill. I am Robert Becker, a coalition board member and a Ward 4 resident. The council did the right thing for DC residents and MPD last December when it enacted the Police Reform Act. The bill reflected unanimity on key details of the justice system DC residents want and need, and it represents years of effort by this committee and the Police Reform Commission. Titles 2, 3, and 7 of this bill would largely undo the transparency provisions the council deemed necessary less than a year ago. Because the mayor's amendments would shield MPD from public scrutiny and accountability, anything less than a flat-out firm rejection would be a grave disservice to your constituents. Without citing evidence, the mayor argues that making BWC videos and police disciplinary records public will impair hiring and retaining officers, will invade the privacy of officers, and will jeopardize their safety. The Police Reform Act does none of those things. Let's be clear. Police officers have no expectation of privacy when they are on duty interacting with the public, because anyone with a cell phone can record police civilian encounters, and officers must clearly display their badges. The redaction of video or the names and badge numbers of officers does nothing to protect public safety or their safety. And accountability and public confidence are far more important than making it more easy for the MPD to retain and hire officers. This bill would severely narrow the BWC disclosure requirements in several ways. It would eliminate from public view many of the use of force incidents that do not end in death, use of chokeholds, and except for use of chokeholds and bites by police dogs. Finally, the bill would allow redaction of officers' faces and exclude their names from the database of BWC video that MPD would have to keep. And that would make it useless as a tool for inspiring confidence or for an investigative tool. The mayor's amendments would hobble the OPC's database of sustained complaints by making them anonymous, no names. So you couldn't search for an officer's record. Most importantly, the bill would hide from public view all sustained complaints that do not end up in suspension, demotion, or termination. That's a lot of complaints, and it encourages the MPD and the union to negotiate dispositions that do not get to that serious level to keep the public from learning about disciplinary cases. We urge you to retain all of the provisions in the police reform bill related to these issues, and we look forward to working with you on making the public more confident and more safe through its oversight of the MPD. Thank you.
Thank you, Mr. Becker. Commissioner Ashley Ruff, ANC 7F02.
Good morning, Councilwoman Brooke Pinto, and good morning, Councilwoman Bonds. I'm a little nervous this morning, so bear with me. I think more of where my concern from is asking questions. The questions that I ask are for the community, and also as being a African-American mother of a young Black boy and a single mother. And when I ask that, I stand for many people in my community. And the questions that I ask today, as my colleagues here, is how can information be redacted from officers and allowing them to view the video before the public does, or before council does, or before anyone does? And I am truly a firm believer of that MPD is an important part of our community, but also, again, how can we allow them to view footage when we are already fighting out here to see footage, previously before George Floyd, and even Trayvon Martin. And so when I speak about that, I also go into the fact that we talk about that people are not allowed to wear face masks. They are not allowed to wear hoods. My child feels comfortable wearing a hood, going to school, wearing uniforms. And it's not to commit a crime or anything. it is because he is comfortable in his personality, he is comfortable of keeping warm in school, and all other issues that we have discussed. And I think that those are two of the most important to me, but the other in our community is also about declaring drug zones. And so when we declare those drug zones, are we mindful about who we are picking on or who we are choosing to pick with at that particular time? If you are not officer friendly of the neighborhood and you do not know that potential person that is selling drugs in the neighborhood that is causing the ruckus, how can you pinpoint who is actually the problem? How can you declare it a drug zone? Yes, we know drugs are prevalent in our neighborhood. We know that K2 is prevalent in our neighborhoods, predominantly in 7 and 8. But when we speak, I speak for the whole entire DC, and maybe not for everyone. But how do we know? How do we know that we're picking on the right person at the right time? That they are a person that has committed a crime or that they have previously committed a crime and that they are now basically being, just picked on because that they made a crime? What if they just made a simple mistake? And I'm not saying that I'm soft against crime. I'm saying that simply everyone is not wrong. Everyone should not be prosecuted. There are people out here that just simply make a mistake at the time. So my question is, what if? Thank you.
Thank you, Commissioner Ruff. Commissioner Kevin Rapp, ANC 5E05.
Thank you, Councilmember Pinto, Mr. Morales, good to see you, Councilmember Bonds. And a bit of my testimony kind of just comes directly in a similar line to the Commissioner. When I look at a drug-free zone, I don't know if this has been stated today, but a drug-free zone is within, as I believe 1,000 feet or 333 yards, roughly 3 football fields away from public or private daycare center, elementary school, vocational school, secondary school, junior college, university, public swimming pool, playground, video arcade, youth center, or public library, or in and around public housing. These zones already exist. What is going to be different here? Are we going to talk to our community members directly? Are we going to post notices? Will signage be put up? Will this be explained to community members? Both individuals who are hanging out in the area, storefront owners, nearby schools. How much time is there going to be before we start enforcing these areas and, in between this communication? On January 21st, Mayor Bowser held a meeting addressing public safety with all of our advisory neighborhood commissioners. We addressed at that time concerns over open air drug markets. On the 16th, the 17th, and the 18th of October, I took walks with Councilmember Pinto, Councilmember White was there, Councilmember Gray, Councilmember Lewis George. We were on Minnesota Avenue in Shaw, Good Hope Road, now Marion Barry Avenue. We are on Georgia Avenue, many areas that are already drug-free zones. We know they exist, but what are we doing? What we can do is I've been out in the community talking one-on-one with individuals, meeting individuals who need help. They need medical help. They need housing. I could go on and on about that. And I want to stick to where I'm at. Chief Smith stated on October 23rd when there was a conference that on day 1, they'd go out and make arrests. On day 2, they'd go back and bring in all DC government approach. On day 3, we'll do a celebration. What are we going to do on day 4? What are we going to do on day 5? What are we going to do tomorrow? Do we have a police task force for this? I don't know if one exists, but if one exists, it's not doing anything right now. I just think this is spinning wheels, and we already have, when we're talking about this public loitering, when we're talking about open air drug markets, enacting this law, unless we're looking at a long-term approach and we're looking at a thoughtful process involving every area of government, public, private, federal, that's what we need to do.
Thank you, Commissioner. Thank you all very much. And Commissioner Ruff, I was struck by a couple things that you said, but I wanted to provide what I think is clarification on the proposals specifically. So when you talk about the body worn camera review, in instances of a police involved shooting, for example, where the public or the council may ask to see this footage, that is a different circumstance than what this is dealing with. This is dealing with the cases that are not involving a police involved incident. For the majority of cases, that might be a traffic stop or another arrest, to review the footage prior to writing the report. And one of the things that we're concerned with is, in practice, we've seen so many of those reports be so terse and so short, and then have to be amended if additional details come forward with the review of the footage. And that has kind of undermined some of the cases in practice. And so I just want to make that clarification there. And then in terms of the mask, and thank you for sharing about your experience and your son wearing a hood. The hood would not be considered part of the anti-mask, is my understanding, but they've included language that suggests that somebody needs to be in reasonable fear of a crime being committed. So it's not just the fact that a mask is being worn, but I still think we need to unpack your larger concern of how are we making that determination and how are we not being too overly broad with that. So I just wanted to share those thoughts. Thank you. Councilmember Bonds?
Thank you very much, Chairwoman, and thank you all very much for your testimony this morning. You know, the bill is focused on police service in the community and how their action actually may or may not affect reducing crime. And so you have made it very clear. You have some very strong points against provisions as provided in this bill. So I want to hear from you. What do you think would be some alternatives that could replace these items? You know, Title II, Title IV. Help me understand what are your suggestions? We know a greater portion of the community has some real strong feelings against many of the provisions that contained in this bill. So I have to ask you, since you're here, what are your suggestions? You got to think about it from that perspective as well. Mr. Becker is ready to.
Yes, ma'am.
All right.
My answer to you is that you did the right thing when you passed the police reform bill. Titles 2, 3, and 7 undo what you did last year. And that is very bad. It is bad for public confidence. It is bad for public safety, because if you don't have public confidence in the police who are serving you, you won't cooperate with them. And so the community doesn't help. And it helps. There are more issues here. Criminal defense lawyers have been forced for years to use the U.S. Attorney's Lewis list of officers under disciplinary or criminal review as a guide to officers who may be problems when they're in cases. If the disciplinary cases are online, if the body-worn camera video is online, then defense investigators can build information that is useful in defending people who are charged with crimes. Not often, I'm not saying that there are a lot of people who get charged wrongly with crimes, but there are lots of cases where officers have problems, and the criminal defense bar, and I was a member of that for 30 years, need to know that information in order to defend our clients. So what I'm asking you to do is do nothing on those 3 provisions. Don't reject 2, 3, and 7.
All right. Yes, please, of course.
If we're looking at what can we do, last June, we had the mayor and the former Chief Conti talk about going back to basics and getting our officers back on the streets, walking the beat. But when I addressed that at one of our ANC meetings in July, I was told by our third district that they didn't have the time to do that. When the gentleman is mentioning police involvement and the community and lack thereof, that's one of the measures. But also, I heard yesterday, and I didn't look it up to confirm, so we'll have to look at that. Don't quote me on it. But that 85% of our police officers are not residents in the city. Can we look at some provisions that would help them to move here? I know we have some measures in place that can help them with housing. Can we get perhaps a monthly stipend to aid that? Can we bring back the regulation that allowed police officers to use their vehicles for personal use when they're in the city? Can we look at their cell phone usage? Every police officer, to my understanding from talking to the police department, is issued a police cell phone. I really don't think they should have the use of a personal cell phone. I love our police force. I'm talking to them every day. But if there's one officer that's using a personal cell phone for 30 minutes, that's 30 minutes too long, especially in this crisis that we have right now. We need to be accountable, and our officers need to be here, living in our communities. We need to support them. We need to, go up to them, have the window rolled down, say hi, say thank you. But we also need to put in some measures that are going to be proactively helping them to engage with our community.
It's off.
Councilman Bonds and Councilwoman Bond. Pinto. So I think that one of my things that I've been battling through when I was trying to write a testimony is that it is the framework of the language in the act legislation for me. It seems that it is geared solely towards Black individuals and brown individuals. And we all know I am not a sugarcoater. I will never take nothing back. If I said something wrong or I did something wrong, I will apologize. But I will not apologize for standing up for the people that I am supposed to stand up for. And it is the language content that is actually posted in the act. If the language was changed, then it will be pliable for everyone in the District of Columbia, not just Ward 7 and 8, not just the problem in one that we seen on the news this morning, not any of those issues, because we're all facing the same issue. So where do we correct the language in the act to fix it to where it is pliable to everyone? When you commit a crime here, they already know there's no chase, no anything. So they think that we're a joke already. So my thing is to change the language to show that it is not towards one or two races, but to show that the language is for anyone that crosses over in here into the district to create a crime or to commit a crime. And that's where I come from.
Thank you. Thank you very much. Ms. Burton, I'm sorry, I've run out of time. Thank you.
Thank you all very much. Thank you,
you.
Councilmember Bonds. And as a reminder, we do have over 80 witnesses today, so I'm going to ask everybody to try to keep their testimony to 3 minutes and my colleagues to keep to our rounds. But thank you for all being here. Really appreciate it. Next, we will hear from Howard Marks from the Residences at Gallery Place Condominium Association. And again, Mr. Marks, if you can sit in this first chair on my right. Rebecca Strauss, Federal City Council. Rog Sedalia, Public Witness. Am I pronouncing your name correctly? Melissa Wasser, ACLU of the District of Columbia. Mr. Marks, whenever you're ready.
Madam Chairperson Pinto, Ms. Bonds, committee members, my name is Howard Marks. I'm the Vice President of the Residents at Gallery Place Condominium Association. First, I wanted to thank Chairperson Pinto, our first ward council member, for her leadership in combating crime in the district. Even though she has been on committee chair for less than 1 year, Ms. Pinto has demonstrated effective leadership in making our streets safer. Thank you. We are one of the largest downtown condominiums with approximately 300 residents. And I know that Councilmember Bonds has visited us, and we're very appreciative of her appearance before our members. I wanted to testify today in favor of passage of Act Now. I have several suggestions on how the bill could be strengthened by eliminating loopholes, which will make enforcement difficult. I want to focus on Title 10, which creates drug-free zones. The once vibrant Chinatown neighborhood is declining rapidly because of the almost around-the-clock open-air drug market, which has emerged at the foot of the Chinese Friendship Arch. Dealers are selling dangerous illegal drugs, which last year caused the deaths of 100,000 Americans because of drug overdoses, many in this city. Our residents daily are faced with a gauntlet of dealers who regularly jump the fare gates at the Gallery Place Chinatown Metro Station. Often, they set up shop at the top of 3 sets of Metro escalators leading to the street. The rights of Metro passengers to have unimpeded access to the street are arrogantly denied by these dealers. Section 3 should be amended to eliminate the 5-day moratorium on drug sales. This will not solve the problem, as dealers will simply move to the next block during this very short period. We need a permanent ban on drug sales in highly active locations, such as near metro stations, sports arenas, and federal and DC government buildings, including lease space. Feel-good solutions will not solve the takeover of parts of our city by drug dealers. These are the other changes that we would like to see. Section 3.4 lays out the criteria for establishing a drug-free zone. It should be expanded to include the adverse economic impact of drug activity on local businesses such as restaurants and the value of nearby residences. Section 5 limits enforcement to the Metropolitan Police Department. This should be expanded to include MPD partner agencies, park police. Section 6 deals with bus passengers. This is very difficult to prove who is a bus passenger, who isn't. And it's a loophole you could literally drive a bus through. This provision should be stricken. If downtown DC is ever going to beat its potential, the council must give police and prosecutors the tools they need to shut down open-air drug markets and other criminal activities detailed in this bill. This concludes my statement. I will be happy to respond to your questions.
Thank you very much, Mr. Marks. Rebecca Strauss, Federal City Council.
Hi, Becky Strauss, Director of Economic Initiatives at the Federal City Council. I'm also ANC Commissioner for 2CO2. And actually my ANC is where Howard Marks lives, and it's good to see you, Howard. He comes to a lot of our meetings. And I just want to say on behalf of ANC 2C, we passed a resolution at our last meeting in support of this bill and the Active Act. As I know, this is a top concern for everyone in our ANC. And the Federal City Council is a business civic organization, as you know, and a lot of our members are CEO level leaders in the city, and public safety is their top concern. They support this. And my main message is that the status quo is unacceptable. And as you've said yourself, the solution to the crime wave, there aren't any easy fixes. There isn't one solution. There has to be many different solutions involving the very elaborate ecosystem that is DC's public safety system. And I also wanted to mention, as I did in my last testimony, that the median voter is behind you on this. Opportunity DC did a survey in September of 800 registered DC voters, and it found that a majority said that MPD needs more tools and resources to address crime. A majority said they wanted more police in their neighborhood. A majority said they don't feel safe going about their daily life. And a majority said they had changed their day-to-day activities for public safety concerns. Of those who are thinking of leaving the district, half say it's because they are worried about crime. And what we do know about deterrence Crime deterrence is that punishment must be swift and certain. Basically, do they get caught? You probably know this. It's not about the severity of the sentence, but it's about whether they get caught. And right now, they're not getting caught. And so our system of enforcement and deterrence is deteriorating. And I think that this bill tries to fix part of that. So thank you. And
Thank you very much, Ms. Strauss. Rog Sedalia, public witness.
Good morning. My name's Raj. I live in Ward 7. I spend a lot of time on Minnesota Avenue. I'm a parent. I live in public. I take the bus, et cetera, et cetera. So first of all, we fixed this about 10 years ago. I mean, if you look back at the state of DC 10 years ago, what did we do then that worked? Maybe look at that. The other thing is the laws in my neighborhood, they're ignored. So any law that you create doesn't really matter to me in my day-to-day life. Go down to Minnesota Avenue, take the bus, take the train, open your eyes. Very few laws are recognized, and that's just the reality of it. Getting to the culture of DC, if we can't fix it, why don't we just feature it? Meaning Arizona features their natural wonders. New York with Niagara Falls features their natural wonder. Maybe crime is DC's natural wonder, a culture, a history. It's fantastic. I'm in awe of it every day. So if we can't fix it, feature it. It's like if I rip my jeans, I make ripped jeans popular now. Okay. Some alternatives. RFK. It's a big campus. Maybe we should turn it into a prison, because I don't know of a 3-time offender who could commit a 4th crime while in prison. That's just a fact. Mandated family planning. I see, young women with 3 kids pushing their stroller down Minnesota Avenue. I'm not much dumber than everybody else, but I have a feeling that's not going to turn out well. Totally unprepared, ill-equipped to face the 21st century. And when they're screaming in their phone or cussing out their kid, again, I'm not much dumber than everybody else, but I have a feeling it's not going to turn out well. And that's generational, it's traditional, it's cultural. But we live in a free country, man. We say land of the free, home of the brave. We don't say land of the safe, home of the brave. So maybe that's just our culture. Another alternative is maybe, when you go to a parking lot and you see there's 25 parking spaces left, you know what to expect. My problem is I don't know what to expect at the corner of Minnesota and Dix. I got to size these dudes up and say, hey, is this the day they're just smoking a blunt and chilling, or they have other things on their mind? What if we have a parking meter that says, hey, welcome to DC. We erased the first 3 felonies on everybody's record, or what else? Matt Graves didn't prosecute 52 cases today. So everybody knows, make it plain, make it public. Thank you. I'm on my way back to Minnesota Avenue.
Thank you, Mr. Stelia. Melissa Wasser, ACLU of the District of Columbia.
Good morning, Chair Pinto and Councilmember Bonds. My name is Melissa Wasser. I'm the Policy Counsel at the ACLU of DC. ACLU DC strongly opposes Act Now, allowing officers to choke people, to escape accountability, and to arrest people without probable cause will not make this district any safer. What will make the district safer and build public trust is holding police accountable for when they abuse their power. I'm focusing my testimony today on the sections dealing with drug-free zones, the neck restraint changes, and body-worn camera and officer disciplinary database changes, but my written testimony will cover the entire bill. Reinstating drug-free zones that were unanimously repealed in 2014 with then Councilmember Bowser's support is not the way to achieve public safety. Loitering is constitutionally protected, and the district can't make it a crime for a person to loiter or to fail to disperse when ordered to disperse by an officer. Ordering a person who has committed no crime to disperse and then arresting them effectively makes mere loitering a crime, which is unconstitutional. We urge the council to reject this unconstitutional section. The definitional changes to neck restraints and asphyxiating restraints are potentially fatal and unnecessary. These changes also stand in direct opposition to the council's own rationale for banning these restraints in the first place. In response to the killings of both Breonna Taylor and George Floyd by police, the council initially passed these reforms and reasoned that banning the use of neck restraints was, quote, the provision most responsive to the circumstances of George Floyd's death. Asphyxiating restraints would now be defined solely on the purpose or intention of the law enforcement officer to severely restrict the person's breathing, which is a much larger legislative change than trying to stop incidental contact, as both the mayor and MPD have claimed. This change, as others have noted, would further the use of chokeholds. The legislation's proposed changes to the body-worn camera program and officer disciplinary database fly in the face of transparency and accountability. Initial police reports should be based on the officer's unbiased recollection of events, and this bill would allow officers to view the footage prior to writing initial reports in direct opposition to the Police Reform Commission's recommendation. The legislation would also remove the requirement that the officer disciplinary records database include the name, badge number, and current duty status of MPD officers with sustained incidents of misconduct. This change violates public trust by shielding officers who commit police misconduct from the public view. ACLU-DC thanks the committee for the opportunity to testify today. We oppose this legislation and urge the committee to review the DC Police Reform Commission's recommendations for alternative solutions that will improve public safety in the district. We are happy to work with the committee on a comprehensive, proactive approach to public safety. I look forward to any questions you may have. Thank you.
Great. Thank you, Ms. Wasser, and thank you all for being here and your continued work and participation in this process. I want to ask specifically about the drug-free zones, because I heard you, Ms. Wasser, say that, you know, in cases where somebody has committed no crime, and I think that is part of why this is formulated in this way, to say it is still a crime to sell and use drugs in the district. But in order to enforce that, to have a 5-day period where this location will be able to be disrupted, will not solve it all, but it could give officers another tool to disrupt it. So when we have residents like Raj and Howard and Becky who see the same people engaged in the same criminal activity every single day on the exact same location, it gives a tool to disrupt. So I first want to ask you, Mr. Marks, when you talked about, you know, 5 days is not a good metric because people will just move. How do you envision a more effective policy, not to have anti-loitering laws throughout the city, but specifically to address the repeat drug sales and uses that we have in certain pockets?
Well, we believe that the ban should be permanent. I mean, it's already permanent around schools, around other facilities within the district. Right around our corner, there are a number of schools on 8th Street. Clearly, the metro station is the big target area because this is a major transfer point between buses going up to Silver Spring along 7th and Georgia Avenue, and also the X buses that go eastbound to Benning Road. So the drug dealers will coming back there day after day after day around the clock because this is where the business is. So in my opinion, the metro stations especially should be a permanent ban around the metro stations for sure. Thank you.
Any other thoughts on that idea, on metro stations, drug bans?
I mean, I can talk a little bit more about the drug-free zones and why they may be unconstitutional in this manner, if it would be helpful. You know, we've seen this already unanimously repealed less than 10 years ago. And as I mentioned, loitering is constitutionally protected, and the district can't make it a crime for a person to loiter or fail to disperse when the officer orders them to disperse. You know, on the other hand, you know, loitering for the purpose of committing a crime is not protected. This means, a jurisdiction is allowed to outlaw loitering if it's being done with the intent to commit a legal act, like you mentioned. The problem comes in the language of the legislation. An officer would need to have probable cause to believe that the suspect was committing or intending to commit a crime, because probable cause is the constitutional minimum for an arrest, not an officer's reasonable belief. And it's for that reason that would fail.
Okay, thank you. Oh, all right. Well, thank you all very much for being here. Appreciate it.
Thank you, Councilmember Pinto.
Thank you. Next, we'll hear from Robert Vincent Branham, Ward 5 Leadership Council, Public Safety Committee. Welcome, Mr. Branham, and if you could sit on this seat farthest to my right. Ricky Bryant, Street Line. Maka Taylor, Global Gains Consulting. Kenethia Alston, Coalition of Concerned Moms. And Roger Marmette, Peace for DC. Ms. Alston. All right, first we will start with Robert Vincent Branham, Ward 5 Leadership Council, Public Safety Committee.
Good afternoon, good morning. Public safety is a paramount duty of government. It helps to lead to a high quality of life for all citizens. To foster public safety, three things are needed and certain. Those perpetrating crimes must be held accountable, the rights of those accused must be protected, and the victims of crimes must be respected and supported. Community reform advocates must not ignore the devastating impact of crime on people and in our communities. While there has to be a concern about mass incarceration of Black Washingtonians, there must be a concern for the many Black Washingtonians as victims of crimes. I do not ignore outlining certain anti-crime measures, outlawing certain anti-crime measures as attempts to criminalize Black people, nor do I discount reports asserting crime is measured in a way to focus primarily on low-income communities of color. Government officials and community advocates must respond with a coordinated plan to address the rise of violent crime in the district. Yes, anti-crime laws must be balanced with constitutional protections and services to address crime avoidance, such as jobs, housing, education, healthcare. But advocates for police reform must recognize the plight crime has on communities of color. This bill is but one step, a testament toward striking a balance between bringing justice for the victim and bringing justice to the perpetrator. Fighting crime is not mass incarceration of Black Washingtonians, nor a racist public safety policy endeavor. I oppose all forms of injustice. I know what injustice feels like. I also know what it means to be a victim of crime. I have picked up a young person in my community from a Virginia jail. I have responded to a mother's plea to help gain the release of her child from DYR's custody. I have marched for civil rights protection for all, even the accused. My heart and mind are clear. Community measures and government initiatives for those in need are necessary for a safe and vibrant city. However, it would be irresponsible to walk away from recognizing there is a crime problem in our city. Our young people are hurting, distracted via social media, growing up physically before their minds are fully developed. This legislation will help to restore community confidence. However, constitutional protection for all cannot be sacrificed or surrendered because of alleged criminal acts committed by those accused of crimes. Reversing law enforcement transparency because certain officers fear accountability and identification is not a justification for government secrecy. Transparency and oversight are not anathemas to sound public policy. Those who take an oath to serve armed with a weapon have a higher responsibility for care and should be expected to be held to a higher standard than those accused of a crime or a developing child. Finally, I urge the committee not to forsake rational and needed public safety measures because they are opposed by zealot police reform advocates. I also urge the committee to go over the legislation word by word to assure and to ensure constitutional rights are protected for the accused and the victim. So throughout public safety, compassion and justice must always be affirmed. May we forever be decent toward each other and gracious unto him. With these caveats, I am in support of the legislation, and I thank you for your time.
Thank you very much, Mr. Branham. Ricky Bryant, Streetline.
Yes, my name is Ricky Bryant. I'm a CEO for Streetline, which is a new program. We are all looking for help and solutions here. And this program, I think, provides just that. What we're not looking at, and I'm not gonna read from my program issue, but I want to iterate everything that's totally been going on in our city, which one has not been looking at, is that we have those that hang out on the corners. You talk about drug-free zones and all these particulars, but you're not looking at why they're hanging out on corners. Nobody's looking at the addiction behavior. They're not looking at it therapeutically. You're looking at it just on a whim that these kids are just hanging out. You know, these guys are just hanging out, but it's an addiction. It's a learned behavior where people feel safe, where they feel comfortable. They have a false sense of security. You know, these are all addictive behaviors. Nobody's looking at it from a therapeutic point of view. And this is what Streetline is trying to do to help out our communities, is to look at things from a therapeutic point of view. You know, don't just tell us, these bad guys are hanging out on corners, which are mostly people of color. You know, and I don't mean the corner just down the block. I mean the corners in stairway hallways and storefronts and parking lots where any group hangs out at. They have been taught negative behaviors. It definitely comes from the streets. You know, our kids are being taught these. You got 6-year-olds singing rap songs. You got videos showing GTA, which is Grand Theft Auto. And you wonder why there's carjackings. You wonder why there's robberies. These things are being taught and indoctrinated. Nobody's looking at it from a therapeutic point of view. There's a debriefing that has to go on in our neighborhoods, a mass debriefing. Streetline is able to do these things if you give a chance to grassroots programs. You got programs out there that addresses all these issues, but nobody knows about them. So what Streetline is a way of being able to have a call center, which is unique because they don't have that you have hotlines for drug abuse, you have hotline for alcoholism, you have hotlines for Gamblers Anonymous, but you don't have a hotline for the people on the street that need to be heard, that need to be understood. These are the things that we're looking for. So if I can just say one other word, give Streetline an opportunity to help our community, young youth and adults. Give them a chance to have a voice as well.
Thank you, Mr. Bryant. Kenethia Alston, Coalition of Concerned Moms.
Good morning, Councilmember Pinto and members of the committee. Committee members, why not provide full transparency to the families of those impacted by MPD, including what took place before, during, and after the incident? All officers involved names, the full unredacted body camera footage, and the investigation. Unfortunately, all of the above still remains unknown surrounding the killing of a DC resident and my son, Marquise Alston, by the Metropolitan Police Department. Pursuant to the legislation enacted by the DC City Council on July 22nd, 2020, I have been asking the DC City Council and the mayor for the past 65 months to provide the full body cam footage from all officers on site and all the involved officers' names. We know there were at least 6 officers who were involved in the jump out, yet MPD only released a few minutes from 2 cameras. I, Kenethia Alston, am the pain-stricken mother of Marquise Alston, and I do not support some of the provisions within Bill 25-555. Within this bill, it states officers should have the ability to review their body cam footage before their initial report, and the public posting of select information related to the officer's discipline should be limited. Allowing officers to review their body cam footage prior to their initial report breeds mistrust and undermines community confidence in its police department, particularly in cases where police officers are accused of misconduct or have used deadly force. It took the deaths of many Black lives from our DC community and the advocacy of mothers like myself to get legislation that would advance transparency and encourage accountability in DC's police department. As a mother of a son killed in the District of Columbia by MPD officers, it is imperative that I advocate for MPD's authentic transparency, moral accountability, and impactful laws that truly benefit our community as a whole. We need to create an environment in which DC residents are not still experiencing jump out tactics by MPD when Black men in marginalized communities simply run from the police when they are not causing an immediate threat. Bill 25-555 does not address the bias and discriminatory actions that plaque MPD from top down, over policing in marginalized communities, the historic increase in civilian complaints regarding officers' harassment, and a series of lack of accountability for officers' misconduct. Bill 255 is a rush to action Band-Aid attempt that undermines transparency and accountability without making DC community safer. In closure, as Marquise Alston's mother, I want the full truth from DC. I hope Black families never have to go through what my family went through for the past 5 years in county. Thank you.
Thank you so much, Ms. Alston, and I'm so sorry about the death of your son. And the committee would be happy to work with you to get you the information that you need. Thank you. Roger Marmette, Peace for DC.
The problem with this bill, beyond procedural or constitutional issues, is that it will not work to reduce violent crime. This is another example of just making things up as we go along, trying to do things that the body of evidence proves do not work. If we want to disrupt drug markets, drug-free zones do not work, period. And we can speak to experts on that all day long. What does work are deeper strategies that take more work and more commitment from the council, from the mayor, from all of us. One example is the National Network for Safe Communities proven and evaluated 9-step protocol for dealing with drug markets based on data and science and deep wraparound work. My son was also murdered in DC in 2018. What's frustrating to me is that in those 5 years since Tom was killed, we have not made progress at system change and communal, working with government, community, business, all of us together to address this problem, this crisis, with proven evidence-based strategies that we have seen work elsewhere. This is why legislation, a slew of legislation thrown at the wall, at the edges, will not make us safer. We are an outlier, as you know, among other American cities. Only 2 other cities have a higher year-on-year increase in homicides and violent crime, because what we are doing is not working. I urge the council to be proactive. I urge the council to lead, to set a goal, a NEAR 2.0. Let's set a goal for 10% reductions every year over the next 5 years, then program our way into it with evidence-based proven strategies. We have to stop nibbling at the edges. We have to make a commitment. Reducing violence is foundational to every other issue the District of Columbia faces. If we are in this together and rely on evidence and science and data and make a commitment, we can reduce violent crime by more than 50% over the next 5 years, but not if we keep going with piecemeal strategies and reactive legislation. Thank you.
Thank you very much, Mr. Marmette, and thank you for, again, sharing your story of the loss of your son. We're so sorry for your loss, for both of your losses, and we will keep their memories alive as we proceed in this work and in these efforts. Thank you both. I want to ask you, Mr. Bryant, about some of the kind of therapeutic responses that you're talking about. And I do want to note that we had a hearing on the district's violence reduction programs several weeks ago, at which time the city administrator announced the rollout of a new 211 warm line for some of these purposes that you're talking about. So people can call and get the services that they need, or refer a family member who might need some services, especially if they are at risk of committing a crime or being victimized by a crime. And so we will be following that rollout closely. It's right now going to be managed, or the call takers will be housed at OUC, taken from some of the folks who are doing the 311 services, so not away from the 911 call operators. So just so you're aware of that update, and we'd love to have your perspective on that. But also on the therapeutic responses, I'm curious what you see as best practices, particularly if people deny services. This is certainly not the case everywhere, but in some hotspots of drug activity in particular that we've seen around the city, we have made several efforts of interventions that are about support, that are offering treatment, that are offering treatment on site or treatment at various facilities. And in some of these locations, people's answer have been no, or in worst case, pulling out a weapon to threaten those offering care. And so in those particular cases, what do you see as some of the best practices to intervene, make sure that that activity does not happen, and get the balance right of making sure we're addressing the underlying addiction challenges that we may have, but also making sure that we don't have areas of repeated incidents of criminal activity that residents are walking by and seeing every day, and their safety is being harmed as well?
First of all, let's say this: mentoring works. So those have been out there on the streets, which I've been. Mentoring works, but you can't be on every corner. You can't be in every neighborhood. So it limits the audience. What Streetline does, it creates a call center where the neighborhood, whoever it is, young, old, or whatever, can call in and get any information needed to reach the ground roots programs, to reach the government issues that need to be talked about, if to learn legal issues like probable cause for officers to stop them, anything that concerns our neighborhoods and concerns the fact that people on the streets, whether they're being harassed or learn how not to be harassed. You know, mentoring again works. So if you're teaching a person, if you got a way of teaching a person and positivity instead of negativity, they have a hotline that they can call and get all these kind of informational prospects of learning how to develop themselves and giving them more hope. Whereas though we don't have that resource now other than street line to look at it from, again, that therapeutic point of view. You know, these are addictive behaviors. When you want to hang out on corners, when you want to feel safe here, when you want to do things that the next guy do because they're in your neighborhood, you know, you're addicted to the what you feel is self-worth. And it's not, it's false. And we want to let them know that it's false. We want to educate them. We want to educate people, you know, in those particular neighborhoods so they don't get caught up in law enforcement issues. You know, if they know about issues like, let's give you an example. Let's take it to the hood. Let's take it to the hood for a minute. Man, he got some nice tennis shoes on. Let's take them. But if they knew that if you take that, that's robbery, and you can get 10 years for taking those tennis shoes, we're talking young age here. You know, if they knew that, then they might be more deterred not to take that guy's tennis shoes. Drug dealers. You know, what made me come out and create this program is all our babies getting killed on these streets where they selling drugs and stuff like that. Babies. So let's go to the drug dealer. I'm not going to try to stop you from eating. You know, law enforcement can handle that. What I want you to do is keep these babies out your way, man. They bad for business. But we got that baby out the way through that drug dealer, hood healing itself. Items like that where they can call street line and learn from a confidential conversation like that to get them off the street, you know, to keep our kids out of harm's way. We got to talk to the streets. And this is a way for the streets to be able to talk to us. You know, I need help getting it up and running smoothly. It's going to be up and running, but I want it up and running smoothly. And that's what I want you to understand when they say therapeutic. It's a learned behavior. Everybody talks to the street, those old hood guys, those young hood guys getting together and they talking and they kicking the bobo. You know what I'm saying? So, you know, and I'm being real as street language with, you know, and they learning how to do this. Man, I want to go on a caper, man. We got to get this. We got to make some money. You call street line, you say, hey, they got a job fair going on. We combating positive with negative. You did. We combating all the negative with positive aspects. That's what a therapeutic process is. And learning that you have an addictive concept going on here. How do you get off these streets? Do you need some hope? Do you need guidance? These are the facts that we need to put forth to our young youth and even some older adults. You know, we have to let the hood help the hood too.
Thank you very much. Sure, go ahead.
Can I just add one quick thing for behavior change, whether it's substance use disorder, hypervigilance, violent behavior? The gold standard is cognitive behavioral therapy. It is underutilized, underdeployed by the District of Columbia government. That's one of the things that Peace for DC is scaling, training trainers locally to reach people with CBT.
Thank you all very much. Really appreciate your testimony. Next up, we will hear from Paul Johnson, 4D MPD CAC Executive Committee member. You can talk to Akima over here and she can. Juliet Howell, public witness. Nina Murphy Martin, 4th District Citizens Advisory Council. Pedro Lima, National Hispanic Council on Aging. Aris Compres, Menchos Dominican Restaurant. Ebony Rose Thompson, Ward 7 Representative, DC State Board of Education. Sky Lawrence, public witness. Neil Gearhart, The Pursuit Wine Bar and Kitchen. Robert Murphy, MRP Realty. Is it Mr. Gearhart? Okay, great. Thank you very much. If you could sit in this third chair, and then Mr. Murphy, if you could sit on the end. And Sky Lawrence? Yeah. Okay, great. All right, welcome all. We will start with Paul Johnson, 4D MPD CAC Executive Committee member.
Thank you. Can you hear me? You hear me
Yes.
fine? Okay. Thank you, Chair Pinto. Thank you, the other council members who were here earlier and had other commitments. But I am Paul Johnson. I'm a Ward 4 member of the Executive Committee for the 4th District Metropolitan Police District Citizens Advisory Council. I am the Ward 4 elected committeeman to the DC Democratic Party. And I'm also a former ANC chair of ANC 4C in Petworth. And I'm here probably most importantly in my capacity as a Ward 4 resident, a husband and a father of a 6-year-old that's concerned about the trend of the public safety environment in the district and where I reside in Ward 4. Therefore, I'm here in support of the active amendment here today with some reservations about how we treat pre-trial detention, particularly for first-time offenders, and safeguarding the presumption of innocence. And I think that there needs to be some more work on delineating the particulars and the specifics in that regard. Personally, my wife and family, on a Sunday, participating in a leisure activity, had to run and duck for cover when an instance of gunfire broke out. Neighbors on my block and constituents around Ward 4 regale tales of feeling unsafe about walking after dinner. Members deep in the community that work with vulnerable populations and populations that need services also expressed to me concern about having accountability from all the stakeholders, whether it's parents or caretakers, whether it's law enforcement agencies and implementers having accountability. It is going to take a community first effort to ultimately solve this public safety problem. But, and I'm looking forward to submitting my testimony on the particulars, but this is a first good step. Council needs to take active action. There needs to be recognition that there is, in fact, a crisis. There needs to be accountability to the residents and our constituents about the problem, and consistent, measured, mature, focused work of the highest priority to getting a control of this circumstance, and also getting, while at the same time having accountability and getting members of our community the help that they need should they need it. So thank you. I look forward to submitting my testimony. Thank you for the opportunity. I'm here for any questions. Thank you.
Great. Thank you, Mr. Johnson. Sky Lawrence, public witness.
Thank you. Good morning, Councilwoman Pinto and all the other members here today. I live in Anacostia in Washington, D.C.'s most violent neighborhood. I'm providing my testimony from what we like to call a very active corner. It is known lovingly by my long-term residents as the drug corner. Last night, I was mapping my route to come here. There's 2 bus stops outside of my home. And I always think to myself, how valuable is my life? And then I take the car. Because outside my house in these 2 bus stops, there has been in the last year 1 stabbing in broad daylight and 1 man gunned down that we knew very well from the building next door. Not to mention there's multiple murders on the block in this surrounding block. One I witnessed where 2 men wearing ski masks shot up the building next to my house. That doesn't get started on the carjackings, the open drug use, mostly in front of an elementary school, which unfortunately had to move its entrance to the side because there were so many people passed out when kids came out of school. The entrance was literally moved. There's also open prostitution, and I can say as a resident, everybody knows who the prostitutes are because you can see cars pulling up every single day. And mostly people just say there's nothing that we can do. And that's not a huge issue. No one really is worried about that because what they're really worried about is the violence. That's the top priority for people. I'm from Maine, northern Maine, basically Canada. So I have a really hard time when people say that ski masks are for warmth. That sounds like a lot of BS to me, especially when it's in August. It's to cover the identity because so many people in Ward 8 have seen people committing crimes wearing masks. It just feels threatening. When you get on the bus and there's 7 people wearing masks, it doesn't feel good. Masks are very different than hoods. I can understand a hood, but masks seem unnecessary. There are 25 times more violent crime in Ward 8 than in Ward 3. That's a tough fact. The fact is that folks in Ward 8 or Ward 7 feel it so much more unequally. With all due respect, I think it's really hard to understand it, as I didn't understand living in DuPont Circle or living in the Wharf, that they have to deal with this violence every day, all the time. And it is a Black community, but they're disproportionately affected by this. And so many of my neighbors say, well, who's protecting the average people here that have to put up with this every day? I'm a political science by training, and I think that the social contract is broken. At least where I live, people say the government is just simply not holding up its end of the bargain, which is to provide safety. There's so much violence where I live that personally, I now know most of the police and the detectives. We have a lot of good cameras on our house, so they come specifically to us. And oftentimes what they say is we don't know what we can do. We're really concerned about what is the right and proper thing, or if our hands are tied behind our back when we're dealing with violent individuals. The last thing I'd like to say is that my husband and I, both from small towns, know everybody within a 5-block radius, and we've started a community group that I think is quite representative. We have mostly long-term residents. We have newcomers. We're Black, white, Latino, old, young, and all of us would like to feel that we could be more a part of our community. But I think a part of that is making sure that people actually feel safe. We have written a letter as a group. We didn't realize it was today was the hearing. So we've written a letter as a group supporting the act legislation and Secure DC for all the above mentioned reasons. Thank you so much for all of your hard work.
Thank you, Ms. Lawrence. Neil Gearhart, The Pursuit Wine Bar and Kitchen.
Morning, Neil Gerhart, General Manager of Pursuit Wine Bar and Kitchen. Firstly, I would like to thank the council's time for being here today. I'm here on behalf of the ownership to represent Pursuit Wine Bar and Kitchen at 1025 H Street Northeast, Ward 6. A little bit about myself. I've worked in food and beverage for a little bit over a decade. I know I have a baby face. I understand. But primarily in the Baltimore metropolitan area for the last 7 years. I've recently started working in DC about 3 months ago. Crime has exponentially rose within city limits, and this is from the MPD website. 250 homicides this year, 3,000 robberies, and 6,000 motor vehicle theft. This has put an unnecessary strain on businesses throughout the city. Never in my last decade of work have I seen some of the things that I've saw while working in DC my last 3 months. H Street suffers from a lack of policing. Almost weekly, I must ask individuals to leave the restaurant as they walk in, panhandle, or harass patrons at the table of the restaurant. After asking them to leave, my staff or myself are often met with threats of violent, vulgar language. These instances do not provide a pleasant dining experience, something that I pride myself on as well as Pursuit on. Within 2023, Pursuit Wine Bar and Kitchen has been broken in on 5 separate occasions. Our point of sale system has been stolen. Products such as beer, liquor, and wine have been stolen. We've seen reduced foot traffic and patronage into the restaurant and surrounding restaurants in the area. I brought packets with me today to show what we have to deal with and what other businesses have to deal with. What we walk into constantly: broken glass, product missing. We have unhoused individuals bathing themselves in the streets, defecating in broad daylight as seen in your packet. This is not what makes a good business. The bill and subsequent other bills hopefully passed today will help play a vital role in keeping local restaurants such as the Pursuit Wine Bar here to stay. Restaurants and nightclubs within the city contribute to the city's economy and culture. We provide jobs, support local economy, and create beautiful neighborhoods that regularly bring in tourists and locals. If the current crime trends keep moving as they have been, these restaurants and businesses and what we provide will cease to exist. We have lost business due to our customers feeling unsafe within the city. We pull from a large audience, not just from city residents, Maryland and Virginia residents, but also from international travelers and tourists. We need a change to make sure that our neighborhood is safe and that people know it's safe. This bill is a step in the right direction, but the consequent steps need to be put in place to stop crime. Crime prevention and reduction is needed for the survival and longevity of the Pursuit Wine Bar and Kitchen, as well as other restaurants in the area. Thank you.
Thank you, Mr. Gerhart. Robert Murphy, MRP Realty.
Good morning and thank you, Councilmember Pinto and members of the Council's Committee on the Judiciary and Public Safety. My name is Bob Murphy, representing MRP Realty. We are a real estate operating company deeply involved in the district, and I'm here to support Mayor Bowser's Addressing Crime Trends Now Act Now. We manage an extensive portfolio comprising approximately 2 million square feet of office space and 3,500 multifamily units across the district, to include in wards 1, 2, 5, 6, 7, and 8. Despite our commitment to fostering a safe and thriving environment, we are facing a daunting challenge: a concerning surge in violent crimes and property theft across our properties. The spectrum of these crimes spans from murder and assault to rampant automobile and property theft. So specifically, year to date in 2023, our residential properties have experienced 1 murder, 7 shootings, 11 armed robberies, 5 assaults, 6 car thefts, including 3 carjackings, 46 property break-ins, 12 property thefts, and 22 incidents of vandalism. These criminal activities not only jeopardize the safety and well-being of our residents and businesses, but also pose a severe threat to the fabric of our community. The impact of this significantly reduced public safety is far-reaching. It tarnishes the day-to-day living and working experience of those within our properties and creating an atmosphere of fear and insecurity. Furthermore, the ripple effect is felt in the broader context of investment and economic development. The specter of crime drives potential investors away, diverting investment opportunities to other cities and jurisdictions. This exodus of investment has grave implications for the district's growth and prosperity. For the vast majority of my 35 years in DC, this district was consistently rated top 5 cities in the U.S. to invest in by both domestic and foreign investors. This is no longer the case. We are barely in the top 20. I think we're 17 or 18. And that has impact when it comes to the ability to add more housing, but also decreases the revenue streams the district needs that have been used in the district to invest and help our citizens, our citizens in all wards. We urgently need comprehensive and decisive action to address these crime trends. The safety of our residents and the vitality of our businesses depend on it. Measures must be put into place to enhance law enforcement, bolster community engagement initiatives, and implement effective strategies for crime prevention and swift resolution. The mayor's bill does this. We, as stakeholders invested in the district's growth, implore this committee to consider the gravity of the situation and to enact measures that safeguard our communities and support the mayor's crime bill. Collaboration between law enforcement, policymakers, and community leaders is essential in curbing this rise in crime and restoring confidence in the district as a safe and thriving place to live and do business in. The time to act is now. We stand ready to support and collaborate in any way possible to ensure the safety and prosperity of the district for all its residents and businesses. Thank you for the opportunity and share our concerns and insights on this critical matter, and please support Act Now. Thank you.
Great. Thank you very much, Mr. Murphy. Thank you all for your testimony. I do want to note, Mr. Johnson, that the pretrial detention provisions are not included in Act Now. Those are included in others of my bills as part of Secure DC, but in terms of what we're focused on today with this legislation, there is nothing about pretrial detention. I want to ask you, Mr. Gearhart, about these instances of people coming into your business, because one of the things that this bill does is have a separate category for organized retail theft. And we have been hearing a lot more of these hospitality related instances of harassment or threats. Are there other tools that you think would be helpful as you see these examples to deter or respond to that type of activity in your business?
Simply on H Street, I'm a Maryland resident, so I commute into DC every day. H Street is a presence of police. From where I came from, working in Towson, Maryland, having uniformed police officers on corners really deters people. And, you know, going up and down H Street, it would be really nice to see more police officers rather than tow trucks. I understand that's a revenue stream, but it's really hard to sit there and say, hey, we're doing our job, when on our most recent break-in, if you flip to one of the pages, you can see whoever broke in rolled up a trash can, one of our own trash cans, had enough time to fill it with alcohol and walk off into the night. Talking with ownership, I believe all the break-ins beforehand, only one person was ever prosecuted for that. So, you know, I understand we pay our taxes, and I feel as if this social contract has been not upheld from the city as far as, hey, provide safety for the businesses. I would like to see just more uniformed police officers. Thank you.
Thank you very much. And Ms. Lawrence, if you can elaborate a little bit on the ski mask provision, and thank you so much for sharing your perspective and how this can impact you and your neighbors. But some of the language in the proposal speaks to kind of fear that somebody may have as a result of seeing somebody wear a ski mask. And as we grapple with how to ensure that that language provides police with what they need to intervene when a crime is taking place or about to take place, but not being so overly broad, can you speak to that kind of balance based on your experience?
That seems really hard. I don't actually know the answer to that. Like, that's the $1 million question, I think. I just anecdotally, there's many of my neighbors that have been there for years and years and years, and they used to take the bus, and they just won't take the bus anymore because everybody has witnessed somebody with a ski mask committing a crime. So I don't know. That doesn't mean that if you're wearing a ski mask that you're gonna commit a crime. Of course it doesn't. But I think that just as the population more and more sees that happening, then you can't blame them for feeling unsafe. So I don't know the answer to that. And I think that is the question. Of course, we have freedom here and we can wear whatever we want. But then when it starts impacting our neighbors and making a negative environment for people, so then people change their daily life, then I don't know where that line is. Like, I wish I had a better answer for that, except that I know so many people are affected by that. I mean, there's many other things, of course, that people are affected by, but it's more that it creates a chilling effect, right? All of it creates a chilling effect. And I think it speaks volumes. We have this group that's like a 3-4 block radius. And someone mentioned, and it's mostly long-term residents. They said, oh yeah, we used to have like a neighborhood watch where people would walk around just at night, and then people got threatened. So they stopped. And they specifically said, do not talk to the police because your house will get targeted. So I think that kind of stuff is just, and people do still talk to the police. And I've learned you bring the police in your house. You don't talk to them on the street. But I think that chilling effect is really unfortunate when everyone's sort of trying to build a community.
Thank you. And when you talk about bringing the police in your house, you mentioned in your testimony conversations that you've had with officers who will say, our hands are tied. Can you be a little more specific with what types of things that they're talking about that they feel their hands are tied in order to intervene or respond to these instances of crime?
Sure. I think a lot of it is just like a Maslow's hierarchy of needs, right? If you're dealing with violent crime, that's more important than the fact that no one can use the bus stop because there are prostitutes that have been sitting. I mean, everybody knows who they are. It's well known, or that there's drug dealers on the corner. And so they're basically just saying we have bigger fish to fry. I think that's oftentimes what they're saying. And I actually tried to ask a couple of police officers if there were other things and they declined to comment. So I think part of it is just, we're trying, there's not that many of them. I know it's the lowest number, I think, in whatever number of years. And so I think they have a really tough job and they're trying really hard to, use their time wisely, which is right. But I think it leaves the feeling that, the security isn't important, especially for people in the wards that are experiencing the most violence.
Thank you. And Mr. Johnson, did you have something to add to that? I wasn't sure if it looked like you were leaning in to speak.
I appreciate that. I think I just like to leave on your mind, on the policymakers' minds, that I support, and my constituents tell me they support, allowing law enforcement more tools to, in a focused, targeted way, intervene with the criminal element while not being caught up in a broad sort of dragnet. And ultimately, to solve for this problem, it's multiple variables, and it's going to take the entirety of the community. And there's a lot of institutional knowledge in Ward 4, in the neighborhoods in Ward 4, and the neighborhoods around the district that we need to empower and work together to solve together. So community first trust is important, and targeted interventions on the criminal element amongst us. Thank you.
Thank you. Thank you all very much. Appreciate you being here. Ollie Figueroa, Moto by Hilton, Washington, D.C. Paula Edwards, ANC 4A01. Michael Syndrome, public witness. Paula? Sorry, say again? Paul, okay. Michael Syndrome, public witness. Hello, what is your name? Oh, Paula Edwards. I'm sorry, what is your name? Okay, I don't have you on this list. Paul Spies? Okay, would you mind just speaking to Akima over here on my team, and we're gonna see. Okay. Okay, well, let me just keep an order so I can keep track, and we'll just hold on one moment. So Miss Edwards, you can sit in the second seat. And then Michael Syndrome, public witness, are you here? Okay, and Jay Brown, community shoulders, you can sit in this third seat. And then Paul Spires, you can sit in this fourth seat. Thank you. Okay. And tell me again, you're from the Ward 6? Okay, great. Thank you. Ollie Figueroa, Moto by Hilton, Washington, D.C.
Good morning, Madam Chairwoman and members of the committee. Thank you for allowing us to be part of this public discourse. As a combat veteran, I'm humbled to take part of this political process that displays freedom and liberties we fought for abroad. But today I don't come before to you as an individual, but on behalf of the colleagues of the Model DC. I'll tell that welcomes travelers from all over the world at the heart of and the geographical center of Chinatown. As part of our corporate culture, we ensure that new colleagues are introduced to our community and our neighborhood so we can both take part in it and share it with our guests. Historical anecdotes of the president to the origins of Chinatown on Pennsylvania Avenue just steps from these doors. Our team takes great pride in sharing local venues and to visiting guests, highlighting the Friendship Arch spanning H Street and telling guests the story of Chinese Mercantile Association building just across the street. But that notion and pride, however, has become increasingly more difficult to avoid. The topic during recruiting of candidates, speaking with guests, and speaking with stakeholders of our business. It's become increasingly difficult to avoid the headlines and articles that describe our community in a negative light. For us, the Model DC, for us, these are not just headlines or footnotes. They are our front doors. The reality of those facts is the welcome and the farewell our team and our guests receive on a daily basis. The window front counter of our cafe is routinely first row seating to an arrest, fight, drug sale, or worse. No visitor to the nation's capital wants to have a side of violence with their latte. In fact, no one expects that. Chinatown is so much more than a vehicular or drug crime statistics or measuring success in those numbers by a drop in percentage points year over year. It's a community of residents, business, and visitors. It's a neighborhood where business leaders and owners still know each other by first names and share a coffee or a story. It's where I personally came to know DC from the inside out as a new transplant to the district. It's also where the city comes to cheer for their favorite team and artists. It's more importantly when my team goes out to lunch or dinner and commutes to work every day to provide for their families. I bring you this statement today to relay the frustration of our colleagues, our guests, and our stakeholders with the current state of the H Street Northwest corridor. We understand the legislation being discussed today has many aspects to be considered and argued. We are not here representing any political view or ideal. Instead, we wanted to bring you the face of what the other side of the headlines look like. We ask this council to consider any actions such as this legislation would support the efforts of Metro Police, local advisory neighborhood commissions, and business owners and managers to improve their communities. We highly encourage and support any initiative except that of inaction. Thanks.
Paula Edwards, ANC 4A01.
Thank you, Chair Pinto, for allowing me to speak today. Thanks also to Ms. Benjamin for her always professional and kind assistance. I'm Paula Edwards, a native Washingtonian and ANC Commissioner for ANC 4A01. I have lived through the various crime surges in the district and once served on 5 juries in a 2-week period during the city's aggressive response to crime in the 1990s. I participated in the excellent MPD Community Engagement Academy and recommended to all DC residents. As others have said, the intent of the recent flood of legislation may be to show the public that our officials are taking crime seriously, but that intent does not mitigate the effect of poorly crafted legislation. We are being outsmarted by 12-year-olds, not because we do not have enough laws, but because we do not enforce the laws we have. For example, by closing out the more than 1,000 open bench arrest and other warrants using a regional approach. We do not give potential witnesses the opportunity and safety to share information with law enforcement to help ensure arrest and convictions. Frontline workers are exhausted and our leaders are working at cross purposes. Our problems are systemic and we are not working as an effective team. I speak in support of and opposition to various sections of this bill. I support Title I's effort to clarify the use of next restraints for frontline police officers in real-world situations and for the safety of those restrained. But as others have pointed out, these are medical and training issues as well as legislative. I've included language in my written testimony that I think would improve this section. I am opposed to Title X to establish drug-free zones. We've been here before and repealed them in 2014. Carlos v. Morales and Smith v. Smith make past unconstitutional muster on this issue an onerous administrative burden for an already overtaxed police force. It is not worth the process complexity and the liability risk exposure when there are existing laws that will serve us just as well. The rest of this bill needs reworking to make it usable as it represents the inevitable conflict of the rights of different parties. I support Title III in its efforts to protect officers' legitimate privacy rights, but oppose efforts to reduce transparency and the public's legitimate right to public information. I support anti-masking as long as the rights of those wearing masks legitimately are respected. I support the retail section and would like to see the threshold lowered to $500 for enforcement and compliance purposes. As far as the motor vehicle pursuit laws. I've heard from Montgomery County police officers repeatedly of their frustrations with our vehicular pursuit policies, and I recommend working with them to ameliorate them. In closing, I think this bill needs a lot of work, and if we could look at our existing laws, we may be better served than reworking this. Thank you.
Great, thank you so much. And before you get started, Mr. Brown, I do want to apologize. We are, as always is the case, you have to sign up to testify 24 hours before the hearing. And so when I asked if you could speak to Akima, I thought that you meant that it was worked out. We cannot add people at this time. I appreciate others are trying to do so. The record is open until December 13th. We would love to read your testimony, but in fairness of the 80 people who signed up to testify who are waiting their turn, I cannot allow you to join at this time. And I'm very sorry I appreciate you coming down here.
It's a wonky system, and I did sign up 2 days ago. And so that my name is not showing up at all in that system lets me know that it's not working, right? So it's up to you guys to really, it's your system, right? It's something that.
Okay. Did that happen to anybody else about the system not working, but you signed up in time? That was here. And that happened before yesterday morning at 9 a.m. Okay. Okay, so if that happens in the future to anybody, please make sure to email us on the Judiciary Committee so we can help resolve it, because there is a new system. It's meant to be more user-friendly and smoother, but that is certainly possible when there are glitches. So please always let us know when that happens. For that case, we will let you testify. But I just want to be clear, because it's important that we have consistent standards for this in respect to everybody's time. As I said, we have over 80 witnesses waiting to testify. All right, Mr. Brown, Community Shoulders.
Good afternoon. Normally I talk as an advocate, but I want to talk about some things that personally affected me. A couple of months ago, we had a young lady who was killed, 10 years old. She was shot in the head on Mother's Day. In that same community, my daughter was in her car seat, and she was pulling in a gate. 4 young men with guns, aimed their guns at my daughter, right? My daughter's 3 years old. She's showing symptoms of post-traumatic stress disorder. It's very hurtful to watch her dive on the floor when a trash truck rumbles past, right? So I understand fear. I understand the concerns that revolve around fear. But that doesn't mean I want my neighbors, my fellow citizens' constitutional rights to be violated. And that's what this bill does. It does not adjust. This bill does not address public safety. There's slave codes that are going back, taking us back to Black codes and things of that nature that are profiling and targeting Black people. Since we are targeting and profiling Black people with these proposed slave codes and attacks on the constitutional rights of Black and brown people, let me address this matter as politely as possible so you will understand what's really happening. In fact, these bills aren't even putting your beloved police officers in more, these bills are even putting your beloved police officers in more danger. So let me start by addressing the community. They're white people and disengaged Black people. Mayor Bowser is lying to you. The deputy mayor of public safety is failing you. And the new chief of police is preaching way too much. Dear white people, these bills will not address your fears and do not address public safety. These three blind mice I just mentioned above are focused on perception. They focus on perception instead of meaningful policies that keep us safe. Or they want you to feel safe. They're not keeping you safe. They want you to say, hey, we're targeting them Negroes over there on Minnesota Avenue. We're targeting those Black people over there. We're targeting those Black people over there in our community. Chief said last night, the wall on Minnesota Avenue is a thorn in her side. The chief can't tell me 3 people she know on Minnesota Avenue or ever talked to or their backgrounds. Dear white people, if you want to know the truth about what's going on, get in touch with Community Shoulders. I can show you emails. I can show you the solutions that we put in place, or that we wanted to put in place to make change in our community so we wouldn't be here. Dear white people, the mayor is lying to you.
Thank you, Mr. Brown. Paul Spires, am I pronouncing that properly?
Yes, Paul Spires.
Spires from the
Yes.
Ward 6 ANC 6A Community Outreach Committee.
Yes. I'm a third generation Washingtonian. Born and raised here. I was raised in Ward 7 and 8. And moving over into Ward 6 and doing community work with youth between the age of 4 to 17 in Ward 6. And in Ward 8, I've done work with youth from every age. I've been doing youth work since I was a youth at Anacostia Senior High School with Team Champions Incorporated, which was a nonprofit that focused on bringing the academies back to Anacostia Senior High School. I'm gonna skip all my accolades and talk about this bill though, because I really felt like, one, I could just sit back and do the work I was gonna do, or do the work that I do with the youth right now, taking inner city youth out of the neighborhood and onto the National Mall, because I work in tourism every day. And I'm realizing that this bill particularly is not like any of the other bills that you guys have. I looked at your bills, Councilwoman Pinto, and one of them is the Secure DC bill, which is like, it's pretty good, I must say. I commend you on the things that you're trying to do. It has rehabilitation pieces on it and everything. I like that. But this one needs to be rejected. And the reason why is because it does not promote public safety or anti-gun violence. This promotes police brutality, discrimination, and inaccountability. And this is something that it would be foolish for you guys to actually pass. And the reason why, and I'll just name one part of it, because the rest of it, you already know this. I think you already know, and that's why it's not so many council members right here, right now. Although you have other things going on, this would have been a very big priority. But you guys know that this is not going to work. I don't know why you put it out there. Maybe it's because if it did pass, you guys are open to some type of local civil war between the youth and our police force. But the language that you're using here to asphyxiate, we've seen for the past 45 years with George Floyd and all the different police brutality cases nationally, that if you decide to use force and take someone's life on these streets here in Washington, D.C., that you're going to have a whole nother storm on your hands. And I really feel like if you were looking for a solution, we would focus on the bills that you guys have and never present anything like this. This is an attack on the public. Simply, as simple as that. This is an attack on the public that really creates chaos. It would create chaos. I want to speak to, before you ask what would we like to have put in place, because you said that on one piece, but I don't think you're going to access that, because I think you feel like you guys are running out of time. It is getting on lunch, coming up to lunchtime, so I will respect that. But instead of this bill, you guys should be funding brick and mortar youth programs with daily programming. We see programs happen, a block party here, it's over. What happens the next day? People getting shot at that same exact spot. Brick and mortar youth programs, places for youth to go to daily, safe havens. Those things need to be funded. A new truancy force. I see kids running around all day outside. This is about youth. This bill does not just focus on youth, but we know that the people that you're speaking to doing crime is the youth. We can see the numbers, right? But we need to be holding parents and the schools accountable. There are schools turning these kids back because they're late to school. No, let them in school, put them in a room, and get them slowly acclimated back into the school day. The MPD and ATF collaboration, I just can't. I've said this on the couch and I haven't gotten a chance to say it in front of you guys.
we need a collaboration. If you want to get the guns off the streets, the Alcohol, Tobacco, and Firearms Agency is on New York Avenue and Florida Avenue. How do we have this many guns circulating in DC? The police do not compete with these children, with the firearms that these children have. So it doesn't behoove them to jump into a gun engagement with them. It doesn't. But if you collaborate with the people who's supposed to be taking guns off the streets of the United States, then it could work. The other thing that you guys could do is an initiative towards the rehabilitation that leads to service members. A lot of these youth know more about guns than everybody in this room. They know more about guns than the people on the police force. Why can't we put them into a rehabilitation piece that qualifies them to join the United States military? That would behoove our entire nation, including Washington, D.C. The other piece that I have here is the resource.
Very over time. So I'm
know.
gonna ask you to summarize and wrap up.
Okay, I will summarize with the last piece of resource jump outs. We used to, as a man spoke about the jump outs. I was outside doing them jump outs. I was on Good Hope Road and 14th Street, where gun violence is high right now. But I was outside. I was one of those youth. The jump outs jump out, plant stuff on you, all kind of stuff. What if we did something in reverse of that? Resource jump outs. We jumped out. What if we jumped out with resources for mental health, housing, job readiness, gun violence prevention, continuing education, with the protection of MPD, but resource jump outs. Let's not go and attack our community. Let's go and empower our community. And that, I believe, will bring the violence down. The violence here, or the problem with DC's crime, is not about drug activity. It's about robbery and gun violence. Those are the things that are high right now. It's about robbery and gun violence. I work in tourism. The tourists are not afraid to come to DC because of drugs. They're afraid to come to DC because they're afraid of getting robbed and killed. Thank you.
Thank you, Mr. Spears. And thank you all very much. I'm intrigued by your comments about accountability. And I know you mentioned someone coming late to school, but when you say parent accountability, what do you think that looks like or should look like? And that can be to any of the panelists. Your mic.
It's easy to throw out there parent accountability without doing assessments of the parent. You don't know what these parents are dealing with right now. To be honest, with this is the crack baby era for parenting, right? So there's a lot of parents that experience a lot of things during the crack era, and they're going to need support. But in order to know that, we had to do some kind of assessments. We have to be consistent with assessments to figure out exactly what's going on instead of making assumptions about what's going on. I correspond with what he's saying, but accountability also includes exactly what you're saying, research and finding out what the issue is. Before I hold a police officer accountable for killing someone, I want to look at what that police officer's record is, what led to these things. What is this person going through? What have they been through mentally? What is their criminal record before they became a police officer? So it's the same thing with the parents. We can hold these parents accountable, but accountability also means assessment as well. It includes assessment, so.
All right.
Accountability is such an overused, empty word. Without support, as the gentleman who said, you can't hold people accountable. So the parents, a lot of the parents I've seen need a lot of support. We have a woman that we've been trying to help who does not have a home. She's pregnant with twins and she has 3 children, one 7, one 9, and one 13. We have been trying to get her support. We've been trying to find her documents. The level of support she needs is so huge. So that's the kind of thing you really have to look at before you hold anyone accountable.
Okay. Thank you all very much. Okay. And can you make sure to say your full name and position for the record when you I'm so sorry. This is just because the technical glitch issue. This is why I asked if anybody else had technical glitch issues. It's just not fair to the 80 people who are waiting to testify to add people late. You have to sign up 24 hours in advance, but any testimony that you submit for the record's open until December 13th. We will read and review. And I am sorry, really appreciate you coming. I can't do this to all the people who are waiting their turn. You did sign up. So what happened to your sign up? And what about you? I hope. Okay, for everybody watching's future reference, all testimony has to be, you have to sign up to testify 24 hours before the start of the hearing. If you have any issues with glitches, haven't heard back, having issues with technology, whatever reason, email us at judiciary@dccouncil.gov and Akima on our team will help you. Okay, so we are going to hear from you three due to the technical issues that we're going to avoid from happening next time. Please say your full name and your position for the record.
Good morning. My name is Erica Green, and I am an ANC commissioner in in Commission 8C. I represent Single Member District 8C04. I'm also the Ward 8 Climate Change and Resiliency Commissioner, and I'm also here. I won't say that actually. Thank you so much, Council Member and committee for having this gathering today. Our voices need to be heard. As strong advocates working to combat crime and other public safety hazards plaguing Ward 8 and our city, we are writing to provide support for the following legislation: Bill 25-555, the Addressing Crimes Act Now Amendment Act of 2023. We are excited to be a part of an active solution to dissolve danger in our beloved District of Columbia. We are in favor of amending the Comprehensive Policing and Justice Amendment Act, focusing on safe and effective policing, vital to addressing public safety challenges. Law enforcement officials in the district must be equipped with the necessary tools and capacities to be highly effective in serving our city, which requires specialized care and concern from exceedingly effective team members. The Metropolitan Police Department's hiring and retention of fully qualified officers is important, as increased staffing and capacity building within MPD will progressively allow for city leaders to hold criminals accountable for choices that endanger themselves and others. DC does not have a loitering law. Reinstating our MPD chief's ability to declare drug-free zones for 120 hours is a measure that will disrupt large gatherings outside of stores, making it difficult for patrons to shop, while discouraging the congregating, leading to the presence of illegal drug sales, purchases, and use. Residents have expressed time and time again that they are not able to enjoy such public spaces because of these issues. Our establishments suffer loss due to theft. Quality grocers and other staples contemplate vacating, leaving residents, especially limited in resources such as transportation, those living with disabilities, seniors, and other populations that can be vulnerable with scarcity, creating a new crime for directing organized retail theft and criminal consequences for those who choose to steal from our businesses is essential to preventing further costs and threats to local commerce. Concealing one's face with a mask with the intent to be in disguise for the purpose of committing criminal acts, intimidating and threatening other people or causing fear is a peril, and we must have legislature in place that disciplines every calculation computed to cause harm in the nation's capital. Every strategy designed to inflict oppression in our district should be labeled and responded to as a crime. We are in support of Bill 2555, the Addressing Crimes Trend Act Now Act Now Amendment Act of 2023. Peace. My name is Erica Green. Thank you.
Thank you very much, Commissioner.
My pleasure.
Mr. Mohammed.
Good afternoon. Chairwoman Pinto. I'm Anthony Muhammad, President of the 7th District MPD CAC in the Great Ward 8. I've lived in Washington, D.C. for a little over 60 years. I guess I'm a Washingtonian. I did it all: public school, UDC, ANC, board and commissions, former state committee man, prison ministry, business owner, CRAVE member, father, grandfather, great-grandfather, and husband. The city is using a model from Chicago, Illinois, and it's not working. Use the model from Virginia if we want to stop the crime trends in DC. The Crime Trends Amendment Act 2023, one would say something is better than nothing. The council needs to find a way to really help the police in doing of their duty. We need you to work day and night to find legislation that would give the city a no loitering law for all 8 wards, not a temporary drug-free zone. A drug-free zone is telling my residents, I know where the drugs are being sold, but the drug dealers can sell there because it's not designated as a drug-free zone. The DC Council needs not to continue to use the dog whistle, accountability. We need meat on the bone. The wrongdoers need to be held liable. All parties connected to the wrongdoers, that's parents and school teachers who do not report our children out of school for 90 days and no one is reporting missing from school, needs to be held liable. It used to be against the law. 2281 code. Contributing to the delinquency of a minor, is it still a law? The health record of our children need to be examined. Most of them who are getting in trouble are showing the side effects of children on Ritalin. And the teachers can give our children this drug without informing the parents. In my conclusion, please don't pass something just to say we did something. The morale may be low and officers down. A CI told me the heterosexual male officers, police, that they are being discriminated against because they like the opposite sex. Some are resigning or going to other agencies. And for the Act 2023, we need some more meat on the bones of it. Thank you.
Thank you, Mr. Mohammed. Go ahead.
Good afternoon, councilperson, chairperson, and members of the committee. My name is Samaya Lane, and I am a resident of Ward 7. I am a witness that, yes, something needs to be done as far as the increased crime in the city. I have been carjacked twice. And the second time I was carjacked, I was in the sanctity of my property, where I was in my driveway and 2 men came behind me, blocked me in my driveway, pointed a gun at me, frisked me, and took my car under gunpoint. So I definitely am a witness to the need for increased action in the city. However, there are some parts of the bill that I definitely do not agree with, which is a decrease in the accountability for police. I know that there is a national effort to have a police record as to those police who act inappropriately. And I hope that the city could still meet with that. But people who support the suppression of police accountability have not experienced a loss or serious physical injury due to actions of police behavior, reporting, and just plain bias. So there must remain intact increased transparency and access to police records, files, medical information, and pictures to assure that police are held accountable for their actions that may harm residents encountered during an incident. The action of narrowing or limiting access to police files may lead to overlooking inaccurate police filings of incidents and officers not following NPD policy and procedures. The amendment will cripple the oversight that is needed in investigations reported by citizens on wrongful police actions. I think that the council would like to have like pure specific encounters. Right now, I have a police complaint that I filed almost 6 weeks ago and have not had any type of action, answers, or anything where there was inaction by the police of arresting the correct person. And so my daughter was part of a domestic violence, which I know is not part of this, but I'm talking about police accountability and having the officers accountable for not following police procedure.
Well, thank you very much. And I'm so sorry to hear about your experience as a victim of carjacking and that of your daughter. And the committee would be happy to help you get some response to what you're looking into for your daughter's circumstance. And so if you can follow up with our team, we'd be happy to help. Thank you all very much. Thanks for being here. All right, that concludes our in-person public witnesses today. We are now going to turn to our virtual public witnesses. Anthony Pirati, ANC 4D08, JP Simkowitz, ANC 3D07, Michael Cohen, ANC 4B07, Patricia Stamper, ANC 7C06, Tom DeFranco, SMD 4C03, Alexander Padro, ANC 2G02, Andre Lee, Mid-City Development, Gregory Pemberton, DC Police Union, Robert Pittman, First District Police Citizens Advisory Council, and Lauren Carr, Public Witness. Give you all a moment, make sure to accept the invitation to join as a panelist. And Commissioner Pirati from ANC 4D08, please go ahead when you're ready.
Good morning, or good afternoon rather. My name is Anthony Pirati, and I want to thank you for the opportunity to testify today in support of Act Now, specifically the provision that would empower MPD to address loitering and open-air drug markets in our communities. I'm an ANC commissioner representing SMD 4D08, located in the upper northeast corner of Petworth. We're a quiet, historic residential neighborhood comprised mostly of working-class families, many of them with children, and many of them longtime residents of Washington, D.C. I'd like to orient my testimony today around a specific anecdotal location within my community to illustrate why this legislation is so necessary and so important for my neighbors. Within my SMD is a small strip of empty grass, which should be a beautiful public green space, but instead has become a de facto open-air drug market. Nearly every day, people, many of them from outside our community, set up shop there. All day long, they loiter and engage in illegal and antisocial activities, drinking, arguing, fighting, sometimes violently, littering, cursing, harassing people who pass by, most commonly women, and most concerning of all, engaging in gang and gun violence. Within the last 6 months alone, this location has been the site of multiple shootings and more than one homicide. And despite this concerning and dangerous behavior, despite the shootings and the harassment and the piles of trash, despite the pleas from neighbors and community leaders, no one seems capable of doing anything about it, which adds to a general sense of lawlessness and disarray to our otherwise quiet and safe community. Everyone suffers as a result. Neighbors are afraid that their children will be caught up in crossfire from yet another shooting. The small businesses adjacent to the space suffer from the lack of foot traffic. People who are just trying to catch the bus to work suffer from the catcalls and taunts. The entire community suffers from the piles of trash and stained couches and tents that people leave behind. Seeing this unchecked bad behavior occur day after day affects all of us, our sense of safety and well-being, our sense of confidence in our city government, our sense of pride in our community. For years, neighbors have been pleading for help. Every month, residents attend our ANC meetings asking for the city to do something. They present petitions demanding actions. They request that MPD address overtly dangerous behavior in our community. And yet every time we contact MPD or a city council member, we are told that, unfortunately, there's really nothing anyone can do to address this specific issue. Well, this is our chance to fix this. We should be more than capable of developing long-term strategic solutions to crime while also providing short-term tools to interrupt dangerous behavior. This is an opportunity to equip MPD with basic tools they need to address overtly harmful and destructive behavior in our public spaces. Our communities deserve better. So on behalf of my neighbors, I urge you to pass Act Now to empower MPD to help make the public spaces in our neighborhoods safe again. Thank you.
Thank you, Commissioner. Commissioner JP Simkowitz, ANC 3D07.
Councilmember Pinto and the rest of the council. My name is JP Simkowitz. I'm a 5th generation resident of the District of Columbia, and I'm serving in my 3rd term as Advisory Neighborhood Commissioner for Single Member District 3D07, which is in the Foxhall neighborhood directly behind Georgetown University. My oath of office is not to my single member district or Ward 3, but rather to the district as a whole. Whenever someone in another area of the district is hurting, we're all hurting. Today, we're all hurting because of crime. I testify today in favor of Mayor Bowser's Act Now amendment, and Mayor Bowser's Act Now amendment will protect our citizens. I'm around the same age as Mayor Bowser and remember how bad crime was in the 70s, 80s, and early 90s in the District of Columbia. Fortunately, our city cleaned up crime in the mid-90s, and the results showed up rather quickly. People moved back into the district, and our city was vibrant. Unfortunately, for a variety of reasons, we've slipped back into a culture of crime. We are in a crime crisis. I want to highlight one specific location, the Tony Chang Chinese restaurant in Chinatown. My family has celebrated countless family celebrations there for over 40 years. My pre-wedding dinner was even held there. My parents, wife, and myself went to dinner there one beautiful afternoon early this year, and there were people using drugs on Mr. Chang's front doorstep that my family had to step over to enter the restaurant. We told Mr. Chang's manager, and he said this is an everyday thing for his restaurant. We went back again during the day a few weeks ago, and the same thing happened. Remember, these trips were in the day. I can imagine how bad this problem was during the evening. People will leave our city if we do not fix our crime problem because they do not feel safe. People will move out. I asked the council to pass the mayor's bill in order to protect our residents and visitors, and I asked the council to take crime more seriously. Thank you.
Thank you, Commissioner. Commissioner Alexander Padro, ANC 2G02.
Madam Chair, members of the committee and committee staff, I'm Alexander M. Padro, Commissioner for ANC Single Member District 2G02. I have represented the Shaw neighborhood for 21 years. I'm the current chair of the commission and have been executive director of Shaw Main Streets since 2004. The Metropolitan Police Department is struggling to regain control over an unprecedented increase in crime that has resulted in an environment that threatens our city's economy and the renaissance that neighborhoods like Shaw have experienced in the past 2 decades. Indeed, one prominent Shaw developer shared with me his fear that a growing number of residential tenants will seek to end their leases due to the atmosphere of fear caused by the recent increase in shootings and robberies in the area. Combined with the potential loss of retail businesses due to loss of customers as a result of rising crime, and mixed-use development like the ones that have been the mainstay of 21st century development in our neighborhood could become unstable, resulting in loss of jobs and sales and property taxes that sustain the district's economy. Fewer eyes and ears on the street can only create safety challenges for neighborhoods like Shaw, making these neighborhoods even less safe. Before the COVID-19 pandemic, crime in Shaw was not a major primary concern of residents and visitors to the neighborhood, as it had been in decades before. It is today, with residents and businesses, customers, and employees facing threats and even assaults from drug-intoxicated individuals on a daily basis and rapidly increasing gunfire incidents. Central Shaw has seen more than 40 businesses close permanently since January 2020. Some of these businesses have specified crime as a primary reason for their decision to close. The atmosphere of lawlessness and lack of repercussions for illegal acts is currently threatening the loss of 60 employees at one major employer in our neighborhood that is facing a difficult lease renewal decision. The restoration of the ability to establish temporary drug-free zones as proposed by the bill before you is much needed. When this tool was available in the past, it was used effectively in Shaw, helping to curb open-air drug sales. This tool will help relieve the pressures being exerted in neighborhood hotspots suffering from persistent drug activity and associated threats to public safety and health. Even if no other provisions of the bill are enacted, this option must be returned to the MPD toolbox in order to create a safer environment for law-abiding citizens. Nationally, major retailers have closed as a result of flash mob style thefts and dramatically increased levels of retail theft, notably in San Francisco. While making organized retail theft a crime may help discourage this type of organized theft, it is unclear how prevalent this type of crime currently is occurring in our neighborhoods. I have, however, heard numerous business owners report that mask-wearing snatch thieves are the preeminent form of retail theft in our neighborhood. If reinstating the prohibition on wearing masks when engaging in criminal activity would increase the penalties faced by the perpetrators of these infractions, it could perhaps decrease this type of theft. I'm available to answer any questions you may have for me now or after.
Great. Thank you so much, Commissioner Padro. Tom DeFranco, ANC 4C03.
Good afternoon, Councilwoman Pinto, and thank you for the opportunity to speak. I do feel compelled to note, as I begin, what a shame it is how comfortable so many of your colleagues feel communicating their lack of concern for public safety in the district with their absence at this hearing. My name is Tom DeFranco. I'm the ANC Commissioner for Single Member District 4C03 and a resident of the Pebworth community. I want to note up front that while I'm speaking in my capacity as an ANC Commissioner, my testimony is not given on behalf of my fellow commissioners in ANC 4C. It is, however, given on behalf of the many neighbors, Pebworth residents, and district-wide residents I speak with on a regular basis who are extremely concerned by the wave of crime that has overtaken our city and which appears to only be worsening. Now, I don't think it's productive to point fingers and cast blame, and that's not what I intend to do today, but I do think it's imperative that the council take action to pass this bill in some form. My neighborhood is home to several schools, including Raymond Elementary and Roosevelt High School. Now, I name those schools in particular because, as perhaps you know, children were shot at both in 2023. The response to those incidents fit a tragically familiar pattern at this point. No arrests, no charges, no justice, and perhaps most shockingly, no visible increase in police activity in the area surrounding either school. Just last month, my neighbors were terrorized by 2 armed robberies at Randolph and Kansas Northwest. No arrests. Just the other week, I spoke with a neighbor who was robbed at gunpoint in his alleyway while taking his dog to receive cancer treatment. Yet we see no increase in police activity in our neighborhood. Now, I want to be clear. The fault for this does not lie with MPD. Their message to members of the community has been clear and consistent. They're trying their best and working to identify patterns of crime to use their resources efficiently and effectively, but they are understaffed and not supported. I don't need to tell you that MPD is in crisis at a time when crime has not been worse in nearly 2 decades. We desperately need more officers, and our officers need to know they have support to pursue criminals and make arrests. This legislation is a step in the right direction. Community policing works. I implore you to pass this legislation to empower our officers to effectively patrol communities that have been overtaken by crime and to pursue criminals when and where they flee. I will add that it is incredibly concerning to hear members of this council and certain members of the public discuss the various public safety initiatives put forward as though they are in competition with each other. as though one must be chosen at the expense of the other. Every one of the bills up for consideration by the council must be passed to ensure dedication of sufficient resources to the unchecked violent crime that has overtaken this city. Let me be clear, no member of this council should delude themselves into believing that solving the issues with the 911 line or obtaining accreditation for the crime lab without more are sufficient to address this crisis. I respectfully ask you to rise to the urgency of this moment. Pass this bill. Thank you.
Thank you, Commissioner. Next, we will hear from Andrew Lee, Mid-City Development.
Yes, I guess, good afternoon, Chairman Pinto. My name is Andre Lee. I am the Director of Community Engagement at Mid-City. On behalf of the owner of Brooklyn Manor Apartments, I'm pleased to offer testimony in support of Bill 25-555. At Mid-City, one of the programs that falls under my purview is resident services. Resident services consist of property management, staff meeting with residents and their families to provide information, assistance, and referrals to a wide range of resources, including food assistance, health services, child care, educational resources, economic development, and other critical services to meet individual and family needs. Among our many services, Brooklyn Manor offers a food pantry, meals for children and seniors, after-school tutoring, health fairs, and summer camp. We have also hosted a series of successful on-site job fairs. We recognize that the community cannot enjoy such activities if proper attention is not placed upon improving the quality of life in the community. Constant loitering and drug distribution in the public space around Brooklyn Manor are the main factors that lead to violent crime at Brooklyn Manor. We have made tremendous efforts to secure the property, but our efforts have not been enough to curb the violence. We have 24-hour-a-day private armed security that patrols the property. We have CCTV cameras facing various angles of the property, and the Metropolitan Police Department has real-time access to watch the CCTV feed. We spend over $900,000 a year on security and CCTV monitoring. We have an MPD officer that lives in a comp unit at the property and hopes that his presence will deter crime. We work with violence interrupters to help ease tension at the property, but the violence still prevails. We host community meetings every quarter and invite MPD officers to attend and listen to the concerns of our residents. These meetings are conducted not only bring attention to violence in and around the neighborhood, but also discuss ways in which the community can offer solutions to these issues. From these meetings, we have engaged in partnerships, discussions, various community organizations, nonprofits to provide residents educational and workforce resources. We understand that violence is often the result of mental health issues and drug abuse. So we partner with various social services and healthcare providers. This is done to assist our residents and neighbors who require mental health and substance abuse treatment or who need mental assistance.
Mr. Lee, you're over time. If I could ask you to summarize and wrap up, please.
I sure will. We have made our best efforts but cannot do this alone. The importance of this legislation in advancing the safety of Brooklyn Manor community is beyond question. We respectfully ask for you to make Brooklyn Manor Apartments and the surrounding areas a drug-free zone. Doing nothing is unacceptable. Thank you.
Thank you very much, Mr. Lee. Next, we will hear from Gregory Pemberton, Chairman of the DC Police Union.
Good afternoon, Chair Pinto. I appreciate the opportunity to testify before you today. As chairman of the DC Police Union, I speak on behalf of approximately 3,000 sworn police officers, detectives, and sergeants who serve our community as members of the Metropolitan Police Department. Having served as a DC police officer for 18 years, I take immense pride in serving the city. Today, the members of the MPD's rank and file would like to express our support for the Act Now legislation. This bill will address a number of issues with the Comprehensive Policing and Justice Amendment Act of 2021, which our union has repeatedly brought to the attention of the council. Since the implementation of the CPJAA, the MPD has lost 1,364 police officers while only hiring 896, resulting in a net loss of 468 officers. This decline has led to longer response times, fewer officers patrolling our neighborhoods, and a severe public safety crisis in the district. The MPD is now using more than 1 million hours of overtime to try to make up for these losses. It's worth noting that 1 million hours is equivalent to nearly 500 full-time equivalents. I must emphasize the gravity of the situation. We are witnessing a historic exodus of MPD police officers, and nearly 40% of these separations are resignations. These officers are leaving for alternative employment opportunities because they no longer wish to work in an environment where their workplace protections have been stripped away, and the fairness and equitability that was once such a highly valued principle within MPD no longer exists. Due to these historically low staffing numbers, crime rates in the district are now surpassing levels not seen in 20 years. Homicides have reached 250. This is the highest number of murders in the city since 2002. This year, 96 juveniles have been shot, 15 fatally. There have been 906 carjackings this year, a 106% increase over last year. Violent crime is up 40%, and overall crime is up 27%. Today's hearing focuses on the Addressing Crime Trends Now Amendment Act of 2023, which aims to address some gaps in the district's public safety ecosystem necessary for reducing crime in DC. We broadly support the policies contained in the bill, and we firmly believe this will help to address both staffing issues as well as some alarming crime trends in the district. Adopting this legislation is imperative as it addresses the urgent need to strengthen our MPD staffing numbers, something critically necessary to reduce our increasing crime problems, as well as reducing tens of millions in spending on mandatory overtime. Once again, I'm grateful for the opportunity to testify, and I stand for any questions you may have. Thank you, Chair Pinto.
Thank you, Mr. Pemberton. Robert Pittman, First District Police Citizens Advisory Council.
Good afternoon, Chairman Pinto, and to all present. I'm Bobby Pittman. I represent the First District Police Citizens Advisory Council, but this issue is so complex. I will only speak for myself at this time. I support many aspects of Bill 25-555, addressing the Crime Trends Act Now, or Now Act. However, there are some things that I do want to point out, and I want to emphasize from some of the other communities within the First District that have already been stated. I wanted to speak to the voices of the Wharf in Ward 6. The Wharf is just one of the areas that have been hit with violent crime since July 2023 and need to ensure proactive policing and strong collaboration with private security in communications like alerts and lookouts. That's something that they wanted me to say. I want to speak to Pursuit Wine Bar and Kitchen. We went there with Chief Smith, and there were vulnerabilities at that location. MPD does patrol that area quite often. And when we have police, we don't have enough police to be everywhere. However, there were some security vulnerabilities at that location. H Street, Main Street, and MPD have worked with them to try and resolve those. When it comes to something else that I'd like for you to look at is the Clear Lanes program for DDOT. Police officers are now getting warning tickets regarding being in bus lanes. Please exempt them from getting tickets once this law is actively being enforced. We can't have our police slowing down their response because they have to look for a private parking space or a public parking place. And whether it's a code 1 call or it's not, calls can change to an emergency real quick. Neck restraints are not chokeholds. And because of the limitations of time, I'll refer to my previous testimony on that. Mr. Pemberton and others can address that along with the chief. The residents at Gallery Place Condominium Association have raised the issues of the drug trafficking there that we've been seeing for a long time. We need Metro Transit Police to be more involved with that issue, not just MPD. We also need prosecutions. My testimony speaks to what is a dangerous juvenile in Title II Subtitle B, criteria for detaining children and the enhanced penalties. It's time to talk about community impact statements for juveniles. We can do that while maintaining the anonymity. Rebuttal, Title V, rebuttal presumption of GPS data for prosecution. In a few more seconds, I'd like to add that instead of having MPD listed as the only entity revolving around CSOSA, let's strike that language and put in law enforcement agencies. Thank you for the opportunity to testify.
Thank you, Mr. Pittman. I think that's a great idea. All right, so a couple of questions from me. Commissioner Padro, you talked about retail theft, and I know that's been plaguing a lot of small businesses in Shaw and throughout the city. And, you know, I heard you when you said you're not sure that this scheme is going to address specifically the problems that we're seeing on these kind of quick, either smash and grabs, people taking items off a shelf and leaving. And are there any other provisions around retail theft specifically that you think would be a more effective deterrent or response to address what so many in our small business community are experiencing right now?
Off the top of my head, you know, what I hear from the street is that the characters that are involved in this type of activity don't believe that they're going to be caught because of the nature of the crime. You know, it happens so quickly. Unless the establishment has a lock that they can remotely use to prevent the thief from leaving the premises, and then you've got a potential situation of a confrontation and perhaps additional violence. So increasing the penalties is what I would recommend, so that perhaps the possibility that there would be an apprehension would result in more than just a slap on the wrist and no real disincentive for continuing that type of activity.
Okay. Thank you very much. So, Mr. Pemberton, I want to ask you about some of the policing changes in this proposal. So one of the items, one of the provisions rather, removes the name and badge of the subject officer from the reporting requirement related to the disciplinary records. So can you speak to why you think that's important, as we've heard from some of our other public witnesses today about the need for accountability, making sure that, especially in incidents where there are repeat violations, the public has access to names and badge numbers. And we've also heard of the import of that information for national database purposes, especially if officers are going between departments. So what is your experience or officers' experience with that provision, and why do you think changing it is important?
That's a great question. So under the current law, both under the DCMR as well as the DC Code, employee personnel records are private and they're not subject to FOIA, and they're not permitted to be disclosed publicly. And that's for all DC government employees. The Comprehensive Policing and Justice Reform Act creates a carve out for that law only for police officers of the Metropolitan Police Department, so that those things can be published in a public way so that anyone can access them. Our concern about that is twofold. One is that the idea about discipline within the police department is to have corrective action. So if an officer engages in misconduct, that officer, and it's investigated and it's sustained, that officer should serve some sort of penalty. Let's assume something minor, like they lost their ID card, and they serve a penalty of, say, 5-day suspension for that violation of losing their MPD property. That person should be able to serve that penalty and then come back to work and not have that violation haunt them for the 25 years that they're required to spend in their career of the Metropolitan Police Department. That the idea is that they're supposed to be able to live it down, not that it will continue to haunt them publicly. And anytime their name arises, whether it's a court case or some sort of public case that they engage in that's reported on by the media, that everyone goes and then finds the information and publishes all of their prior misconduct, regardless of what it is. It creates an environment where employees are not going to want to work. And that's what a lot of the provisions within that act do, is that they cause people to look for employment elsewhere. So what we're trying to do is encourage people to work here. And what they should feel safe is that if there is misconduct that they engage in and it's minor and they're disciplined for that discipline should stay within their personnel jacket, just like it does for all the other 30,000 government employees.
Okay.
But, well, let me just add quickly, and I'll wrap up quickly. But we
And Mr.
also
Pardon,
have-
I do have a couple more questions for
Sure.
you.
Please go ahead.
You can add to it if you'd like, but I want to make sure we get to the body worn camera changes. So it has been initially explained that what's been happening in practice with the changes of current law is that some of the reports that officers are making are so brief, and that if after the review of the footage, addendums need to be issued to change the report, that it is both a draw on officer time, but also can undermine the efficacy of the case. Can you speak to that second piece? Why in practice are these body worn camera review rules undermining the efficacy of our cases?
Yes, that's a great question, and I'll try to be brief. So when we initially agreed to the body worn camera policy, one of our main concerns was that it could be used as an evidence collection tool, so that officers could go back and look at their footage and then make sure that the police reports that they complete commensurate with that scene or that situation would be as accurate as the video. The Comprehensive Policing Justice Reform Act eliminated that and prohibited police officers from being able to look at their footage before they completed the report. And then what we saw after that was, as cases would make their way into the court system, there would be an inconsistency between what was written in the report and what was on the body worn camera, because the officers weren't permitted to view it. And then in a number of court cases, judges actually made veracity findings against police officers, indicating that they weren't being truthful in their testimony. And then that had a very adverse impact on those officers' career and the prosecution that was at stake there. So not being able to allow officers to look at their own body worn camera footage to make sure that the reports are accurate is what has caused officers to just put a very generic set of facts together in the narrative portion of the reports, so that as that case makes it down the line, they're not accused of some inconsistency between what they wrote in that report and what's on the body worn camera. One of the most important tools that the body worn camera gives us is that officers can go back and look at exactly what happened and make sure that they document it as correctly and as accurately as possible. So it's a very important part of this bill.
Thank you very much for that context. I want to acknowledge we've been joined by our Ward 5 colleague, Councilmember Zach Parker, and our Ward 8 colleague, Councilmember Treyon White. I'm going to turn first to Councilmember Parker for any opening statement you may have, and any questions for this panel of witnesses. So we'll give you a couple extra minutes if you need them. Go ahead.
Thank you, Councilmember Pinto. I really appreciate your leadership and your team for holding today's hearing on potential legislative changes to our criminal code and MPD related policies. I've said it before and I will say it again, all district residents deserve to feel safe in their communities, and the level of violence in the city is completely unacceptable. Over the last several weeks in Ward 5, residents have witnessed unacceptable string of armed robberies in Brookland and in Edgewood, shootings in Gateway, Edgewood, Bloomingdale, and tragically one homicide on New York Avenue. And that is only a fraction of the trauma that is impacted and the crime that has overtaken our city in many respects. I want to be very clear that I have fought and will continue to fight for the things that I believe will help turn the tide, the reprogramming of money to expand our violence prevention resources on the ground in Ward 5, the deployment of more MPD cameras and resources, better coordination of our public safety, behavioral health, and human services agencies, more scrutiny on low closure and prosecution rates, and more accountability for public safety agencies that are frankly falling short, including the Office of Unified Communication, the Department of Forensic Sciences, the Department of Youth Rehabilitation Services. Other cities have adopted and rigorously implemented data-backed violence reduction strategies, and they are working. DC has not, and it shows. What is not addressed through today's proposed legislation is expanding the district's violence prevention efforts. What is not addressed in today's proposed legislation is creating a citywide public safety strategy. What is not addressed in today's legislation is improving MPD's closure rates. And what is not addressed in today's legislation is forcing our federal partners to hold violent perpetrators accountable. Our crime problem is a math problem. Take, for example, MPD only closes roughly 40% of cases. The USAO, or the U.S. Attorney's Office, prosecutes roughly 50% of gun cases that are closed. So that means 10 crimes involving a gun, only 4 of those cases are closed by MPD, and the U.S. Attorney's Office will prosecute roughly 2 of those cases. Again, our crime problem is a math problem. My point of highlighting these issues is not to point or shame or blame our agencies or partners, but to ring the alarm that we ought to spend more time and focus on the levers that will immediately improve public safety. There are aspects of today's bill that have merit and others that warrant more probing. I look forward to engaging with public and government witnesses here today about this legislation and returning again to the simple question, how will these changes make the district safer? Thank you. I am now going to transition to questions. And thank you all for your testimony. Mr. Pittman, I wanted to come to you first. Section 1001 revives and amends the Anti-Loitering Drug-Free Zone Act of '96 to reauthorize the chief of police to determine and declare a drug enforcement zone and to prohibit the congregation of 2 or more persons on public space on public property for the purpose of participating in the use, purchase, or sale of illegal drugs within the perimeter of said drug enforcement zone. The law permits an officer to consider the totality of the circumstances, including a long list of factors that some might argue may make it impossible to challenge an officer's determination why said zone needs to be a drug-free area. From your testimony, I just wanted to follow in on this proposed change. Can you just speak to your history in the district and how you've seen policies like these in the past work, and what might be some potential pitfalls that you would caution us to pay close attention to?
Well, first of all, good afternoon, Councilmember Parker. Councilmember Lightfoot spoke to when we did this legislation back in the 90s. There were challenges in terms of the courts, and the language was amended. He did those amendments. At that time, as he stated, we had orange hat groups, green hats. We were a lot of people were out there, red hats. The times were different, and I think that we need to be very, very careful. I think the pitfalls are we need to ensure that the chief judges and that the judges in Superior Court and in appellate courts and that the AG and the U.S. Attorney's Office are going to be lock in step with this. I also think that more cooperation and discussion with community, all community, whether they agree or disagree with this, We need to have a balance that we can agree with. Otherwise, I think we're going to find ourselves in a lot of litigation, and it's going to cost the city money. So on that particular issue, you'll see in my testimony, I kind of step away from that. I think we need more work there.
Thank you, Mr. Pittman. And you're underscoring what I was speaking to in my opening statement, that passing this law is one step, but if we don't have our federal partners alongside and with us, some might argue it's all for naught. That does not mean we should not act. But again, it is to say that it's more than just council passing legislation that's going to turn things around. Mr. Lee, thank you for your service. I appreciated your testimony on behalf of Mid-City and your long commitment to Ward 5. Can you speak to the drug-free zones? I know you referenced that as it relates to Brooklyn Manor and the broader community. What are some of the issues that you're hoping this policy might address on the ground for you?
What I am hoping that it will stop the loitering and the constant open air drug sales that are going on the corner.
Absolutely. And I know that's been a issue not just for Brooklyn Manor, but a number of communities throughout Ward 5, and it is a concern. So again, I appreciate you being here to share your testimony. And then Mr. Pemberton, I wanted to come to you. There were two areas I wanted to zero in on. Section 101 of the legislation amends limitation on the use of chokeholds to clarify the definitions of asphyxiating restraint and neck restraint and apply them retroactively. It modifies the definition of asphyxiating restraint to exclude actions that have the effect, quote unquote, of severely restricting the person's breathing. Some might argue that this would call into question an officer's intent. Is that how you see it? And if not, how would you encourage the council to look at that proposed change?
Thank you, council member. So no, I don't see it that way. Chokeholds and neck restraints have been banned in the District of Columbia since the Chokehold Restraint Act of 1985. So for almost 40 years, officers have been prohibited from two types of chokeholds: one, blocking airflow to the lungs, and two, blocking blood to the brain, which would basically consist of any sort of neck restraint or neck chokehold, headlock, any sort of pressure applied to the neck in any way. The union has been in support of that. I don't think we've ever opposed it that I'm aware of. What the Comprehensive Policing and Justice Reform Act did was it changed the definition so that any contact with the neck that involved the suspect's movement, or was incidental contact during a use of force would also be classified as a neck restraint. And during any sort of use of force, tussling with someone on the ground who does not want to be arrested, officers will often incidentally contact their neck or contact their neck in a way that is not, in fact, the definition of a chokehold, not blocking blood flow or airflow in an effort to sort of choke them out or render them unconscious. And so what this bill does here in the section that you mentioned is it actually repeals that part of the section so that officers will feel more comfortable when they are in a circumstance where they have to use force, that if there is incidental contact with the neck that doesn't involve the intent to sort of choke or render someone unconscious, that's not also going to be classified as a chokehold and then ultimately become an unjustified use of force. So we're in support of that position, and we think that it increases officer safety and it will decrease the number of people who are leaving the agency, given the fact that these provisions are so onerous.
Thank you. And one last question, and Chairperson Pinto has been very generous with the time. Chairperson Pinto asked about expanding officer ability to view body-worn camera prior to filing a report. There's another part of Section 201 that curtails the obligation to release body-worn camera footage within 5 days of quote-unquote serious use of force. That is an aspect of this bill that has not gotten a lot of attention. Again, it would change the requirement of releasing body-worn camera footage within 5 days of a serious use of force. Can you just speak to why that change is necessary? And that's again from Mr. Pemberton.
Sure, absolutely, council member. So one of our concerns about releasing the video that quickly is that that's prior to the police department even really being able to conduct their own investigation. And in an officer use of force, many times those investigations go directly to the U.S. Attorney's Office to determine whether or not there's any criminal conduct by the officer. So within that short window, most of the agencies that are investigating that incident don't even really have a handle on what quite happened yet. And so as we're releasing this video, which does not ever really paint the entire picture of the incident, the public is now viewing it and they're coming up with sort of their own interpretations of what happened. And that could cause outrage. It could cause a lot of ire against the police department or for that officer in particular. As you know, the officer's name is also required to be released. And we've seen incidents in the past since this bill has been passed where officers have been threatened online, and there's even been arrests made for people who have threatened police officers. And so our concern is that short time frame of that window really creates a lot of difficulty in investigating the case, and also creates some exposure of threatening circumstance for the officers involved.
Okay, thank you. It would be helpful to know if there's another set of days that would be better suited. Is it 10 days, 15 days, 20 days? Because right now, as I understand it, that the change is it just removes the requirement to release the footage. But thank you all for your testimony.
Thank you.
Thank you, Councilor Parker. Councilmember Trayon White, for any opening statement you may have and or questions.
Yes, thank you, Councilmember Pinto, and your leadership in hosting this very important hearing. We are in a unique space and place and time where the crime is the highest it's ever been in 20 years. And I remember in just joining the council, the narrative been hearing that crime was down when I was going to vigils and funerals every other day. And now it's reached critical mass. In fact, I just read that we had over 900 carjackings this year, most of those being armed carjackings. We've had a milestone of 250 homicides this year, the most we've had in 20 years, with over 700 people getting shot that we don't speak of, that didn't die. I think that, yes, we do need some new edits to our criminal code. We do need some more wraparound services, but we need a real plan. And I think that this is part of a larger plan, and I'm still trying to decipher which parts I agree with and disagree with. And I'm excited to hear from the government witnesses coming up, and also law enforcement, but more importantly, the community. The community is in fear and around our schools, faith-based institutions, people going back and forth to work. Everyday people are impacted by the violence in our city. I'm also thinking that we opened up what is now known as the WANS Office of Neighborhood Safety and Engagement, to address some of the highest risk youth and young adults in the city. Yet in the height of violence, we're scaling back our programs like the Pathways program that targets and redirects some of the hardest to reach young men in the city. So I'm not sure where we're going as a city, but I do know that it's imperative that the council, the mayor's office, and also our federal partners work together to provide some solutions, but also some accountability all the way around the board. And I think that this hearing gives us some tools that we can use. And I was listening to, I guess, Mr. Pemberton, as relates to trying to figure out what do we land with law enforcement about giving them not disclosing them, their names or their badge numbers, but they are different than regular government employees. They are sworn in. And so what is their healthy balance? I don't know. But I do know that there are people in dire need, needing resources, wraparound services, but also accountability. And so I've been listening and learning from the residents here. But I do know that, we have to act now as the legislation leads to, and we have to do more with our resources. Because in one instance, I'm hearing the executive say we spent $50 million on crime prevention. Then the next year, I'm hearing $50 million to $100 million. But when I inquire about how they're used to decrease violence, it falls on deaf ears. And so it is imperative that as we talk about criminal code reforms or addressing public safety, that everyone is included into the conversation. So I want to thank you, Councilmember Pinto, and my other members on the council and the mayor for seeing this as a priority as she declared a state of emergency, which has been cleared 7 years ago. that we are doing something about it and creating an equitable solution. So I'm excited to hear from you guys. I don't have any particular questions, just a lot of concerns I have about what is being said and what is not being said as an expert in juvenile justice reform. So I want to thank you all. I'm gonna digress there and look forward to hearing from you guys and those others who will be testifying today and the government witnesses. Thank you.
Ask on behalf of Councilmember Parker, will just finish his line of questioning. To Mr. Pemberton, is there a number of days that you all would recommend to provide the police department to review the body-worn camera footage?
I mean, that's something we could research and come back to, but I think the most important thing is that the agencies that are investigating that incident, whether that be MPD or Internal Affairs or OAG or the U.S. Attorney's Office, that they have an opportunity to sort of get their heads and their hands around all of the evidence in that case. And then at that time, they could release the footage, with some sort of factual timeline, maybe a bullet pointed timeline of stuff that's able to be released to the public so that the public can sort of get a chronology of events as well as some facts that they've collected. And then that way, I think everybody could sort of appreciate the entirety of the circumstance rather than just seeing the video and the officer's name and sort of filling in the gaps themselves. That would be my answer.
Chairwoman, may I say something to that?
Sure.
In addition to the fact that I know that there's a very limited number of staff that are involved in reviewing that camera-worn footage, perhaps between MPD, the executive, and the council, you could come up with a number that's not arbitrary, but takes into account an equation looking at the staffing, addressing that particular issue and the need of the community and the severity of the incident that has occurred to try to come up with a number that may be more reasonable. That's just my thoughts.
Okay, thank you for that. It's a good idea. I want to ask you, Mr. Pemberton, one more question about a practical effect of the disciplinary matters. And this comes up a lot around the changes proposed for incidental touching of the neck or anything that can restrict movement. And so one of the things that I hear from officers is, well, even in the event of trying to provide care to somebody in the event of an arrest or prevent them from hurting themselves or us or somebody else, and something has an incidental touching of the neck, I could be subject to discipline. And if I'm subject to discipline, then that could undermine that specific case or a future case. And I hear from folks in the public who say, well, even if the officer has an opportunity to prove that they didn't violate police policy, why not go through that process? And I'm curious your perspective on the implications of that review process, what that actually looks like, and what effect that has on officers who are subject to it.
Yeah, so I'll give you a specific example it's on the department's website in their community briefing section. We had an officer in the 7th District. He responded to a call for service. It was a young woman's, a juvenile's mother had called. Her daughter had a custody order and was wanted for arrest, and she was going through some sort of mental health crisis and acting erratic. The officer arrived on the scene, and the young lady was in fact erratic and yelling. And as the officer approached to investigate, the young lady began to throw her head backwards into the brick wall of the building she was standing next to. The officer, in what I would describe as the most gentle and professional way possible, gently put his hand on the back of the young lady's neck to prohibit her from hitting her own head against the brick wall. That was investigated as a neck restraint, an unjustified neck restraint. The Use of Force Review Board ruled it as an unjustified use of force neck restraint, and that officer was disciplined and now has on his record an unjustified use of force neck restraint, which appears at first glance to be that this officer was unlawfully choking someone. And now it's going to be difficult for that officer to ever testify in any future case, because the defense will obviously make hay out of that part of his record, which will be disclosed in any criminal case. So, and as you said, even rendering first aid, even just using your hand to check for someone's pulse on their carotid artery would be a violation of this law here, which it was obviously not thought of. So repealing this part of the section will allow, first of all, those proper types of contacts, like the one I just described, to not be investigated and then sustained as discipline against any member. And because of that, I think they would then be able to adjudicate those cases and sort of clean up officers' records for when they were not engaged in misconduct or had not violated the use of force policy or the city's neck restraint prohibition. I'm not sure if that quite answers the second part of your question, but I'm happy to address it if it did not.
Thank you very much. No, that's helpful, especially in how this is presented in future cases. And I have seen that example and that video as well. Just kind of lastly on this, we had some witnesses testify earlier today about the language for restricting movement. And one of their proposals was, in lieu of striking all language that disallows for restricting movement, they propose to keep the prohibition but have exceptions. And those exceptions could be things that you've laid out, like administering care or the need to get somebody into custody who is refusing to do so, or exceptions that, have incidental touching that don't block an airway, as opposed to just affirmatively striking the prohibition. I'm curious your perspective on that kind of technical language shift, if that would accomplish most of your goals.
I would be very concerned that would not be effective. I think that the current policy or the prior policy, I should say, that restricts officers from blocking airflow to the lungs or blocking blood to the brain is more than adequate. And the department has enough ability to investigate that as misconduct. The U.S. Attorney's Office can even investigate that as criminal behavior under the statute, under Title I. But trying to implement this nuance as to what is and what is not a chokehold there, creating these exceptions, I don't think it alleviates the problem. I think we will continue to see situations like the one I just mentioned, where an officer has no motive to harm someone and is just happens to be touching their neck. I don't know how that language would get there. And I think one of the things we're trying to establish here is that we want to show these officers that we support them and that we're not creating all of these onerous environments. And so to kind of go back and try to split hairs on the language, I don't think that gets us there. I think we want to tell officers broadly that we're not working under these provisions anymore.
Okay, thank you. Thank you very much to all of the witnesses on this panel. I'm sorry I didn't get a chance to ask you all questions, but I appreciate you all being here today and your continued perspective. And thank you to the many ANC commissioners who are here today. I know you hear about these issues every day from residents and are working in partnership to be part of the solution. So thank you very much. Thank you all. We are going to turn to our next panel of public witnesses. We have Sandra Seegers from Crave, Ruby Yearling, Civil Rights Corp, John Townsend, Restaurant Association, Metropolitan Washington, Anthony Hood, Public Witness, Keith Hassan Towery, Public Witness, Geoff Gilbert, Beloved Community Incubator, Kyle McCullen, Greater Washington Board of Trade, Nini Taylor, Harriet's Wildest Dreams, Talib Din Ukda, 14th Street Uptown Business Association, Olivia Henderson, Washington Highland Civic Association, and Barbara Jones, Fort Stanton, Civic Association. Sandra Seegers, whenever you're ready, please go ahead.
All right. Good afternoon. I'm Sandra Seegers. I live in Congress Heights, Ward 8 Southeast. I am in support of Bill 25-555. I have a couple of observations. I am a co-founder and convener of Concerned Residents Against Violence, which is CRAVE, with 7 members. I am co-host of the First Friday Group monthly virtual meeting to discuss ways to reduce crime. Crave is a member of the East of the River Public Safety Consortium with a membership of 38 organizations. Number one, making it illegal for any person to act as the organizer of a theft for profit scheme by recruiting or directing individuals to commit organized retail theft, which amounts to conspiracy. I hope it will be easy to prove in court. Number two, the wearing of a mask law and the drug-free zones law should never have stopped being enforced. This is an example of the inconsistency of elected officials and MPD. However, I'm glad to see that the drug-free zone will be expanded to cover areas other than schools. Number three, to be fair to an officer, I believe an officer should be allowed to review the camera footage prior to writing a report because they have so many cases that they could confuse incidents unless they write it immediately after the incident. Number four, I believe in some cases the police should be allowed to pursue moving vehicles. However, I also believe that even though this law gives the police the authority to do so, the officer takes a risk to pursue because the cars are always stacked against the police. Number five, I believe we do need to be flexible to the ability to be able to address crime trends, even if it's temporary. Number six, I do believe the chokehold should be banned. I also believe that a suspect should follow a command by an officer. Number seven, dispersing and ordering a person not to re-congregate within the drug-free zone during the duration of the zone is absolutely impressive. However, I'm not sure if marking the areas with barriers, tape, and officer posts is going to work. With the officers shortage, it would not be practical to post an officer. Depending on how the barriers are positioned, they may be too obstructive, and the tape could easily be removed. So I suppose of the three, the barriers would be more permanent and tamper-proof. Number eight, the language in the drug-free zone section is wordy. The part about reasonably believes the person is congregating for the purpose of committing an offense may need to be removed. And number nine, I believe there are too many restrictions imposed on the police, and the laws need to be written distinctly so the charge sticks, or else the police are going to look the other way. Thank you.
Thank you so much, Ms. Seegers. Ruby Yearling, Civil Rights Corp.
Thank you, Chairperson Pinto. The council should not pass the Act Now amendment. My name is Ruby Yearling. I'm a DC resident and a staff member of Civil Rights Corps. Civil Rights Corps works with survivors of violence, individuals accused and convicted of crimes, families and communities, and government officials to create a legal system that promotes safety, equality, and freedom. We litigate and win state and federal civil rights lawsuits challenging unconstitutional practices in the criminal legal system. The council's responsibility to keep DC safe includes protecting residents from police abuse. Unfortunately, MPD violates residents' rights every day. CRC represents people who are impacted by the deadly and destructive police practices that the Act Now legislation seeks to expand and shield from public oversight. I come here today to tell you from our practitioner experience that if passed, this bill will make our communities less safe and even more vulnerable to police violence. First, we should not narrow the legal definition of deadly use of force. We have data showing that MPD officers overwhelmingly target Black community members. 46% of DC residents are Black, yet 91% of police uses of force are against Black people. Narrowing the definition of deadly force to exclude lethal maneuvers allows police officers to act with absolute impunity when interacting with community members. Second, police misconduct information should not be hidden from the public. We decrease police violence by exposing, not obscuring it. Against the Police Reform Commission's April 2021 recommendations, this act would deny public access to police misconduct records unless that misconduct has been sustained by MPD itself. The act weakens even what the council can learn about MPD behavior. MPD should not be the sole arbiter of what the public knows about officers' conduct. That these anti-transparency provisions are being proposed at all should be raising red flags for you and all district residents. The drug-free zone prong of this bill is fundamentally antithetical to achieving the goal of curbing addiction and drug-related violence. Illegal drug use is already against the law in the district. What this provision does is criminalize everyday behavior such as people merely standing together outside. This is the epitome of broken windows policing, which has been proven time and time again to be ineffective. The council repealed these provisions in 2014 over concerns that they promoted racial profiling and were unconstitutional. You should do the same today. CRC calls on the council to curb violence in our city by making evidence-based, meaningful investments into our collective well-being. Specifically, pass the Policy Reform Act to decriminalize personal possession of drugs and invest in harm reduction centers. Remove all police from schools by 2025 as previously planned, and create and fund a universal basic income as outlined in DC's gun violence reduction strategic plan. Stop expanding police authority, stop investing in strategies we know to be counterproductive. Our city deserves robust investments into the things that will truly keep us safe and thriving. Thank you.
Thank you, Ms. Yearling. Sean Townsend, Restaurant Association, Metropolitan Washington.
Good afternoon, Chairwoman Pinto and other members of the committee. I'm Sean Townsend. I have the pleasure of serving as the president and CEO of the Restaurant Association of Metropolitan Washington. I'm also a resident of Ward 5. RMW thanks you and the Committee on the Judiciary and Public Safety for the opportunity to provide comment for the Act Now Amendment Act of 23. For more than 100 years, RMW has advocated and provided community for more than 1,400 entrepreneurs and small businesses in the greater Washington area. We count among our members' favorite neighborhood spots, family-owned businesses, homegrown restaurant groups, and national and regional favorites. Together, we are one of the largest job creators in the district and leading contributors to revenues. Small businesses, especially our local restaurant operators, feel like every day they're on the front lines of the district's historic year of violence. Public safety tops the concerns of our operators and workers, some of whom have been repeatedly robbed at gunpoint or in smash and grab burglaries. In a survey of RNW members, 72% rank violent crime as a paramount concern, and almost 3 out of 5 restaurants said violent crime is affecting their ability to hire and retain staff. The damages are more than just the immediate financial costs. Crime deters investment in our community and furthers an environment where violence persists. Some operators pay hundreds of thousands of dollars to hire off-duty officers and private security to keep their guests and workers safe. Some have even paid to break leases in order to move to a safer area, all money that could otherwise be reinvested in their businesses. With the Act Now Act, Mayor Bowser seeks to send a strong message that violent crime cannot be tolerated and that those who commit these acts should be held accountable. Among other measures, the proposed legislation will create new penalties for organized retail theft, including increased accountability for the individuals responsible for directing it. The proposed legislation would also limit loitering and allow the chief of police to declare temporary drug-free zones to disrupt public drug dealing. Many of these open-air drug markets have been set up across or adjacent to our neighborhood restaurants, threatening safety in the area. There's an additional measure that would further bolster the safety of workers and diners, pausing the Cashless Retailers Prohibition Act until the district's gun violence is brought in line. This law, first introduced in 2018, passed by council in 2020 and taken effect October 1 of this year, requires businesses to accept cash payments or else be levied with a $1,000 fine. We support the goal of the legislation, which is to ensure that those who are unbanked or without access to financial services are not shut out from purchasing necessities such as food and clothing. However, requiring businesses to accept cash during the sharpest rise in crime in 2 decades needlessly risks the safety of restaurant workers and diners. As we approach an average of 1 restaurant closing per week this year, many other restaurants are considering closing and or relocating to Maryland or Virginia. Our members tell us that crime and public safety concerns need to be addressed now in order to ensure that our restaurants, a major economic driver of the District of Columbia, can focus on other challenges that they face. We know that there are many community stakeholders and organizations with ideas and insight as to how we address public safety and potentially strengthen this bill even more. The proposed Act Now legislation, taken with other proposals.
Mr. Townsend.
Yep.
Thank you so much. You're a bit over time. If I can ask you to summarize and wrap up.
Yep. Thank you for the opportunity to testify. I'm available to answer any questions.
Great. Thank you so much. Appreciate the testimony. Thank you for your chairwoman edit. We will next hear from Anthony Hood, public witness.
Good afternoon, Chairperson Pinto, other council members and staff. My name is Anthony Hood, and I am a lifelong Ward 5 resident. When it comes to public safety, I am a former Orange Hatter. At the time we started the citizen patrol groups, we thought outside the box and helping to make our neighborhoods safer. Mr. Leroy Thorpe, who is still active today, was the leader and founder of the Red Hats, a model that other groups followed. We had the orange hats, no hats, black hats, white hats, you have it. Whatever we had, whatever people, neighborhoods bought into that ideal and idealistic of preventing crime in the neighborhood. Those patrol groups have been very successful as a citywide effort. I support Bill 25-555 and its initial start of making all who work and live feel safe again in the District of Columbia. We have to start somewhere, and this is a good place to start. Let's stop talking about it and be about it. It's time to take the handcuffs off of our officers and give them the tools and support they need to be successful in ensuring our safety. When they are successful, we all win. I support Bill 25-555 as a start in making the district safer for us all again. Thank you all, and I'm available for any questions. Thank you.
Thank you, Mr. Hood. Keith Hassan Towery, public witness.
Thank you, Chairwoman, and other council members. I can't necessarily see who's all on the dais, but thank you so much too for allowing me the opportunity to speak. I really don't have prepared remarks. I kind of just wanted to remind people, of the situation we went through in the early 90s, where we saw a resurgence of crime and everything happening, and we decided to double down. And because of that, there's a whole generation of men and women, particularly in my community, that are behind the walls, and they almost have no way to get back home. What's even more striking to me about this legislation, which there are some parts of it which I think are good, and there's some things that can definitely be fleshed out, is that there's provisions in here in which I guess we're holding folks accountable, but not necessarily having that same standard for police officers. I do believe police officers are people too, right? Like teachers are people. You have to remember that when you're in class. Teachers are people. Police officers are people. And I think they should have the right to be able to review their body-worn camera. I don't see nothing wrong with that. But I also think the public should have access to that. And the public should be able to see what happened, as well as the police officers could recount what happened within their stories. I also wanted to make sure I touch upon my disagreement with the drug-free zones. I mean, drug-free zones was a policy that we also did in the 90s to kind of, stir people away from schools and other public places. Putting a 5-day ban here, all it's going to do is just displace that traffic somewhere else into the community. And I would like to see a bill that's going to address that. I can look outside my house. I still have a bullet hole in my wall and one by my door. And, it's because they was told they couldn't hang out at Benco. So they came on B Street and did what they needed to do. So it should just be more than simple displacement. Also, the other thing that I really felt strongly about, which made me want to get on the call today, was just the organized retail theft. Sure, it's a pandemic. It's happening throughout the nation right now. We probably do need to have some stuff. But I don't know if that $1,000 line is arbitrary. Maryland is doing $1,500. A lot of other states are doing $2,000. I think Virginia might be at $1,000. The lowest is $200, but maybe that's increased that threshold. Last but not least, officer discipline. I just think that it's okay for us to know the name and badge number. If one of us as adults were arrested, our name will be out there. Our picture, our mugshot will be out there. I don't see why it wouldn't be the same thing for a police officer to also have to have that same thing. I do want to thank you for allowing me to have this time today. And I look forward to answering any questions if I have any pitted to me. Have a great day.
Great. Thank you so much, Mr. Hassan Towery. Appreciate that testimony. Next, we'll hear from Kyle McColgan, Greater Washington Board of Trade.
Good afternoon, Chairwoman Pinto, committee members and staff. My name is Kyle McColgan, and I serve as the Senior Vice President of Policy at the Greater Washington Board of Trade. We are a pro-business and nonpartisan organization supporting all industry sectors in the District of Columbia, suburban Maryland, and Northern Virginia, having done so for the last 134 years. I appreciate the opportunity to testify in front of you all today in support of Mayor Bowser's bill B25-555, the Act Now Amendment of 2023. I would first like to thank you, Chairwoman Pinto, on your efforts thus far to address the issue of crime and public safety, particularly that of violent crime, and the many challenges it creates for citizens and businesses alike within the district. The emergency legislation passed and extended this year was a step in the right direction, as was the introduction of the Secure DC plan. With homicides topping 250 already this year, a 2-decade high, roughly 900 carjackings, 77% of which involved a firearm, and a rise in youth-related crime, public safety has quickly risen to the most concerning and pressing issues shared amongst the business community. We at the Greater Washington Board of Trade are firm believers that a comprehensive approach that includes both addressing the underlying structures which lead to crime and more immediate actions to hold offenders accountable is the only way to solve this complex and challenging issue. While addressing violent crime must be a priority for our communities and businesses to thrive, we cannot disregard other criminal activity. This proposed legislation takes aim at addressing a concern our members have been impacted by: organized retail theft. Retailers of all shapes and sizes have been negatively impacted by increases in theft, with some choosing to implement costly internal security measures to help mitigate the issue themselves. While protecting their goods is a priority, most important is the safety and security of their employees and customers, who are at risk of becoming victims themselves as these thefts are carried out. The business community would greatly appreciate increased efforts and means to hold those who commit these crimes accountable. It is also necessary to have an adequately staffed law enforcement entity who is provided with the resources and means to effectively do their jobs. This legislation would help to support an environment where this is possible. Without addressing crime and public safety, there will be no meaningful recovery, not just in the district's downtown area, but it's in its entirety. While this bill is a component in assisting with the recovery, we urge the council to continue their efforts to comprehensively resolve the issue. Thank you for the opportunity to testify, and I'm happy to answer any questions.
Thank you very much, Mr. McColgan. Nene Taylor, Harriet's Wildest Dreams.
How you doing, Councilman Pinto? Please forgive me. I really don't want to put on my camera. It's just a lot, and I'm like high in anxiety right now with this, just reading over the act and just knowing what's to come of it if this legislation was to be passed. My name is Nene Taylor, and I serve as the Executive Director of Harriet's Wildest Dreams. It's a Black-led abolitionist community defense hub, centering all Black lives most at risk for state-sanctioned violence in the Greater Washington area. As a DC native and an advocate deeply invested in our community's well-being, I express strongly opposition to the proposed Act Now bill legislation, highlighting significant flaws and could undermine civil liabilities and the overall health of our community. Firstly, I am deeply concerned about the view of body-worn camera footage by officers before making statements. Allowing officers to tailor their statements to fit video evidence undermines the very purpose of body-worn cameras, providing objective records of events. This practice raises serious questions about transparency and accountability within law enforcement. I have personally known, first of all, humans lie. So we know a cop is a human, so therefore cops lie. Allowing officers to review their body cam footage before making statements will only influence them and lead to more biased and inaccurate recollections of events. This undermines the small accountability measures in place. Addressing the laundering. The flaw in this proposal lies in the potential for abuse and power and infringement of individual rights. Granting an MPD chief the authority to be the sole person to declare a drug-free zone for a limited time raises concerns about arbitrary enforcement and the presumption of guilt based on location rather than individual behavior. Declaring temporary drug-free zones criminalizes public space, targeting not just illegal activities, but also individuals who may simply be present in those areas. The authority to declare particular places drug-free may be implemented unfairly, resulting to bias enforcement disproportionately impacts underprivileged people, specifically those in predominantly Black communities. Furthermore, the notion drug-free zone lacks tangible substance. Making the mask, the flaw in the law for the mask, its potential disproportion penalize individuals who wear masks or face coverings for reasons unrelated to criminal intent. Given the widespread of masks due to COVID-19 and other public health concerns, many people wear masks for entirely innocent and lawful reasons. Reinstating laws that prohibit mask wearing without a clear distinction for criminal intent could result into unfairly targeting of individuals who are simply adherent to health guidelines or personal preference. In closing, although I acknowledge the significance of addressing crime trends and improving public safety, me for one who actually fight for public safety, I urge the committee to reconsider these specific provisions of the Act now. It is essential to ensure these provisions align with constitutional principles and avoid undue restrictions on civil liabilities. Thank you for your time.
Thank you, Ms. Taylor. Talib Din Ukta, 14th Street Uptown Business Association.
Yes, good afternoon. Chairperson Pinto, members of the committee, as well as members of the council who may or may not be present but are listening. My name is Taladin Ukta. I'm testifying in opposition to the crime bill before you today, as it continues to show a long-standing failure and short-sightedness on the part of this and past administrations in not addressing the root causes of our crime and violence issues. The fact is, we're never going to legislate our way out of behaviors caused by ignorance. No one is born a criminal. It's their environment that makes them who and what they are. We've all heard the African proverb, it takes a village to raise a child. But the rest of the proverb says, a child abandoned by the village will burn it down just to feel the warmth. What we're facing today are our children and young adults who we have abandoned, burning down our city to get our attention. And they've got it. But this and other bills like it leave our young people with no support system. If it leaves me with a feeling of abandonment, imagine how it makes them feel at a time in their lives when they're crying out for the warmth of the community to embrace them, to show we care, not write them off as being less than or some other species of a human being. Admittedly, I have not read the bill in its entirety, but trust as my elected representatives, you all have. I only hope you viewed it through the problem-solving lens of vision. We have to envision the solution before we can solve the problem. The problem in this instance being the root causes of crime and the attractiveness of the criminal lifestyle. If this was a math problem, we would decide which formula to use. That takes vision. If it were an essay, vision requires you to first create an outline. Science envisions a hypothesis before solving the question. Even in sports, every athlete envisions winning before they compete. They're all presented with a problem where the solution takes some semblance of vision to resolve. But in this instance, with crime and the violence associated with it being the problem, what is the formula we're using to solve it? This bill? I don't think so. Giving more power to MPD and judges to punish criminal behavior or creating legislation to punish offenders hasn't worked in the past, and it won't work now because we're still fumbling around trying to envision the right formula, throwing stuff at the wall to see what sticks. What do we do to solve this problem of increased robberies, carjackings, auto thefts, assaults, and gun violence? Let's solve this problem with a vision for embracing our young people by identifying opportunities and offering innovative solutions that will produce positive impacts. In the indelible words of Gil Scott-Heron, nobody can do everything, but everybody can do something. Thank you.
Thank you very much. Olivia Henderson, Washington Highlands Civic Association.
Good day, Councilmember Pinto, Judiciary and Public Safety Committee, and members of the committee. My name is Olivia Henderson, and I am here to testify in my capacity as the president of the Washington Highlands Civic Association. I am deeply committed to fostering collaboration between our community and government to address the pressing issues of crime within the Washington Highland communities, which is known to be amongst the most violent neighborhoods in the District of Columbia, with probably the most children and the highest rate of poverty that's overlooked and never addressed by those officials that can bring about the necessary change required for all of us to survive and be alive at the same time. On behalf of the Washington Highlands Civic Association, we stand in solidarity in support of the Bill 25555. The collaboration between the community and government is paramount in effectively addressing the crime trends that has plagued Washington Highlands. It is imperative that we work hand in hand in government agencies to create a safer environment for all residents. By standing in support of the Bill 25555, the Addressing Crime Trends Act Now Amendment Act of 2003, we can collectively tackle the challenges posed by criminal activities and work towards sustainable solutions. This collaborative approach is central to effectiveness of proposed Bill 255 aimed at addressing the crime trends within the neighborhood. The bill provisions, including the establishment of temporary drug-free zones and enhanced policies measures, align with community efforts to work alongside government officials in tackling crime head-on. Through joint efforts such as implementations of temporary drug-free zones, we can take the shackles off and empower law enforcement to take target actions that directly address crime hotspots in which unwanted guests and drug boys sit less than 25 feet from areas where children from both child development centers and elementary schools play within. Small business quarters, which are the backbones of the community, and now senior living assistance facilities and short-term family homes, all in which proposed Bill 2555 will help support crime occurring in the District of Columbia, no matter if it's a high-level crime or low-level crime, because crime is crime. And I have to move forward because my time is short and I will not be having 5 minutes. I have 3 minutes. So I'm going to skip a couple of my paragraphs. Furthermore, standing in support of Bill 255 reinforces the idea that both the community and government share a vested interest in the well-being of safety when it pertains to the Washington Highland community. By supporting and passing Bill 2555, we can harness the strength of both entities to implement comprehensive and sustainable solutions that address the root causes of the crime while promoting a sense of security and unity within our community. In conclusion, the collaboration between our community and government is fundamental in addressing the crime trends in Washington Highland community. It is through this partnership that we can harness collective strengths and resources to effectively combat crime, ultimately fostering a safer and more secure environment for all residents. To conclude, being more transparent and hands-on by hearing those who are closest to the crime that can play a great impact. Thanks to Councilmember Allen for at least coming to our community and to experience the open-air drug markets that we as residents experience every day. With Councilmember Allen insight on such neglect areas provide all the reasons why we should all stand in support of Bill 25555. Thank you.
Thank you very much, Ms. Henderson. Next and last on this panel, we'll hear from Barbara Jones, Fort Stanton Civic Association.
Yes, thank you. Good afternoon, Committee Chairwoman Pinto, Ward 8 Council Member Trayon White, and members of the DC Council. My name is Barbara Jones. I'm a Washingtonian, a Ward 8 resident, and the president of the Fort Stanton Civic Association, which includes about 2,500 residents plus in the Fort Stanton Southeast area. While I do not support every element addressing the Crime Act, name the chokehold element, but I do support some of the elements. My city, and more importantly, my Ward 8 community, helping to foster a sense of safety, security for our Ward 8 seniors and children, of which many of my communities are comprised of. Let me see. I am in total agreement of wearing the mask, We are. We are in total agreement of the theft, retail theft, but we do have a problem with authorizing the Metropolitan Police Department declare temporary drug-free zone, which would allow MPD to limit loitering in these zones. They had indicated this is unconstitutional, and they should leave that out. They indicated that they should leave this out. In closing, I'm gonna be short. In closing, I support Addressing Crime Trends Now Act Amendment 2023 Act Now Act with some change language to address targeting and chokehold aspect of the bill. Mayor Bowser has always been a leader in these areas of public safety. Mayor Bowser has always demonstrated and committed to the public service, and also my councilman, Trayon White, Ward 8 Trayon White. That's it.
Well, thank you very much, Ms. Jones. Thank you all, the witnesses on this panel. Really appreciate your testimony. I'm going to turn first to my Ward 5 colleague, Councilmember Zach Parker, for a round.
Thank you. I'm going to pick up where you left off, Ms. Jones. Can you elaborate on your concerns about the chokehold aspects of this legislation?
Oh gosh, the chokehold. If you have noticed across United States, we have issues with the police department of individuals who had died based on the chokehold. And that's my concern. I'm really concerned about that.
Understood. Understood. Thank you for that. Mr. Townsend, one, it's great to see you, and I appreciate you calling out that you're a proud Ward 5 resident. We have talked at length about the needs of our restaurants and businesses. Beyond this legislation, what are some other supports in the short term that the Restaurant Association is looking for to help restaurants weather this spike in violence?
Well, thank you, Councilmember, for the question. And I think, as I mentioned in my testimony, the cashless retail legislation that was passed in 2020 and implemented earlier this year, most of our members we've heard feedback from, and it's just a safety concern, and wondering if there's any opportunity to pause this enactment of the legislation as we are dealing with a crime crisis here. There's been some concern as we've seen an increase in burglaries in some of our restaurants. So I think that's one thing. Obviously, there's some we have a reimbursable detail program. I've spoken to Chief Smith about this recently. Restaurants and nightclubs and bars oftentimes request police services at night. Some are required by the ABC board, but because there's a shortage, there's a shift in priorities of the police department, and sometimes those officers are not able to show up at night when they've been requested by some of our members. So taking a deeper look at that as well. I know MPD is trying to address it, but those are just two top of mind things that in addition to the other things I said in my testimony that could be looked at by this council.
I really appreciate those concrete recommendations, and I trust that those are things that the committee will follow up on. And I would just note that I too share concerns around our restaurants' ability to weather this period. It's a very tough time, and just yesterday, a Ward 5 restaurant lamented about being robbed and it being a repeated occurrence. And so everything you're saying resonates with me. Mr. Hood, thank you for your many years of service and also your testimony. It is quite persuasive to have someone of your stature here sharing why you're supporting the bill. Do you have any reservations to the changes to the chokehold requirements or the law as several others on the panel have spoken to? And it's fine if not, I just wanted to make sure.
Okay, thank you. First of all, let me also speak to my council member. Good afternoon, Councilmember Parker. I didn't know if you were there, and I see Councilmember White as well and other council members. I don't necessarily have any. Unfortunately, I'm not the subject matter expert. I just know that I hear the discussion, and we can go back and forth about how we agree. Certainly, I don't want anything done wrong, as we've seen in last few years, especially nationwide. But I think when I think about what the officers do, I put myself in their position. They only have a split second sometime to make decisions, and sometimes that decision it will last them a lifetime. And I think I've heard that through this discussion. But I think we have to start somewhere. Now, if we have to put something in place and back off of it, then let's do that. But we got to start somewhere, because at this point it's out of control. Like when we did the orange hats, we had to start somewhere. We had residents across the city who bought into what we were doing under the leadership of the Red Hats under Mr. Thorpe. And this came from the administration at the time, Mayor Kelly. So yes, there may be some concerns and some tweaks that need to be made, but we got to start somewhere. We can have this discussion all day long, but we got to get started.
And I'll take you up on that, and I appreciate that testimony. There are several others that I appreciate. Mr. Hassan Towery, very powerful and compelling testimony. I'll give my last 15 seconds to Mr. Ukta. Very persuasive testimony, and much of what you shared resonated with me. You spoke about addressing the root causes. Very briefly, are there areas that you would recommend this committee to pay closer attention to?
Yes, sir, I would. But with the understanding that this is a complex issue, I would suggest to us that we start looking at alternative methods of reaching out to our young people, particularly in the world of entrepreneurship. I would also suggest that we start looking at specific activities that they could participate in legally. And I'll just give you one brief example and cut this off. We have all witnessed our young people riding our streets on these ATVs and motorbikes. I can't speak for everybody on here that's testified, but whenever I see them, that's genius to me. I realize that the dangers involved, but we're not providing them like other places do, places where they can go and participate in that sort of activity.
I hear you. And I really appreciate that example. I am at time, and I would love to follow up to hear more.
Yes,
but thank you.
Thank you.
Thank you, Councilmember Parker. Councilmember White?
Yes, thank you. I want to start with you, Ms. Yearling. You spoke in reference to the definition of serious bodily harm. Can you go a little bit in depth about the pros and cons to that language and what that really means for the officers and to the community if you have that analysis?
I'm sorry, you said what was it that you said?
The definition of serious bodily harm as relates to an officer with restraints, as we talked about neck restraints. I
see. Yeah, I don't think I mentioned that in my testimony, but I'm happy to talk about that. I point to what Ron Hampton, who's a member of the Police Reform Commission and a retired MPD officer, says, which is that in his 24 years of police work, he never made contact with someone's neck incidentally. So I just want to emphasize that this practice has been banned here and in many other cities for good reason. It's extremely dangerous to have this type of serious force on a person. Nonetheless, the sky has not fallen. Police are continuing to apprehend people. And so the council should do everything possible to reduce the likelihood that police interactions with community members will end in someone losing their life. It is the job of elected officials to reduce violence in any way you can between the police and community members. And there's no way that the only option for a police officer to do is use a chokehold in these situations.
Thank you. We're analyzing that based on some of the data we're getting and research we're getting in our office. I want to jump to you, Ms. Henderson. You talked about the violence and crime in the Washington Highland community and how you were in full support of this legislation. How do you see this legislation decreasing the violent acts of crime or in the community at all? I know you say you're in support of it.
Can you hear me?
Yes, ma'am.
It's just not me in full support, it's the association itself. So I didn't make this decision. And it can help us because within the area in which we serve, all we see is individuals standing within corners that does not live in the community. We know they don't live in the community because that's the relationship that government and the community have to know who live there and who don't. But on an everyday basis, during school hours from sun up to sundown, these individuals, let's speak specifically on Livingston Road, that everyone is aware of. Oh, please. Sorry, everyone. I'm still at work and I have a job to do, okay? However, let's speak on Livingston Road. We have 2 elementary schools. We have a fire cadet program. We have a small business quarter that's been over there for 30 years. We cleared up South Capitol and Southern Avenue. Everything, like they stated, moved to the next quarter, which is Livingston Road, a 4600 block, in which we have family, kids, and everyone. But these individuals are able to go out every day and sell narcotics, get locked up, guns found, get second gun charges. And this is right across the street from an elementary school. So how is this able to be done? If we can eliminate individuals standing in our communities that don't live there in hoodies, in black clothes, and it's an everyday scenery. Let me go on 4th and Chesapeake. Let me go on 4th and Atlantic Street.
When you say eliminate, can I ask more? When you say eliminate, how does this legislation help to, I don't know what your definition of eliminate is, but I guess cure this particular issue in this community?
Well, at least someone first put some resources out there to bring attention that individuals such are hanging in our community. So that'll allow MPD to make these drug-free zones. If it's for five days, MPD will have that resource or that ability to allow these areas that we complain about all the time to make them a drug-free zone. That will allow us as a community council member White to breathe for a chance and not feel as though that we are threatened by individuals just standing out there. We have to do something. And these are schools, these are drug-free zones. So what do we do to eliminate individuals from standing out there all day selling drugs?
Thank you. I'm gonna jump to
because you're
Mr.
the council member.
I'm sorry, ma'am.
What should we do? Because we're the council member and I'm asking you, like, what should we do?
So I'm gonna go to my next question for Mr. Talib. You said you are against this because, mass incarceration has never cured or created an equitable solution to the community. Is there any aspects you do agree with this legislation, or are you just totally against it for what the consequences could be long term?
But as I stated in my testimony, I have not read this bill fully. You all are the legislators there. What I am opposed to is that what I did read is that I don't see anything in there that is being supportive of our youth. I heard earlier that the council passed a bill during the budget of authorizing $500 million for the police department. In contrast to that, there were millions spent on preventive programs. What if we reverse that number and put $500 million in these various programs that are out there? I don't know what they're doing or not doing. I know the ones I've participated in. I've been doing this. I'm 71 years old. So I've been doing this for decades, working with youth. I represented the city at the first National Gang Summit under Sharon Pratt Kelly. Or Mayor Sharon Pratt. So I've worked with these youth and still continue to do so. But I don't see where this bill is helping our young people. What I see is
let me jump back to I'm over my time. Let me jump back to Councilmember Pinto. Can I get an extra minute, Chairwoman?
Sure, go ahead.
Thank you. I want to jump to Ms. Taylor. You spoke in your testimony. Are you still here? Yeah.
I am.
In regards to your experience working with law enforcement and the ability for them to remain transparent as a law enforcement agency. Can you speak more in depth of how you see this bill helping or hurting the long-term effects into communities? Because there's some who are for and against, and I've been following Harriet's dreams and the interaction with police. Where do you see this going?
Yeah. First I want to name that I people have a tendency to think that, like we hate cops. We hate a system. It's no good cop in a racist system. And when I say that, we literally have, you can give the time, whereas they say like maybe this not be for the police violence when they kill someone. But if we're out there protesting and the police, they do violent things to us, tear gas us and all this, and then we have to like go to court, some of us get locked up. You're telling me that a cop get to go through the body cam footage and everything before anything that was violent put out there, that was done to citizens or just everyday people outside of, say, police brutality, right? Police when they kill someone. No, I've actually witnessed the cameras myself with families, and I've actually seen police lie. Like police have lied on me. And so therefore, I think just like any other person, when you get that statement from a regular citizen, a policeman, your best acknowledgement of what happened just then is for me to tell you right then and there what happened, not when I get to go watch a body cam and then be like, well, say you did this, you choked this, you kicked that person because they done that. Say you did this because they done that. No, they're fixing the body cam so they won't be transparent of the whatever actions that were taken that could have been illegal. So I think that they should not have the right to look at the cameras.
So let me ask you this. I heard in the last panel, one of the law enforcement officers was talking about the contradiction between what's happening on camera and what's in the report, because the reports are so limited in what they are wording. And he's explaining that they need to be able to access to make sure it lines up. And you're saying that this is counterproductive in trying to get the truth out. Is that what you're saying?
I am, because it's counterproductive because they're telling them not to write the whole report so that they can protect the cop. So they can write a whole report, but they be like, no. So the union is telling them not to write the whole report. So it's the whole system, Trayon. Let's be clear. So when they write the little bit of report, and then it's to protect them so that if anything was done wrong, they can't be held accountable. But if we do this, then once again, right now, what we are fighting right now, Sutton, the cop that killed Karan Hilton, he will be a free man right now.
Council member.
Thank you. Councilmember Pinto, thank you all for testifying today. Appreciate it.
Thank you very much, Councilmember White. Thank you all for being here and your testimony and participation today. Appreciate it. We are going to move on to our next panel of public witnesses. We will hear from Angela Franco, DC Chamber of Commerce, Deregi Danielle, Abernash LLC, Yalin Zhang, 1882 Foundation, Anwar Salim, H Street Main Street, Joshua Baker, Public Witness, Carmen McCall, AARP Local 4870, Corresponding Secretary, 7th District Citizens Advisory Council, Lesiel Farrakhan, Public Witness, Don Cook, Benning Ridge Civic Association, Kenyatta Robinson, Mount Vernon Triangle Community Improvement District, and Maria McPhail, Vita Senior Center. And Angela. Here. Deregi Danielle, Abernash LLC. All right, we'll go to Anwar Salim, H Street, Main Street.
Okay, good afternoon, Chairwoman Pinto and members of the committee. I'm Anwar Salim, the Executive Director of H Street Main Street. which includes the areas east of 8th Street Northeast, Minnesota Avenue. I'm also a native Washingtonian. 8th Street Main Street and Minnesota Avenue Main Street strongly supports the Addressing Crime Trends Now Act, a recent legislation submitted by Mayor Bowser. This pivotal legislation is a clarion call to comfort the unsettling challenges undermining our city's public safety. As we champion this act, we anticipate it will equip MPD with an arsenal of tools essential for thwarting the audacious activities of criminals encroaching upon our neighborhoods. Residents, entrepreneurs, employees, visitors, and the very fabric of safety and quality of life in our beloved city. As experienced by many sectors throughout the city, 8th Street has had its share of high-profile crime covering the newspapers and TV screens throughout the past year, negatively impacting businesses and our community's overall quality of life. This legislation will allow the city to customize its approach to disrupt crime legally. Compared to this country, the DC Metropolitan Police Department runs one of the country's most professional enforcement agencies and can administer the law effectively. The pandemic aftermath laid bare to tattered safety nets encapsulating homelessness and the prolonged struggles of individuals grappling with mental health challenges. We acknowledge that tackling the pressing issues transcends the scope of MPD's duties. In a city so sophisticated as ours, rectifying the discrepancy is imperative. Enacting this legislation must be mirrored with innovative ideas, robust support, and systematic shifts within the purview of pertinent DC agencies dedicated to addressing the needs of those battling with adversities. These responsibilities must operate independently from MPD. I can ask more questions, answer more questions, and give more people time. I'm glad that you allowed me to testify, and we're opening to answer any questions.
Thank you very much, Mr. Salim. Derege Daniel Abernash LLC.
Yes, good afternoon, everyone, council members, mayor office, and all the community members. I live in the District of Columbia. I've been a long time. I have a couple of restaurants and lounge. Restaurant on the lounge. So I'm really supporting the mayor offering 25-555. I've been seeing it, a lot of crime happen on different areas, entire, I can say, every locations. I see robbing, to carjack. I seen it, the people, to beating. I seen the people broken a car. I seen it, a lot of activities. So this is the time to get together, everyone to stand to help the mayor offer to be, amended.
Mr. Daniel, are you done with your testimony?
Hello?
Hi, you cut off. I wasn't sure if you were frozen or if you were finished with your testimony.
Yeah, so basically, we need this amendment, everybody have to be same page, council members, mayor office, the community, ANC, to be amended, top the police officers, get back to, give them a power to deal with this kinds of situations. I'm really against for ski mask. This is the hardest season now, this is the winter side. Everybody wearing, most of the people wearing ski masks. That is to be really hard to be manage the restaurant and lounge. I would love to, to be avoid the ski mask.
Thank you very much.
No problem.
Gillen Zhang, 1882 Foundation.
Good afternoon, Chairperson Pinto, members of the committee, Councilmember White, Councilmember Parker. My name is Yalin Zhang. I am a longtime DC resident and resident of Ward 2. Today, I'm here on behalf of the 1882 Foundation, a nonprofit established more than a decade ago that has made Chinatown, DC its home and works to ensure Asian American Pacific Islander voices and stories are shared and heard, and works to build cross-cultural understanding. Throughout the years, we have seen the changes in Chinatown and have serious concerns about current and future safety. Concerns include open drug sales, loitering, and trashing of the sidewalks. The declaration of the drug-free zones that would be allowed through Bill 25-555 would mitigate these concerns. In the long term, we also believe in a public health approach that addresses the root causes of the current safety concerns, which would support those experiencing homelessness, mental health conditions, and long-term unemployment. As an organization, we will work with and continue to work with the Mayor's Office, the DC Council, organizations, and residents to build a sense of community and safety. And to wrap up, we would like to thank the Downtown DC bid for working with the Department of Transportation to make part of the I Street by Chinatown Park pedestrian friendly, which we hope will ultimately become a plaza and a place for community members to gather and build community. Thank you also to the Mayor's Office on Asian and Pacific Islander Affairs for continuing to work with us to hold community events, which we collaboratively can then revitalize Chinatown and help residents, commuters, and visitors feel safe. And finally, thank you to Councilmember Pinto for bringing the community together to address public safety for Chinatown this summer and for your leadership across Ward 2. We appreciate the opportunity to testify. Thank you.
Thank you so much, Ms. Zhang. Appreciate your testimony. I do want to note we have been joined by our Ward 6 colleague, Councilmember Charles Allen, and member of this committee. Once we are done with this panel and are in rounds of questions, I'll add a few minutes to your time if you have any opening statement you'd like to add. Next, we'll hear from Joshua Baker, public witness. Carmen McCall, AARP Local 4870, Corresponding Secretary, 7th District Citizens Advisory Council. And Ms. McCall, you're still on mute. If you can see, if it's on your phone, it should be at the bottom left if you tap the screen. Still on mute. If you tap the screen, some options should come at the bottom of the Zoom screen. Okay, Ms. McCall, we're going to move on to the next witness, but our team will reach out to you and see if we can assist to make sure that you can testify. Okay, thank you. Oh, you got it.
Good afternoon, everyone. Councilmember Pinto and other council members present. My name is Carmen McCall. I'm the AARP President, Local 4870, and the Corresponding Secretary of the 7th District Citizens Advisory Council. And I just want to say, in a nutshell, I wholeheartedly support this bill. It needs to be done post-haste. And I just want to thank everyone for all of their comments. But I feel that the bill needs to be passed. There's too many things happening in this city that should not be. For example, on my block, I already know what's happening there. The drug-free zone would work perfectly there at Mellon and Martin Luther King Avenues. So without further ado, I would just say pass the legislation. Thank you for your time.
Thank you, Ms. McCall. Asil Farrakhan, public witness.
Good afternoon,
Councilmember Pinto or Council Chair Pinto and the other council members, Trayon White and others who are here and the general public. My name is Liesl Farrakhan. I am a high school social studies teacher at Maya Angelou Public Charter School and a resident of Southeast Washington, D.C., 7th Ward.
In your classes, we are on a no movement. We are on no
sorry.
movement. Teachers, please step out, get your students back into the classroom. We are on.
As you can see, I'm just, this happens to be my planning period, so it works out perfectly. But I've also worked for DCPS at Ballou High School and lived in Ward 8. I'm the mother of 6, 4 daughters, 2 sons, who and 4 of my children have attended and graduated DC public schools. The children that I work with at here at Maya Angelou are some of them, a good portion of them involved in the criminal justice system. So I can see things from many sides. I have not, I was just made aware of this meeting a few days ago, so I have not looked at the entire bill, but I did use the opportunity of this live meeting, council meeting, to share with my students and got feedback from young people. The bottom line is young people know when they're right and when they're wrong. And as an older DC citizen, they believe that I do have the right to have a quiet and safe community. I'm not afraid of the people in my community, but just across the street from me, since I purchased my home in 2009, there is an open air drug market that brings in prostitution. And for example, I told them I have a bullet hole in my garage. I'm fortunate to have a garage in DC, but I do have a bullet hole in my garage. Something needs to be done, but we definitely need to give young people opportunities that are going to change their lives. Of course, truancy is an issue. And getting them active in school and after school activities or whatever after school activities we can come up with. I don't think we have enough community centers, for example, in Washington, D.C. Even though I've been coming back here, I initially came in the 70s for high school field trip. I thought it was a beautiful place to live, came back, attended Howard University, and the bottom line is there are 2 cities here. One of the courses that I teach is DC History and Government, and there are 2 cities here. So that's really about all I have to say. But on my block, 51st and Queen Stroll Place in Southeast, there's all kinds of horrible activity, which includes speeding traffic. I see things have been done with the speed bumps, but it's really not enough. There's even been a van put outside.
I'm sorry to cut you off, but over time.
Okay, ask me any questions you want to ask. But there was a police van outside on the street, and they sat on the police van. I'm talking about the drug dealers. It's like, this is crazy. Okay, thank you.
Okay, we will come back to you for some questions on that. That is
okay. Thank you.
Alarming to hear. Okay, Dawn Cook, Benning Ridge Civic Association.
Good afternoon, everyone. My name is Dawn Cook, and I'm testifying in support of the Act Now Act. As president of the Benning Ridge Civic Association, Ward 7 resident, and a high school educator, I find it jarring and troublesome to see the high number of gun-related offenses committed by juveniles. Most recently, I experienced firsthand the direct effect that gun violence has on our youth and community when my former student was gunned down a block away from Dunbar High School. The significant shortage of manpower in MPD is a community struggle and has a direct impact on policing. As a result, crime increases and the community suffers gravely. I support the Act Now Act specifically for its initiatives to limit loitering and the 120-hour drug-free zones. The Minnesota Avenue and Benning Road corridors have been a pariah to the bustling business and residential areas that were erected to improve the quality of life for new and old DC residents. However, the sight of individuals aimlessly sauntering near metro entrances, bus stops, and retail areas is off-putting and continues to be a threat to the community. Moreover, National Stadium and the Wharf, where I frequently walk, has also been stigmatized by criminals who prey on the patrons that simply want to enjoy the amenities meant to attract families and increase the financial viability of our city. I also support the Act Now Act initiative to penalize those responsible for organized retail theft and forbidding the wearing of masks. Furthermore, I think the sale of masks at convenience stores in the district should be prohibited across the board. Desperate problems calls for desperate measures. And although this initiative seems petty and pointing to some, it is on behalf of the victims of these crimes, tax-paying residents, and for the revival of our city that I support the Act Now Act. I thank you for your time and attention, and I just want to say, as an educator, I feel that parents need to be held accountable for the acts of their children. I know that we do have a lot of actual community centers. Mine is Ridge Road Community Civics Community Center. And what I see is that they're being underutilized and underprogrammed. They mainly have programs that are related to athletics, and they don't have enough that deal with the social skills. Additionally, I feel like in DCPS education, we need to adopt a community schools model where we bring wraparound services and supports into the schools to support the parents who are in need, as well as the students who are being challenged and also committing these crimes. I have several students who are walking around with devices on their ankles as a result of committing these crimes, and they need extra supports and services in their communities, as well as for themselves as young individuals, to help them to be better citizens in our nation's capital. I am a DC resident. I was DC birthed and earthed, and I love my city, but we have to do better. And it takes collaboration and it takes a community. Thank you.
Thank you, Ms. Cook. Next, we'll hear from Kenyatta Robinson, Mount Vernon Triangle Community Improvement District.
Good afternoon, Councilmember Pinto and members of the committee. My name is Kenyatta Robinson, and I'm the president and CEO of the Mount Vernon Triangle Community Improvement District. I also serve as chair of the DC Bid Council. It is in this role on behalf of my colleagues on the Bid Council that I come before you today to testify in support of the Addressing Crime Trends Now Amendment Act of 2023. We also come before you not as experts in the practice of safe and effective policing, although we can all agree that it should be an essential part of the economic recovery strategy for any city, but rather as professionals who are passionate about the creation and sustainment of clean, safe, and welcoming spaces. In other words, vibrant places that people want to be. Thank you for giving us the opportunity to speak constructively about the nexus between place management and public safety and economic recovery. As practitioners who are intimately connected to the communities we serve, we understand our stakeholders to recognize the inseparable relationship between safety and other leading quality of life indicators, and therefore believe that our bids have unique experiences and perspectives to lend to this conversation. We know from conversations with stakeholders the following two things. First, public safety has become the primary topic discussed in just about every discussion. And if not the first item discussed, it is usually not far behind. Second, our communities believe that both their personal safety and that of their families and employees and economic security are being put at heightened risk due to what is perceived to be a lack of focus on the problems that make them feel unsafe. Issues such as being unable to buy basic necessities because organized retail theft has rendered store shelves bare, to having to navigate open-air drug markets while walking a child from school, to fears of being robbed or carjacked by masked criminals while enjoying a night out on the town, all contribute to heightened perceptions that things are out of control. Increases in personal anxiety about safety then lead to decreases in public perceptions about safety, which combined contribute to a downward spiral that will lead to municipal disinvestment, and a negative cycle continues. The DC Bid Council fundamentally believes that we all deserve to live in a safe and just city, that we should do all we can to prevent crime before it happens, that we should provide help and support to those who ask for it and need it, and that, as a basic societal organizing principle and operating agreement, must hold accountable those who commit crime. It is therefore our consensus view that, on balance, both Act Now and the specific tools aimed at eliminating retail theft from our stores, removing drug dealing from our corners, and increasing the consequences for wearing masks for the purpose of committing criminal acts are positive, significant steps toward enhancing public confidence in our public safety environment. And this public confidence is critical toward promoting the city's robust and sustained economic recovery, and for creating the safe, welcoming, high-quality public environment that is vital to Washington, D.C.'s ongoing attractiveness within what has become an extremely competitive regional landscape. Thank you again for allowing me to testify on this very important issue that we deem to be a critical priority for our city. We appreciate your consideration of our perspective and are happy to answer any questions that you may have.
Thank you, Mr. Robinson. Maria McPhail, Vida Seniors Center.
Good afternoon, members of the City Council. My name is Maria Teresa McPhail, President and CEO of Vida Senior Centers, an organization that has been serving Latino and other seniors community in the city for over 52 years. I am thankful for the opportunity of advocating and testifying about the importance of and desperate need of safety and security measures, especially for our older adult community in Washington, D.C. As we all know, there has been a concerning rise on violence threatening an elderly population in our neighborhoods. This has left many of our elders feeling vulnerable and afraid to go about their daily lives. As a community, it is our responsibility to act and ensure the safety and well-being of our population and elders overall. I strongly advocate for the implementation of the Addressing Crime Trends Act Now Amendment. Any other initiatives that specifically address the safety concerns and security are our concern. It is imperative to increase presence in areas where elder adults circulate, as well establishment of neighborhood watch programs specifically tailored to meet the needs of our elders. Now there is a need for increased outreach and support services for the elderly population that might be experiencing fear or isolation due to the recent violence threat. That is our job, but we cannot succeed doing it without the right safety measures being in place. I know seniors who have left the city after being victims of violence. This is not acceptable in any ways that we can see it. Our seniors have worked so much in this city to provide what we have, to leave them abandoned now without the right measures and security. We have been asking for security cameras, more police presence, and still we have failed to deliver those. We are hoping that with the approval of or the pass of this act, this measure will come in place. Our elderlies are counting on us, and we are all responsible to taking proactive measures to ensure that our elderly community feels safe in a city that they have helped to build. Thank you so much for the consideration and for the opportunity of being here today.
Great. Thank you, Ms. McPhail, and thank you for the work that you do for our seniors in the city and for all on this panel. I want to zoom in on some of your comments around the enforcement of a 5-day drug-free zone. And in my conversations with MPD, I think there is a recognition that this type of intervention is not going to solve all of the issues around drug use and repeated drug sales in certain hotspots, but it could disrupt it. And so with any disruption, likely will lead to that behavior moving to another location. And so for some of you who testified in support of enforcement of a drug-free zone, what are some of your thoughts around the practical effects of that type of interruption, of what it could mean for surrounding neighborhoods, you know, a street over, a block over, several blocks over? And I know Ms. Zhang, you testified to this and you see this in Chinatown. Maybe we can start with you. Ms. Farrakhan, you mentioned this, Mr. Robinson, and Ms. Cook, if you have comments on the next step once we have the enforcement.
Thank you for that question, Councilmember Pinto. In discussion with my colleagues at the 1882 Foundation, there are hotspot areas where the open drug sales usually occur in the Chinatown area. And we do believe that this would be effective in disrupting. And in the long term, what we hope is to really increase foot traffic in the Chinatown area and to increase the quality of life. So that I believe would be the long-term prevention, is to increase foot traffic to our small businesses, make sure they have what they need so that there's no unnecessary loitering in front of their businesses, and making sure that there are also other approaches in addition to MPD being there, but also making sure that we work with social work to see if there are different ways to respond to needs when someone is experiencing a mental health condition. So we believe that this act now could be a first step toward a more holistic public health strategy.
Great, thank you. Ms. Farrakhan?
Yes, I think the interruption may be a good thing, but it's definitely not a cure. And I don't even understand how this interruption would take place, or how, for example, my 51st and Queen Stroll would be designated a drug-free zone. It's not. I mean, there are schools in the neighborhood, but not at that intersection. So it would be a positive thing theoretically, but how its implementation would change things, I'm not sure that it would. Like I said, there was a large police van parked on the block for weeks, and I didn't see any police activity, just the van. And the patrons, or whatever you want to call them, the loiterers, and these are people that have Maryland and Virginia license plates and once lived in the neighborhood but no longer live in the neighborhood. They were just sitting on the van, chilling on the van. So to me, I don't
Are there any
understand.
police in the van, or the van was just parked alone?
The van is just parked, an empty police van, like a motorhome, parked, and no police activity, walking the blocks. This is a residential neighborhood. It's not even a public, I mean, of course, it's public space, but it's not a commercial space.
Right.
So
okay. Thank you for that. We're definitely going to follow up with MPD about that. That certainly sends the wrong message. So thank you for raising that. Mr. Robinson?
Yeah, as I mentioned, thank you for the question. And I think that's a very a prescient observation that displacement could occur if interventions are made to disrupt open air drug trafficking. Our community is just north of the Gallery Place Chinatown area, and we've seen firsthand that when there's been increased police activity to disrupt some of the things that are happening down at, say, 7th and H, some of those individuals do move up, or have in the past moved up to our community. As I mentioned, we're practitioners in the management of public space. And so one of the things we look at first are the environmental conditions that create sort of a safe environment and a safe haven for individuals who want to do activities that aren't necessarily productive. And so while I agree that this isn't the cure-all panacea for that one specific issue. I do think it's a good tool and a good first step to be combined with other solutions and interventions, such as enhanced lighting, such as cameras in public space, things of that nature that we've used to help when we've experienced displacement into our community, help disrupt that. Now, granted, might that displacement have gone somewhere else? Absolutely the case. But with cameras, you can pair that with law enforcement activity to hopefully gain prosecutions and convictions for individuals who may be peddling drugs on our corners. And so what we've seen is that when there has been displacement to our community, the combination of a number of different sort of environmental solutions has been very productive in disrupting activity, and activity has not come back. One particular corner, an example is, for example, 5th and K near the 7-Eleven. We had, basically an open air drug market there for a while, and working very closely with that operator and that property owner to get that camera solution there, in addition to better lighting and better environmental conditions. Just cleaning up the space has really helped tremendously and preventing that displacement from affecting our community.
Okay, thank you so much. That's really helpful perspective. And Mr. Salim, I see your hand raised if you want to have any brief final thoughts before I turn to my colleagues.
Well, we have similar issues at 8th and 8th Street corner, where you have clients that refuse to or afraid to go into Bank of America because of the outside drug activity that's taking place not only in front of Bank of America, but also the rear of Bank of America encroaching the residential area. And we have the same issue where the 7-Eleven moved, and then you have another market there that is operating, and you have a dental environment or establishment there, where the clients are afraid to go into the dental environment to have their services done. So because of the activities that are taking place. So we believe we have some MPD out there with the police, the bike patrol, and we also have a new commander and a new captain who's been initiating some disruption activities there that's been working for us. And we believe this type of legislation could help enhance that. We need to, and it's been a challenge for have them to move on to a certain degree. So we need to disrupt that. That's the good area, the good reason to disrupt that area for time being off and on to disrupt those type of activities over there.
Okay. Thank you.
I'm sorry, I wanted to know if I could touch on something as well, if possible. Is really quickly. I just wanted to say that I think that the biggest thing, of course, because we have limited manpower from MPD, I think that signs are important, because I think instead of having to, it's the how you do it. So if we are looking for manpower to redirect or tell them, hey, you're not to loiter here, or this is a drug-free zone, I think that there needs to be signs stating what this is, what's not to be done. And that way it minimizes a lot of the back and forth. Well, I can stand here. This is a public place. I find that minimizes negative interactions. I know in my area, we have a lot of great community policing. But again, also I feel like there needs to be more officers walking their beat instead of sitting in their cars or riding a bike.
Yeah.
Because I feel like when we have that presence, it creates kind of like a casual feeling where people feel like they're there to actually protect and serve the area rather than to penalize people.
Right.
So again,
thank you so much, Ms. Cook. I'm going to have to cut you off. I'm trying to not set a bad example for my colleagues of going so over time. Thank you all very much. Councilmember Trayon White.
Yes, thank you, Chairwoman Pinto. Just listening and hearing some of the sentiments, especially from the business community or the business corridors, which we've got a lot of concerns from other areas throughout the city. I guess my thoughts is in listening to MPD, how this would be implemented. First of all, I just know that MPD's manpower is down. And even if they had the tools in the toolbox to move people along, how would that be done? Where would they move to? I mean, in these zones, I'm not even clear about how the zones will be geographically done. But I do agree that something has to be done. I do know that some businesses have started exercising stay away orders and getting people off their properties that have been effective. I guess for me, I was trying to ask the former commissioner about what that looks like in practice. And I guess I'll wait till the government witnesses to hear how that works and if it works, right? Because there's a breakdown in communication between law enforcement and the community, especially for those who are already breaking the law. They just, I mean, most times they just don't move because you say they just tell them they need to move. And what's the enforcement process and what that look like. And so while I hear some of the concerns, which is valid, just concerned about the implementation and how that will work and if it's even constitutional. So I want to thank you all for testifying today. I don't have any questions for this panel. I just appreciate your service. Thank you.
Thank you, Councilmember White. Now going to turn to our Ward 6 colleague, Councilmember Charles Allen, and a member of this committee for any opening statement that you may have and or questions for this panel. So we'll give you a little bit extra time.
I appreciate that. Let me first thank you, Chair Pinto, for holding this hearing. You've held a hearing on numerous bills that have been before this committee. So I know that that's a lot of hard work for you and your staff. So just want to make sure I acknowledge that and thank you for doing that. DC ended last year with an overall reduction in violent crime from the year before, but this year has seen a complete reversal of that trend. It's put the city moving in the wrong direction, and we already know we're going to end this year with a sharp increase in crime in our city. It's unacceptable, and action is needed across all of government. Public safety is, I believe, the top priority in our city. I believe it is for this council. I know it is for me. And I think we've heard repeatedly from our witnesses today throughout the hearing that it's their priority as well. And they want to know what can this city, what is this city going to be doing, and what is going to be done. I hear from residents concerned about armed robberies, about armed carjackings, about gun violence, about crime in their neighborhood. And this is obviously not a time for ideology, it's a time for solutions. And I think that's what we're all trying to work on. And that requires all of us to have an open mind and considering this in every proposal before the council, as well as to be able to take a look, what is working and what is not working, and be able to answer both those questions. The work of the council is reviewing numerous proposals that are in front of it, holding oversight of agencies and action and demanding more coordination from our city and from those actors. As I look at all of these, I've kind of talked about this before, I try to look at this with three questions in mind for each of the proposals in front of us. First is the proposal a smart, equitable, and most importantly, an effective way to prevent and reduce crime? Said another way, should this proposal become law tomorrow, is it going to make a difference in preventing and reducing crime? The second question is, does this fill a gap in the law that needs to be filled? Have we found a hole or a gap in the law that needs to be filled? And third, does this proposal help us and require a strategy and coordination across government and within community that is so sorely needed? I think I'm looking for a yes to either of those three questions. And then that tells me this should move forward. And I think in the proposals that you have before us, we see examples that I see yes. And in some, that's the point of the hearing. We explore that to find out the answers to those questions. Because at the end of the day, we know that public safety is about both accountability and justice. And in our work towards solutions, we must demand both and not trade one at the expense of the other. They go hand in hand to truly achieve what we want. So I'm grateful for all the witnesses that have come forward today to talk about these solutions, to share their feedback, and to help try to answer those questions. I did want to, with my time, at least ask a couple of questions to Mr. Salim from 8th Street Main Street and Mr. Robinson from Mount Vernon Triangle Sid. One of the things that I wanted to focus on had to do with the proposal around retail theft. I know that none of us want to see retail theft. The proposals that are in the bill before us right now make a few changes to this. One of the questions I guess I'm trying to understand, though, is what I think we also see is a lack of charging. And so is there anything in these proposals that you see related to the change in retail theft that would make moving forward with prosecutions or move forward with charging any easier? I could go to Mr. Salim or Mr. Robinson if you'd like.
I'll start, Anwar, if that's okay.
Go ahead.
So the bids and a few other organizations had an opportunity to meet with AG Schwab about 2 months ago on this topic, on the topic of retail theft. And along with us in these meetings were individuals from the big box stores, Target, Home Depot, others, who are experiencing this as well. And some of the numbers that we're hearing are staggering in terms of the amount of shrinkage and shortage at the stores, in addition to the threats to personal safety of the associates in the store. So our understanding is that there's going to be new criminal penalties for organized retail theft, and there's going to be a new crime for directing organized retail theft. And so without knowing the absolute specifics in terms of what that means legally, what I can say is that there's something that needs to be done with respect to retail theft. We're seeing stores that are having products taken off their shelves and literally being sold right outside the store. Right. And I'm talking in the tens of thousands of dollars. What we're also being made aware of is that some of the individuals who are stealing these items are being directed by other individuals to go in and steal those items, right? And some of these individuals are juveniles being directed by adults. So therefore it's organized. And then what we're further being made aware of is that some of the proceeds that are being made from the sale of those items are then being used to purchase weapons and narcotics, perhaps both, and perhaps other things as well. And so there's an entire sort of series of direct consequences as a result of this fundamental issue. And I think getting to the root cause of the issue could help eliminate some of these downstream consequences that we're seeing. So that's my sort of long-winded answer to that question. That is, I don't know if it's a direct, panacea to it, but I think it's a start, and there's something that has to be done.
Yeah, well, and let's be clear, there is no panacea, right? There's no one solution here. So I agree with you on that. Mr. Salim, did you want to jump in on that?
Yeah, I want to look and focus more on the Whole Foods, CVS, and the Nike in the Nike stores. Basically, you have retail theft is taking place, and what we're finding is that people are going to the Whole Food and the CVS, and they're coming out and they are selling wares on the corner. Most of them are drug users, and the drug users are purchasing drugs. They go right to 8th and 8th Street and purchase the drugs after they sell their wares. It's been tough for the last couple of years on Whole Food and CVS. Nike is currently having some issues with people coming in, organized, trying to steal retail items out of there. And you look at it again, if it's organized, how do we deal with it? How do you determine what is organized and what is not? I think the CVS and the Whole Food is more organized, more so than anything else, because they know that they're encouraged to go and purchase those items to sell drugs. To purchase their drug from personal drug use along the quarter. So, there's some issues there.
I appreciate it. Yeah, thank you. Last question I was going to ask was focused on the proposal around the drug-free zones. And, Mr. Robinson, you were talking about this. We did a walk just last night, actually, at 5th and K. We went over to that 7-Eleven. I partnered with our ANC commissioners and the 1st District to do a walk with neighbors to focus in on that. And we talked through a lot about the additional lights and cameras there. One of the things that I want to try to help look at, and I'm kind of bringing you in, Mr. Salim, on this as well. We talked about 8th and H, for example.
Yeah.
I've asked MPD to make 8th and H a focal point, and they have. MPD has gone in, they have made arrests, they have increased visibility and presence, and I appreciate that. They've focused in at 8th and H. But what we also see, though, is that even when there's an arrest made, frequently it's no papered, meaning it's not prosecuted. What I'm trying to understand from our drug-free zone, and this will be part of what we want to understand from our other agencies, is kind of twofold. One, what's going to happen differently than happens today? Because clearly selling drugs at that corner or any corner is already illegal. So are we going to be able to see a higher level of effectiveness with the ability to charge someone and be able to effectuate that when you've got somebody, for example, with possession with intent to distribute? And then secondly, for 120 hours, one of the things my understanding is the idea is that with 120 hours, it'll allow other agencies to come in, and Mr. Robbins, you talked about that multi-agency effort, whether it's a vacant building, whether it's improved lighting, whether it's other efforts that agencies can make. I'm not sure if 120 hours we'd actually see the agencies come in with that. I know there's some areas we've been asking for months for agencies to come into these spaces. So just a quick reaction from both of you on that as to how you think that would actually work in practice would be welcome.
Well, to me, I think this legislation has to be mirrored with other types of legislation that would include the other agencies. For instance, behavioral health and Department of Human Services, and also in Department of Human Services. If you don't mirror these agencies in with this type of legislation to help to deal with the mental health and the unhoused, you are not going to really get to the bottom of what you really need to solve these issues. To us, H Street, if you look at most of the crime that's taking place on H Street, the underlying issue is mental health and homelessness. And if we can resolve those issues, I think we will have 70% less crime on H Street than we currently have. And so you have to find a way to mirror the two together. If you don't mirror the two together, I think we're gonna still be where we are today, tomorrow where we are today.
Yeah.
Thank you.
I could not agree more with Anwar, and I appreciate you coming into the neighborhood last night, council member. I was busy writing my testimony, which is why I couldn't join you all, but I did see Commissioner Hart's recap on social media. That corner at 5th and K, which we've effectively cleaned up as a result of a number of interventions, required sort of a multi-tool approach. We purchased homeless outreach services and behavioral health outreach services from a local organization, and they're there in that corner every day, reaching out to individuals who need it. We do need law enforcement. We had a bicycle officer who would basically be there on a day-to-day basis, who's been relocated elsewhere as a result of reduction in force. That was very helpful as well, in addition to some of the tools like cameras and lighting.
Like a bear.
So it takes multiple approaches.
Sure.
I know I'm well over time, so thank you both very much. Thank you, Chair Pinto.
Absolutely. Thank you, Councilmember Allen. All right. Appreciate all of your testimony and partnership and ideas. I think a lot of great suggestions on this panel. Thank you. We are going to move on to our next panel. Maria Patricia Corrales, Fiesta DC, Jean Homza, Public Witness, Madhvi Bal, Migrant Solidarity Mutual Aid, L. Veronica Nelson, DC Commission for Women, Billy Easley, Public Witness, Sandra Basanti, DC Nightlife Council, Krishna Maturi, Minnesota Avenue Civic Association, Faye X, Good Trouble Co-op, Liliana DiMaggio, Barbara Chambers Children's Center, Kimberly Lockett, the Petworth Action Committee, Retirees for Accountability. I don't know if that's the organization or if there's someone, we'll come back to that. Betty Murray, Genuine Sisters Supporting Sisters, Lisa Queen, Public Witness, Caitlin Peter, AOBA, Kathy Henderson, Commissioner 5D06, and Kelvin Brown, ANC 7B. Give you all a moment to join. Make sure to look at your screen and accept the invitation to join as a panelist. All right. See who's here. So I don't see Maria Patricia Corrales. And if you were on the previous panel, if you wouldn't mind exiting as a panelist, so we can see the screen on who's here for this one. All right. Madhvi Bal, Migrant Solidarity Mutual Aid.
Hi. Good afternoon, Chairperson Pinto and members of the Judiciary Committee. My name is Madhvi Behel, and I'm testifying today in strong opposition to the Addressing Crime Trends Now, or Act Now Act of 2023. The bill is a clear attempt to expand police power and limit oversight and has nothing to do with public safety. Act Now is such an egregious power grab by MPD that it even rolls back recent reforms made by the Comprehensive Policing and Justice Reform Amendment Act of 2022, going against recommendations from the Police Reform Commission. Act Now will drastically reduce transparency around police misconduct and abuse. This legislation no longer requires MPD to release body camera footage when an officer negligently discharges their firearm, if it doesn't put the public at risk or if they're targeting an animal. What purpose do these provisions serve other than to protect cops who fire their weapons for no reason and shoot people's pets? Less transparency around cops carelessly firing guns and killing animals very clearly makes us less safe, not more. Act Now also allows MPD to categorically deny or redact FOIA requests for any disciplinary record that is not sustained or that occurred prior to the effective date of this act, thereby shielding cops with a pattern of repeated prior misconduct from liability. Another provision that's only function is to protect cops who have harmed our neighbors and allow them to harm many more going forward. Perhaps most egregiously, Act Now will allow MPD to restrict someone's airway and apply pressure to their neck, including their trachea, carotid artery, or jugular vein, to stop them from moving. There's not one single, even halfway legitimate reason for this change. Did we learn nothing from the murder of George Floyd? Was the mayor's plan always to paint a street, wait a couple of years, and try to bring back cops asphyxiating people? Yesterday, Chief Smith said that Act Now will give her officers the tools they need. If chokeholds and asphyxiation are the tools MPD needs to do their job, it is clear that their job is nothing more than violence, and violence makes us less safe, not more. The Act Now Act is another piece of legislation in a long line of deeply concerning crime bills that the DC Council and the mayor have introduced this year in the name of safety. And that is by design, to overwhelm community members and advocates with countless new bills and endless hearings, thereby making the process inaccessible to many people and limiting dissent. If expanding criminalization, pretrial detention, surveillance, and police brutality had strong support, this strategy would not be necessary. This legislation is reminiscent of the 1990s, relying heavily on punishment rather than care. In fact, this very hearing opened with a former council member who passed crime bills back in the 90s, advocating for Act Now because of how similar it is to the bills he worked on in the past. If that isn't a red flag, I don't know what is. This approach didn't work back then, and it won't work today. It is time to abandon old, ineffective carceral framework and focus on root causes instead. Council members, I urge you to reject the Act Now Act and any future bills that contains its provisions. Unleashing unchecked state violence on the city will not make us safe. Thank you for your time.
Thank you very much. And I appreciate your testimony. And I just have to say, because it is so fundamentally important to me and my committee team, that the idea of limiting consent is antithetical to everything that we have been doing this year. We have been purposely trying to have breakdowns of all of these hearings every week, different times of day, different days of the week, different wards, different neighborhoods at the Wilson Building, in person, virtually, because we specifically received the feedback from people that not every time works for everybody. And that's a reality, that not all of our residents can come to the Wilson Building, for example. And so that is something I will always continue to be open-minded about, to figure out how we can best reach residents with serious notice, with different opportunities to participate. We have heard from thousands of residents about all of these proposals over the last several months. And that is always fundamentally important to what we are doing every day.
Can I respond to that?
Is
Or
Veronica Nelson here? We'll do rounds of questions, and you may be able to speak then. Billy Easley. Sorry, I'm just trying to find, I think a lot of these folks are not here yet. Oh, Billy Easley, I see you. Please go ahead.
Thank you for giving me an opportunity to speak. My name is Billy Easley, and I am an advisory neighborhood commissioner for Single Member District 1A10 located in Columbia Heights. I'm here speaking in my individual capacity as a commissioner and not for ANC 1A. I applaud the efforts of Mayor Bowser and the DC Council to respond to issues like the increase in retail theft, robberies, and other crimes impacting Washington, D.C. and our residents. While there are aspects of the Act Now Amendment Act of 2023, which I support, I urge the mayor and DC council to support comprehensive reforms that can really go to the issues that are the root causes of issues that are harming our city today, and also things that will quite honestly have a bigger impact. Things like funding and increasing staffing for the Department of Youth and Rehabilitative Services, so that not only are they taking care of juveniles who have been detained, but can provide them with necessary resources. Increasing oversight over the Department of Forensic Sciences and speeding up the accreditation of the DC Crime Lab, so that the U.S. Attorney and OAGs have no excuse in deciding whether or not to no paper cases, unless there actually isn't enough evidence. And also, and this is a big one for me, implementing thoughtful, ambitious plans, like implementing the Criminal Justice Coordinating Council's Gun Violence Reduction Strategic Plan, which was released last year. I know I have limited time, so I'll just go a little quicker on this point. And the rest of the things that I mentioned will be in my submitted testimony. As a co-chair of ANC 1A's Public Safety Committee, there are just a few things I wanted to point to in this bill. First, the new offense for directing organized retail theft. I support the creation for an offense for organized retail theft, where an individual is directing other people to engage in that offense. But I recommend the council consult with the DC Sentencing Commission and the public about what the maximum prison term is, instead of simply relying on what the mayor put in this bill. Retail theft doesn't just harm our businesses. There's a CVS at 14th and Irving. Those shelves are cleared constantly. And I always hear from residents about what an embarrassment it is and how demoralizing it is that when they go to get essential goods, they're confronted with empty shelves. And that's not acceptable. So I'm okay with additional penalties as long as it's combined with other activities, like providing more funds to MPD for and working with working with our businesses to deal with this issue. Outlawing masks in certain situations. I've had a resident who was really concerned, who says that who had video of someone stealing packages while they were wearing a balaclava, and he was very he thinks that mask wearing can facilitate criminal activity. So I support this provision, but I think the council needs to have oversight over how this provision is being used, so it's not being used to harm everyday citizens who happen to wear a mask. And finally, with the drug-free crime zones, I am not a constitutional law expert, but I do not want the council to pass a drug-free crime zone thing that might violate constitutional jurisprudence regarding anti-loitering laws, especially if it might force them to go into litigation over a policy that's never implemented. Finally, I'll just note, people really are crying out for leadership in our ANC, and the DC Council should engage in more ambitious plans than just this bill. The Robert White plan, Councilmember Nadeau's, Councilmember Brooke Pinto's own plans as well, I think are far more ambitious. I think that's more will be more successful way to respond. I'm sorry for going over time.
Thank you, Commissioner. Jean Holmza, public witness. And I want to acknowledge we've been rejoined by our Ward 1 colleague, Councilmember Brandon Doe.
Okay. Good afternoon, Madam Chair, Council Members White, Allen, Nadeau, and other distinguished council members. My name is Jean Holmza, and I've been a resident of DC for more than 40 years, and I live in Ward 5. I have worked in DC since the early 80s in various bars, the Washington City paper. I've been an employee of the 930 Club since 1997, and I'm currently on the board of the DC Nightlife Council. In all these years, I have witnessed the blight and then the revitalization of the city's commercial corridors. Prior to the pandemic, our industry, the hospitality industry, and our city's main industry was thriving and exciting. Since the pandemic, the hospitality industry is struggling, and I'm extremely concerned about the increase in empty storefronts on H Street Northeast and U Street Northwest. Yes, the pandemic has impacted the attrition of businesses, But what I hear mostly from small business owners is that crime is what is keeping their customers away. So I'm here to express my support for the Addressing Crime Trends Now Act Now. I believe this act is essential to increasing public safety and effective policing in our city. While this act is not a panacea, it certainly is a step in the right direction in helping MPD and the courts have better tools for enforcing the law and making our neighborhoods safer. I am particularly supportive of the following key provision: addressing loitering around open-air drug markets. The reinstatement of the MPD chief's authority to declare temporary drug-free zones and instituting a no loitering law will substantially disrupt drug-related activities and allow for the reclamation of public spaces for community use. We have an intractable problem on the 600 block of T Street Northwest by the Howard Theater. The customers and employees of the small businesses, as well as the neighbors living there, endure abuse every day, and the businesses are looking at relocating. It's an absolute horror story. I encourage anybody that's not aware to please go by there. I also support supporting the safe and effective policing part of this act, and also obviously combating organized retail theft. So I'm skipping part of my testimony to wrap up. I strongly urge the council to act swiftly to pass the Act Now Amendment Act. This legislation is an important first step toward enhancing the safety, security, and hopefully the prosperity of our community. Thank you, council members, for listening and for your dedication to making our city a better and safer place.
Thank you, Ms. Holmesa.
Thank
Kimberly
you.
Lockett, the Petworth Action Committee.
Good day. My name is Kim Lockett, and I am with the Petworth Action Committee. I'm speaking on behalf of myself today and the Petworth Action Committee, so I'm going to try to get through this as fast as I can. I'm a native Washingtonian, born and raised in the northwest section of Washington, D.C., specifically Petworth. I have lived my entire life, with the exception of going away to college, in Petworth. I have never, ever seen crime this bad. I had a conversation with one of my neighbors recently, and he said, well, it had to have been bad back in the 90s. I quickly told him it was not. I feel as though we're a city under siege. I have never been afraid to walk the streets, yet I find myself looking around, simply walking my dog. There was a time when we planned to run errands during the daytime because it was safer to go to the ATM and to go to the gas station. That is no longer the case. You will get robbed at a gas station near our home at 11 o'clock in the morning. We are half a block away from an elementary school, and there were 2 robberies at gunpoint between 3 and 4 p.m. this summer. While on a Zoom call for my job this summer, we heard a loud boom, boom, boom. My colleagues asked if I was okay. I told them I was. Shortly after, I came outside, walked down the street to a body, a dead body on the street. This is overwhelming. Something has to be done. I have a special needs older brother who lives with us, who we can no longer allow him to walk the dog by himself because we are afraid that a gun is going to be pointed at him and they will take our dog. My neighbors move in and they move right back out. We had a young couple to stay for less than 2 years. This summer, a for sale sign popped up across the street, and I asked them why they were leaving. They indicated at that time that they wanted to have a family, and it's just not safe in DC to do so. While my time is running out, I have to get to some of the PACS issues. We have a Safeway in Petworth. The employees are every time I go in there, we were in there last week, and a Safeway worker was being assaulted. They are under siege in the stores in our neighborhoods. I don't have time to get to all of my testimony, but you can read it. But I will leave you with this. It is imperative that we make some changes. It is imperative that we stop pointing fingers at each other. It is imperative that we give the police the tools that they need. There's a thin line between, there should not be a thin line between killing Black and brown people and allowing the police to effectively do their jobs. We can come up with all kinds of solutions in this city. We can fix this. We can't fix this because we should not be living like this. Please pass this bill, this amendment. Thank you.
Thank you so much, Ms. Lockett, and thank you for sharing your experience and that of your family. Sandra Basanti, DC Nightlife Council.
Good afternoon, Chairperson Pinto and distinguished council members. As a Ward 5 resident, Ward 6 business owner, and the executive director of DC Nightlife Council, I welcome all ideas surrounding crime prevention and reduction and support elements of Mayor Bowser's Act Now bill as it pertains to our local economy, commercial areas, and small businesses, with the stipulation that modifications and careful attention are given to bring about sustainable and meaningful improvements. Businesses endorse and advocate for laws that empower MPD to serve and safeguard our community decisively while also maintaining transparency to foster public confidence. The alarming increase in crime in 2023, evidenced by 250 homicides, nearly 1,000 reported carjackings, and almost twice the violent crimes reported last year, poses a severe threat to local businesses and our local economy. Several established businesses cite escalating crime as a primary reason for recently closing their doors and leaving the district. As a small business owner on H Street Northeast for the past 14 years, I've watched the majority of the remaining businesses on my block close this year. Crime at any level directly impacts the safety and perception of our neighborhoods. When people feel unsafe, they are less likely to visit and spend time in areas where our businesses operate. This reduced foot traffic and patronage has been devastating to our local businesses who have struggled to recover pre-pandemic levels. The nightlife and restaurant sector in DC is a significant contributor to the city's economy and cultural appeal. And these venues provide jobs and create vibrant, dynamic neighborhoods that attract tourists and retain residents. However, the current crime wave undermines this appeal, deterring potential visitors and new businesses and compelling longtime residents to reconsider their living choices. This bill does not address the lack of prosecution for over half of the criminal arrests in DC in fiscal year 2023, which sends a concerning message affecting the confidence of visitors, business owners, employees, and patrons alike. If people do not feel safe coming to our city or venues to work or enjoy their time, the very fabric of what makes DC a desirable place to live and visit is threatened. This bill takes steps towards addressing organized retail theft and open-air drug markets. However, a more comprehensive approach is needed, particularly when dealing with meaningful community engagement and investment, stolen goods markets, persistent reported issues around loitering and repeated burglaries, forcing businesses to keep cash on their premises, and finally allowing local business operators a seat at the table when developing effective community-based legislation. As others have mentioned, a 5-day limit for MPD to declare a drug-free zone isn't going to cut it. It's essential for MPD to have the authority to permanently disband chronic loitering hotspots as reported by the community. The framework for devising solutions around consequences and deterrence must accurately address the actual effects on our businesses and the broader community. We don't just have a crime problem, we are dealing with a serious perception problem. The perception that DC is lost, that we have become lawless, and criminals can continue playing catch and release with MPD. And let's not limit the enforcement to just MPD. Let's make it easier to call in federal agencies like ATF, activate Metro Police, and bring in private agencies and organizations for a collaborative effort that can only strengthen our immediate response. We're not just talking policy here, we're talking about the future of our local economy and the preservation of our neighborhoods and local businesses. Act Now represents a first step towards developing immediate, tangible solutions to DC's crime crisis. Thank you.
Thank you, Ms. Basanti. Krishna Maturi, Minnesota Avenue Civic Organization.
Thank you, Chairperson Pinto and esteemed council members on this committee specifically. And I was also happy to see our council member, Karen White, earlier being part of the conversation. I, along with my fellow citizens here around where I live, we are in a tough spot. We live on Minnesota Avenue, and my civic organization consists of about 20 people. and Minnesota and 19th Southeast. And I've had my car slashed and damaged on 2 separate occasions, and a house yard set on fire, and a mentally ill person defecating on my front door. And we called police in all of those occasions, and along with EMS, they've been able to address the issue in a sane and humane manner without any violence or provocation. But today I'm representing my association. I'm speaking on behalf of my neighbor who's been here for 3 generations, possibly more, who is unable to sit in his front porch anymore because of the threat of violence. I'm speaking on behalf of a 40-year-old neighbor, or rather a neighbor who has lived here 40 years, who shared with us in our monthly meetings that he's unable to go on walks around the neighborhood where they used to because of the threat of violence. So I'm speaking on behalf of another old gentleman who are just significantly worried about the situation that has deteriorated in the past 20, 30 years. So I am in support of the bill. So are my 20 people in the organization. Specifically, I would like to talk about the safe zones. We witness drug activity, drug addiction, as well as drug exchanges all the time. And we have videos that are capturing that. And people who are dealing drugs and users using bus stops to conduct their activities. And not only they are breeding sort of criminal activities, but they're also dissuading folks to use public services and bus stops. So my last point I would like to end this with is, if we can empower the police and the city agencies to take care and make the public spaces safe, we, on behalf of the citizens, and we as citizens, are able to and feel empowered to take care of the private spaces and also the individual residential streets. So in support of the bill, this doesn't address everything, but it is a start. So yes, thank you.
Thank you very much, Mr. Maturi. Kimberly Lockett, the Petworth Action Committee.
Yes, and let me apologize for getting emotional. I've been here my entire life and I've never felt like this, so I'm sorry about that.
You know what? Do not apologize at all. I'm sorry, my order got a little messed up. So we will come back to you. We've got a few more folks on this
Thank you.
panel. Lisa Queen, public witness. Lisa Queen, are you still here? Okay, Commissioner Kathy Henderson, 5D06.
Good afternoon, Councilmember Pinto. I want to begin
Hello,
by.
I'm here. I'm sorry. I'm here. I'll wait.
Do you want me to continue?
I'm sorry, who was that?
That was Miss Queen. Yes, I do want her to continue. I'm sorry.
Okay, thank you, Miss Queen. Commissioner, we can hear from you and then we'll come back to you, Lisa Queen.
So
Commissioner Henderson.
I would respectfully request the resetting of my time for my full time. And I begin by just saying, thank Commissioner Kathy Henderson, 5D06. And I'm also here on behalf of 5D Court Watch. I thank you, Councilmember Pinto, for all of your hard work and your leadership in helping to move the council closer to work that supports the mayor's administration to help fight crime. We're in crisis. I'm here in support of the bill. I think it provides a broad framework of support. And to Ms. Lockett, please don't be emotional about what the majority of citizens are feeling and expressing throughout this city. We're in a crisis, and we need to give our police chief all of the tools necessary to protect public safety. I just want to make a few quick points within the time frame that I have. Certainly, not allowing organized retail theft is a common sense approach. We also need to make sure that the language is written broadly enough so that we don't have issues with the U.S. Attorney's Office. And we also need to include people who are at the neighborhood level. We're not talking about crime bosses. We're talking about individuals at the neighborhood level who collaborate and then decide to go and rob businesses within the area in which they reside. Then, once they've had a number of successful opportunities in robbing and disrupting their area businesses, then they move on to businesses in other wards. That has to stop, and we need to hold people accountable. Just regarding the body-worn camera issue, if we're going to allow officers to view the body-worn cameras before they write their statements, that's fine. I just want to make sure that there's complete transparency, that the public narrative matches the internal narrative, and that we need to find a way to make sure that the public can have access to this information timely. We also want to continue to work on accountability. We don't want the scales to tip so far in one direction that we are not continuing to focus on the excellent training that we provide our officers, the excellent officers that we do have, and for those officers that may act outside of MPD's general orders. So we want the chief to have the tools that she needs to protect us. Regarding the drug-free zones, it's a common sense practice that we need. I would respectfully ask that we consider expanding that to bus stops. We have individuals that come from all over. They don't live in the community. They use bus stops as opportunities to operate mini offices where they plug in their phones, they drink, they drug, they sell. That has to stop. There have to be penalties for that too. Expand the drug-free zones to include businesses that give businesses the opportunity to request a drug-free zone. Typically, most ANCs have the opportunity to respond to requests for liquor license renewals. So I'm focusing on liquor stores. And we always see instances where we hold the businesses accountable for all the loitering, the illegal activity that takes place outside. And what I have found over my many years of serving as an effective commissioner in the city is that some businesses are negligent and could do more. But the majority of businesses are being held captive. They're being held hostage by people that they do not want to disrupt their businesses. So you have throngs of disorderly people that converge on these businesses, and it expands. We have convenience stores. We have the Walmart that was put out of business. We have, you heard Anwar Salim talk about what happens on 8th and H, which is a nightmare on any given day. Throngs and throngs of disorderly people selling drugs, drinking alcohol, committing crimes with seeming impunity. That has to stop. That has to stop. And I continue to call on the mayor, the council, and our congresswoman to work together to activate the National Guard. We could easily have the National Guard to come in and help to promote the drug-free zones throughout the city. Their motto is, "We're here to help." Let them help. Activate all of the 38 other law enforcement agencies in the District of Columbia to help out, particularly the Uniform Division of the Secret Service.
Commissioner?
Well, I will summarize. And also, when we're continuing to have these conversations, let's look at child and family services. Let's look at, child protective services and their protocols. Juveniles don't just pop up one day and commit crimes. There's a pattern and practice
Commissioner?
of neglect that we need to address.
Thank you. Thank you very much for your testimony. Caitlin Peter Ayoba. Ms. Peters, you're on mute still.
Hello?
Yeah, we can hear you now.
Okay. Good afternoon, Councilmember Pinto and Councilmember Nadeau. I believe that you are the council members that I see in front of me. My name is Catalin Peter. I am the Vice President of Government Affairs for the Apartment and Office Building Association of Metropolitan Washington. AOBA was founded here 50 years ago, and within its borders, our membership represents around 108,000 apartment units and more than 76.6 million square feet of commercial office space. We are invested in the long-term viability of our city, and we believe that we have a lot of work to do over the next 15 years. On behalf of both of our residential members and our commercial members, Councilmember Pinto, thank you for taking on the Herculean efforts that you are doing at today's hearing and at the hearing the other week. Other council members who are supporting you in working through all of the issues that have been discussed today, you have our full support and our hats off in any which way that our membership can be helpful to you in providing you additional information from our residential members who have dealt with resident safety issues and employee safety issues, who have not known what to do or where to turn, as well as our commercial members who are seeing consistent declines in terms of their office tenants coming back into the workplace, or having their security officials have to deal with frontline situations in terms of violence that they're not currently prepared for. We know that both of the bills that are in front of us, the acronyms are very appropriate. We thank Councilmember Pinto for what we believe is going to be a hopefully singular piece of legislation, in addition to what has been put forth by the mayor. We think that you can work out the details in this. What I'm really trying to get at is we support moving forward in terms of improving where we're at today. We do not know the perfect answers, but we're here to give you, and what we're here to follow up and provide additional information on is some of the specific examples. And hopefully within these bills, we can find additional tools that we can help the city with in terms of being better ambassadors and in terms of improving communication. So again, with regards to Mayor Bowser's proposal, thank you for hearing us, for listening to us, and for being proactive and for putting forward this piece of legislation today. I know you have a long list, so we're here to help in any which way we can and to be a resource. Thank you.
Thank you so much, Ms. Peter. Lisa Queen, public witness.
Good afternoon, everybody. Thank you for the opportunity to testify today. So the first thing that I did want to say, and trigger warning or whatever, I do want to discuss the mayor, who is quite capable of playing both sides of Washington, D.C. So she'll jump from one side to homeless affairs, and then she'll jump to one side to businesses who pay minimum wage. They're bringing millions of dollars, a year. And so she'll jump from side to side. I do agree that there is, and it's not about being agreeing that there is a crime epidemic, but we all know, and I don't really want to stay on myself. We all know who those people are. It's Black youth. You might not want to say it, but that's what's going on. But what I see as a victim of crime myself, who actually ended up getting locked up, was that the actual police officers are not taking reports. They come a lot, and actually they won't take a lot of reports. Or if it's what they if it's an assault, they won't take a report, or they'll either take a report and the detectives won't call you back. Now that depends on what neighborhood you live in too. It depends on if you're Black or not. It depends on if you're poor or rich. So I see it as you know, a lot of times these people who don't want to be violent, that these people have to actually take on their own situations when they shouldn't have to, because the police are not, and I challenge anybody before Pamela Smith gets on here and starts lying about what she's doing and what she's not doing, because I know she's preparing to tell her lies. I actually called who was her name? Morgan Kane, who's a patrol officer over the 2nd District. I'm a Ward 3 resident, and they have a building here, 4,000 mass. It has a lot of assaults going on. This is not an area where a lot of assaults go on, but when you have people with subsidies, it tends to be that way when they are allowed to come and whatever and I'm not judging, but I'm sorry, it's my phone. I'm sorry. That's what tends to happen. So I would say that whoever Morgan Kane is, I tried to make like a report as far as police misconduct with them, with the assault. They have yet to even try to, no detective has called me. They have yet to try to even get a warrant for the assault that happened to me. It's been over a month. So I would say that what you think it is, there's a large part has to do with MPD. And I wanted to say that where do you think these MPD officers are coming from? They're coming from the same neighborhoods that you all are complaining about. They're coming from Ward 5, Ward 7, Ward 8, and they're definitely not coming from Wards 2 and 3. So when you think about that, think about the kind of officers. Don't rush to get a whole lot of officers in, because that's the neighborhoods where they're coming from. Okay, or from Prince George's County. And so we have the type of police officers that we have now I can see the definite change in the professionalism and them wanting to close cases. They're not closing cases. They're not closing cases, and they're doing it at their leisure. So they close cases with what people that have money, and then don't close cases with people that do have money. And they close those cases. So
Ms. Queen, you're over time. If I can ask you to wrap up.
Okay. So I'm going to wrap up. Before I'm going to ask before Miss Pamela Smith gets on here and starts lying, that she needs to contact her the person I just mentioned, who is a patrol officer over the 2nd District. And so that when people do want to complain about misconduct from officers, they lie even with their body cameras on. So I would hate to see them having to look at their body cameras, and they do it on a regular basis. So I'm not against police. I love police, but this police conduct stuff, they're just too comfortable. And second of all, they're not closing cases. Thank you so much. I'll answer any questions. Thank you.
Great. Thank you very much, Ms. Queen. Kelvin Brown, Commissioner for ANC 7B. 06.
Thank you so much, and good evening and greetings, season greetings to everyone on the call today. Thank you very much, Councilmember Pinto and other council members, for holding today's hearing on this very important matter. My name is Kelvin Brown. I'm an U.S. Army veteran, former police officer, former high school educator, current housing executive, ANC commissioner, and I have the privilege of chairing ANC 7B. Today, we stand at a crossroad where our lives literally hang in the balance. And important decisions before this committee on whether to continue to offer innovative solutions to protect our residents and their possessions or not. Crime and criminal mischief are up across the District of Columbia as a whole. Violent crime is at an all-time high, and residents east of the river, specifically in ANC 7B, continue to feel both physically and psychologically unsafe. There have been a number of incidents ranging from armed carjackings to homicides being experienced by my neighbors on a continuous basis. Our residents are fearful to go about their daily lives in fear of being victim of violence and become another statistic. Something, better yet, everything has to change about how we deal with crime in the city. This change is needed immediately, not only across ANC 7B, but across Ward 7 as a whole. However, we have to be very thoughtful and approach public safety from a holistic perspective and address not only the symptoms of crime, but also its impact on our communities. This includes addressing the root causes for why people commit crimes versus choosing a more socially acceptable way to engage in our community. The Metropolitan Police Department is only one entity within the criminal justice system, and the solution for crime requires an all of the above approach. This approach includes more resources for violence interruption organizations that have shown a positive results in our communities, more opportunities for our youth, access to safe, affordable housing, access to healthcare for professionals and community-based institutions and other organizations. Crime and inequity are byproducts and first cousins of one another. The proposed Addressing Crimes Trend Act Now Amendment of 2023 makes positive steps towards addressing the symptoms of crime, but do not target the root causes of why people commit crimes, nor address the proactive ways to mitigate criminality. So specifically, I support the following: equipping the Metropolitan Police Department with the necessary tools to proactively do their jobs efficiently and safely. For example, implementation and enforcement of loitering laws where constitutional, increasing transparency and reporting to ensure compliance, allowing the Metropolitan Police Department on a limited basis to engage in responsible vehicle pursuits where the lack of apprehension would cause greater public threat or harm to life, establishing a new crime-directed legislation around directed organized retail theft. Information related to the use of force incidents should be public information and available upon request. Next, officers should receive adequate training on report writing, and any inaccuracies should be noted to ensure that there aren't inconsistencies in reporting. Officers should continue to announce that they are recording via their officer body-worn cameras. The use of technology such as spot shot or blue light technologies, license plate readers, and other innovations can help law enforcement and act as a deterrence.
Commissioner?
Specifically, yes.
You're a bit over time. If I can ask you to wrap up, please.
Absolutely. Specifically, I do not support the following: allowing MPD to view their body-worn cameras prior to writing their reports, and also the use of negligent restraints. So I close by saying we have to balance our approach in equity, hold offenders accountable, and offer opportunities for our community, including our youth to advance and thrive. I'm available and open to all questions that you might have. And thank you very much for holding today's hearing. And I look forward to your continued support and engagement in our community.
Thank you, Commissioner. And thank you all on this panel for your testimony. I'm just making sure I didn't miss anybody on here. I'm going to turn to you, Councilmember Nadeau, for any questions that you may have for this panel.
Thank you, Madam Chair. I actually don't have questions for this panel. I really enjoyed the testimony and appreciated everybody's insights, and I look forward to hearing how you'll incorporate them as you continue your work on this bill. Thank you.
Thank you very much, Councilmember Nadeau. I want to ask you, Commissioner Henderson, about the drug-free zones in particular, and if you have any views on, sorry, here's some background noise. I don't know if that's on you. Screen
yes,
or
I just muted myself.
Okay. About we're having a conversation on an earlier panel of what could happen if activity was disrupted in one area, but then just moved across the street or another street, disrupting another area and potentially a more residential area. And curious your perspective, as I know the S&D that you represent has dealt with these challenges for many years.
Yes, and thank you so much for the question, Council Member. That when our officers lawfully give a command to disrupt behavior that our citizens are fearful of and complaining about, and the participants move to another area, that's an example of brazen lawlessness. Instead of redirecting their perspectives and going back to where they live, which is often not in the community where they are, or not even in the city as a whole, They simply move because they are defiant. There should be increased penalties when an officer has to tell you, or officers, or there are multiple calls for service for the same issue, and all these individuals do is move. That should be, there should be increased penalties for that, because that type of brazen behavior is unacceptable. And I don't even know of any jurors, any of our neighbors in Maryland or Virginia that allow that foolishness. I don't know of any neighborhood where I can sit in a lawn chair, bring out a grill and alcoholic beverages, sit there and block the sidewalks all day, or to sit in front of a business and sell socks and umbrellas and then get up and go back to their home in Maryland. That's just absurd. We have to make sure that we give the police chief the tools that she and her team can use to help protect us. And these behaviors are not simply isolated to my community. You're hearing that these types of aberrant behaviors are happening across the city. And I maintain that we're in crisis and we need to stop it. So I think that this legislative framework that is before you, expand that to include those language. And I can certainly make some recommendations about that language and provide that to your office about how we can address people that move from one spot to another when you challenge their unlawful activities. And again, thank you for the question.
Thank you very much. Ms. Basanti, if you're still here.
I am. Hi.
Hi. Great. I want to ask you about theft in our hospitality and nightlife establishments, because oftentimes when we're thinking about, or the way that the statute proposal is drafted around organized retail theft, we're talking about cases where an individual goes into a 7-Eleven, CVS, Walmart, and takes all the items off the shelves. And that's what we're seeing in all of news reports around. But as we think about thefts that are happening from our nightlife establishments, can you speak to what some of your members are experiencing, either with, liquor thefts or other break-ins, as we think about how to ensure that this proposal and others before the committee are most effective at addressing the challenges that we're seeing in our communities? I think the hospitality community is experiencing a somewhat unique set of challenges. Want to make sure that those solutions are targeted.
Sure. Ultimately, there's a couple of things that are maybe somewhat more unique to the hospitality world. One is this requirement of businesses carrying cash is becoming an issue. A lot of businesses would prefer to go cashless. There have been so many break-ins just to steal a register or POS system that could be avoided. The law that was written and passed was 5 years old and was just passed this year. But since then, there's been so many advances to different ways of payment digitally, since obviously with the pandemic and everything like that. So that's one thing to consider. Another thing is when we see, especially, I'm using A Street as an example, when we see multiple businesses getting hit, burglarized every day, and in our instance and in other neighborhoods, it's turned out to be the same case based on my conversations with MPD. It was the same person or the same 2 or 3 people. And even though we were able to identify them and locate them, MPD wasn't able to arrest them. And in fact, one person who broke in, who finally got caught in the act of breaking into Maquetto, was then released a few days later and immediately went and broke into Maquetto again as soon as he was released. So there is an issue here of being able to prosecute, as we all know. And again, it seems to be these repeat offenders, and MPD is doing what they can to arrest them, but then what happens after that?
Thank you so much. I appreciate you raising those examples. And is definitely part of our thinking about addressing some of these gaps that we're seeing, especially over and over with repeat incidents of crime in the same location, which can be especially traumatizing. And I know we see this in residential spaces as well, Ms. Peters. So thank you for your continued work there. And we will keep that in mind as we think about how to ensure that you all have the tools you need to keep your members safe too.
Repeat, we heard exactly what was just expressed by Ms. Basante is repeat. We've been hearing that something happens and the same person, they're back on the property, whether it's in their unit, in their residential unit, and you have the residents who are then seeing them the next day and said, what happened? I thought someone got involved, and they're back on the floor or they're back here. And so, like you said, it's like a trauma, and then you're hit with it again, and you see it again, and you're constantly faced with it. So I think particularly for our residential our residential tenants, it hits very hard.
Thank you. I'm not sure if you heard my last part, but I was thanking you all for coming today and sharing your perspective. We really appreciate it. That concludes our virtual public witnesses today. We have 2 more in-person public witnesses that we are going to hear from. Michael Syndrome, public witness, to the table, and Ebony Rose Thompson, is the Ward 7 representative of the State Board of Education and the president of the State Board of Education. And thank you both for joining us. If you can come to the table, we will hear your testimony. And then for those following along, after we're finished with public witness testimony, we're going to recess for about 15-20 minutes. And then we will hear from our government witnesses this afternoon. Welcome to you both. Thank you. Yep, Miss Thompson, you can start.
Greetings, esteemed council members. First, I'd like to thank the committee for its flexibility because this is my second testimony today, so I missed my initial slot. My name is Ebony Rose Thompson, and I have the privilege of representing Ward 7 on the DC State Board of Education and serving as the board's president. I'm testifying today in my personal capacity. Thank you for providing me with the opportunity to speak today regarding the Addressing Crime Trends Act Now, Amendment Act of 2023. I approach this issue not only as a concerned resident, but also as someone whose family has recently experienced the harsh reality of crime. This month, my aunt, a retired teacher who has been in her home over 30 years, the same home, became a victim of a break-in while she was peacefully asleep. Someone climbed through her window in her kitchen, walked upstairs into her bedroom where she was sleeping, found and went through her purse, took her cash and keys. She absolutely felt violated. I feel deeply the urgency of adopting a comprehensive, smart on crime strategy that prioritizes both prevention and responsible responses. First, I ask that we consider the importance of a holistic prevention approach. Investing in programs that tackle the root causes of crime, such as poverty, mental health, and addiction, can significantly reduce the occurrence of criminal activities. While a chokehold would not have prevented my aunt's experiences, it is likely a truly preventative approach would have. The person who broke into her house took only one thing, really, money. They used the keys to leave through the front door, and they rifled through her car, but ultimately left the vehicle. This sounds like someone who was in desperate need. Addressing underlying causes is critical for creating a safer community for all. Now, let's address the proposed changes to transparency regarding MPD discipline and police complaints. Full transparency is not only a fundamental aspect of accountability, but also crucial for fostering unbiased policing. Rolling back on transparency measures may compromise public trust and negatively impact public safety. We must strive for a system where accountability and transparency go hand in hand, ensuring the community's confidence in the police force. Another key element of the bill that deserves our attention is the reintroduction of drug-free zones. While these zones were intended to enhance public safety, I tell you, I am a child of the 90s in DC. And I remember what these zones both looked and felt like in our city. The previous implementation contributed to systemic inequalities. We must consider if the zones are targeted and effective rather than disproportionately impacting specific communities. Selling drugs is already illegal. A more nuanced approach and the recently declared opioid emergency will go further to improve the health and safety of our residents and help create a fair and just system. Secondly, the proposed changes to the prohibition on chokeholds, warrant careful consideration. While it is essential to prioritize the safety of law enforcement officers, unnecessary and dangerous altercations with police can have severe consequences. No documented incidents of officers being charged or disciplined for incidental contact with anyone's neck have been cited. We must structure a balance between ensuring officer safety and avoiding unnecessary risks that may endanger the lives of community members. Lastly, I urge the committee to take seriously the recommendations of the recent Police Commission. The insights and suggestions provided by the commission can serve as valuable guidance in shaping a more effective and responsive public safety framework. By incorporating these recommendations, we can foster collaboration between community and law enforcement, creating a system that is better equipped to meet the evolving needs of our city. In conclusion, as we deliberate on this proposed public safety bill, let us remain focused on smart on crime strategies that prioritize prevention, transparency, and reasonable responses. My aunt's experience was a poignant reminder of the real impact that crime has on individuals and families. And by working together, we can build a safer, more just community that benefits everyone. I thank you for your time, patience, because I know it has been a very long day, and consideration.
Thank you very much. Mr. Syndrome.
Good afternoon, Madam Chair. Good to see you again. Every time I see you, look younger and younger. I want to, Michael Syndrome, disabled veteran, served our country more than most. I want to echo the sentiments of Mr. Talib, who testified earlier. I think he gave some points and he honed in on the issue supportive of our youth. That's most important. There's a lot of money that's being good money thrown after bad. And it's time, all too often, government is reactive and not proactive. And so we need to, instead of getting to the topic, get to the root of the problem. For instance, if you have a mole and you scrape it off, right, it's gone for a minute. But unless and until you get to the heart of the matter and eradicate it totally from its root, it's going to keep coming back. And that's what we've seen here, echoing time and time again, of recidivism, which needs to be addressed. I also want to endorse Commissioner Kathy Henderson has made some valid points as well, that for the committee to take under close scrutiny, this operating movement, bus stop, and so on as a pretext. These are things, crime pays, and criminals know that. And eternal words of truth indicate, why do people commit crime so readily? Because crime is not punished quickly enough. We can have all the law in the books, and that comes from Ecclesiastes chapter 8, verse 11, actually. We can have all the law in the books, but unless and until it's vigorously enforced, we're going nowhere quick. And that's what we're seeing. Right now, everybody is up in arms. Crime is an uptick. Some would have us believe it is not, but indeed it is. And so we need, as again, Mr. Talib pointed out, supportive of our youth and to pour resources and funds to that end. In terms of prosecution, we know the district doesn't have an independent U.S. attorney. We are a enclave, sad but true, federal enclave. So there is a disconnect there. And these things have repeatedly reared their ugly head, and we need to find a solution to them, to address, this uptick criminal crime epidemic, if you will. We are in crisis, and people ought not be afraid to be on their porch. They ought not be in their domicile and somebody just strolls in and steals and threatens and harasses. It's been said, stay DC. Well, who would want to stay here when this foolishness is going on? So I applaud your efforts. You had a hearing previously, and I might add, I never did get a copy of the hearing, copy of the proposed law. So I'm at a loss, and I want to make mention too. It was a challenge getting down here today, and not only a challenge on public transit, but getting into the building, which ought not be. This is not my first rodeo. I've been here many. I've seen them come and I've seen them go, Madam Chair, and I hope you stay for a while. In any event, the gouge downstairs, woefully lacking training, and that's indicative of what a root problem is: lack of training. That ought not be. And I had, like pulling teeth, a nightmare just to get into the building. I have a bag here because I am on crutches, rifling through it, clearly illegal search and seizure. And when we want to task you and the council to rewrite a constitution, that ought not be. There are safeguards put in place. And if the police do what they're supposed to do, that's a disconnect too, which they don't. Things would move more effectively and expeditiously. Office of Police complaints too, there's a disconnect. And I want to put a plug in as well for Veterans Court. And I'm going to wrap up with, it is the veteran. Veterans Court, please, take that. We have courts. We need one tailor suited to our veterans, all right? It is the veteran, not the preacher, who has given us freedom of religion. It is the veteran, not reporter, who has given us freedom of the press. It is a veteran, not poet, who has given us freedom of speech. It is a veteran, not campus organizer, who has given us freedom to assemble. It is a veteran, not lawyer, or was it liar? A lawyer, who has given us right to a fair trial. It is a veteran, not politician, who has given us the right to vote. The veteran who salutes the flag, who serves under the flag. God bless America and our troops. And I'll be delighted to field any questions that you may have or the committee has.
Great. Well, thank you both very much. And Mr. Syndrome, we'd be happy to work with you to get you a copy of whichever law you're referring to, if you want the act now, or if you are referencing the Active Amendment Act when you testified last. So we'd be happy to work
Both.
with you and figure out what you need. And I'm sorry to hear about your difficulty getting in the building. It's certainly something we continue to work on in this building to make sure it's accessible, and that everybody is met with dignity, and that it's also safe. And that is part of the challenge around kind of increased security around the building, to ensure that there are not weapons or bad actors coming in. I certainly know you are not one. But that is part of the added conversation around how we can make improvements to the building and make sure it's truly the people's building, and be as accessible and safe as possible. So thank you for raising that, and we'll keep following up with them.
One of the best prognosticators of violence, if you have it in your background, I have none. I've never raised my hand to anybody in this building. I've never cursed nobody out, which some really need to find employment elsewhere. But the bottom line is that when you don't like somebody, you make life hell. And that's what's going on. And oftentimes where you sit, your colleagues don't like what I have to say, or anybody else. It's a constitutionally guaranteed right, per preferred amendment. Not only what I have to say, but my constitution guaranteed right to say it, whether you agree or disagree. Reasonable folk, 9 of them, on the Marble Palace, right? They don't all see eye to eye. So we're not going, we can agree to disagree without being disagreeable, but not to belabor the point. And I invite you to see the camera, the video, everything else. These guards that have been here for the longest, they need to go. They need to go and they need to clean up their act. And there has to be better, more experienced professional oversight because there is none. And when the cat's away, the mice will play, and they are indeed playing, as indicative of just about everybody who's testified here today.
Well, thank you for raising that concern. I certainly appreciate and am very grateful to our hardworking security staff around the building. And if there are specific concerns that you have seen, we can certainly follow up with you another time as well to figure out if something needs to be reported and if additional training or otherwise needs to happen. So thank you.
There's one final thing, Madam Chair, if I
Mr.
may.
Singer, I am going to have to move on.
The Commission on Judicial Disabilities and Tenure seems to be defunct, and the judiciary oversees all of this. And you call or whatnot, they're unresponsive. Do they still exist?
They do still exist. They're recently fully staffed up. So hopefully that should be resolved soon. But I think, as I mentioned to you last time, we have added that to our performance oversight kind of considerations as we go through to make sure that people can get responses. So thank you. Ms. Thompson, thank you so much for being here and your testimony. I know you're testifying in your personal capacity, and for sharing the experience of what happened to your aunt. I'm so sorry that that happened to her, and it sounds extremely traumatizing. You mentioned a couple things that were interesting, but around the need to focus more on prevention. And I do not disagree with you. I think that is where we do need to focus on. Admittedly, the bill that we are talking about today is more on the response side. And so I don't think that there's disagreement around what's also needed. But as we think about when prevention fails, or the city has failed, or we haven't gotten to someone on time, or somebody has denied services or isn't interested in that, there's a whole array of reasons that we could have missed somebody. And crime does occur, and we have to respond. What do we do next? And I know you mentioned, a chokehold wouldn't have prevented it. And chokeholds are banned in the city. They have been banned for a very long time. They would be continued to be banned under this proposal. But this is a little bit specific, but just because you mentioned the chokehold piece, an example was raised earlier by one of my colleagues of an individual who may be in crisis, is called for an arrest. I think in this specific case, her mother called the police to come help. And the police came, and the young woman was resisting arrest and was banging her head against the wall. And the police officer put his hand on the back of her head like this to prevent her from knocking herself out. That was considered a violation of the policy. And so I think that example is too far, but chokeholds are not acceptable. And so as we try to grapple with the majority of these cases that are somewhere in the middle, do you have any thoughts on, once we have to respond and we need to do so in a fair and thoughtful way, on how the committee should be thinking about that balance?
Yes, I actually do. I mean, I have had the unfortunate experience of seeing and being party to actually more than one mental health crisis. So I totally understand and appreciate not just like the intensity of those situations, but the training that needs to happen for people to be able to respond and the nuance necessary, both to make sure the person who is in crisis is safe and the responder is safe. I think one person who I would look to, and I believe actually served on the police commission, and this is one of the reasons I said it would be responsible for us to go back to the recommendations from the police commission, is actually Ron Hampton. He's a Ward 4 resident. He is a former police officer. I believe I've actually gotten to know him through education circles, but he was quoted, I think in a DCS article recently, where he talked about his experience in responding to the situations you're talking about and like what was necessary, what would cause him to hesitate, which he said, in many cases like this, what we are describing here would not have been helpful to him. And so I would look back. This is why I said go back to those recommendations, because I totally appreciate the need to react responsibly, to keep people safe, right? I don't believe in magical worlds where crime doesn't exist. I just told you about an instance with my own family. But I think the question I'm asking myself is, what do we need to do to reduce the frequency that crime occurs? And when crime does occur, are the reactions that we are recommending, do they actually have the responses we want? So that is, I think, and I'm happy to send and pull exactly what he said, to send it to you, because I also have to upload my testimony. But I thought his advice as someone who was a former police officer here in the district for many, many years and still lives here and is invested here was helpful guidance.
Thank you very much. Appreciate that. Councilmember Nadeau, do you have any questions for this panel?
No, ma'am.
All right. Well, thank you both very much. Appreciate you being
I want
here.
to thank you, Madam Chair, for your indulgence, and I want to renew my request. I haven't gotten the hearing dates, upcoming hard copy, and also of the council staffers and council staff members. You may recall last go around, I asked for that, and it still hasn't happened. So I would appreciate if you give a gentle nudge, because word on the street is when you say jump, people say how high, and make it happen. So you should have my address. If not, I can give it offline.
Do you want a list of our committee staff or of
The whole 9
entire
yards,
council
everything.
staff?
Previously, I got it, but all of a sudden, everybody's digital, and I happen to be cybernetically challenged, as are a number, of us that want to participate and be informed, but we are not. So I'm renewing my request once again, respectfully.
Okay, great. Can we take a note of all those requests, and we'll make sure to get the information to
Thank
Mr.
you.
Syndrome. Okay. Thank you. Thank you both. Thank you to all of
Have a good
our
Gandhi day.
many, many public witnesses today. We hear you, appreciate your perspective. I think how much interest and involvement there was is really indicative of how important these issues are and how much solutions are in people's minds. So thank you all. We are going to take a short recess. It's 4:27. Let's try to reconvene by 4:45 for our government witnesses. And the time is now 4:27 and we are recessed. Good evening, everyone. Welcome back. The time is now 4:56 p.m. on Wednesday, November 29th. We are reconvening this hearing on Bill 25-555, the Addressing Crime Trends or Act Now Amendment Act of 2023. I want to thank our many public witnesses who came to testify today, both in person and virtually, to share your perspective on what is clearly the priority for district residents across the city right now around public safety. And I really appreciate the many thoughts and observations around specific provisions in this bill under consideration, and also a larger scale approach to interventions that need to happen in the district. So we are now turning to our government witnesses who are here with us today. Thank you all for joining us. We have Pamela Smith, the Chief of the Metropolitan Police Department. And Chief Smith is also joined by our Deputy Mayor, Lindsay Appiah, as the Deputy Mayor for Public Safety and Justice. We have Michael Tobin, the Executive Director of the Office of Police Complaints, who is joining us online remotely. Katya Seminova, Special Counsel for Policy and Legislation at the Public Defender Service for the District of Columbia, and Janu Park, the Executive Director of the Criminal Code Reform Commission. I was going to invite you all to the table, but you are already here. Thank you very much for being here. As you know, it's the tradition to swear in all government witnesses who appear before it. So if I can ask you all to raise your right hand. Do you swear or affirm under penalty of law that the testimony you are about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
I do.
Thank you all. You may take a seat. I'd now like to invite all of you to make any opening statement you may have, and we will start with Chief Smith from the Metropolitan Police Department.
Good evening, Chairperson Pinto, members and staff of the committee, other council members, and everyone in our great city of the District of Columbia watching us today. I am Pamela Smith, Chief of the Metropolitan Police Department, and I am here with Lindsay Appiah, Deputy Mayor for Public Safety and Justice, to discuss Mayor Bowser's proposed legislation, the Addressing Crime Trends Now Amendment Act, or Act Now. I would like to thank Chairperson Pinto for so quickly scheduling this hearing. It is critical that we continue the work that has been done so far this year to try to ensure that DC has the laws and tools to best address the most significant public safety issues we are facing: illegal guns and the increasing of those of them who use it in DC, and the historically low sworn staffing levels at MPD. Violent crime, largely driven by people using illegal guns, has been growing since March of 2023, when the number of robberies and carjackings suddenly spiked. The increase peaked in June with more than twice as many robberies and 3 times as many carjackings reported than in June 2022. Mayor Bowser and the administration reacted quickly with the introduction of the Safer, Stronger Amendment Act in May. Chair Pinto picked up the baton, holding a hearing on the legislation in June and in July, proposing and shepherding through council the Prioritizing Public Safety Emergency Amendment Act to immediately address some targeted legislative needs. This momentum has continued with Chair Pinto's active legislation and now Mayor Bowser's Act Now proposal. The forward momentum on policy and legislation is critical. Crime is still higher when compared to the same period in 2022. It is going to take some time to reverse the sharp rise in crime beginning this past March. However, since mid-July, when I was appointed and the emergency legislation was enacted, we are seeing promising trends. Carjackings are down 7%, assault with a dangerous weapon is down 6%, and vehicle theft is down 11%. Overall index violent crime is down 3 crimes, and robbery is up 14 crimes over the prior period in 2023. The second major public safety challenge we are facing is the lowest sworn staffing level in 5 decades. As of November 22nd, we have 3,339 sworn members. This is 460 fewer members than just 3 years ago. To put that in perspective, at that time, there was an average of 342 sworn members in each police district. In just 3 years, we have lost staffing for 1 1/3 police districts. However, there is reason for optimism. Our recruit classes are slowly growing. The classes for August, September, and October were the largest in more than a year. And attrition was lower in FY23 than originally projected, with decreases in both resignations and retirements. Nevertheless, there was a net loss of 123 sworn members in FY23. The many steps that the administration has taken to address violent crime and police staffing have been discussed at our other hearings this year. So I will only focus on the new tools in Act Now. To begin with, Act Now proposes changes in 3 criminal charges to help address emerging crime trends and reduce crime. First, residents have valid concerns about public spaces with persistent drug distribution and the disorder and other crimes that accompany it. Addressing open air drug markets through enforcement is challenging. Investigations take significant time and resources. There is less reliance on cash changing hands, making transactions harder to identify and track. And when arrests are made, the arrestees are often quickly back on the street or others quickly take their place. We need a new strategy, or maybe an old one, to help disrupt this criminal activity. For nearly 20 years, DC law authorized the chief to establish drug-free zones to interrupt illegal drug activity. We believe this can be an effective tool by authorizing police to disperse groups of people engaging in illegal activity in designated areas. Our goal is not to make a lot of arrests. Previously, under this, MPD apparently did not make many arrests for failure to disperse, but disrupting the illegal activity will allow time for communities to come together to reclaim their public space and potentially to work with other government and community partners to enhance it. As detailed in the legislation, MPD could establish a zone for up to 5 days when evidence and analysis indicate that drugs are being bought, sold, or used illegally and threaten the health and safety of our residents. MPD would post signs in the area notifying the public of the boundaries, the effective dates, and the prohibited behavior that is unlawful for 2 or more persons to congregate to illegally buy, sell, or use drugs, and to fail to disperse from the zone when warned by a police officer. Violating the dispersal order could result in an arrest, if convicted, a maximum penalty of 180 days. To highlight a few key points, the zone is limited to no more than 1,000 feet per size. Zones will be clearly marked with signs posted within and along its border. The law would not change the requirement for an officer to have reasonable, articulable suspicion before conducting a stop and to document it. Officers must consider the totality of the circumstances to determine if someone is congregating for the purpose of illegal drug activity, such as observing the exchange of money for small packages, information from a reliable source, or prior drug convictions. Officers must also consider whether someone has legitimate reasons for congregating, such as waiting for a bus or being near home. Some council members had concerns that this would be used to target people coming and going from drug treatment centers. Language certainly can be added to the legislation to include that as an example of legitimate activity. Finally, the OAG had previously testified on its concerns of the constitutionality of the prostitution-free zones, which was similar to the drug-free zones. We address this concern with language adding an intent to commit a drug crime. The OAG has certified this legally sufficient. In short, drug-free zones are a useful and constitutional tool to address drug-related crime on district streets and protect the public from the dangers often associated with the distribution of illegal drugs. Secondly, the administration hears the concerns of businesses and residents from across the city and all 8 wards about the damage from retail theft. Just last week, the Washington Post highlighted how retail theft is negatively affecting businesses on the H Street corridor. The prior week, Forbes Advisor released a national survey which estimated that the cost to business of retail theft in DC was estimated at $880 per resident. Act Now proposes new legal tools to help police and prosecutors address key trends in retail theft. Currently, first-degree theft, also called theft 1, requires that the value of the goods stolen exceed $1,000. Under Act Now, theft 1 could include the theft of 10 or more items having a value of $250 over a 30-day period. Committing an assault or intentionally destroying or damaging the property of a retail establishment would also qualify as theft 1. In addition, recruiting, directing, coercing individuals to commit organized retail theft would be a new crime. This would address individuals who are directing others to steal for them. This is critical to help break up criminal enterprises by getting to the top people. The proposed penalty of a maximum of 15 years is higher than the penalty for theft 1, which is maximum of 10 years, or for conspiracy to commit theft, which is a maximum of 5 years. It doesn't make sense that the people at the top of a criminal enterprise should be subject to a lower penalty than the people at the bottom. It's important to know that a maximum penalty of 10 years does not result in a sentence of 10 years. According to public data published by the Sentencing Commission, the average theft 1 sentence is 13 months confinement. Even for offenders with 2 or more prior convictions for theft 1, which has a maximum penalty of 15 years, the range under the voluntary sentencing guidelines is 14 to 32 months, part of which may be suspended. With sentences like this, it is clear why there is less deterrence from committing theft 2, which carries a maximum penalty of just 180 days. Our businesses need some relief, and this proposal can help the criminal justice system to address this problem. It should also be clear from this discussion why the council should take up the mayor's proposal in Safer Stronger to change the composition of the Sentencing Commission to include greater representation by people accountable to district residents. The final proposed change to the DC Criminal Code is to revive a section of the anti-mask law that was repealed in the summer of 2020. The repeal was perhaps an understandable reaction to the need for the public to wear masks during the pandemic to protect public health. However, wearing a mask for medical reasons is already protected. The law prohibited people over 16 years of age wearing a mask on public space for the purpose of committing crimes or violations, intimidating, threatening, or harassing other people, or recklessly causing a reasonable person to fear for their safety. MPD has charged this provision sparingly, only 15 times in the 30 months before its repeal. In 14 of the cases, the subject was also charged with other crimes. In the other case, officers were canvassing for someone who had committed multiple misdemeanor sex assaults. They were able to arrest a masked subject who was harassing a woman before he actually assaulted her. This last case highlights how this law can be an important investigative tool. Anecdotally, we are hearing from more residents and business and victims about people committing crimes such as robbery and retail theft while wearing masks. I have personally seen 4 individuals in a car all wearing full ski masks. If this law is revived, an officer may have reasonable articulable suspicion to stop someone wearing a mask, depending on the totality of the circumstances. For instance, wearing a mask in January when it is 20 degrees outside, or a costume with a mask on Halloween would not be unusual or unexpected. However, it could be reasonable for an officer to conduct an investigative stop of someone wearing a ski mask in July while hanging around a convenience store that has repeatedly been robbed. This is all of the more important now when retail theft and violent robberies and carjackings are plaguing businesses and residents in our city. We urge the council to revive this common sense law. In addition to these changes to the criminal code, Mayor Bowser, Deputy Mayor Pia, and I urge the council to consider the sections of Act Now that take a second look at some of the provisions of the 2022 policing and justice legislation. We recognize the importance of fair and constitutional policing, and MPD is continuously working to earn and strengthen the trust of our communities. DC has been a leader in systematic reform for decades, such as with the use of force and First Amendment assemblies. MPD has also long had one of the most restrictive policies and practices related to vehicle pursuits or using neck restraints. However, when it comes to matters of public safety, it is important that we be willing to assess our efforts and continue to adjust when appropriate. And the 2022 legislation merits review and revision in order to, number one, support public and officer safety, 2, allow otherwise strong criminal cases to move forward. And 3, ensure that MPD can recruit and retain the best police officers. I will explain in depth a few of the provisions and highlight others. We appreciate the council's passage this summer of emergency legislation to amend the prohibition of pursuits in the 2022 legislation. Since its passage, MPD has engaged in 13 pursuits, slightly lower than the prior average of 4 per month. None of these would have been permissible under the original law. The emergency language is more restrictive than our prior policy, but preserves the ability to pursue in some circumstances when the fleeing subject poses an imminent threat of death or serious bodily injury to another person. We urge the council to make this provision permanent. We also urge the council to repeal language that permits certain practices that MPD does not authorize, including caravanning and ramming. In future litigation, this law could be used to justify practices that we just prohibit. MPD also strongly supports the intent of the provision addressing neck restraints and asphyxiating restraints. For decades, MPD has required officers to avoid tactics that may impede a subject's ability to breathe or may result in chest or throat comprehensions, airway blockage, or positional asphyxia. Officers were also required to immediately seek medical attention if a person appeared to have difficulty breathing. However, the definitions in the 2022 legislation went much further and have caused what we believed are unintended consequences. The new law is rigid in its definitions, leaving officers with sustained use of force violations for contact with the back and side of the neck that is either incidental, lasting only moments before an officer realizes where their hand or arm is, or was intended to protect a subject, such as one officer who held the back of a neck of a subject who was banging their head against a brick wall. I have also seen officers hesitate when trying to control a combative subject. This hesitation, although understandable given the law, could have disastrous consequences for the officers or a member of the public, especially if the subject is armed. And the sustained uses of force have serious consequences as well, because cases with uses of force outside of law or policy may not be papered or prosecuted. In addition, in future cases, officers with sustained use of force violations may be portrayed negatively by defense counsel and lose credibility with the judge and or jury. Therefore, we urge the council to pass the proposed language clarifying that the prohibition on neck restraints applies to actions that restrict breathing or choke an individual, but not simply contact with the side or back of the neck during a physical struggle to bring an individual into custody. The much broader definition of asphyxiating restraints, which essentially applies to the whole torso, would be clarified to apply to actions where the purpose or intent is to severely restrict breathing. Otherwise, anytime a subject's breathing is severely restricted, which can happen, for instance, when someone runs from the police, an officer who has made contact with the subject's torso risks a sustained use of force violation. The legislation would continue to prohibit what the public thinks of as a chokehold or using an object or any body part with the purpose of severely restricting breathing. In addition, we recommend that this change be retroactive to the date the provisions were enacted so that MPD's Use of Force Review Board can review each case to determine whether the conduct is prohibited under the amended definition and expunge sustained violations permitted under the amended law. Body-worn camera videos. The administration once again urges the council to reconsider the prohibition on officers watching body-worn camera videos before writing reports for routine cases. By establishing what is essentially a random memory test for officers, this law needlessly jeopardizes the city's abilities to hold officers accountable at every step from arrest warrants to papering prosecutions. The credibility of officers can be impeached for any difference between the initial report, which has to be based solely on an officer's notes and memories, and the video. This prohibition is a departure from national best practice. Allowing officers review in most cases has the support of the Independent Police Executive Research Forum, which conducted extensive research supported by the U.S. Department of Justice to develop best practices around BWCs. As Perf notes, and I quote, "Real-time recording of the event is considered best evidence. It often provides a more accurate record than an officer's recollection, which can be affected by stress and other factors. Research into eyewitness testimony demonstrates that stressful situations with many distractions that are stressful are difficult even for trained observers to recall correctly, end quote. The current law provides a strong advantage to the defense, which was not the intent of DC's investments in the BWCs. Under Act Now, officers could not review BWC video before writing initial reports for incidents such as officer-involved death, a police shooting, and any use of force with an immediately apparent serious bodily injury. The U.S. Attorney's Office supports amending this provision. The council should pass this common sense revision. Lastly, several provisions in the 2022 law would result in MPD officers having fewer privacy rights than convicted criminals. Under district law, except in limited circumstances, MPD cannot release information about an individual's arrest or conviction record without the person's consent. I support holding officers accountable for misconduct up to and including termination. However, we must strive to balance enhanced accountability for officers while acknowledging that they have privacy and safety interests as well. In order to continue to attract and retain the best officers, we must ensure that there is equity in handling their routine performance of duty unless it is a serious violation of policy or law. To that end, Act Now would allow the faces of DC and federal employees to be redacted from BWC releases. The name of the officers using force are already released by the deputy mayor. But without good reason, we should be cautious before subjecting government employees and their families to the virtual and real-life harassment that has become so prevalent in today's society. We also have concerns that the automatic release of the individual officer's name before any evaluation of whether the use of force is justified may unduly prejudice members of the public and subject the officer and family to harassment. However, at least there is some tie to the officer's actions rather than simply being a government employee at the scene of a use of force. It should also clarify that no personally identifying information or medical information about officers shall be subject to disclosure. We should all be able to agree that the district government should not unduly expose private medical information about officers or information that would put them at risk of identity theft. We should also remove employees' name from release discipline records and the announcement of adverse actions hearings and require disclosure only in sustained investigations that result in suspension, demotion, or termination. To compare this to the handling of criminal cases, this provides for the release of identifying information only if there is a conviction or a sustained violation for serious misconduct that merits a significant penalty. This still requires more information to be disclosed about officer conduct. It should also clarify that when an officer is a victim of a crime for which the trial is usually a bench trial, the defendant can have a jury trial only if the officer was in uniform or acting in official capacity at the time of the crime. Defendants should not be granted special privileges or advantages, rather, just because they commit crimes such as misdemeanor sexual abuse, attempted theft, or destruction of property against someone they did not know was a police officer. If we want officers to live in DC, they should have equal protection under the law. We should also repeal the language giving the Office of Police Complaints, or OPC, unfettered access to information related to any case under OPC's purview. This includes all complaints, all use of force incidents, and any in-custody death. Instead, the administration's proposed language would reinstate OPC's timely and complete access to information, as well as the requirement that identifying information in these files remain confidential, which was inexplicitly repealed in the 2022 legislation. This provision creates substantial risks regarding the release of security sensitive information, such as the identities of witnesses and confidential sources. This concern is highlighted by a recent incident where an OPC employee was discovered to be watching body-worn camera videos with no justification, particularly since OPC lacks the many layers of accountability and oversight that have been put in place at MPD. Providing OPC unfettered access to all MPD files without any obligation of confidentiality is highly problematic. MPD has a strong record of providing requested information to OPC under the timely and complete access standard. However, unlike unfettered access, it allows for the possibility that we may not always agree that all the requested information is either relevant or should be released outside the department. And in these infrequent cases, OPC is able to seek redress with the chief of police or the council. This standard is important not only to members, but should be important to anyone who may be identified in a police file. The chief of police and MPD members are subject to questions and accountability for our actions daily through the public, through the media, the courts, OPC, auditors, the council, and others. That is not true of OPC. Therefore, OPC should not have unfettered access to these highly sensitive files, and they should be required to keep the identity of people named in them confidential. In conclusion, thank you for the opportunity to speak with you today about Act Now. By closing some significant gaps in our criminal code, Act Now will enhance the ability of MPD and our government partners to protect our communities and hold offenders accountable. In addition, by amending some recently enacted legislation, the council will support the community and officers in key ways. The amendment will lower or remove recently enacted barriers to closing and prosecuting cases, hopefully allowing us to remove violent offenders from the streets. The amendments will not only support good police officers who are doing good work in our communities daily, but will support officer retention and recruitment. In turn, this will help us gradually reverse the devastating reduction in police staffing and therefore support a safe and vibrant city here in the District of Columbia. I appreciate your consideration to this important legislation. Thank you.
Great. Thank you very much, Chief Smith. Katya Seminova from the Public Defender Service.
Good afternoon. I'm Katerina Seminova, Special Counsel for Policy and Legislation at the Public Defender Service for the District of Columbia. PDS opposes the Addressing Crime Trends Act, now Amendment Act. This legislation is a remarkable and cynical departure from where we were less than 3 years ago when the mayor painted Black Lives Matter on 16th Street. This legislation inexplicably walks back a prohibition on chokeholds by law enforcement. It decreases community trust by limiting public access to police disciplinary findings and limits the public from even learning whether disciplined officers remain employed, and allows police unfettered access to their own body-worn camera prior to writing initial reports. With respect to each of these provisions, the bill would reverse legislation passed unanimously by the council less than a year ago, and also passed as emergency and temporary policing reform legislation. Like the other crime bills that the council has already considered this year, this one does not address the root causes of violence, nor does it have anything to do with dedicating resources to implementing the gun violence reduction strategic plan. Residents want real strategies to reduce violent crime. Decreasing police accountability, allowing police to use more neck restraints, displacing and harassing residents who police believe may be engaged in a drug offense from one block to another will do nothing to make the district safer. Given today's time limitations, PDS's oral testimony will address only some of the provisions of the proposed legislation. PDS's written testimony will address remaining provisions. With respect to chokeholds, the legislation allows neck restraints, meaning chokeholds, by law enforcement when done to restrict someone's movement. Since no law enforcement officer will ever state that they are choking someone in order to restrict their breathing, it was the prohibition on the use of neck restraints for the purposes of controlling movement that actually did the work of banning chokeholds by law enforcement. If this restriction is lifted, law enforcement would be able to grab DC residents by the neck for the purpose of preventing what they allege is conduct like resisting arrest. This is exactly the type of police action and justification that resulted in the murders of Eric Garner and George Floyd. This legislation has nothing to do with incidental contact with the neck, as stated in the mayor's letter introducing this legislation. In its ban on all neck restraints, passed unanimously less than a year ago, the council included this explanation. Quote, police brutality is abhorrent and antithetical to district values. It can't be that police brutality is no longer abhorrent and antithetical to the district's values. The council should reject this change. With respect to police accountability, maintaining public trust is essential for a functioning law enforcement system, and this legislation violates that public trust by shielding law enforcement misconduct from public view. The mayor's legislation would unwind the council's progress in policing reform by removing officer names, duty status, and replacing disciplinary decisions with MPD-created summaries in the yet-to-be-funded police misconduct public database. The legislation would repeal similar reforms to FOIA that favored public access of sustained disciplinary findings. Dozens of licensed professionals in the district have their names and license status available to the public. The public can see sustained and complete disciplinary findings for lawyers and doctors on public websites. As Karen Dale of AmeriHealth Caritas testified at the hearing on comprehensive policing reform, public accountability and transparency have long been standard in healthcare. It should be no different for police officers. In crafting police reform legislation that the mayor now seeks to repeal, the council struck a balance between the privacy interest of law enforcement officers as employees and the need for transparency and accountability. Responding specifically to testimony from Greg Pemberton, chief of the MPD Police Union, the council limited the public database to sustained allegations of misconduct involving interactions with the public, the integrity of the officer, or the officer's commission of a crime. The officer's personal information, such as address, would not be available. Infractions solely related to employment rather than public interaction, for example, arriving late to work, also would not be available for public view. This was a laudable and entirely reasonable reform that needs to be funded by the mayor's office, not overturned. This reform was also in line with reforms in other jurisdictions. New York makes all sustained disciplinary complaints available. California budgeted more than $6 million for the creation of a public database of police complaints and instances of the use of force. According to the Pulitzer Center, 19 states now have laws that allow these records to be mostly available to the public. Removing accountability and transparency is not an acceptable recruiting tactic for police officers and cadets. The district should not want to attract and retain officers who want secrecy for sustained disciplinary findings. With hiring bonuses, consensual overtime, and benefits, the district should be attracting officers who want to be part of an accountable police force. Further, there's no meaningful evidence that accountability and transparency reforms are behind MPD attrition. Reporting by Jenny Gathright at WAMU documented that the primary drivers of attrition were mandatory overtime and canceled planned time off that showed how little MPD valued quality of life for officers. A report by the not-for-profit Police Executive Research Forum surveyed officers and found that two of the greatest contributors to low morale are canceling employees' days off and requiring them to repeatedly work overtime, often without prior notice. CNN reported on lawsuits filed against MPD by more than 20 employees alleging a toxic work culture, including racial and sexual discrimination and a culture of intimidation. As reported by Gathright, one former MPD assistant chief said that solving MPD's attrition problem requires the department to address deep and ongoing wounds caused by decades of discrimination, favoritism, and retaliation. The district cannot give up transparency and accountability reforms for the illusion of employee retention. The council should stick with what it enacted unanimously less than 12 months ago for all the reasons it had then for doing so. With respect to body-worn camera, the proposed legislation repeals a provision that prohibits law enforcement officers from reviewing their own body-worn camera footage prior to writing initial police reports. This provision was included in the council's unanimously passed policing reform legislation and was based on a recommendation of the Police Reform Commission. As noted by the Police Reform Commission, research shows that these recordings can bias the officer's memory, suppress what the officer originally recalled, and cause over-reliance on video footage for recollection. Recent research concluded viewing BWC of an event introduced multiple changes in officers' event memory and memory for their state of mind during the event. Therefore, there should be constraints on permitting officers to view their BWC even after they complete their initial report. As concluded by the Police Reform Commission and ultimately by the council in legislation passed less than a year ago, officers, like other eyewitnesses, should not be permitted to view BWC footage prior to preparing their initial reports. There's no evidence-based reason for changing this practice now or for giving law enforcement privileged access to video while all other witnesses must rely on memory for initial accounts. The council should decline to make this change. With respect to retail theft, amendments to the DC Code to create a new offense criminalizing organized retail theft should not proceed in this manner or at this time. Controlling retail theft will require studying the problem, collaborating on solutions, and only then potentially writing a statute that fills any gaps in liability. Prior to legislating, the district should create a task force to work with industry and residents to address and understand issues surrounding retail theft, such as the use of self-checkout, retail staffing decisions, the role of online resellers of merchandise. In the meantime, organized retail theft and all theft from stores can already be prosecuted under DC Code 22-3111 as second-degree burglary, as first-degree burglary, first-degree theft, misdemeanor theft, and as second-degree burglary under 22-801 because the individuals have an unlawful intent at the time of entry. The district's existing theft statute criminalizes wrongfully taking the property of another. When that value is less than $1,000, the crime is a misdemeanor, punishable by 180 days. The value is over $1,000. The theft is a felony, punishable by 10 years of incarceration and a fine of $25,000. With 2 or more prior misdemeanor or felony convictions, the prosecution can charge the offense such that it is punished by 15 years of incarceration, a mandatory minimum term of 1 year of incarceration, and a fine of $37,500 or both. Under existing district law, aiders and abettors can receive the same punishment as principals, and co-conspirators can be punished for the separate offense of conspiracy to commit a crime and charged with the same offenses as the principal under a theory of co-conspirator liability. Prosecutors have the legal means to severely prosecute individuals for offenses related to organized retail theft. Thus, the council should refrain from passing new criminal offenses in a patchwork fashion when there is insufficient evidence to support the need to do so. Reinstating drug-free zones. Finally, this legislation takes the baffling step of reinstating drug-free zones, legislation that the council, with then Councilmember Bowser's support, unanimously repealed in 2014. Then Attorney General Irvin Nathan's office testified for the repeal because the office had substantial concerns about the constitutional soundness of prostitution-free zones, which were written identically to drug-free zones. This resurrected statute would criminalize the failure to disperse from a designated drug-free zone after being instructed to do so by an officer who reasonably believes the person is congregating for the purpose of committing a drug offense. This legislation provides no parameters for what would constitute an officer's reasonable belief about an individual's actions and would lead directly to police harassment of certain people in designated zones. And it is not necessary. Officers who have probable cause can already make arrests. While the legislation will result in constitutional challenges, protracted litigation, and police harassment, it is clear that it will do nothing to improve public safety. Individuals intent on selling and buying drugs may merely move 1,000 feet after being ordered to disperse from any newly declared drug-free zone. The legislation does not address drug use, help individuals struggling with drug abuse and addiction, prevent drug-related deaths, or improve public safety. As the district faces a crisis in opioid use and drug-related deaths, the focus needs to be on a public health approach to drug activity, not diverting resources to ineffective policies that will result in costly and protracted litigation and invite harassment by law enforcement. Thank you for this opportunity to testify, and I welcome any questions.
Thank you very much, Ms. Seminova. Janu Park from the Criminal Code Reform Commission.
Good afternoon, Councilmember Pinto, and thank you for allowing me to testify today on behalf of the CCRC regarding the Addressing Crime Trends Now Amendment Act. My comments will be abridged today due to time, but we will be submitting more detailed written testimony before the close of the record. But my remarks today will address 3 provisions in this bill. So creating the new offense of congregating within a drug-free zone, changes to the first-degree theft offense, and the creation of a new directing organized retail theft offense. So under this bill, the chief of police will be empowered to create drug-free zones. And officers are always permitted to request that people move to a different location, but this bill would give teeth to the officer's orders to disperse by creating a new criminal offense that has 2 essential elements. So 1, 2 or more people must congregate with the purpose of committing a drug offense. And then 1 of the persons must refuse to disperse after being ordered to do so by an officer who has a reasonable belief that the person has the purpose of committing a drug offense. So as this offense is drafted, it's unclear how the offense would exactly empower officers to enforce drug laws more effectively than under current law. So as a general matter, officers can lawfully make warrantless arrests if they have probable cause to believe that a crime is being committed or has been committed. So as applied to this offense, that means that officers not only have a probable cause that the person refused to disperse, but also the person was congregating with another person with the purpose of committing a drug offense. So an officer has probable cause that a person is congregating with another with the purpose of committing a drug offense. In nearly all cases, they would also have probable cause that the person is or has committed an actual drug offense. So for example, if the officer has probable cause that a person is congregating with another person while possessing fentanyl with him to distribute it, They could order them to disperse and then arrest them if they refuse to do so, but they could also just arrest them on probable cause for committing possession of a controlled substance with intent to distribute. We do think that there would be a significant deterrent effect, as this bill requires that drug-free zones be marked by barriers, tape, or officers. The likelihood of being caught within the drug-free zone would certainly skyrocket, and the deterrent effect would be significant. But again, the drug-free zones can only remain in place for 5 days. Any would-be drug offender can simply wait out the 5 days before resuming their activities, or they can step out of the zone. And for this zone to really work, presumably would have to be staffed by MPD officers. And so any temporary deterrence benefit, it's unclear if the temporary deterrence benefits would really be substantially greater than having those officers patrolling the area on a regular basis. Let's switch to first-degree theft. Currently, theft is divided into 2 grades. So second-degree theft, which is a misdemeanor, and first-degree theft, a 10-year felony, which requires that the property be valued at $1,000 or more. This bill creates 2 new versions of first-degree theft, and the CCRC opposes these changes because they're both unnecessary and create disproportionately severe penalties. So first, it would include stealing 10 items or more valued at an aggregate of $250 over a 30-day period. So this change is unnecessary when applied to items that are stolen sequentially over that 30-day period. So under current law, if a person steals 10 items on 10 separate occasions, they can already be prosecuted on 10 separate counts of theft. So even if that's just 10 misdemeanors, that would still provide an aggregate of nearly 5 years of incarceration. And moreover, under the sentencing guidelines, sentences for even non-violent misdemeanors can be ordered to be served consecutively when they do not occur on the same day. More generally, imposing a 10-year max sentence for stealing multiple items valued at just $250 is disproportionately severe. So felony liability is typically reserved for theft of objects with significant value because this is a non-violent property offense. So under this proposed revision, stealing a single backpack that contains a few notebooks, a couple textbooks, a few pens, and a pack of gum with an aggregate value of $250 would constitute a 10-year felony. Whereas stealing a single bag valued at $250 or more would be a misdemeanor, subject to a penalty that's just 1/20th of stealing the bag that happened to contain 9 items. Second, the bill would change first-degree theft to include either knowingly committing assault or intentionally destroying or damaging property of a retail establishment. So with respect to committing assault during the course of a theft, this revision is unnecessary as this conduct is already criminalized as robbery, which carries a 15-year max, higher than the 10-year max for theft 1. Both the DC Court of Appeals and centuries of legal authorities have clearly stated that the key distinction between theft and robbery is the use of force or threats. This revision would completely eviscerate this fundamental distinction between theft and robbery. Now, with respect to causing property damage to a retail establishment, this revision is also necessary, as in these cases, a separate charge of malicious destruction of property can be brought. And applying this kind of 10-year felony liability to sort of non-violent property crimes, regardless of the value involved, is disproportionately severe. So under this revision, a person who steals a single candy bar and while fleeing knocks down a store display, causing minor damage, would be guilty of a 10-year felony. And this relatively minor non-violent property crime would be subject to the same maximum sentence as aggravated assault, which includes infliction of life-inflicted or life-threatening injuries, and a higher maximum sentence than attempted murder. And to say more generally, creating proportional penalties for this type of serialized theft using the grading structure is especially difficult because, again, we have an antiquated code that only uses 2 gradations of theft as compared to the vast majority of jurisdictions which use 4 or 5 or even more gradations. So fitting this into our current code is using some fairly crude tools. Lastly, this bill would create a new offense of directing organized retail theft. Just as an aside, I personally take this conduct very seriously. Not too long ago, my wife was at a store when an organized retail theft, a group of people swept in an organized retail theft. And it was a frightening experience as she and other customers and employees actually hid out in a back room. So I definitely recognize that this kind of coordinated shoplifting is not the same as someone just slipping a candy bar into their pocket. And creating a new offense would be warranted if there was a real gap in law, if this conduct were not criminalized or if the penalties were disproportionately lenient, but it's just simply not the case. So this offense requires the defendant directs at least 2 people to steal merchandise valued in the aggregate of more than $1,000 with the intent to trade the merchandise or fraudulently return it. So under current law, a person who directs 2 other persons to engage in this conduct could be convicted on at least 2 counts of theft under an accomplice theory, and accomplices are subject to the same max sentences as if they committed the offense themselves. Not only that, but entering any building, including a store, with intent to commit any crime within, including theft or shoplifting, constitutes second-degree burglary, which has a 15-year max. So a person who commits this offense can also be convicted under 2 counts of second-degree burglary as an accomplice. And it seems maybe some of the thinking behind this proposed offense is that it's worse when people act in concert. They can do greater harm. They can aid each other in avoiding apprehension. And criminal law has long recognized this intuition, which is why we have conspiracy liability. So any person who directs a group of people to engage in organized retail theft could also be convicted of conspiracy, which carries a 5-year max for non-crimes of violence. So in total, under current law, any person who commits this organized retail offense would be facing roughly 36 years of total incarceration. And that's only if they directed 2 participants. If there was a larger group, say 5 participants, they'd be facing a max of well over 80 years, which is tantamount to a life sentence. And this isn't even counting other potential charges that could be brought depending on the facts, like blackmail, extortion, or contributing to the delinquency of a minor. And it's not even the case that these forms of accomplice and conspiracy liability are difficult to prove and that this new offense would be a useful tool in prosecutors' toolkit. Accomplice liability and conspiracy would actually be easier to prove than this new offense, as this new offense requires the added element of proving that the actors had the intent to fence the merchandise or fraudulently return it. So I think it's frankly beyond debate that current law provides sufficiently severe penalties for this conduct. And as I said, I recognize that this conduct is quite serious and needs to be addressed. But when current law already provides offenses that are easier to prove than this proposed offense and that carry decades of incarceration, creating this kind of new overlapping offense is not going to have any effect on diminishing the rate of this sort of criminal behavior. And more generally, I have to note that this sort of reactive legislating is how we've ended up with such a disorganized code with needlessly duplicative overlapping offenses and disproportionate penalties. And this is why we have not just destruction of property offense, but offense that specifically covers destruction of boundary stones. It's why we have not just offense criminalizing disposal of waste in waterways, but an offense that specifically addresses disposing watermelons and cantaloupes in waterways. It's why we have 2 threat statutes that are identical, except one has a max sentence that's 40 times longer than the other. So we already have one of the absolute worst criminal codes in the nation, and we should not degrade it further with measures that will not actually improve public safety or order. So that concludes my remarks, and I'm happy to answer any questions that you may have.
Thank you, Director. We'll next turn to Director Mike Tobin, from the Office of Police Complaints, who is testifying online.
Thank you, Council Chair Pinto and members of the Committee on Judiciary and Public Safety. My name is Mike Tobin, and I'm the Executive Director of the Office of Police Complaints. Our mission is to improve community trust in the district's police departments through effective civilian oversight. And today I'm going to use my allotted time to address the provisions of the proposed bill as they relate to police oversight in the district. I'm going to try to keep it just to those issues as they relate to my agency and the Police Complaints Board and the Office of Police Complaints. You know, the Police Reform Commission that the council put together at substantial expense to the taxpayers, that hired special subject matter experts, that hired full-time staff, that had a lot of volunteer experts, spend a lot of time making a very extensive report and making a lot of very good recommendations for police reform in the district. The council enacted, in actuality, very few of those recommendations. Some of the recommendations are in this bill today, though. They're, as far as the current proposal of this bill seeks to walk back many of the proposals of the Police Reform Commission. Most of those proposals, by the way, have not even been put into effect yet because they haven't been funded for this fiscal year. This bill is curiously named Addressing Crime Trends Amendment Act. If it was up to me, I would have named this bill the Handcuffing Police Oversight in the Nation's Capital Act, because most of this proposal has absolutely nothing to do with addressing crime trends and everything to do with reducing police accountability in our community. Reducing police accountability in our community will not contribute in any way to addressing crime trends or making us safer. In fact, it will have the opposite effect. There are large segments of our community that do not trust the police. Rolling back these nominal police accountability measures that are in this bill will only exacerbate the mistrust experienced by many parts of our community. If we want a safer community, trust in police has to be improved. An integral part of the formula to increase safety is to have effective policing. Effective policing starts with the community trusting the police. We cannot effectively move towards a safer community without a basic underlying trust in the police. If you want to support the police in making our community safer, then you should support effective police oversight. Effective police oversight leads to increased trust in the police, which in turn leads to more effective policing. And really, this is the essential and overarching concept of police oversight. That is, that effective oversight leads to effective policing. And that in turn leads to safer communities. It's really short-sighted and imprudent to believe that reducing the authority of my office and limiting the ability of the public to participate and understand and see the workings of its own police force will somehow reduce crime and make us safer. It's just a wrong assumption. The provisions of this proposal, and I'll talk about some of them because some of them haven't even been mentioned today. And I don't think a lot of members of the public even realize that a lot of portions of this bill that are disguised as addressing crime trends really go to reducing police accountability and reducing the authority of my office. And it's not right. And I think we need to do something about that. First of all, removing unfettered access to all information. This has been a recommendation that's been tossed back and forth for many years since I started here more than 9 years ago in this position. And finally, it was passed by the council. The reason for that has been documented, well documented in past hearings that we've had. But the police chief who just testified indicated that one of the main reasons is for that is because we can't basically my office can't be trusted with the information. I'm subject to the same rules of confidentiality as every other government director in DC government. The police chief mentioned one incident that occurred 4 years ago, and she didn't tell the whole story. She was probably misinformed by her advisors. But I did have an employee, the only incident I've had since I've been here, that downloaded part of the written history of BWC and provided that written history. That means the auditing field of who looked at BWC when and for what, and provided that history to their own private attorney that they had hired in defense of a disciplinary action that was against that employee. And I disciplined the employee for that BWC violation. That's the only incident I've had since I've been here and since BWC was implemented. I'd like the police chief to testify under oath today about I'd like her to say that they've never had a single instance of one of their members misusing BWC. And I'd like to know how many of their members have actually misused BWC and what they've done about it since BWC was implemented. We don't know. And we don't know. One of the reasons we don't know is because I don't have access to MPD records. I only have what they decide I'm going to get. And that is not effective police oversight. It hasn't worked now. It's not going to work in the future. And the reason they don't want my agency to have it, you'll have to ask them the real reason is because they have records that they don't want this committee and they don't want this public to be aware of because they may be detrimental to the reputation of the department. I mean, that's the real reason they would not want an outside agency to have access to their records. Let's be honest about it. So unfettered access is really one of the essential tools of police oversight. It's not new in this country. Many other oversight agencies have it. And in the district where we constantly hear the refrain that we are the most progressive police department and one of the best police departments in the country, that doesn't apply to police oversight. Not anymore, especially over the last few years. And especially if this bill goes through, because we're walking back some of the most essential provisions that provide police oversight in our community. And I'll be glad to go into more further detail in that in the Q&A. I next want to talk about some other provisions that have nothing to do with reducing crime in the district and everything to do with reducing police accountability. The next one is removing the requirement for public review of MPD directives. I haven't heard that spoken about yet today, but it's in there. What they're proposing is they don't want the public to have any input in police directives and policies and procedures. We haven't even enacted that provision yet because it hasn't been funded, but they don't want it. This is supposedly a community-oriented police department that wants community participation, that wants community trust, but they don't want the public participating in any of their policies or procedures. That's not effective police oversight. Next, removing the requirement for officers to notify the public that they're being recorded when they come in contact with a citizen, and hiding officers' faces in BWC. Some of these things, in fact, all of them were already addressed in multiple hearings we had several years ago when we first enacted the BWC policy and the legislation that followed. There were many, many people. One of the hearings went late into the evening. I was there, I think, till 10 or 11 o'clock at night. There were so many people that wanted to testify about BWC. And as a result of those, we have the current law. Now, in the spur of the moment, we want to reverse many of those provisions without any data, without any reasonable cause that I can see, and slip it into a bill that we call reducing crime trends. And I don't agree with it. Next, concealing the identity of officers, and that's really what it is, concealing the identity of officers that have committed misconduct by limiting the public posting of disciplinary information, by preventing release of disciplinary records information through FOIA, and by hiding the names and badge numbers of officers in serious misconduct hearings. Why do we need to hide that information of our own police department? Next, removing the prohibition against neck restraints when it relates to preventing movement. This bill would be a serious error. It would completely reverse the law. And I will explain that right now in as brief a manner as I can, because I know it's been a long day for everybody. I am the only non-MPD member that sits on the Use of Force Review Board as a voting person. I've been on that board. I think I've been on that board longer than any other person on the board presently. I reviewed hundreds of serious use of force cases, maybe even more than that, and made determinations on it. This bill would completely reverse it. Probably 90 to 95% of all neck restraint cases involve trying to restrict the person's movement. And this would take that all away and make that perfectly legal within policy. This is not the way to do it. I agree that we need to tweak the policy. And I'll make a suggestion right now because I've been thinking about it for a long time. And it's the same suggestion I would have made if the person in the mayor's office that drafted this policy, or the person in the police chief's office that worked on drafting this policy would have picked up the phone and gave me a call, or picked up the phone or convened a special meeting with the Use of Force Review Board, all the experts that sit on the board and see all these cases every day and review them. And here's a recommendation. Instead of deleting it all, just make an exception for brief, unintentional, and incidental contact with the neck that is not a policy violation. I think that would fix the problem. We're going to exacerbate the problem and go back to square one if we do what this bill proposes, and it'll be a serious error. So that's my suggestion on how to fix that part. I think we should tweak it. But this bill doesn't do it right. Next, restricting the release of officer disciplinary records information by my office. I think that's a serious error. Other police departments already do it. New York City does it. Others do it. The largest municipal police department in New York City has been doing it for years. And guess what? The last time I checked, the sun still rises in New York City. And there's been no detrimental effect by it. And to the naysayers, I say this, because this question always comes up. Well, why should police officers be subject to this added scrutiny? Well, remember this. Police officers are the only employees of the District of Columbia, the only employees in society, wherever you go, that have unique responsibilities and unique authority. They're the only people that can restrict your freedom and my freedom at will. They're also the only people that can take your life under certain circumstances at their will. That increased responsibility comes with increased scrutiny. And that's why we need increased scrutiny and increased police accountability. And that's why disciplinary information should be released. And that's why I should have access to all of the police records. And that's why it shouldn't be limited from the public. And that's why the public should participate in the policies of the police department and not leave it up to the police department to determine what their policies and procedures are. This is our police department, the community's police department. It doesn't belong to the police chief. It doesn't belong to the mayor's office. It doesn't even belong to the council. It belongs to the community. And the community should be able to know these things because these are heightened responsibilities that a police department holds. So none of the proposals really that I've talked about with respect to my office serve the stated purpose of addressing crime trends. All the proposals serve the purpose of insulating MPD from public scrutiny. And they also further erode, and this is an important part, they also further erode community trust in the police department. And that's going to make their job tougher. I'm not here to make the police department's job harder. I'm here to make it easier. That's our purpose. That's in our mission statement. This bill's not going to do it. I urge the committee members to not even send these provisions forward to the full council for a vote. I'm going to just leave it at that because I know it's been a long day and I'll wait for the questions and answers. Thank you.
Thank you very much, Director Tobin, and thank you to all of our government witnesses for being here today. So my colleagues know our order. We're going to do 10-minute rounds. I'm going to start and then we're going to turn to our committee members. First, we'll hear from Councilmember Henderson, then Councilmember Bonds, Nadeau, Parker, Fruman, Lewis George. Okay. So I want to start with organized retail theft. Chief, can you speak to how the new proposed crime of organized retail theft would differ from what we're permitted to do under existing criminal offenses for things like conspiracy? You heard Director Park's testimony, but why would this tool better enable law enforcement to pursue these cases?
Well, thank you so much for the question. One of the challenges that we have, with our retail businesses, obviously, are large groups that are coming into retail establishments, stealing items. And it's very challenging for us with having the threshold for $1,000. What this will do is give us the investigative tools to really arrest those individuals who are stealing items of an aggregate of up to $250 over a 30-day period. And for us, that's a tool that we can use not only to arrest individuals who are committing those crimes, but also investigate other aspects of that, of those incidents where we have folks who are directing, coercing, and then folks who are really making it very challenging for others to just go into the retail establishment and be able to purchase items. I heard, I'm not sure, I forget your last name, Mr. Park, talk about his wife, being in a space or a place where there was criminal activity, a robbery of an establishment, and how difficult that must be when folks come into a place or a space and steal items or take items out of an establishment. And what we will do with this new legislation, specifically related to organized retail theft, is give our officers another opportunity to have investigative tools in order to address this crime.
Okay, and can you speak, if you can, Deputy Mayor, directly to what Director Park was talking about that we're able to bring these cases?
Sure. So I think that what I would say is, first of all, there are 34 states that have specifically passed organized retail theft statutes. And there's a reason for that, because what Mr. Park just laid out is we've heard it multiple times in these hearings. We have a very complex code. He laid out a number of ways to layer and stack and otherwise. And if it was as simple as that, we wouldn't be having this conversation. And in fact, would not be hearing from retailers that cases aren't moving forward. If it was as simple as what Mr. Park laid out, which isn't simple at all. It's a very multi-layered of, well, you could bring conspiracy here, robbery here, otherwise. If that simply isn't happening, right? So what we're trying to do, we recognize that we need a code overhaul, but that's not where we are, and that's not what's going to happen in any sort of time that will address what is a worsening problem in the district. I have no doubt that other jurisdictions, the 34 others that have passed specific organized retail theft, also have theft 1, theft 2, burglary, right? Because these are not new charges. These are all historical charges. Certainly, shoplifting and even large-scale shoplifting or theft has happened over time. So our goal is to streamline this, to give not only the officers a tool to help with what we're hearing at places like Giant or otherwise, where they're able to, they know some of the repeat patterns of offenses, but that, if the U.S. Attorney's Office would prosecute these cases, then fine. But they also need additional tools to ensure that we're able to hold people appropriately accountable. Our goal is to create a clear, streamlined, specific offense for what we're seeing. So I think we could get into the complexities of how they could layer and all of those different things. But what we're trying to do is to give our officers, our businesses who want to partner with us and who are also putting together basically cases to help us with some of these people stealing 10 things of detergent and selling them on the street on a table in Columbia Heights, direct, easy, specific tools that can be implemented quickly. Our goal is to turn things around as quickly as possible. And so I won't take too much time, but I recognize that things take studying and all of that. Unfortunately, we don't have that, right? So yes, we have to be in a position where our ability to legislate and to make policy and make decisions is nimble enough to actually address what we're seeing. And that's what we're trying to do, to put forth.
Okay, thank you. And Director Park, the organized retail theft component is one thing, and sorry that happened to your wife. That sounds extremely scary. And the Deputy Mayor just mentioned other examples that we've seen where things are stolen from stores on a large scale and then immediately resold. Those are the organized cases that we're talking about. But what about the cases of the individual who's not working in a conspiracy, who's not working to sell it? Do you think that there are other tools that we should be thinking about, as this bill could be the vehicle for, around lowering the threshold for retail theft from 1,000 to 500, let's say, as has been recommended recently?
So it's not totally clear to me why we would lower the threshold for retail theft, but not for ordinary theft. Unless they're thinking that it's just dramatically worse to steal from Target than it is to steal from an individual, which is not abundantly clear that's the case. Should say though, in shoplifting cases, again, due to the breadth of our current offenses, someone who walks in and commits, again, like a petty shoplifting, like stealing a candy bar, can be convicted not just of shoplifting, which has a relatively low max, but at least of misdemeanor theft, which has an 180-day max. And again, assuming they actually had the intent to commit that shoplifting or theft offense when they entered the store, can also be charged with burglary. Maybe not the most obvious charge, but it's readily available to prosecutors if they so choose. And again, I want to stress that I know some of these doctrines can be complex to non-attorneys, but I want to make it very clear that anytime an officer can make an arrest under this organized retail theft offense, when they have actual probable cause, they could also arrest this person for actually committing the offense, for conspiracy, for accomplice liability. At any time a person could attain a conviction, these turns out could obtain a conviction for this organized retail offense, they could also obtain easily a conviction for the accomplice liability or conspiracy doctrines that I was talking about. And it's easier because this offense requires that the product in the aggregate is valued at more than $1,000. And you have to prove they actually had an intent to go fence it or fraudulently return it. So if it's a few people sweeping into the store, stealing, I don't know, some candy, some detergent, they may have at the trial level be able to show reasonable doubt that no, we were going to use this for ourselves. We weren't going to fraudulently return it. We weren't going to fence it or anything like that, and the conviction would fail. Those elements are not required for conspiracy liability or accomplice liability for theft or burglary too.
Are the rules different for juveniles for the amount thresholds for what constitutes felony or misdemeanor theft?
No, but it doesn't really matter because when a juvenile they're not prosecuted, but it's in a civil proceeding where they're deemed delinquent. And in that case, they can be deemed delinquent regardless of whether they're committed first or second degree theft or shoplifting or any number of other offenses.
So, I mean, that raises a broader concern when you say, should retail theft be in a separate category? I mean, we see cases all the time where somebody's bike was stolen or scooter was stolen and there's no consequence. And we hear from prosecutors saying, there's nothing we can do because this threshold is so high. And so is that because in practice, those cases are not being assigned a misdemeanor sentence and they're being dismissed or no papered? Or is that a gap in our current code of having a threshold that's too high?
Yeah, if the stolen property doesn't meet that $1,000 threshold, they can still be charged with misdemeanor theft. It has a 180-day max. So it's not as if nothing can be done. They can still be prosecuted and convicted of an offense. Of course, the value could be changed just that the felony threshold is lowered, but I would caution against that. Again, remember, this is not to trivialize the harm when someone has their bike stolen or their property stolen that they've purchased with their hard work, hard-earned cash, but it's still a non-violent property offense. So I would just recommend some caution before imposing felony liability on these kinds of offenses.
Okay. And Chief, why do you think, because I've heard this from officers too, who will have shown up on various scenes and say, well, there's nothing we can do when somebody is called and there's a theft and they'll say there's no consequence or there's nothing we can do here. And so I've gotten a lot of questions of, well, do we not outlaw theft in the city? So where do you think that disparity is coming from?
Well, I think that, again, it's the repeat offenders, looking at the threshold being $250. I think the significant problem for some of our officers is that, with the threshold being so high, these folks are coming back in, repeating the same crime over and over and over again. At least with it being lowered to $250 over a 30-day period, it gives us the opportunity to arrest these folks because that's our job. Our job is to enforce the law, right? And the way the law is currently established does not give us the opportunity. It would have to be $1,000 before we can, when we see the same folks going into these establishments over and over and over again. As a matter of fact, last night I was up at Starburst Plaza in the Safeway and walking around with the manager at CVS, walking around with the manager. And some of these shelves are bare because folks are just walking in and just taking these items. There's not much we can affect the arrest, but obviously if it's not over $1,000, there's really not. These folks are just coming back in. We need to be able to hold them accountable with this new legislation in order to at least have the public feel as though there's a significant impact when we make these arrests.
But isn't the $1,000 threshold only for a felony?
Yes.
So why can't an arrest be made for a misdemeanor offense?
We make the arrest for the misdemeanor offense. We can, but at the same time, again, these folks, it's habitual. They're not held accountable. We enforce our portion, but they're just not held accountable.
So do you think that the feedback of, well, there's nothing we can do is more of a feeling of frustration
is
because when
yes.
the arrest is made, then the
Yeah.
same people are coming
Yeah.
back out with.
Yep, absolutely. It is a frustration.
Okay, go ahead, briefly, Ms. Seminova, I'm over time.
Thank you. So if somebody's arrested on a misdemeanor for misdemeanor theft, second degree theft, and they are released under 1321, and they are rearrested for a subsequent theft, they would have a hearing under 1329 to revoke their conditions of release. They could be held as a result of the violation of their conditions of release. They could then be charged with offenses committed while on release for the subsequent theft. If they are convicted of theft 1 and they are convicted of theft 2, then theft 3 is a felony with a 15-year max, a 1-year mandatory minimum, and a fine of $37,500. So there's staggered penalties that are imposed and that are quite severe within the existing code. And there was discussion of layering. It's not layering, it is charging an individual with a count. An individual can be charged with more than one count. They can be charged with all the counts that the prosecution can prove beyond a reasonable doubt. The prosecution proves the elements of the offense and the individual would be convicted. And then a judge would sentence them to the terms that are allowed under the law. And all of that exists under current code.
And I appreciate that context. I think that one of the things we need to grapple with is that how it's working in practice for all these cases when people see over and over again the same people engaged in misdemeanor theft. All of those possibilities under the law aren't necessarily working as intended. I won't use any names, but I've heard several cases and read several cases of everybody in the system agreeing that the offense was committed, but the defendant having no ability to pay the fine, and everyone saying, well, there's no more that we can do. And so I think it's important to think about what tools we have under existing law, especially when we're going to add to it. But I think we need to also think about the kind of practical limitations on what that current situation is allowing for. I don't know if Deputy Mayor, you want to briefly.
I just wanted to say, I think we can talk, I am an attorney. We can say all these things that could happen, but I think we're all sitting here because we also see what is or isn't happening. And so our goal is to, right, like we would love for that to be the case, that we have people in our community with who are on pretrial release for homicide. That's a fact. There's no question about that. So our discussion about whether or not someone who is habitually, and this is what I've been to Giant, I've been to Safeway last night, I've been to CVS, habitually ransacking our stores right now, they are coming back in repeatedly. So the idea, I think we have to be realistic about what's happening and address what's happening, which is we have a system where accountability has been tipped in a certain way, and we are trying to find our way back to some sort of ground that will allow for both victims, whether we believe a property crime is important or not. If you live in Ward 8, maybe your scooter's your way to work, right? Like it's not for us to make a value judgment on whether a property to someone is important or not. It's for us to figure out a way to appropriately hold people accountable so that they recognize there is value on that for someone else. So I think it would be unrealistic to say, based upon what we've seen and what we've heard through multiple hearings this year from our own U.S. attorney about the challenges of trying to get people held pretrial on what are sometimes very violent and under the law violent offenses. So we're trying to give more direct and more additional tools, because if our prosecutors were doing what people said that they can do, we perhaps wouldn't be having the discussion we're having right now.
Thank you all. Councilmember Henderson.
Thank you. Listening to this conversation, sometimes I feel as though the district has like one hand tied behind its back because we don't control part of this process. Because in sort of talking about retail theft in conversations with the U.S. Attorney's Office, they would say one of the tough things that they have is that retailers won't send someone to testify. And so the thing I'm thinking, okay, let's say we do this organized retail theft. If they still don't have someone to testify, what happens? Like, how does this change that?
So we've been working on that a lot, right?
Okay.
Like, so you'll see one of the things is that the National Retail Federation is very in support of organized retail theft, right? And in the city ourselves, right, like this doesn't just start, right? Like certainly we've had conversations and the chief can talk more about it with people like CVS. Like you have to actually work with us to enforce. There sometimes like practice becomes, people become lethargic because what they're seeing is, well, and I spoke with the people at Giant myself, nothing's going to happen. So we have all this video, we have all this stuff, but people keep running in. So we have to then do the actual work that you hear. There's legal side, but our system is multifaceted. And that means we're doing the work of helping them with security plans, with all of the things that they understand are necessary to help us make good cases. So this is not a but or either or, right? Like it is, we're having very active conversations with CVS, Target, and small retailers about how to help them build good cases, right? Or with what they have over time to help us help them. So we're doing both and right now.
So let me ask this, Chief. To what extent are you all working with or having conversations with online retailers? So stealing Tide is one thing, but I've also seen where if folks will come into a CVS and they're stealing like face creams. Folks aren't selling that on the street. They're selling that on Amazon or other retailers in that way. Like, are we pursuing investigations in that?
So today, I cannot definitely say that we are pursuing investigations on online retail theft, but I'll certainly check.
No, not online retail theft. Physical theft that has taken place and that they are now selling those products online. Does that make sense?
It does make sense. I don't know the answer to that, to be honest, but I will certainly look into it. And I just want to piggyback on something that Deputy Mayor Pia stated. You know, our assistant chiefs have been working very, very diligently. One of the other aspects of some of the retail establishments, they do have special police officers also engaged in these spaces. And what we've been finding is that they have just been inactive also, if that makes sense. And so we have been working very diligently with the contracting officers for some of these special police officers that are assigned to get them also to know that they have the authority here in the District of Columbia
to stop.
Absolutely. And what we found is that there has just been a soft approach to that. And so our team has been working very diligently with some of the corporate offices for like CVS, Giant, and other entities to ensure that they are also telling their employees or telling these SPOs or special police officers that they also have to engage. Because when you talk about folks not being witnesses, they are also in those stores and they're the eyes and ears also of those activities that are taking place. And we need them to be proactive and to be able to do their job as well.
Right. I mean, I definitely have these businesses tell me I'm spending hundreds of thousands of dollars on special police. And I'm like, okay, that's great to have that additional layer. But if they're just standing there and not enforcing, then what are we doing?
And we're working with them on that.
Okay, let me switch to drug-free zones. You know, Chief and Deputy Mayor, how I feel about drug crimes in the district as it's connected to the opioid epidemic that we're also facing as well. And, you know, something that Mr. Park talked about is a question I had around the concept of a drug-free zone, right? If even with the language that you all are adding around intent to XYZ, if you believe they're standing on that corner with the intent to sell fentanyl, why would we disperse them as opposed to just arresting them for the fentanyl?
Well, if they are selling narcotics, we would arrest them. I mean, obviously we arrest them, but one of the things that I can say to you, you know, when I show up on the scene, they're not doing that, right? They'll
have 4 stars,
disappear.
Chief. When you show up to the scene, it's not like you're plain clothed.
Right. Sometimes I am. But I think the point of it is that we can affect arrest. What I've heard from many community members, I'm getting a little feedback here. What I've heard from many community members, and I've been in a lot of communities since I've been in this space, they have all talked about the nuisance and being able to reclaim those areas in their neighborhoods where there's just what we believe and they also believe that there's illegal use of drugs, selling, and what have you. As you know, now folks are no longer doing a lot of hand-to-hand money exchange for drugs. Most folks are using these apps and different things in order to exchange funds. But we do have the opportunity to do that. What the intent is not to just affect a significant number of arrests. We also want to be able to reclaim some of those public spaces where folks are gathering, and we have. we have to have, it's not going to just be we're going in and just claiming a particular area as a drug-free zone. There are certain parameters that are in place that we have to look at it in the totality of the circumstances. And I think it's outlined in the legislation how we would address that.
Okay.
And I know that, I'm sorry, ma'am.
Sorry, I
No,
only
that's
have
okay.
like 4 minutes. She's definitely going to cut me off. How will MPD balance the goal of preventing drug-related activities in certain zones with not criminalizing individuals who are suffering from substance abuse disorder?
And again, one of the things that I think we are doing very well with our partners from DBH is being able, when we go out to different spaces and places, is to have them with us and partner with us, because we do recognize that there are some substance abuse issues. There are some unsheltered individuals as well.
Right.
And we would certainly take that into consideration when we go to those spaces and places and have those same DBH personnel and other social services entities with us, as we do when we conduct our public safety walks.
Okay. You all referred to this bill, what are we, I don't know, it's Act Now, but addressing crime trends now. To the public, when they think about crime trends now, one thing that comes up is carjackings. That's not in this legislation. Why, Deputy Mayor? Now, it could be because Chair Pinto has a bill that does deal with that, and so you didn't want to be duplicative, but I want to get clarification.
Sure, there's a number of bills, as you know, that have been proposed this year. And so one of the things that we said is, as we see things, we're going to make proposals. And so in Safer, Stronger, I'm not sure if we proposed a number of things related to vulnerable adults, shootings, gun crimes. As you pointed out, Chairperson Pinto has a bill in active and in secure, in the overall security C. So if there are specific things that we can think of that we need that's going to help us with carjacking, then we'll do that. But some of what we believe is the overall environment, as we're able to bring down robbery, as we're able to, because we have a lot of juveniles engaged in behavior.
Well, so you brought that up.
Yes.
So if I think of Safer, Stronger, prioritizing policing, Act Now, active, nobody, like all of it, for the majority, we are dealing with adult code. We have yet to touch the juvenile code.
That's right. Just yet. So I will say this. So obviously we did things around pretrial, but when it comes to juveniles, what we don't, there's a complexity. I'm not saying that adult is not complexity, but what we are working more on the juvenile side is on things like safe passages transferring to us so that we could get more information. Is my office running a juvenile critical incident protocol? We did shooting review today where CSS, Court Social Services, was involved, because we now are trying to, right? Like, we do need legislation. Our teachers have told us they need more disciplinary tools. We need parents more engaged. We know all of those things. But I think that there is an opportunity, maybe when we talk a lot about public health, more so than any other space, us with our curfew pilot brought in DHS, DBH, and CFSA to start the conversations. And we're seeing a lot of kids show up there who have CFSA connection, trying to really look at, we often hear root cause, right?
Yeah.
The root cause of what's going on with our kids.
And I can appreciate that. I'm just saying, we're saying addressing crime trends. I got an email response today from MPD. So I asked some questions about the carjacking numbers so far this year. And in terms of arrests, it's kids for the most part. We got some adults who are doing some things,
but our kids need to know. So our kids also need to know, like, what we're saying about the environment, because if we're not holding adults accountable, you see the videos and otherwise where they're like, nothing's going to happen to me. So I think that there's a holistic nature of, they're not separate, that we have to, if they see adults being able to sell things on the street, and that's an environment we created, why wouldn't they go and come up from check and ransack the CVS? So I think this is like a holistic process of changing our environment from a lawless one, unfortunately, where lawlessness seems to be acceptable, to one where it's not, and then also addressing social determinants and other things with our kids.
Okay. I'm over my time, but I just want to say, I mean, we talk about the impetus of drug-free zones is to disrupt behavior. And I'm trying to understand how we're disrupting behavior on the trends that we're seeing the most. So if you've got juveniles who are going in and doing retail theft, the proposal from the mayor on this doesn't address that. how are we disrupting, you know? And so, sorry, okay. Thank you, Chair Pinto. Sorry, I know I'm trying to be respectful to colleagues on time.
Thank you very much, Councilmember Henderson. Councilmember Bonds?
Thank you very much, Chairwoman. I just have a few questions about this proposal, because that's what I see it as. In the mayor's introductory letter, it was stated that the department is dealing, of course, with unintended consequences of the Comprehensive Policing and Justice Amendment Act. And I want to know, what are some of those consequences that we're dealing with? Because what I hear in community is that we're dealing with problem juveniles. And we are in fact talking about what can we do about our adult population that may be out of sync with the rest of us in society. So how do we answer? How do we look at that?
I'll start and then the chief will jump in. So one of the things that when we're talking about the policing bill is like, there's no question. And I think that we have to be honest about it, that our officers are humans and the environment they exist in is what are we looking for from them, right? And so there have been significant changes over the past 3 years, many of them well-intentioned and otherwise, that indicate what we want from officers, how they engage in community. Some of the consequences of the comprehensive policing bill have made them tentative in a way that we cannot have. And so there have been some proposals around pursuits or what we have seen with incidental net contact. Our officers, there's always policy where they can't do chokeholds or otherwise, but if they are tentative and we're seeing the videos, it leads to injury for them and for those who are they're engaging with, right? So what we need right now, when we are seeing what we are seeing in community, is our officers fully engaged and understanding we want them to engage. We want them policing in a constitutional and fair way. And that means that we have to set an environment where we're not hostile to them. That's just a reality.
And I agree, and thank you for that. And I certainly am one that certainly has said time and time again, do not touch the neck. And I do mean that. And I think many people in community mean that. And yes, you may bang your head until everything oozes out, but don't touch the neck and the head. And I do mean that. I'm trying to figure out, how will the success of this new bill be measured? And we're talking again about adults, and then we'll talk about our young people.
So the first part has to be numbers. Like everything has to be focused on reducing crime right now. Like that's the mayor's charge to us. Isn't that complicated right now? It's we have to bring crime down. Our people need to feel safer. And so the chief in her testimony, and so people ask on how is legislation that we've done this year affected crime? Like there are charts that are attached to or submitted testimony that show you they are down. Crime is down. And we would love for it to be like all the way down in a way that really people can feel. But we know that incrementally, like we are seeing the types of reductions that we need. So I would say it's going to be a reduced crime.
All right. So if we are already seeing reductions, is more legislation needed?
Yes, it is. Because, right, like that's a good start. But one of the things that we're addressing and what we've said is that over time, maybe 8 years or so, there have been significant changes that have come together to where we are. And so what we're asking for is adjustments. Some of these now were a flurry at the end of last year. I'll say that a year ago this time or earlier this year. So yes, we're proposing for what we're seeing, organized retail theft.
I appreciate that.
Yes.
I thought you were going to lead us into a discussion about the fear of crime and why it's important to clear out these neighborhoods or these areas where people feel that I can't walk through that park because there's the congregation and I don't know who they are, and I'm afraid that they may attack me because random attacks seem to be happening. But you're not taking me there, and I'm a little confused.
So let me take you there just for a moment.
Okay.
You know, we presented to you a chart that kind of shows you what has happened over the year in comparison to 2021 and 2022, 2023. And some of that certainly is due to the fact that we wanted to demonstrate to you how crime has gone up, and we were at our peak June, July, and how crime is going down. And when you talk about what people feel and the fear, that's the purpose for having our robbery suppression initiative. That's the purpose for creating our focus patrol and our hotspots in those particular areas where we've seen an uptick or an increase in crime. That's the purpose for us, even now, starting Friday, creating another operation, Operation Atlas.
And so
to
they're
address.
working, right?
They are working. They are working. And we will continue to create different initiatives and strategies. When I hear from the public and the community about how they are afraid to be in certain places, even this Friday, coming up Friday night, and I will be also somewhere, I won't tell you where, but we are standing up another operation 7 days a week in order to address violent crime.
And so those operations, do they address our juveniles, our 12-year-olds, our
Yes, ma'am.
15-year-olds?
Yes, ma'am.
Our 16-year-olds who
Yes,
say,
ma'am.
I have a gun charge, but it's my first rap, so therefore I'll be out in a few days.
The intent for all of these programs, initiatives and strategies are to address the issues that we're seeing with our young people. But we also have a Youth and Family Engagement Bureau that are dealing with at-risk youth across the District of Columbia. That bureau is set up and established to do just that, even in our schools and even in our neighborhoods.
And so what kind of results are we getting from those kind of interventions with our young people? Do you have stats that you can present to us about that population?
Yes, we do. I don't have it in front of me today, but I will certainly ensure that we provide you with some data and statistics around that.
And we also have data too, when it comes to kids on school-based incidents, how many detentions we're seeing, because there's really that's also an important piece of what's happening with school-based violence, because it's in and out with kids, right? Like what's happening in school is happening in community and otherwise. One of the things I'll say, Councilmember Bonds, is when it comes to people's safety, we also want to say that people deserve to do more than just not feel scared. Like we want people to enjoy living in the District of Columbia. And so some of the things where we talk about drug-free zones, it's okay for our residents to feel comfortable. Like it's okay for us to do things that address issues that are taking away from their feeling, yes, of safety, but also of enjoyment of neighborhood, of parks, of other things. So I just want to say that matters to us as well, how comfortable and enjoyable it is for people to live in the district.
Okay, so then may I ask, is the intention of the act proposal to be very specific about some of the immediate issues that we have in community and to try and highlight how current law, current regulations are not necessarily working, but if we highlighted them in a more definable way, we could really get some result. Is that the intent? I'm just trying to understand, because I heard what Mr. Park said, and it's very confusing because he says we got everything we need already. I know we don't have what we need from the U.S. Attorney's Office or from the DC Attorney General in many instances. And I don't know how what we're discussing today can be affected by them unless they really come into play. And they're not here to come into play today.
Well, we're going to do our goal is to make as many proposals and to give as many tools to our prosecutors as possible to prosecute. And so these are more efforts, and they're obviously programmatic and other things, getting our lab up, all of those things. So that's our goal.
Yeah. And so I think we need to hear from them as to how they would use the new tools, if at all.
Oh, Ms. Bonds, I didn't mean to imply that we have everything we need. I just meant as far as the statutory tools that are available to the U.S. Attorney's Office to prosecute these kinds of cases, they do have everything they need.
Yeah,
that's why they don't do it. I can't say, but
I understood what you meant.
yeah, it's
Okay.
unclear why, if they're not using the current tools they have, why they would though jump to use new tools, which are harder to use than the tools that are currently available to them.
So that's why we need to hear from U.S. Attorney and from the DC Attorney General as to how these tools can be used and be practical. Thank you. Thank you, Chairman.
Can I just
Oh,
add?
yes, of course.
Thank you, Councilmember Bonds. As we talk about youth, and I heard so much talk about youth, and there are the prosecutorial tools that exist in the code are there. There's subpoena power to bring individuals to court. All of those tools are there and are not lacking. When we there was just a hearing in late October about violence intervention, and people from the community talked about the need for mentors, for youth who are not system involved, for year-round job programs. Roger Marmette testified today about cognitive behavioral therapy. Those are the tools. Those are deep solutions and root cause analysis that are needed, not additional criminal statutes that already exist that can do the same things.
I hear you, and I appreciate that very much, being a mother, grandma. I appreciate it, but I also have to respond to what I hear from people in community and from what I see and the alerts I get every day, 3 and 4, 5 alerts. And it's always a young person that is carjacked or has committed some offense. I want to know how we're going to deal with that part of the population as well. We have to do something because they obviously do not feel that there is a problem. They think it's a game or something that doesn't work in broader society. So I'm concerned about that aspect of the issue as well. And I appreciate you.
Thank you very much, Councilmember Bonds. And I do want to also note that the U.S. Attorney will be joining us on Tuesday for our council breakfast. So we can all discuss the kind of the next step of implementation of some of these proposals. And his perspective, I should say. Okay. Councilmember Parker.
Thank you. The exchange has been fascinating. I do think there is a missing variable here. And I hear a lot of the conversation around statutes, which is really important. But what I'm also hearing between the lines is that the chief and the deputy mayor are trying to find tools. That's a polite way to put it. I'm concerned that our prosecutors and the courts are not holding people accountable at the levels that they could be. And I'm very clear-eyed about that. I've had conversations with the U.S. Attorney as well as our Attorney General. And I think we need to make that clear to the public that the council can take action, the executive can take action. There's another variable, a very important variable. And so some of what I'm hearing here, not to say it's all great and positive, is that the executive is trying to force the hand of that other variable that in too many instances is not papering cases or pursuing plea deals or what have you that allow people to cause harm, to shoot, kill, rob, maim, steal, and then end back up on the street the very next day or the next week or what have you. I would also caution residents from hanging too much hope on this single piece of legislation because there are a number of factors that are informing the crime crisis that we have in the district. And I do have questions, but I just want to circle back to the math problem I gave earlier. We know that MPD is only closing about 40% of cases. So if we took on average 10 gun charges, MPD is only going to close about 4 of those cases. Then it goes to, let's say, the U.S. Attorney's Office. We know that their paper rates are only roughly at 50%. So out of those 4 cases, now we're only papering 2 of them. And that is not accounting for the fact for the cases that are plead out or what have you, or folk are not held accountable by the courts. And so out of those 10 charges or incidents, only 2 are actually being pursued in court. And then we have the other very important variable, which are our judges and courts. So I just want to be clear-eyed about that. So Chief Smith, I want to come here. Earlier today, we heard testimony from Mr. Pemberton from the police union who claimed that officers have been subject to discipline for making incidental contact with the neck while attempting to administer aid. And it's this video that I think many of us have seen. Do you have concrete data now or after today's hearing that you can point us to for the number of officers who have faced discipline because of this innocent, quote unquote, touching of the neck?
Yes, sir, we do. We'll make sure we provide that. Our office will provide that to you. We do. We have all of these cases go before our use of force review board. Any case where there is an allegation of use of force or any type of we consider incidental contact. They go before our use of force review board. So I will have someone from my staff provide you with the data.
Okay, while we're talking about that, the change to section 101 amends the limitation on the use of chokeholds to clarify the definition of asphyxiating, restraint, and neck restraint and applying them retroactively.
Yes, sir.
The bill would modify the definition of quote, asphyxiating restraint, end quote, to exclude actions that have the effect of severely restricting the person's breathing. But would keep in place the restriction when there is the purpose or intent.
Yes.
That last part of this bill, would that not require a court to prove an officer's intent, which is almost impossible to do in a court of law?
I'm not.
So if there is an incident where an officer has someone by neck restraint, the language here, as I would read it, would require a judge to interpret an officer's intent. And I'm asking, is that your interpretation, or are you all seeing this differently?
I think we're seeing it differently, sir. I think that the interpretation is that we would like to be able in this particular legislation to not have the incidental contacts to be considered use of force. And typically, like I said, not typically, but all of those cases go before our use of force review board to determine whether or not it's justified or not justified.
And to that point, there's also a piece here where you don't want the officer's name and their badge number released. And part of that is because you said, you know, I'm going off of your earlier testimony that
Yes, sir.
OPC shouldn't have that information, especially if the officer hasn't been found guilty of whatever the accusation is.
Say it again.
Maybe I'm complaining.
You're mixing a bunch of them.
I'll come back to that.
You're
Okay,
mixing a
section
bunch of them.
201, it curtails the obligation to release body worn camera footage within 5 days of a quote, serious use of force, end quote.
We're already doing that.
Why is this change necessary? And is there a specified period of time that you think would be better?
We're not changing the 5 days. So within 5 days after,
Right.
like so it'd still be a 5-day release for the perfunctory or those that are spelled out in statute. So anytime if there's an officer involved death, anytime the officer discharges a firearm with the exception of so it's in here. So we're not actually changing the time frame. We can give a red line, which might help this. So
I'm looking at the red line. My understanding there is that the body worn camera footage is changing for 5 days in instances of a serious use of force. And earlier, the police union Chief Pemberton said it's because officers need more time to review the camera footage. Did you want to jump in here?
I can jump in. I mean, it's removing serious use of force altogether, so those will not be disclosed at all. So it's not a question of
And
time.
that is my understanding. And so what I'm getting at here, the recommendation is to remove the obligation to share the camera footage at all. And I'm asking if the concern is because 5 days is too.
no, so it's not the time frame. The serious use of force, the definition, council created a definition in the statute that is conflicting with what actual MPD serious use of force is defined at. So what we're trying to do is have consistency because this is kind of the issue
And
with
the
all.
change, just to make sure that
It's
the
not
public
the
is,
5-day. It's not a 5-day. It's
the change curtails the obligation. And put that in layman's terms, it would not force MPD to release the body worn camera footage within 5 days. That is currently the law in the serious use of force. And
so,
essentially,
no, but what we're doing is putting in here what MPD actually defines, right? Like, so the council made a definition of serious use of force. This does not necessarily match it MPDs. So what we're doing here is conforming when MPD would release. So what we're saying, this is what we do now. If there's an officer involved death, 5 days. If there is a discharge of a firearm.
so you're suggesting you're not changing that?
No, it's all spelled out in here. We're spelling out specifically when it will be released, right? Like, so that it's conforming and not confusing. So, right, like if there's a head strike, if there is a use of force resulting in serious bodily injury, which is what we call it, right? Then it will be released.
But if not, then it would not be There would not be a requirement for it to be released.
It could be released under the other part of the statute, which is that the mayor often releases body worn camera footage in instances that are determined as matters of great public interest. So this is the compulsory, and then there is another way in which the mayor.
Okay, I want to move on, and I'm going to come back to that. But as I'm understanding, we're removing a requirement from MPD of sharing camera footage, and that, okay.
We're not.
We're not on the same page there. There's also a change in section 201 that would allow officers to review body worn camera footage. Do you have data, chief or deputy mayor, on how many cases are being dismissed or lost because officers inaccurately reported something? In other words, I'm trying to get at where's the data that points that this isn't a needed change?
So USAO, this is something that USAO, perf, everybody supports. Some of this becomes incidental because, right, like USAO has pointed out cases in which an officer's or the court has relied upon BWC, and as an officer is testifying, things like car color might be different. So I don't know that there's data collected for each of those instances when a case has been lost by USAO because of a chasm between things that are seen and what's in the report. But this is why USAO supports this, why PERF supports this, the Department of Justice, because sometimes incidental memory of the man was in a blue shirt and what the court sees man was in green shirt is enough for a case to be dismissed, these are normal recollection issues that have nothing to do with the actual credibility of the officer or the guilt or innocence of the accused.
That is my time. I will come back to some other questions, but thank you.
Thank you, Councilmember Parker. Councilmember Fruman?
Thank you very much, Chair Pinto, and thank you to the witnesses. I'm going to go over some territory that others have gone over, but I just want to make sure that I fully understand. Maybe it's Chief Smith, maybe it's Deputy Mayor Pia or others, but on the drug-free zones, one of the things that people talk about the drug-free zones is this a return to stop and frisk or something like that? But the way that I'm understanding what your testimony, Chief Smith, is that there may be a drug-free zone, lasts for 5 days. It's a limited area, maybe 1,000 square feet, 1,000 feet on each side, but a limited area. And that an officer, that if there are people who are congregating, and there's an assessment that they're there for the purpose of doing a drug transaction, then an officer can tell them to disperse. And then the officer wouldn't have the opportunity to stop that person and search that person unless they had probable cause that that person or those people were engaging in a drug transaction. Is that right?
Yes, sir. They would have to have probable cause.
So, and if they had probable cause, even if it wasn't designated as a drug-free zone, they could still search that person, right?
As long as they had probable cause, yes, sir.
Yeah, so it doesn't change that. Now, and if what happens if the officer says disperse, if they don't leave, then what happens for the officer?
But so I don't think it just works like that. Only the chief of police can actually, based on this legislation, declare an area a drug-free zone, and it's based off a totality of circumstances where we would do an evaluation or assessment of that particular area. We would also look at certain factors, right? We would look at 6 months worth of data in that particular.
You've made that declaration. What's the experience of the officer on the street, and how does it differ from?
They can affect an arrest.
They can, if they say, this is a drug-free zone, disperse.
That is correct.
And the people don't disperse, they can affect an arrest.
That is correct. Not
just search, but they had probable cause that the person was engaged in a drug transaction. They on that basis, they tell them to disperse. They can make an arrest, and if they make an arrest and the people don't have drugs, but does what does that mean?
Well, if it's in the drug-free zone and we have the, the markers up to declare that a drug-free zone, then they would be in violation of the officer's order to disperse from that area. It's not necessarily at that point when the area has been declared a drug-free zone. It's not necessarily at that point we will be looking to make an effect based on the drugs portion, more so about the failure to follow the directives from the officer.
But and that would only, I mean, it seems to me they couldn't have told them to disperse unless they had probable cause that they were engaged in a drug transaction. And then if evidence suggests they weren't involved in a drug transaction, I guess there would be a fight about whether or not they had probable cause in the first place.
Well, if the area is declared a drug-free zone and we have the markers up where it's 1,000 feet on each side, the expectation is that no one would be in that particular area. And if we ask them to disperse and they do not disperse, then that's when the arrest would occur.
But I thought it's not that nobody would be there, because the whole idea is the community is supposed to reclaim it. People will be there, but people shouldn't be there who are
and that no congregating in that particular area that's been declared the drug-free zone.
With the intent, there's an intent element. So, right, like, so it's getting a little convoluted here, but if an area is declared a drug-free zone, then people cannot congregate with the intent to commit an offense under Title IV of the District of Columbia Uniform Control. There may or may not be a reason that MPD tries to arrest someone for actually violating the underlying law. They may not believe there's enough for USAO to carry a case forward. But if they believe, based upon probable cause, that there is a reason to believe people are congregating for the purpose of committing an offense, and they do not disperse upon the request of the officer, they will be arrested for violating the drug-free zone, this portion of the code.
But I do have to say it worries me a little. I mean, you could have people who are gathered, the officer thinks for some reason that they could be engaged in a drug transaction. They tell them to disperse. The people say, we're not, we're doing something different. And then the officer arrests them. And it doesn't matter whether or not there's any evidence that they actually were involved in a drug transaction. Now they're arrested. We're all grappling with this. I hear you, Deputy Mayor Pia, that this sense of we've lost control of certain places and we need to seize control of these places for the benefit of the community. I hear you on that. And on the one hand, it's 5 days. On the other hand, there is concern about the way in which it might be misused. And one big thing that's out there that Mr. Tobin spoke a fair amount about is rebuilding trust between the police and the community, and what effect will, on the one hand, we may reclaim an area for a short while. On the other hand, we might erode trust in the police from members of the community. So there are trade-offs.
Perhaps, but we do have some sort of history we can look on. I mean, this was the law of the District of Columbia from 1996 to 2014, or when it went away in 2015. We can look at what happened during those periods, right, and see what sort of complaints or otherwise, right? Like, this was nearly a 20-year statute in the district. So we do have history upon which we can look. The other thing is, I think that sometimes when we talk about police trust, I hear you, but we also have to listen to community. And some of what we're saying and what we've heard in every community, I don't think there's a ward across the district that has not asked for this and for us to do something and address this issue more than any other. And so the Metropolitan Police Department is not freed from the responsibilities of constitutional and just policing, for the sake of executing this particular statute or any other. So they still have the accountability to act in a just and constitutional manner. And so we can see, was there a significant amount of concern about this during those periods? And then let's address how to correct it if so, but that isn't what we've necessarily heard from residents or those who I know.
I hear you. I hear you on that, but I also, there's limited time and I do want to get to other things, but I hear you on that, but our own mayor voted to end that policy, and it was ended by the council maybe for a reason.
With prostitution-free zones at the time, both were repealed at the same time. And I know there was significant concern about prostitution-free zones and also about constitutionality for this, which is why we added the intent element.
Okay, so I want to move to over to the retail theft. a thing that puzzles me is at least 10 items and $250 over a 30-day period. How do you know? How do you prove that? If it's different episodes over a 30-day period, isn't that going to be, that strikes me as pretty hard to prove. How are you thinking about how we're going to prove that if there haven't been already convictions for the steps along the way where there were other thefts? How are you thinking about that, and how you're going to prove the amount of theft over a period of time?
I'll let Chief Smith speak on that, but one of the things, just using, examples that we've seen when we went to Giant in Ward 7, they discussed how they have a significant amount of evidence of repeat people stealing. They have video, right? They have other things. It's not hard for us to work with retailers to determine the value of, if we have someone who is repeatedly going in, but each time they've stolen a $20 or 3 things of Tide, we know the cost and we know how to aggregate that based upon the video. So that's the type of, right? Like, we're not talking about chips. I think we all see like people taking things of deodorant. The stores have video. Many of them, they don't move forward with cases because getting USAO or others to prosecute someone repeatedly coming in and taking 10 things of deodorant is not actually an easy thing to do. But over time, right, that's different than shoplifting. So there is a lot of evidence that actually is available in this space by the retailers.
So, I mean, yeah, go ahead.
Great. Certainly, in many of these cases, it's going to be difficult to gather the evidence required to prove the defendant committed this offense being a reasonable doubt. It's not easier, though, by simply redefining first-degree theft to say you stole 10 offenses. That doesn't make it easier than proving 10 discrete instances of theft. And this is essentially what you would have to prove under this proposed version of first-degree theft. You have to show that they stole 10 different items, each proven beyond a reasonable doubt, that were valued in the aggregate at $250. Again, that's not any different than proving 10 distinct counts of theft under current law.
I hear you on that. And that's actually, I mean, the way in which you were proposing to approach it almost seems tougher, honestly, because now what's happening is Giant's sitting back and waiting for multiple offenses. Why wouldn't they go forward if they're going to wait for the person to come a third time or come over a 30-day period? Why wouldn't they go forward the first time when they have the evidence that could land to 180 days in jail?
Because they don't. Because it's
But-
very unlikely a misdemeanor will land a misdemeanor theft from Giant lands anyone in jail.
Yeah, but they don't. But then now we're going to create a different way that goes to what Mr. Park was saying. It's a different way that's more complicated for them to pursue. Why don't we press to have it to enforce the law as it is?
Yeah, and the cases could be joined. If, again, under current law, if someone came and went within a relatively short period of time and stole things successively, even though they're separate counts of theft, they can still be joined into one case. So it's not as if Giant would have to wait for, one theft trial and then months later another theft trial and then months later another theft trial. They could be joined and then handled in one single case. So I don't know there's even significant efficiency gains to be had by redefining theft in this way.
Yeah, I mean, I get it. We got to do something in this space, because you're right, Deputy Mayor Pia. It has the whole city shaken. And so what it is we do, though, is that we create new things that might be complicated, or we enforce the things that we have. I'll leave it at that and come back on another one. Thanks.
Thank you, Councilmember Fruman. Councilmember Lewis George.
Thank you. Director Tobin, if you are still with us, I want to start with you. The first portion of this proposal focuses on making changes to which will impact your agency, I think, rather greatly. How will these changes impact your agency and the ability for you all to do your work?
Thank you. And let me preface my answer by saying this. these proposals to roll back police accountability come at the exact time right now, where we are experiencing a historic rise in police complaints. This past year, we received more police complaints about officer misconduct than any other year in the history of the Office of Police Complaints. That's in our annual report that we just put out a couple of weeks ago. If anyone wants to see the specifics about where, the where and how and the numbers. So all of these provisions, and keep in mind too, that many of these provisions haven't even been enacted yet because they haven't been funded. I shouldn't say enacted. They were enacted, but they have not been funded. So I really question how we could have detrimental unintended consequences of laws that aren't even being used yet. So
Can you give me an example of some of the laws that have not been funded, so they have not been even enacted yet?
giving my office unfettered access to police records, giving the ability of the Police Complaints Board to review policies and procedures of the department before they go into effect. That's the part I was talking about with allowing the public input into policies and policies of the police department. Those are two of the big ones. Another, the third biggest one is the disciplinary records. Publishing the disciplinary records has not been put in effect either. Those are I would call those the three biggies that have not even gone into effect yet. But yet people are apparently complaining that they were going to have unintended consequences. That's not happening.
So those have not been in effect yet. So there's no evidence of unintended consequences at this point. And so these are, so I guess you had a few questions that you wanted to make sure we asked the chief regarding this. What were those questions that you had that we should be sure to ask regarding those?
Well, I think with regard to confidentiality, I had mentioned, the chief mentioned one example in my office where there was a breach of confidentiality. The one breach that I've experienced regarding body-worn camera in 9 years. And I suggested that maybe we should look at how many breaches that police department has had. She didn't mention any. I'd like to know, maybe it would be good to know how many breaches of the body-worn camera policy have been committed by MPD members. I've had one, and I disciplined a member. And I find it totally unbelievable that MPD's not had a single one since body-worn cameras were implemented. So that's the kind of information that we don't get unless we ask for it. And even when we ask for it, we only get it when the police department decides and what in particular they decide we should get. And that's one of the main reasons why we should have another agency with unfettered access so that we could tell the community, look, it's not just MPD saying this. The Office of Police Complaints can also confirm that this is true. We want the community to have trust in the police. And by giving my agency that unfettered access, that will go a long ways in community trust.
Awesome. Thank you. I appreciate that. Katerina, I'm going to come to you, if I may. From the Public Defender Services perspective, I know it's you all's job. You will have to ask for evidence, Brady evidence on behalf of your clients. How these changes impact your ability to do your work?
So it not only impacts our office, it really impacts the public. The Public Defender Service has to make requests to the prosecutors or has to make requests under FOIA to receive information. FOIA is cumbersome, and some of the changes that are proposed here would also be to FOIA. So it would be substantially more difficult to receive those records, or we would be barred from receiving them at all. Going through prosecutors means that there's longer delays. Sometimes trials are delayed. Information is delayed. It cannot be researched in the same way. Clients cannot be advised about it. So it is cumbersome, though it's cumbersome and it causes delays. So there are methods for the Public Defender Service to hopefully receive that information. Often it would be received under a protective order, so it can't be used to help to sort of to transfer the information from one case to another case. But the biggest impact is for public transparency, accountability, and that sort of access, is that the public cannot access this information that was in the comprehensive policing reform. And that impacts not only the role of defense attorneys, but just the role of police in the community, and that access to that information. And it's also access to the decisions early on. I think it's critical, the removal of names, the removal of badge numbers, the removal of duty status, and the actual decisions, having the actual decisions, and not just a summary written by MPD is a hugely important thing. And that's what you have for lawyers. That's what you have for doctors. You don't have the doctor themselves writing a summary of their disciplinary report, or the lawyer themselves doing that.
Yeah. Thank you. I appreciate that, and all the ways it impacts not just your office, but the greater community as a result of that. I want to come to you, Mr. Parks, if I could, Mr. Park, I'm sorry. It sounds like to me what you're saying is the provisions that are establishing organized retail theft at this moment, you believe that prosecution could go under burglary, do 2 counts of second attempt burglary, accomplice liability, and others. So it is of your opinion that we don't need an additional charge. We just need the enforcement and the prosecution to happen.
That's right. Once you can prove that a person aided, assisted, or even just encourage another person to commit an offense, that person is then guilty as an accomplice. And as long as we ensure that people had an agreement and the one person took at least one overt step, they're not officially to complete the offense. They're guilty as a conspirator. So actually the burden of proof for accomplice and conspiracy liability is actually quite low. And so anytime you have the evidence to make out the case for this organized retail theft, you would already have the evidence to make out the case for accomplice liability, for theft, shoplifting, burglary too, and also conspiracy liability, without having to prove the extra elements that they intended to fence the goods or fraudulently return them. And it's also regardless of value. If someone stole very low-level items, these same kinds of accomplice and conspiracy liability doctrines would still apply, and apply decades of liability, of possible incarceration, rather.
Got it. I don't know if did you have a chance to look at the addressing loitering around open drug markets? How would this, or is there any, we already have possession with intent to distribute on the books. How would that interact with our already ability to prosecute possession with intent to distribute as a charge?
Yeah, that's what's a little strange. And for background, the prior version of this bill allowed officers to order someone to disperse and then arrest them if they refused to do so. And there was no requirement that that those persons actually had any purpose to engage in a drug offense. And so officers didn't need probable cause to believe that the persons were actually going to engage in a drug offense. That's why it was constitutionally problematic, the prior version that was repealed. Under this version, though, of course, to lawfully arrest someone for failing to disperse, the officers need probable cause that they were, again, congregating with the purpose of engaging in a drug offense. And again, there may be some very bizarre hypos, but in the vast majority of cases, it sounds as if, and other people at the table agreed, that officers could also just arrest the person for under probable cause that they're committing possession with intent to distribute. It seems like that would be also the more effective way of enforcing these offenses, as opposed to merely asking those persons to disperse.
Right.
Assuming that's not probable cause to make a lawful arrest.
Right. So, Chief Smith, as far as possession with intent to distribute arrests go, how many PWID arrests has MPD made this year?
I don't have that data in front of me, but we can certainly provide you with that.
Okay. And what if any impact would the drug-free zones have on the ability for an officer to effectuate a PWID arrest?
I mean, it's the same opportunities that they have today. They can certainly affect a possession with intent to distribute arrests. Okay.
And what are the, I know you talked about some of the changes, which I think that is different, where people are using Cash App and phones. Okay. What are you all seeing on the ground as far as if people are not exchanging funds, then is the exchange of drugs and the
the
amount
actual.
of drugs the only thing that you all have to get probable cause for a PWID?
I mean, I'm sure there are still folks out there using money exchanges. Everybody has, I don't think I said that in totality with regards to how folks are now making transactions for payment. I'm sure there are certainly others out there who are using cash, but then also the drug transaction itself. And I will add, ma'am, that like if in fact, the current provisions or laws were working, like we wouldn't be here today, right? Like we're looking for other alternatives or tools in order to support us in this space so that members of our community can feel safe. I mean, as you know, and we've had some preliminary conversations, and I've spoken with many community members and members of the council, city council here. Folks are sick and tired of being sick and tired of having these types of things happening in their communities. And we are vastly looking at different alternatives in order to address this. And this is one of those tools, number one, that was already in place, right? We're just asking for that to be reestablished, to give us something a tool so that our communities can have those public spaces back and feel a lot safer in their communities. Oftentimes, whenever there are drugs, there are guns, right? We've seen that time and time again. And so my expectation as the chief of police, and actually hearing from all of these communities, and I think the deputy mayor has said it in all 8 wards, I've been there, I've witnessed some of these things myself, and it's very troubling. It's very troubling when we know for a fact, and community members are the ones who are looking out of their windows, looking out of off of their porches and watching these things happen. And again, yes, we do go in. Yes, we affect the arrest. As a matter of fact, for narcotics this year, we have made over 759 arrests just for narcotics. And that's a lot. And so when we talk about some of these drug-free zones, yes, our officers are in spaces and places where we see 2 or more people congregating. And if there are drug transactions taking place, they certainly have the authority based on probable cause to effect an arrest. And I'm sorry for being passionate about it, but I
appreciate your passion. I think we all are passionate, and I think we have to address non-enforcement and non-prosecution as a part of these 2 things. And that's why we're trying to look through as legislation, as proposals come, which proposals are going to make a change to the non-enforcement and non-prosecution pieces in that regard. But I'm over time. Thank you, Chairman.
Thank you, Councilmember Lewis George. So really appreciate everyone's time and stamina. I have to report we have many more questions to go. So I want to offer you all a 5-minute bio stretch break if you need it. We've been going about 2.5 hours. So it's 7:11. So why don't we try to reconvene right at 7:16 and we'll keep it moving. Thank you all. All right, everybody, welcome back. 7:18 p.m. We are reconvening our hearing on Bill 25-555, the Addressing Crime Trends Act Now Amendment Act of 2023, after a 5-minute recess. We are hearing from our government witnesses. We've just done a round of questions from council colleagues, and we are going to our second round. So I want to turn to drug-free zones. First off, we had a witness testify today about expanding prohibition similar to we having around schools, and their ideas was perhaps we should expand this to metro centers or federal buildings. And it led me to wonder about that idea, but also as this current proposal is laid out, what are the displacement concerns of a group of people engaged in criminal activity moving just 1 block away or 2 blocks away, and perhaps into even more residential areas as a result of this policy? Is that a concern?
I mean, displacement's always a concern with anything that we do, right? Like, so we're doing enforcement efforts for nightlife. We do our multi-agency task force and look at displacement, right? Because as we increase even just regular government presence, I use MLK, the MLK corridor as an example. People a couple of blocks over then say, oh, there's activity here, at which point MPD adjusts policing strategies. But I don't know that it's as simple as then they just go to the next block because you've created a market here, and it doesn't necessarily mean it follows you to the next block. That doesn't necessarily mean that's how it works. So yes, there is a potential that there would be displacement, at which point we have to appropriately adjust policing strategies. But interruption of your disruption and interruption is actually an effective tool.
Thank you. And Ms. Seminova, can you speak to PDS's experience with enforcement on the law that was in place until 2014? It's my understanding this proposal is a bit narrower than what that was, but can you speak about what that was like?
No, I was at PDS then, but I just can't. So I can get back to you on that. Talk to it with other colleagues.
Okay, thank you very much. And Mr. Park, the drug-free zone proposal requires specific notice and the use of objective evidence before MPD can establish one of these zones. Do you have any concerns about the constitutionality of this proposal given those guardrails?
Given those guardrails? So our staff's still looking into this. There may be some concerns about the delegation of authority. Essentially, it's essentially creating one of these sort of implicit unstated elements of this offense is being left to MPD's discretion to decide. That is, this conduct has to occur within one of these drug-free zones, whereas typically offenses are defined by the legislature. Whether that rises to the level of being constitutionally problematic is unclear. And so we're still actually researching that, and we'll address that in greater detail in our written comments.
Okay, great. Another concern we've heard is that this could undermine efforts to help people suffering from addiction, and that it could also result in harassment. Could you respond to kind of safeguards MPD would take to address both of those issues?
Sure. Thank you for that question also. As I stated before, one of the things that we have at the Metropolitan Police Department are really great relationships with our Department of Behavioral Health and other social service agencies. And even in this particular instance where we recognize that there may be unsheltered individuals or folks who are substance abuse dependent, we will have those resources available to us to assess and evaluate that to ensure that those folks are not the folks. We're specifically focused on dispersing crowds or groups that are engaged in illegal drug activity, whether it's for sale, whether it's for purchase, or whether it's for distribution.
Thank you.
Yes, ma'am.
So let's talk about the anti-mask law. We've heard from some advocates who have expressed concerns around allowing for an increase in pretextual stops, specifically given broadened language of making it a crime for a person to wear a mask, quote, where it may cause a reasonable person fear. And so what is your response to this concern? How will officers in practice assess when to stop or arrest an individual in violation of this anti-mask law? Because reasonable articulable suspicion is one thing, but the power to actually make an arrest based on this is another category.
And so what I will say, and again, another good question. Our officers work very diligently with a lot of our investigative tools whenever we obtain information from witnesses or video surveillance. We utilize those tools as an opportunity for us to actually apprehend suspects who have committed crimes. And this would be no different, right? I think it's really important for us to also understand that these individuals who are walking around committing these crimes with full ski masks, it creates fear everywhere you go. Even for me, just knowing that I saw 4 individuals in a car with full ski mask on, only thing I could see were their eyes. I could identify the car. I could also identify their clothing. And so when we think about not harassing, this is not a harassment tool. This is the ability for the Metropolitan Police Department officers to stop individuals, have a dialogue with them. Most of the time, I'm not saying all of the time, most of the time that we've come in contact with individuals with ski masks, they have been engaged in some sort of criminal activity. Either we are chasing them, pursuing them for a limited period of time based on our policy. They are either utilizing stolen vehicles, they're bailing out of these vehicles, and in their possession are these ski masks and things that we have already observed as their way of committing crimes and inciting fear across the District of Columbia.
I'd also note this was the law of the District of Columbia for nearly 40 years until the pandemic, which at that point in time, it certainly made sense where we were to make alterations. But during that 40-year period in which the Metropolitan Police Department enforced this, they would have to make the same determinations that they would make now. And so I think, they make determinations all the time when trying to interrupt criminal activity about, is this based on the totality of circumstances, is there probable cause to believe that this individual is wearing a mask to commit a crime or attempting to intimidate or harass individuals or deprive them of their rights? They made those assessments for 40 years. We don't have evidence that they have ceased to be able to do so. That was not why the repeal occurred.
Right. Thank you. And Ms. Seminova, do you have a response to that? What have you seen with some of the clients that you've served? Or have you seen examples of pretextual stops with ski masks?
I have not personally seen this charged. I can't remember an instance of it being charged. I don't know how frequently it was charged. I believe that there could be data available on that. I don't know if the deputy mayor has that data. But it's problematic to say that there are 4 individuals inside of a car wearing ski masks, and that alone gives police cause to stop the car. That's not indicative of any intent to do anything. That is, 4 individuals are wearing ski masks. And so that alone, that ability to stop and then potentially harass people, but just by stopping them, that is an impediment. And then the broad way in which this law is written, which is to commit any civil or any criminal infraction, that's the intent. It includes masks or hoods obscuring any part of the face. So very broad. And then with the intent to commit any crime. And so how is it that police are evaluating any civil or criminal offense?
Okay, but in the example that the chief gave around the 4 individuals in the car, under the language of where it may cause a reasonable person fear, if that was the only factor present, would that constitute a totality of the circumstances?
Absolutely. And I, my level of frustration, again, I apologize, but like I've had to talk to folks who have been intimidated, harassed over and over again by 2 or 3 individuals with handguns, inciting fear. It's troubling. It's troubling when you have individuals walking up to you, full ski mask, taking your possessions, your car, what you own. People have a right to be free from this kind of activity. And clearly, if there was something else in place that we could do to suggest that this would not happen, then fine. We will certainly work with the committee to come up with other alternatives. But right now, what we're hearing from victims of crime is very disturbing. And we need to have tools in place in order to address this.
Okay, thank you. And Ms. Seminova, you can you can say what you wanted to say as well, but I wanted to ask you, other than kind of general opposition to this language, are there certain exceptions that you think would make improvements to this proposal, like around religious reasons or medical masks? Or Councilmember Trayon White introduced another bill called the Ski Mask Prohibition Act, which bans wearing masks in certain contexts. I know that this hearing is not about that bill, but is it just the way that it's phrased in terms of reasonable fear in the civil and criminal offenses that is the most problematic to you?
I think it's all of it. So as the police chief just stated, it is for individuals in a car. There's no intent. There has to be an intent to cause another to be in reasonable fear. So if individuals in a car are in their car and some other person happens to see those individuals who are together in a car, there's no intent by that group of individuals to cause that other person who just so happens to see them any fear. This is exactly how it would be enforced in a discriminatory way that just inflicts harassment on residents. And it is, I mean, it's the inclusion of hoods, it's the any obscuring of face. And in instances that the chief is talking about where there are individuals who commit crimes while wearing ski masks, there's no punishment provision listed, penalty provision listed in this law. It was previously, I think Director Park said that, told me it was a 1-year offense, just in the hearing room. So if there is another offense to charge, those are offenses that are going to carry incredibly lengthy periods of incarceration, and those would be charged. So if we're talking about armed carjacking, that will be the lead charge, not this prohibition on wearing a mask.
You asked for data. So between 2018 and July of 2020, when the law was repealed, the MPD made 15 arrests under the anti-mask law. 4 of them all but one of them included other crimes, including 5 charged with firearms for illegal operation of an ATV, 2 with burglary. The other was where an individual was wearing a ski mask and officers were patrolling in reference to a string of sexual assaults and observed the subject wearing a mask to conceal his identity, approach a female and grab his groin area. So MPD regularly up until July of 2020 enforced this, used it sparingly, but certainly in what we believe is law actually does help create culture and behavior. And so we do have to do some things that say what is acceptable in community. And there is some of that here where we have normalized behavior that is oftentimes connected to criminal activity, intimidation, or fear. That's our effort to not normalize that any longer.
Okay. Thank you all. I'm out of time on this round, but I will come back. Councilmember Bonds.
Thank you. Thank you, Chairwoman. I'm intrigued with this probable cause. And I'm intrigued because I'm sitting here and I'm listening to every word of the testimony that you are providing to try and figure out how the uniform officer will determine when someone is gathering to commit an offense. I'm really struggling with that. You have examples of what would be occurring on the ground when individuals maybe are gathered that would indicate that they are up to something no good, so to speak?
The use of drugs, the transactions, a drug exchange.
All right.
In those spaces and places.
But if I were standing there and I was puffing away and I've been there for 20 minutes puffing away, would that be an infraction in your opinion?
No.
Okay. I guess I'm also questioning, how would a citizen know whether or not they would be stopped in a so-called drug-free zone or at a place where there's a gathering? Because they would want to know.
We post notice. I think that the chief attached it to her her. We will give actual notice, and there's like a sign that says this is designated as a drug-free zone, so that people have. It's like a very visible sign. This is a drug-free zone.
All right,
and so to be posted.
Okay, and so then the officer, right? Okay, the officer will. Yeah, got it. Okay. See, okay. The officer will say, move on. And I'm like, but I'm not doing anything. So I'm just there now. Remember, I'm smoking and I'm smoking. Officer says, move on.
Smoking. So what are you smoking, right? Like if you're smoking a cigarette, then the officer has no reason to actually even really engage you. The drug-free zone is for the purposes of breaking up illegal drug.
I understand.
Yeah.
But I'm trying to get to real life circumstances.
Yeah.
And I'm trying to get to helping our community to understand what is the practicality of the law.
Yeah.
How will it be applied and will it affect me,
Yeah.
the individual who may be in this situation?
So I can give you a couple of examples. I worked with the 5th district with residents who contacted me. They were looking out their window. There was a open air drug market that had just was springing up. They had a shooting that went through, and they said, me and my neighbors want to help MPD, will do whatever. What MPD said at that point in time is we can, using some of our now crime suppression teams, we have been successful over time in building up cases that will move forward to prosecution, but it will take some time and we'll need your help and some work, right? So these residents, they did do that. They let them surveil from their home and do all of these different things. That's one tool, but not everybody wants to do that. Sometimes if we have this tool, what the officers could do instead of like these people having to potentially, there was a shooting through the door and otherwise, we know there's criminal activity. We see it. There are other open air markets that we could point to in your ward, Councilmember Parker, where people are just sitting there using drugs. It's not like a big secret. You can see them sitting using drugs. Right now, MPD, they could try to arrest them, although there's no exchange necessarily going on. They're just sitting there utilizing unlawful drugs. This would give MPD the opportunity to break some of that activity up and say, this area is not one where you can sit in lawn chairs utilizing drugs half the day.
Okay, I guess then I have to go further to what would be the training elements that the officers would receive in order to be able to identify this so-called likely unlawful activity?
So, anytime there's a change in laws or legislation, our Metropolitan Police Academy provides training, whether it's through roll call training, whether it's training at our academy, or if it's through our training bulletin. So each person, each individual, each officer would be exposed to the appropriate training for this type of engagement.
All right. Okay. That was my big concern. How long will you have to wait before declaring or moving the drug-free zone from one place to the other? Is that kind of like, remember you indicated you can only stay at one location 5 days. Okay. So if you get the so-called troublemakers to move on, you are going to then, what happens to that space now they moved on? Do your signs stay up? It's
Not
past
after
5
5
days
days.
now. Yeah.
No, ma'am, not after 5 days.
All right. So they come back. I come back.
And I can declare it again.
And you, okay.
Yes,
So
ma'am.
that's how you see it operating.
Yes, ma'am.
Okay. So for the use of the drug-free zone signage, the officer must determine if someone has or is engaged in no apparent lawful activity or purpose. Am I correct?
For the signage, the chief would determine that, right? Before
Yeah,
to
the
designate.
signage is up, but
Yeah.
the officer comes by and, okay, and they point to the signage. What are they looking for that would say that I'm just there smoking a cigarette? I'm just standing there.
Where they're
Shooting
looking
the
for
breeze,
for any
chatting.
illegal drug activity that's taking place in that space.
All right, so they don't see that, then I get to stay in the space.
Well,
No,
It-
so
it-
there's a
yeah.
bunch of things listed in the
Yeah.
law as to how they're going to determine this, right?
Yeah.
The conduct of
6
the
months.
person being observed, including but not limited to, are they acting in a manner that's a reasonable belief? Is there information from a reliable source indicating that a person being observed routinely distributes illegal drug? Information from a reliable source indicating the person being observed is currently engaging in illegal drug activity. Such person is physically identified by an officer. There's intelligence, and our officers, B cops, know as a member of a gang or association which engages. So there's a whole host of considerations that the officers will do, including just regular police work and intelligence of the PSA and the lieutenants knowing their area and knowing who the people are.
I think that's very important information because the public is also saying, I'm using the space, the exterior of our community. I'm using that space, and they want to know whether or not they will be engaged in some sort of a trapping.
Right.
That's why I'm asking these questions.
Absolutely. And
Trying to understand just who are we targeting? Because
Right.
we're targeting someone if you have a sign up and it says warning.
yes, ma'am. And in the code, it describes the procedures for establishing a drug-free zone. And I know oftentimes everybody don't read it, so.
There you go.
Right.
Thank you so much,
yes, ma'am.
Chief. Thank you.
But we want to make it clear as to what those parameters are.
I had to come at it a
Yes, ma'am.
long distance, but just trying to get it on the record
Absolutely.
because that's what people are asking.
Yes, ma'am.
They're asking that. Thank you very much.
Thank you.
Chief.
Thank you very much, Councilmember Bonds. Councilmember Parker?
Yes, thank you. Trying to determine where I want to go. Say that one more time. Yeah. Okay, so let's start here with the mask. I think there was some misunderstanding about why this was proposed, and hopefully you all can clarify it. So section 801 would reestablish the prohibition on individuals over the age of 16 wearing a mask with the intent to engage in unlawful conduct, deprive someone of their rights or equal protection under the law, force or threaten, intimidate, et cetera, et cetera, et cetera. Can you just elaborate on what you're hoping to accomplish with this change in the law? That, as I understand it, is that there will be an added penalty for someone that commits a crime while wearing a mask.
Yeah, I mean, so a lot of this too is like addressing things that we're seeing. I use this, and it's not just anecdotal, but it is in conversations when we're having a significant number of issues in the U Street corridor. We met with business owners who were like, can you do something about these masks? It's the middle of the summer, and most of the shootings or others we're having are people coming in with masks. And what MPD said at that point in time is we can't, like, unless we have some reason to approach someone, we don't have a mask law right now. We used to. And I think that's real. I mean, I think maybe some of that is perceived by officers as well of what do we do? And part of that might have been the times of how officers engage. So some of this is, in fact, like we are seeing people, you can see it across the board in our bolos of, it's the summer and people are in masks.
To clarify, would this change in the law empower MPD to stop someone and say, hey, you have on a mask?
If there's so it has to be with one of these things. It's not just they approach someone on a street with a mask. They have to make a determination, right, that they're engaging in conduct that's prohibited, that they're being threatening or intimidating, that a reasonable person would feel that harassment or others. It's not just stopping anybody with a mask.
But if a person is engaged or is suspected to be
They could
engaged
then
in one of these things and is wearing a mask, this would empower MPD to be able to stop and question them. Whereas you're saying right now, they don't have that authority.
You can't. So MPD is law enforcement. If there's no law to enforce, then if we want them to engage in appropriate constitutional policing, they shouldn't be engaging, right? So we want to, interfere and break up and prevent any potential criminal activity.
And Mr. Park,
Yeah,
seemed
no,
like you
it-
wanted to jump in here.
Under Terry v. Ohio, police are empowered to make investigatory seizures when they have articulable suspicion that crime is going to be committed. And so some of the hypotheticals, maybe not all, but at least some that were discussed earlier, in which someone's wearing a mask and they're casing out a store, look like they're about to break in. Mask law or no mask law, that's almost the exact facts from Terry v. Ohio, and officers can perform an investigatory stop. Maybe not necessarily in all the broad cases where it's just for, people driving in a car wearing masks, under Terry, they might not be able to stop them under.
So am I to interpret you would be one of those that would say there's no need for this addition?
Not in all hypos. I think in some of the hypos that were raised, it does seem that under Supreme Court case law, officers already can perform investigatory stops.
Okay.
Not necessarily in every last instance, because this offense is quite broad, and so it may apply in circumstances that are beyond the normal range of investigatory stops. But
officers can also engage in consensual encounters. So if we're talking about U Street where people are on foot and not in cars, an officer can walk up to an individual and say, "Hi, what's going on here?" But there can be a consensual encounter for which they need no suspicion.
The operative word there being consensual.
Sort of just approaching somebody
What does
like
that mean, consensual?
a non-force, non-stop, the same way that you could ask somebody what time it is when you are as a non-officer, a sort of a regular civilian
So let's
encounter between
hypothetically
people.
Say an officer stops someone with a mask and they keep,
Well, it wouldn't be stopping. It would be
or tries to
engaging,
stop someone with a
engaging.
mask and they keep walking.
Right. I mean, I think it'd be important to call it engaging rather than stopping. So an officer could have a conversation.
Walks alongside.
Right. And talks to the individual. Maybe you don't need a mask law for that. Officers engaging in policing can already engage with people in the community, speak with them, see if there is anything that rises to the level of reasonable articulable suspicion, which would then give cause
But in
for.
the scenario I'm giving, let's say the person does not consent, keeps walking, or says, "I'm not going to engage," then what?
Then that's it. But then there is no reasonable articulable suspicion if the officer has reasonable articulable suspicion that the facts warrant a stop, that there's reasonable articulable suspicion of criminal activity, or that a crime has been committed or is about to be committed, then the officer can engage in an actual stop. But that investigatory step, you don't need a mask law and something that broadly creates more
And I'm
police.
just thinking out loud, and I don't want to speak out of turn, and I don't mean any offense. I believe me, I understand not wanting to have a knee-jerk reaction and undo a lot of the progress that we've made. At the same time, there are very real issues that the city is facing. And in Ward 5, we do have open air drug markets. We do have individuals in the dead of summer walking around with masks. That may not necessarily mean that they are doing something illegal, but what I'm also hearing MPD and the deputy mayor saying is we need tools to engage to see, are you doing something illegal? And I guess the tension or the challenge I'm hearing as we are just keep coming back to the language of the statute. For example, the language you just gave around consensual engagement, like that just doesn't seem to mesh with reality or what we're seeing play out. Because if an officer were to stop a young person with a mask and they flip them off, right now there is no recourse. And so what do we do?
Well, the young person hasn't done anything. So, I mean, apart from having a potentially disrespectful interaction with police, a young person with a mask who doesn't want to talk to a police officer hasn't done anything. And there's not reasonable articulable suspicion that they have done anything or that they are about to do anything. So I think this is where we engage in sort of what interventions does this, maybe the conversation should be like, what programming can this youth do? But
to push back on that,
the
just
youth
slightly.
hasn't done anything apart from
Push back
where
on
the
that
mask.
slightly. There are clauses attached to this. So it's not just you're wearing a mask, I get to stop and interrogate you. It's if I suspect you are doing something unlawful, and the list goes on.
With the intent to commit a
yes,
crime. It's the crime plus the civil infraction. It's an incredibly broad statute, including hoods and civil infraction. So if you're wearing a mask and you're going to not pay the parking meter, is that, as written now, it includes any civil infraction, any criminal infraction. It gives an incredible amount of discretion to police officers, and discretion that in many instances they already have if there is in fact reasonable articulable suspicion.
Okay. I want to use my last 2 minutes on the drug-free zones. I share a concern that Councilmember Henderson raised. We know we have a lot of people sick, and by that meaning addicted to drugs in our city. And so hypothetically speaking, let's say you're in Brooklyn Manor, you say this is now a drug-free zone for the next 5 days. That's where someone lives. How can you just parse out a scenario where people are just existing and needing to operate within a drug-free zone? And how can we ensure that we're now not going to lock them up because of illness or addiction?
Yeah, that's that. So we don't chuck all our values, right? Like, so we actually do have a value on offering service and support. And that's true whether it's agencies like DHS or DBH or others who work with MPD or within MPD who have homeless outreach officers and others, right? Like, so if we're seeing activity, our primary goal first should be to try and engage people on an ongoing basis. But we also know the difference between those who are engaged in criminal nefarious conduct, right, in a persistent manner, and those who aren't. I believe that it is our responsibility to work with DHS and outreach workers and others beyond just police, because we don't need our police to do everything. Like they need to really be focused right now on law enforcement. But the other thing is we do have to have a balance between that and people's right, our residents, to also live free of the concerns and the challenges and others of people who DBH will tell you getting people into treatment is a very long-term and difficult process. And do people then, do our residents who are rocking their children to places?
I'm thinking of unhoused neighbors, for example.
Of
Let's say
course.
there's an area and this is where I live, and maybe I do engage in drug use, and now MPD has declared this a drug-free zone, and I'm refusing to move. Like, should we lock someone up for that?
No, we don't want to
And
lock.
how do we safeguard that we can target the folk you were referencing earlier that are selling drugs from folk who are either addicted to drugs or unhoused and find themselves for a number of reasons in a drug-free zone?
I think these are the same types of questions we ask with encampments, right? And with other areas when MPD has to come in and effectuate, there's public safety challenges within our encampments where we work together with the host of government partners that are responsible for helping us to address those issues. They're challenging, they're difficult, they're not easy. MPD, we won't lock people up because it's very unlikely people would be held. Like, let's actually be like honest about what's going to happen here, right? Like that's not going to happen. And maybe then it's an opportunity to connect with our DHS providers or others who haven't had an opportunity otherwise. But I think it's not that different from where we find ourselves now when we have even an individual who there might be a public health or public safety issue in an encampment or some other area where we have to alter the activity because it is unlawful, and MPD also does need to address unlawful activity while public health and the other side of the house works on the long-term treatment and other things like that.
And may I
I am
also
way over
add-
time, but Chief,
Okay.
I'm gonna
Okay.
take a point of privilege
Good
and
job.
say you can finish your point.
Oh,
Yeah.
I was just going to add that we also have co-response officers also who have been trained in being able to identify folks who are substance abuse users. We've also partnered with DBH to ensure that we can also have non-sworn personnel or professionals to support us in that work and in that effort. As we talked about earlier, when we conduct our public safety walks, we bring those other DC government agencies along with us to be able to identify, and this will certainly be one of those areas. We will ensure, and we can certainly add this to the legislation if we need to ensure that we have those partners engaged in this space so that we won't
I think
be in
that
a
would
place.
alleviate a lot of concerns.
We can, if there's a possibility, and we certainly will work with the committee on being able to do that.
Thank you.
Yes, sir.
Thank you, Councilmember Parker. Councilmember Bonds reserved 2 minutes of her last round, and so we're going to turn to her to complete that round.
Thank you very much, Chairwoman. I just have one question, and it is about, you mentioned something, Deputy Mayor. You said you evoked the issue of we know who some of these parties are. And I really want to understand, if you know who some of these parties are, and they tend to be repeat characters, I'll say, players on the board. Is your thinking that the drug-free zone stipulation will help you to be more determined in bringing these individuals to justice? I'll just call it that.
Well, we're determined now, and there might be a host of things going on. If it's a known individual, there could be a larger or longer term investigation that's happening that could also be kind of working in the background. In the meantime, residents shouldn't have to suffer, right? Like that's really the thing is while they're also working on, we use Kennedy Street as an example. That was a very long and lengthy and large investigation, right? It took a long time. But in the meantime, if we have resources to make residents comfortable for them to be able to live safely, we need to use, it's kind of a both and.
Okay, and so then for those that we have determined or have given indications that they are repeat perpetrators, I'll use the right terms now. Do we have a way of being informed before they commit criminal activity that they are en route or about to commit criminal activity?
We try, right? Like there's intelligence. So I used today, we started shooting reviews, right? Where we brought together court social services, all of the supervision agencies, representatives from VI agencies to talk about shootings and things that have happened over time to see what do we know, the jail, we brought in the gang intelligence unit from the jail, like everybody to talk about these things because our goal really would be to not chase crime. Our goal is to prevent crime. So yes, hopefully.
All right. Okay. That's very important. Thank you. Thank you, Chairwoman.
Of course. Thank you, Councilmember Bonds. Councilmember Fruman.
Thank you very much, Chair Pinto. I want to ask a couple of questions about the neck restraint provisions. I had the good fortune to participate in the Community Engagement Academy this summer with MPD, and it was really great. Thank you again, Chief Smith. I commend it to anybody out there who wants to learn more about the operations of MPD. And I actually heard from a lot of different officers about the concern around the rules around neck restraints and the challenge of incidental contact. And so I've been, when I heard that the mayor this was a thing.
Councilmember Fruman, I'm so sorry to interrupt you. It's a little bit hard to hear you in the hearing room. Could you make sure your speaker's not obstructed or that you could speak up a little bit? We'll turn our volume all the way up as well. Yeah.
Okay. All right. I'll
That's much better. Our heat is on really loud in here.
Okay.
Thank you.
All right, I'll try to speak louder. So I was talking about my experience on the Community Engagement Academy and talking with many officers about the neck restraint issue. And when I heard that the mayor was going to address this issue, I thought that that was a good, important thing. And then I saw the language. And I do wonder about the approach taken because the cover letter speaks to clarifying that incidental contact isn't actionable. What is it? Clarifying the definition between a serious use of force and innocent incidental contact with the neck. And we had a conversation with different witnesses during the course of the day. And does it have to be done in the way that you're proposing in the legislation as it stands? Or if we came up with different language that protected against treating as wrongful, unintended contact that was to the neck, would that work for you? I guess that
Can you
goes.
repeat what you said, sir, as far as
So the way in which it gets talked about is we want to make sure that incidental contact is not criminalized and that officers aren't held to account for unintentional contact that to the wrong place. But the way in which you made the changes proposed in the current legislation feels broader than that. But if we came up with different language that said that that incidental contact to the neck would not be deemed wrongful, and that would apply going back to whatever date it was. If we did it in a different way and we focused on incidental contact, would that achieve your goals, or does it need to be the way that you're talking about it in the proposal?
Councilmember Freeman, we're certainly open to working with the committee on any of the revisions or what you've just suggested or recommended.
I think that's great, because I mean, one of the things that's out there on a lot of this is frankly sending a message. And I think on the drug-free zones, frankly, I think you want to send a message to the community that, you know, we want you to feel safe. We're going to take dramatic action here and send a loud signal to both the community and the people who might be doing wrongful activity, you know, engaging in drug transactions in a specific place. Many people use the word disrupt, and disrupting might send a message. I think I understand the desire to send that kind of message both to the folks who are engaging in drug transactions and to the community that wants to feel safer. I want to be careful in how we do that so that we're not throwing the net so widely that we're alienating people or treating people unfairly. So as I look at that one, I'm trying to think through, how can we help you send that message? Because I think it's important with minimal harm happening at the same time. And I think that's where a lot of the questions have been coming from around those things. The same thing, you know, on the organized retail theft, I am, you know, during the course of this conversation, persuaded that we have the tools, and that this again sends a message. This is a new category of crime. We haven't seen it in the same way. We're passing a law on it, but I don't know that passing a law on it is the best way. In that one, is passing a law on it that might even be more complicated to enforce, better than doing real enforcement of the laws that we have. On that one, honestly, my inclination is that we ought to be enforcing the laws that we have. And when the U.S. Attorney comes to our legislative breakfast, I'm sure we'll all be asking about that subject. A different one, there's a message sent in this, but there's the question of whether or not the officer can review the video. And Chief Smith, can you speak again to when the officer can review the video and when the officer cannot review the video in preparing their report? Because I thought you said there were circumstances where it might be officer use of force, or some settings where they couldn't. But what are those settings where they cannot?
Councilmember Freeman, we're having a hard time hearing. Did you want me to? I can weigh in on that.
He asked.
Well,
Mr.
actually, thank you, Ms. Semenova, but I'm sorry, I'll need to speak louder, but the question was to Chief Smith, when is it that the officer cannot look at the video before doing their report? I did intend then to go to you and ask you, given those carve-outs, why it's an issue. So I would like to start with Chief Smith. When is it that an officer can't review the video before doing their report?
In instances where we have an officer involved death, when an MPD officer discharges his or her firearm, when an MPD officer applies a head strike, or when there is force resulting in serious bodily injury or loss of consciousness or creating a substantial risk of death, and also whenever there's an MPD canine bite, MPD officers do not review the body-worn camera footage.
So then, Ms. Heavenov, now I'll let you respond to it, because I'm curious, if the officer can't in those settings, what is the harm in having the officer look at it before he or she does their report?
So what the Police Reform Commission recommended to the council, and then what the council did, was say officers cannot watch their body-worn camera prior to writing their initial reports. There are very few officers who write initial reports in cases, but those officers who write the initial reports cannot view their body-worn camera prior to writing those reports. They can watch the camera numerous times before they testify at trial. They can watch the camera of other people. They are frequently shown their cameras, other people's cameras, all before testifying at trial. And that is what is done with witnesses as well. So a witness who experiences a burglary would testify about their experience of the burglary, and maybe after, or not testify, would provide information to prosecutors about what happened when they were in the home and experienced the experience of the burglary. And then they might, after that, review security camera footage. So it's the same sort of policy that happens with every witness. And the problem is that the memory of what actually happened, what they were thinking, why they acted the way that they did, is supplanted by the body worn camera footage. And that's what evidence that research that the Police Reform Commission looked at when they made this recommendation was the problem is supplanting memory of the video with this other thing.
But
And
why?
so
Why is that a problem if the body worn video is accurate? I mean, we all know that there's a real challenge of eyewitness testimony, and it's a stressful situation. What's the harm in having the officer look at it? If the officer could look at the video from the Giant, if there was a camera, why can't they look
the camera from what? I'm sorry.
They could look at other things, other video before writing the report, but they can't look at their own body worn camera. What's the harm?
The harm is that it's two separate things. So this is the initial reports, which often say this is done without reviewing the body worn camera. Those reports may say what the officer was perceiving at the time that they made the stop. So what was the reason behind their reasonable articulable suspicion? What was the reason behind probable cause? What was it that they heard? What were environmental things that happened? And this is done in short order after the event. It is the recollection of the officer then that is captured. And here's another thing that a judge also has to consider, that a jury also has to consider. There's no need for those things to be, they're different pieces of evidence and they are each important. And the sort of the piece of evidence of the officer's experience is erased essentially by the body worn camera experience. So you want to have these two pieces of information.
Why? But I mean, I guess I'm wondering, are you worried that an officer, if it goes to like why they did the stop, are you worried that they're going to look at the body worn camera video and come up with a reason for a stop that they didn't actually have in mind, that they're going to create a story to justify that? I don't understand what the harm is in looking at objective evidence of the events that they involved in before writing the report.
Because it's not entirely, in lots of ways, it's not entirely objective evidence. It's a separate piece of evidence, but it shouldn't overly inform this other piece of evidence, which is the officer's experience at the time, their recollection of what was happening. So the same reason that you wouldn't want it in a use of force case, right? So we're saying in a use of force case, it is entirely independent, right? It's the same logic that applies. In a use of force case, the officer's perception, their reasonable fear of the individual, you don't want all of that to be supplanted by the video, because there is an importance to their subjective perception, right? So if we can agree that that is the case in officer-involved use of force instances, there's no reason why it isn't also the case in every instance that you want independent information that is this one source, and here's this other source, and you want those two sources of information to be independent in order to get the full evidence, both from the body worn camera and the officer's perception. And then prior to trial, after initial report writing, then there can be further review of that. It can be part of investigation. Is there something else on the body worn camera? Can a license plate be picked out from the body worn camera, and that furthers investigation?
Okay, so I'm 2 minutes over. Thank you very much. And I will turn it back.
Thank you, Councilmember Fruman. And that's okay. I figured with the sound issues, you could have another minute. Councilor Lewis George, forgive me. I just want to ask one follow-up question on this if I can, but it'll just take a minute. What do you think, Ms. Seminova, the purpose of body-worn camera footage should be for?
So why did the council pass the body-worn legislation?
Just you on principle, what is this footage for?
It is, I think it's a important transparency and accountability tool for policing. It has a deterrent effect, hopefully, on police misconduct. It has a safety aspect for community and police interactions. It can also provide evidence in cases. So it has multiple layers of utility. It can provide witness statements if police are speaking with an individual. That may be the only statement of an individual that they can have because they never find the individual again.
Okay. And Deputy Mayor, what do you think the purpose of body worn camera footage?
I also think that there's accountability and also protection for everyone involved in an incident. I don't actually believe that it's necessarily best evidence, but that's what it's become, right? Like that it becomes, I believe, and I'll just say this, right? Like that what we're talking about now is creating credibility challenges for the officer. If what they perceive, this is part of our issue overall with some of what we propose is officers have a high standard of which they must meet because of their jobs, but are they on trial always? If they saw a green car and the car was actually blue, this now becomes a credibility in the underlying case of whether or not a crime was committed now is out the door. And so from our perspective, all of this is for the fair and proper administration of justice, both for the accused, but also for the victim. So if we're creating needless challenges to the credibility of officers who are not on trial, they are there to enforce the law, then oftentimes justice for the victim will be denied because our courts, for better or worse, do rely upon body-worn camera as best evidence. So if there are conflicts, there is no question that the subjective, the initial report, any deviations can now lead to a lack of justice or the denial of justice for victims.
Thank you both for that, because I think it's really important as we think about ensuring that there is accountability for officers, especially or in cases where there was misconduct or a police involved incident, and as an evidence collection tool. And we are telling people all over the city, get cameras, get these rebates for private cameras, retail cameras. We need this footage. We have footage on our officers recording all of these instances. And so I don't want to lose sight of that second and very important assistance and help of these cameras. I'm going to turn to Councilor Lewis George and then Councilor Lewis George. Sorry. Thank you for your.
That's okay. It was good. It was good commentary back and forth that we needed on the record. Chief, this is my opportunity to raise some Ward 4 specific questions. I want to keep them, if we can keep them short. The first question I have is very easy. I recently saw you in Ward 1 and Ward 6. My question is, are you and Deputy Mayor Pott appear willing to come to Ward 4 and do a community safety meeting in the near future?
Absolutely.
Wonderful. I appreciate it.
Yes, ma'am.
The second question of that is, there's been some questions about how we, I guess, how you all decide the number of officers to patrol in a certain area. And if you keep a log of that information. I know in your testimony, you noted there was a spike in crime this year. And I'm wondering, would the shift in patrol areas be the reason? So how do you all go about dispersing officers in a specific area? And is that something you log information on?
We do have information on that, and we do look at, it's all based on data, obviously. You know, we look at our data. We have our crime analysts look at areas across the District of Columbia. We have crime analysts assigned to all 7 districts, and they take that information and they look at it, and we sit down as a team and evaluate those areas where we have high impact crime across the District of Columbia. And in those spaces and places, we sit down and come up with our strategies on how we're going to address those crimes. I won't talk about the tactics in which we use to do that. But what I will say is that I provided to the council, the city council today, kind of an overview from January through today of how our crime trends and patterns are occurring with regards to our robberies and our carjackings. And what you see as far as the decreases are certainly a direct result of the different strategies and initiatives and how we are providing resources in those areas where we have seen an impact in crime in the past.
Right. I appreciate that. One thing I would like to do, I've done, I don't know, my fair share of ride-alongs as prosecutor, et cetera. What I would like to do is attend a roll call in 4th District is my district. I think all council members should do a time at roll call to see how it's dispersed. I was wondering if we could, we could agree to just do a session where we go to 4th District and just see how a roll call is done and how officers are dispersed as different PSAs.
And I'll even offer you our robbery suppression initiative that we host on Friday nights, where you see a full complement of those resources, actually Thursday night, those complement of those resources and how we conduct that roll call and disperse those officers across the city, as opposed to one particular area across the District of Columbia. And we will certainly get you to the 4th District to do a roll call as well.
Thank you. I appreciate it very much. My next question, you've mentioned it just now. We have seen in Ward 4 a large uptick in thefts, car thefts, and robberies as well. I know you can't give me all the details of sort of how you all are going about suppressing. I got an email from a resident in Crestwood saying, like, they had a few theft from cars and no one sort of came out to collect information. They sort of just did a report over the phone. What is the, in my opinion, the only way we're going to sort of solve some of these theft issues, we have to do the follow-up work and the investigative work. What I've seen is if, we can pin down a time of day that they're usually acting, if we can get some video footage of a potential, suspect vehicle, if we could sort of narrow down sort of, when they're hitting the neighborhoods and how they're doing it, then we could actually solve, get to solving the crime and catching the perpetrators. What is the robbery suppression unit doing? What does that follow-up work look like from robberies to thefts? And what can I tell Ward 4 residents that is happening in the follow-up and what your expectations are as the chief?
So as the chief and my directive to the team is primarily what you just said. Whenever we have a report of any type of theft, and you talk about theft from autos, you talk about stolen vehicles, we have our armed carjacking task force that have its own set of resources that go out and conduct these investigations. Our investigators are out there all the time. We also have our commanders who are responsible for the crime that's in their particular area, where I meet with them every single morning at 8:30 to discuss the crime for the past 24 hours, to talk about strategies and approaches on how we're going to use our crime suppression teams, how we're going to use our civil disturbance units, as well as any other resources that they have available to them in order to address crimes. And when you talk about the follow-up, there is an expectation. I mean, they were doing this before I arrived, to continue to conduct follow-ups. If you have a citizen or resident who is concerned about that, my recommendation is that you send that over to us so that we can make sure we provide good follow-up for that person in the event we may have missed something along the way.
Great, thank you. I appreciate that. I want to ask, I understand sort of some of the, we already clarified, the chase policy. I think this is just making it permanent. I guess I understand the body worn camera. You guys had a robust back and forth. I understand the body worn camera piece of it. I don't understand the other pieces of this, of like not all giving public officer information. Some of the clawbacks that I believe were reasonable and built public trust. In what way are those specific ones going to impact our ability to have a reduction in carjackings and robberies and thefts and the things that we're seeing? And why are we doing this so quickly when many of them have not been implemented yet?
So, I mean, that's sort of part of it, right? Like part of the process of the back and forth of policymaking is discussion, but some of the issues that we may have raised over time that aren't addressed, we believe need to be addressed, whether implemented or not. What we do know is this: when people talk about, we can be sure it has not impacted officers, that is not what they tell us, and not honestly what we see in some of the behavior in community, right? Like what we're saying, because of what we're seeing, is we have to have an environment, both a policy environment that supports accountability and yes, for officers, but what is the right balance? It is a I'm not going to mince words that it's a competitive time in law enforcement in which it's not the most popular profession. And we are certainly in a competitive space in the district. We want the best officers possible, and they have a lot of choices and options. So we will lead on reform when it comes to transparency or otherwise, but we also do have to recognize that they have privacy rights, that their medical info, one of the provisions is that where like their therapy records don't need to be made public, right? Like because they chose to be officers. And so we can have a conversation about what the right balance is. But it is important, and we will say this, that we are a local city first and foremost, and that many of the reforms that we made being forward thinking based upon what was happening nationally, is that what was happening in our police force? Is that what is happening with the Metropolitan Police Department? Are we addressing issues that we see? Because whether people want to believe it or not, we did have a significant attrition in officers in order to address things like gun violence, we have to have the right amount of officers. And when they are given a choice where it feels like a hostile environment towards them, then, that is also not going to help us to have a balanced ecosystem. So some of what we're doing is.
And I hear what you're saying. And I think you put a key word in there where there needs to be a balance there.
Balance. Yeah.
I do think that we were dealing with that. We were dealing with issues in our community. I know from Ward 4, because we had Hilton Brown, right? But what I guess Peter Tobin, the director, said we've had the highest amount of Office of Police complaints this year than any other year. So police complaints are going up. And we're saying, let's claw back. And I don't know how we reconcile that. And I think the best officers, and from working in Philadelphia and DC and interacting with them in a prosecutorial role, the best officers are the ones who know how to, investigate a case and get the evidence the way that they know it's going to present well in court and do honorable work and things of that nature. So if we want to attract the best, I think we keep our standards high, because if we lower our standards, we're going to get the worst, and that's not going to do anything for the city.
I think we already have very high standards. So one of the things that I said at Safer Stronger is that we're proud of reform, but that doesn't mean that sometimes that the choices that we make don't have impact, and we have to determine across the board what the impact is. I'm not saying whether Mr. Tobin is correct or not, because none of us have seen those numbers. They're not put anywhere. They haven't been provided to us. So I don't have reason to question what he's saying, but I would also say, what are the types of complaints or otherwise that are being made? Because you've been in here and heard our residents, and you also are in community where they're like, support our police because they're the ones who show up. So if we have bad or officers who need discipline, then we're all for that. But we also are not going to criminalize or add unnecessary suspicion as if our entire police force is problematic or awful or these things.
Correct.
And I think that's
I think that's the case. And you were right. In 2019, the country was seeing the justice system in the United States was failing to hold people accountable, and it all boiled over in 2019. I think everyone can recognize what happened in 2019. In no way was that saying all of our officers are terrible, horrible people. No one is saying that. I think the George Floyd and Policing Act happened on the congressional level, and then every other jurisdiction, not just DC, but every jurisdiction sort of modeled after what Congress was doing to make sure we had some accountability spaces so that we don't get back to 2019 again, that there's no repeat of like 10 years of injustice and then a blow up happens where people get killed and then we go back to reform. So whenever there are reforms, there are clawbacks, and we just got to make sure that we are finding balance within reform, and we are finding and we're not doing clawbacks prematurely, but we're being reasonable to like what you're saying as to how we can ensure that we are attracting talent to the city and doing the work that we can in that way. So I think Councilmember Pinto is going to be working. I'm committed to working on finding a balance within the means of, how we present really strong cases in court, and how we also ensure accountability and trust. Because what we do need to win cases is witnesses, because witnesses are evidence. And in order to get witnesses, we have to have trust. And so all those things sort of are connected in this ecosystem, and we got to work our best way to get it done. And I'm with you on that.
Thank you very much, Councilor Lewis George. Appreciate you being here. Director Tobin. Hi. When it comes to officer discipline and use of force investigations, can you elaborate on the distinction between the Office of Police Complaints jurisdiction and MPD's internal affairs jurisdiction?
For use of force complaints, well, First of all, our system in my office is completely complaint driven. I have to kind of a complaint in order to move forward on any use of force case. MPD's internal affairs does not need a complaint. They can move forward on their own volition, or if they get a complaint, or if they simply suspect something. So that's the main differentiation between the two of us. But once we get a complaint regarding use of force, then we can move forward on it in the same manner as the MPD would move forward on it.
Okay. And you touched on this in your testimony, but the provision in this bill that changes access to information to OPC from unfettered access to all information and moves it to timely and complete access to information. What is your view on what the practical implication would be of that change?
What we have now is supposedly timely and complete access to all information. The bill would move us back to where we were before, which means I am reliant on the police department deciding what, when, and how I get information, in what form I receive the reports. I have to ask specifically for the reports, and I get exactly what I asked for and not 1 ounce more. I don't know what else is in the records, because if I don't know what I don't know. And that's the biggest, that's one of the biggest problems with not having unfettered access is I don't know what to ask for all the time.
Right.
I don't know what's in the records. And I can't tell the community that that I know everything, because I don't. I have to tell them I'm only relying on what the police department says. And that affects community trust. I'd like to tell the community, yes, what they're saying is true, because most times it is. But I can't say that because I don't have the access.
Okay, well, thank you. And Chief, it's been reported today, but also in the past, about difficulty of getting information. And so if this language was changed to timely and complete access to information, what layer of accountability would be next in the event that it wasn't timely, or it wasn't accurate, or it wasn't complete, or to address what Director Tobin's talking about of how to know what the full scope of the information they need is in order to do a full investigation?
So I guess, so currently we are providing information that is timely information at his request. If I'm not mistaken, is that right, Director Tobin?
Yes.
Well, it depends on what the definition of timely is, and that in many instances, my definition of timely is not equivalent to what the people in your department believe is timely. So
And clearly, Chair Pinto, if there, and this is the first time I'm hearing this, but if there are some accountability issues, we will certainly address it to ensure that Mr. Tobin and his team has exactly what they need in order to conduct their appropriate investigations.
And well, I appreciate that, Chief. And those are almost the exact same words that your last three predecessors have said to me and said to this council. And still we have numerous instances where the actions or the words do not meet the actual actions. And it's not you personally, it's members that handle that. And it's the culture of secrecy within the department that is really at issue. I appreciate you making that offer, but that should be offered at the beginning anyway. That should be the starting point. And what we really need here is a definitive way of ensuring that that my office has unfettered access. And this bill would take all of that away. And we'd just be back to square one.
Director, about the body worn camera review, can you elaborate on your thoughts of allowing officers to review their body worn camera before writing their reports? And what about the importance of not allowing officers to review body worn camera related to certain disciplinary actions or serious use of force? Is that a sufficient exception in your view?
I think that's a huge question, because like I indicated before, there was many hours of hearings and literally hundreds of people testified and talked about it, many of them experts in the field. So to look at this in this very short time frame, I think is wrong. If we're going to change BWC policies like this, my preference would be to do it as a standalone bill so that we can really look at it closely, not as an add-in bill, basically disguised as something that's going to reduce crime. It's not. The purpose with the body-worn camera, with officers reviewing it, it's a much longer conversation than what we have tonight. But I'm suggesting that these proposals are not going to be sufficient, that they're going to have, as have been mentioned a lot of times, unintended consequences. The Public Defender's Office has mentioned a lot of them. I think they did a good job expressing that, and I have some of the same concerns that the Public Defender's Office has mentioned regarding it. But and the whole question goes back to balance. And I'm not convinced in any way that what the proposal is here with regarding BWC will actually give us a good balance. Could there be some changes? Yes. Are these the ones that we want to do to make that balance? I'm not convinced of it.
Okay. And I hear you on the need for balance and on the need to make sure we're unpacking each of these proposals because they are distinct and they deal with a broad array of categories. I do want to say though, because we heard this from some of our public witnesses today that, oh, this is all happening so fast. Some of our feedback from the emergency this summer was, this is too fast. There needs to be standalone bills. The hearings that we've been having all fall, the hearing that we're having on Mayor Bowser's proposal today is on permanent piece of legislation that was introduced several weeks ago. We are having a hearing on it's going through the normal legislative process. And so could there always be more time to every issue? Yes, but time is also of the essence in some of these other trend categories. And so just wanted to make that point. But Chief, about the body-worn camera language. So I know there's been a lot of questions back and forth in this exception issue today, but as I read the proposed language on allowing officers to review their BWC footage prior to their initial report, it allows them to review it except in cases of a serious use of force. Okay. But then after that, there's another exception to that exception where an officer was unaware of the use of force. So what purpose is that exception serving? And can you give an example of a situation where that would come into play, where an officer was involved in a serious use of force, but they were unaware of that use of force?
I mean, that could happen if somebody comes back and reports. I mean, there are times when you're engaged in, I'll say, the physical altercation with an individual whom you are trying to arrest, and you may not believe that there was any serious physical use of force, but after the person has been arrested and then the investigation begins, then there are allegations of serious misuse of force. I
can actually give you an example. Like we watch these videos all the time, sometimes during an arrest when cuffing, right? Like you will later, when a detainee is brought to CCB, they may complain of an injury, go and find out there was a broken wrist or otherwise. That then becomes classified as a serious use of force and be subject to release. But at the time that the officer made the arrest or otherwise, they weren't aware of what the injury was. And you watch the video and you're like, there was a struggle, they put on cuffs. Later, they find out that that qualifies as a serious use of force based on whatever the injury is, which sometimes isn't complained about by the individual being arrested until they're actually at CCB or lockup or otherwise. So it's really like an example like that where we would do release on that. There's oftentimes too, sometimes later watching video where I don't know, like that's like a real example of one where it's like happened multiple times and they find out this person has a broken wrist or something like that. That then would not be readily apparent at the time of the injury to the officer because they don't know.
But and that makes sense as an example, but going back to our earlier conversation on if, let's say, the two purposes of body-worn cameras are for accountability for police and for evidence collection to prove cases, that category is not really helping us prove a case.
So that would still be distinct, right? Because in that instance, it's the first where the officer, the body worn camera footage in that instance is for the accountability of the officer, because they will now be investigated for a serious use of force. There's the accountability. It doesn't change necessarily what might have happened in the underlying offense, which now is used to write to the report. So and that instance where the officer did not know there was a serious use of force, they may have reviewed the BWC to write their report, and then later there's a serious use of force. So there's no way. It's important for that distinction to be made because of how they discipline officers or otherwise, right? So you still get both purposes, evidentiary collection and then also accountability for officers.
But that would make it sound like the distinction should be on a timeline basis as opposed to a whole category of cases that's based on when the officer didn't know. Because if the officer didn't know, wouldn't that become relevant in proving that they are innocent in the serious use of force allegation? But it's not relevant to proving the underlying case.
Yeah, it isn't relevant for the purpose of, right, like proving the underlying case. So I don't know if what you're saying is, well, everybody should be able to, that to me seems like that everybody should be able to view video. That's kind of what it sounds like to me, right? Like, because if it's always has evidentiary value, it's going to have evidentiary value regardless. What MPD is.
Well, I think going back to, there are these two beneficial purposes, accountability and evidentiary value. And if we're generally agreeing that there should be exceptions for the first category when there's serious use of force, to ensure accountability, to create an exception for that in this category of cases where they were unaware, I can see that exception growing pretty broad. Because if everyone's reviewed their footage, and then this kind of goes back to Ms. Seminova's point, then maybe the argument could be made, I didn't know. You looked like you wanted to jump in there, Ms. Seminova.
It just seems problematic that the example is somebody's arm is broken. They report that their arm is broken when they are away from the officer that broke their arm. And yet the thing that should be credited is that the person didn't know that they broke the individual's arm when they were detaining them. I mean, I do think that it's an exception that then hinges on the credibility of the individual who's being investigated, which is then. No, I think that it is not only the video there, it is the subjective report of the individual. How much force did they believe that they had to use? There's all of the individual circumstances and the decision-making of the officer that are independent evidence of the video that are important, right? It is a piece of, the body worn camera is a piece of evidence, but so are the subjective perceptions of the individual. And this is why it's important to always separate those two pieces of evidence. So, and they are not forever separated, the same way that witnesses then in trial will review camera footage, police officers will review camera footage, witnesses who testify, civilian witnesses will review later camera footage. And I want to look at this example of blue car, green car. Now there's no conviction beyond a reasonable doubt. There's a jury instruction that addresses inconsistencies in testimony, that individuals are frequently inconsistent, that they're inconsistent for perfectly normal reasons like memory, perception, that there are inconsistencies between witnesses, between the witness at one point and the witness at another point. So I don't think that this is where cases need to be propped up to prevent the potential for inconsistencies, because inconsistencies exist all the time and they're not, the importance is preserving those two different streams of evidence.
I guess I think of that kind of akin to our conversation about organized retail theft, though. It's like, if that instruction is given and was followed in practice, perhaps we wouldn't be seeing what we're seeing. But in practice, and I hear from officers all the time, the reports are so limited because of this fear of non-consequential detail, that it's not just the fact that there was a distinction, it's the fact that the initial report is so sparse. Because in practice, there's this frustration of having to do an addendum after that may have additional information. And I think that is relevant as we try to solve these problems of, like, not only what is the current law, but what in practice is undermining our city's ability to improve safety.
Right. I understand that there's potentially a training issue then if officers don't want to write addendums and they are identifying that as the issue, or that USAO needs to train more directly on constitutionality if cases are not being brought because of constitutional issues that they're seeing. But the solution can't be, we want to obscure this one level of evidence, this subjective report of what the officer believes, sees, hears, that, and entirely sort of erase that and replace that with the body worn camera. That can't be the solution to diminish the actual amount of evidence and different evidence that people get to hear, because these are incredible. I mean, not only is the only interest can't be accountability meaning convicting an individual. The overwhelming interest is there proof beyond a reasonable doubt that this individual should face such a drastic circumstance? And it shouldn't be that the council is tipping the scales towards conviction every time by let's limit as little as possible the evidence, because we don't trust jurors to deal with nuance, which we should trust jurors to deal with nuance, and therefore, get it to a point of conviction as quickly as possible. That cannot be the answer.
I do not see it the same way. I don't think this is about tipping the scales of evidence. It's about what are we considering, the point of these body worn cameras, and also how we can ensure that it is a useful tool. It's not just, I don't want to phrase this. It's not my understanding that the subjective view of what the officer's, peripheral vision or subjectivity of the interaction was. It's the entire report as part of the evidence, right?
The report doesn't come in a trial. A report doesn't come into evidence. The officer comes in and testifies. And the officer may be impeached with something that could be different in a report if their oral testimony is different from a report. They could also write an addendum. They could also explain it, but it's not, these are not cases based on documents. I think it's really important to view that the pieces of evidence that come from body worn camera are important. They are one piece of evidence. The other pieces of evidence come in various different ways, and those are also important. And those pieces of evidence shouldn't be overwhelmed by these other pieces of evidence, and that the system is and jurors are complex enough to take it all in and figure it out.
Okay. I want to turn to the neck restraint language. So Director Tobin testified to this earlier, and we heard from some of our public witnesses about a different type of language. And so I heard from a lot of public witnesses today who were generally open to some changes here. And I think we talked about, my colleague, Councilmember Bonds, cited this example of this video that I think we've all seen now that's on your website, about the individual who was banging their head and the officer went to protect their head, and that constitutes a violation. And so, or subject to investigation. And so as we look at the language that kind of takes out the prohibition on movement, one of Director Tobin's recommendations, and Director, I'm kind of paraphrasing here, but is instead of just saying it's okay to restrict movement, it would be to maintain the restriction, but then have exceptions for brief or incidental touching of the neck to try to address some of these cases. And so I wanted to get your sense on how you thought about that framework in lieu of how it's currently drafted.
Well, I think we're willing to work with the council on language that would be appropriate. I think for us in particular, and with our officers, having this incidental contact and having our officers kind of charged with serious use of force is certainly problematic, especially in instances where there is no intent to restrict, if you will, or present a type of restraint that the public sees as a chokehold. It's just an incidental contact. So we're certainly willing to work with the DC Council with regards to that change.
Okay, thank you, Chief. And
yes, ma'am.
Can you just explain a little bit about some of MPD's policy when it comes to current policy when
We,
it
we
comes?
currently have a prohibition on chokeholds, no chokeholds there. It has been a longstanding policy of the Metropolitan Police Department. I support it 100% and we will continue in that same vein.
That also includes so there's been a lot of people talking about chokeholds and these different things. I don't think people really know what that means. And that's sort of what's going on now, but the chokeholds are not, no one's talking about bringing back chokeholds. The other thing too is I think it is always against MPD policy to touch the front of the neck. That wouldn't change, right? Like, so there are some real specific policies already in place. And this kind of added went to the next level. And so even if this change would made, MPD's policy would still be against chokeholds and any sort of restraint or touching of the front of the neck, either which is here. She can't do it, but I'm like demonstrating the anything here is currently, she could do it on herself, but like we won't.
Is currently prohibited.
It's prohibited.
And would be prohibited
would-
under the proposed language.
Yes, that
This is
correct.
about incidental touching.
Correct.
Or that's at least the category that you're trying to get at.
Correct.
Right, and also the piece where we talk about someone who's causing injury or harm to themselves. And if it's with the neck hitting the head up against the wall, being able to give our officers the opportunity to prevent that without being charged with serious use of force.
Mm-hmm. Okay. And Chief, can you speak to, again, a practical effect on some of this? Because I know we've talked about some of these examples, and I know this is certainly not MPD policy, but I continue to hear cases where officers have said to the public, I'm not going to engage in that chase because I don't think that I will be able to arrest them without some sort of disciplinary action. And I raise that because I hear it often connected with the incidental touching examples, because officers will see their colleagues be subject to it. And I'm wondering kind of what you're hearing and what your kind of responses to that impact.
Yes, ma'am. So not just what I'm hearing, but what I've witnessed. I also served as the chair of our Use of Force Review Board when I was the assistant chief of police for our Homeland Security Bureau. And one of the responsibilities that I had was to chair that board. And on many cases where we saw use of force, you would see an officer who was engaged in apprehending or making an arrest. You would see the officer hesitate. And for me, that puts the officer in, and again, he or she thinking like, oh my God, I can't, if I just slightly touch the neck, there's a jerk. And that puts the officer at risk. It puts the public at risk. And we don't want our officers thinking that way. With the legislation, with the law as it is right now, it really puts our officers and the public at risk when it comes to apprehending violent criminals and those of them who may have guns in their possession.
Thank you. Briefly, let's touch on vehicular pursuits. As you know, we worked very closely together this summer, and the council passed emergency legislation that made changes regarding vehicular pursuits. Mayor Bowser's bill adopts these changes, but also goes beyond them, creating additional changes and removing a subsection that defines certain uses of force. So can you explain what the rationale is for those additional changes? And also, MPD's general orders can currently be changed without public input or OPC oversight. And so when we think about ramming, for example, why shouldn't the council codify those protections to seriously limit those tactics? I heard you say earlier you don't allow for them anyways. So trying to figure out where the distinction is.
That's not a part of our training. We don't train people, our officers during their police training to ram or to caravan. That's just not a part of the training. And with this language in here, what it will do is, with the legislation that was in the emergency bill, is what it will do is give the officers the opportunity to think that they can do that when that's not a part of our policy currently.
Deputy Mayor, did you have something you want to say?
Yeah, on the, so there, you talked about the change to serious bodily injury. So you'll see that the change throughout, because what we're trying to do is actually match the definition that's currently included in MPD policy. So there are places, so in this particular section here, like what we did was amend the definition of serious bodily injury so it matches the current MPD policy definition, right? So.
And is that also for ramming?
The ramming piece,
Yes.
we took those out because these are all, so we're trying to conform to current policy, which is really what we were trying to do with the emergency legislation. Adding in these tactics, they can't do any of these things. So saying they can't do them when the policy they're like fully prohibited, gives some sort of idea. It says this constitutes a serious use of force. They're not allowed to ram. They're not allowed to.
So it's just like a cleanup repetitive.
It's cleaning it up. Yes. So it's consistent with policy. So there's no confusion with the officers between what the current state of policy and law is.
So what do we say to someone who says if it's against the policy, why not codify it in law?
I mean, I guess you could put serious use of force, which says it's allowed. Yeah, yeah. So it's kind of like a backwards backing in. So you're saying this constitutes a serious use of force. It's not allowed. So it's not a serious, it's completely prohibited.
Oh, I see. So by including it in the definition, it is almost condoning it.
Yeah, that's what, so we're trying to make clear, you cannot do these things.
Okay.
These are prohibited
Thank
by
you.
MPD policy. It's not a serious
There's a
use
lot
of
of double
force.
negatives. I
It's
got you now.
prohibited.
Ramming is not prohibited in the District of Columbia for
Oh,
MPD
it's
policy.
prohibited.
I mean, so excuse me. Wow. Again with the double
See?
negative. I'm so
There you go.
sorry.
Yeah.
We're on hour 12. That's my fault.
Yeah.
Okay. Okay. I think lastly, disciplinary records. There have been several poignant points made over the last several years, but also today, about national databases. And when we see violations of human rights or civil rights by officers, making sure that other jurisdictions have access to this information, but also that has now turned into the public had fake access to information. And so what have you seen, Chief? Because there's also been a conversation about pieces of the bill that haven't been funded or implemented yet. So is this a perception challenge? Is this something to correct before it goes into effect? What are you hearing from officers about this?
It's something that we're looking to correct before it goes into policy or law.
Yeah, so we participate in the National Certification Index. So this is one that honestly is I think for officers is actually a very big deal. It hasn't gone into effect because it wasn't funded. This was put into place, I think, in March, or it was passed in March and was not funded anywhere. And so we are trying to find a way in which to provide greater transparency where we can, while also recognizing there are some privacy protections for officers. And so this is us really honestly coming to the table to try to come up with some ways to do this that both recognizes the desire of the public and the need for public for a level of transparency, while also respecting that officers do have some privacy rights. That, I pointed out the exception about medical history of participation in therapy. Like we recognize officers, there's a higher standard or otherwise, but as a District of Columbia employee, none of these things apply to me. None of this would be subject to disclosure for me. So what is the right balance? The other thing is all disciplinary records for other district employees actually wouldn't be released. So is there a way to release those who are engaged in adverse action or found guilty of what would be an adverse action if it was in the DPM or otherwise? This is what we're trying to do. So it really is one where there's a balance.
Okay.
But in terms of sharing information across to other forces, there's a way to do that, right? The national decertification. Yeah.
Sorry, I need you to say it because you're all sworn in. Thank you, though, Kelly.
I'm sorry, the National Decertification Index. So where you discussed where other forces, knowing that we have somehow terminated or decertified an officer, there is a way for them to know that because we participate in that national index.
Okay. And Director Tobin, in the conversation of what information OPC should have access to versus what disciplinary information the public should have access to, what are your concerns about limiting public view to these personal and personnel files in the event that OPC still has access?
Well, I'll start off by saying that, you know, this is another one of those balancing issues, but my office is subject to the same confidentiality rules as everybody under FOIA, and this change would give us some opportunity to inform the public about disciplinary actions that other departments are already releasing. If you look at, and a couple of previous speakers actually testified to this point, was that in the studies that were done, the interviews that were done, the main reason officers were leaving MPD are because of internal operations of MPD, having their days off canceled, having mandatory overtime, and having management issues. None of them ever mentioned anything about having the disciplinary data published. Well, for one thing, it's not being done right now. But this is one of the community trust issues that we need to make serious consideration of. I recognize the deputy mayor and the police chief's goal, but that goal is not going to be accomplished by this bill and this provision regarding the publication of disciplinary records. This is nothing new. It's nothing groundbreaking that other departments are not already doing.
Go ahead.
Thank you. I'm also just looking at section Title 5116, Officer Disciplinary Records Database. It would provide, under current law, the name, badge number, rank, length of service, and current duty status of the officer against whom the allegation has been sustained, a description of the complaint, of the allegation of misconduct, the basis of the sustained allegation of misconduct, and then the final disposition of the misconduct allegation. And all of that's available only if the allegation of misconduct is sustained. There's also the discipline imposed in response to the sustained allegation and the date on which it was imposed. I don't see in this public database the personal therapy records of the officer. But that's a different section. So the FOIA section is a different section. And this is the core thing I think here is the public records database. And there are within FOIA, it's sort of I think it's the operation of these exceptions, but I think we should be clear that the public records database is not putting police officer medical information there.
But would be available to the public upon a request of a FOIA?
I don't think so, honestly, but I need to look at that section much more closely. But I think that it's important to separate those sections. Maybe Director Tubin knows the answer to it.
But if, again, going back to the practical effect of all of these laws, if the practical effect is that your information is available to the public to that granular personal level, then the piece of the statute that it's in is almost irrelevant.
No, I think it's really relevant because a FOIA goes through a FOIA officer. It's a request that is made. There's a lengthy process to get information from MPD. MPD does not automatically disclose it. There are exceptions that would apply. It could be litigated. Whereas we're talking about a public database. And this is the part that the public database isn't funded. It is supposed to be created. Other jurisdictions have it. This is individuals. This is what we have for doctors. This is what we have for lawyers. It is a public website that people can go to and they can look at complaints for 2023. What are the sustained allegations? Let's read all of them for the entire department, or maybe you can look at them by officer. Nothing in that public database has anything about therapy records. I think we can separate that out and have a separate discussion about that. And then there's FOIA. So I think it is if I'm remembering correctly, it's whether it can be an automatic exclusion. So it doesn't say automatically this becomes something that must be released by the police department under FOIA, but it's a separate discussion. And I think they're being mixed together.
Okay. And what do you think the purpose or highest level purposes are of the public database?
To provide the public information about their tax-funded police force that has an incredible amount of power, authority, discretion. And that is a basic function of democracy, is to give the people information about their government. And that is an incredibly powerful aspect of government, the ability that the police have in everyday life. It is why we have open trials. It is why we have open courtrooms. It is why we have the protections that we have. It is a basic function for individuals to have access to that information. And it's now limited to sustained misconduct, and only sustained misconduct that goes to their interactions with other individuals and breaches of integrity and then criminal convictions. So it is not their, day-to-day employment mishaps of coming late to work or whatever that is.
Okay. And what do you think about the proposal around keeping all of the information, but removing the name and badge number?
That fails. That is a failure of transparency. It is a failure of oversight. The people should know who is policing, what they have done, what discipline was imposed by MPD, and whether they are still a police officer. It can't be a secret database. It does not help to have a secret database without anybody's names, with a summary written by MPD of what actually happened, where nobody can go back and get the documents unless you go through some Byzantine FOIA process and maybe get more information. It should not be that way.
Okay.
And other jurisdictions, as people have testified, have it, and they have police forces that they're able to hire. So that is not, we don't need police officers who serve only because they are going to be in a place with no accountability.
Thank you. My colleague, Councilmember Bonds, reminded me of a very important issue to raise. And I've heard that this is a trend going on with some of our carjacking cases. So I just wanted to raise it in context of our conversation about ramming, not police policy for ramming. I had a constituent who over Thanksgiving, individual backed into their car. They got out to exchange insurance information, held up at gunpoint, car stolen. And they were told that this is a trend that's happening more and more now as a kind of scam to get people to pull over. And so while we have you here, what is being done about ramming right now? And is there any kind of warnings we can give to the public around what they should do in those circumstances?
Yes, certainly. I mean, the same information that we've been sharing with the public when it comes to how to protect themselves when they're in spaces and places, not to sit idly in a vehicle. When you talk about how these armed carjackings are taking place in different areas across the District of Columbia, making sure that people are aware of their surroundings, ensuring that they're not sitting in their cars late at night, parked in front of their homes, or in spaces and places where there seem to be an uptick or an increase in those types of activities. What I will say is that when it comes to the ramming piece, we certainly have our robbery suppression crime initiatives out there. We have our officers that are in all of the spaces and places where we need them to be. And if we identify that those activities are happening, we do our best to make sure that we apprehend those suspects or subjects that's engaged in that activity.
I think there's also some basics too, like that, because people are going to pull over in a more public space, in a brighter space, right? Like if, don't pull over, because our inclination is to pull over, call the police, right? Because they will come to take traffic report too, right? Like it's the type of precautions that we should take if you feel that it's unsafe.
Yeah, and I think people are calling us. I mean, that's the reason why we have so many cases with regards to armed carjacking. I also think that people have to just be vigilant and have self-awareness.
Thank you very much. I understand all that, and very practical way of handling the situation. I'm more concerned with is there something that we need to do to make this an offense? I'm thinking Mr. Park, I know you saw me looking at you many times. Is that something, I mean, we're talking about modernizing the code. Okay, can you think about that? Okay, and whether or not it makes sense.
I can, if I'm understanding the fact pattern correctly, it's armed carjacking.
Okay.
I mean, it's just a serious offense, has a 15-year mandatory minimum, a 40-year max. Yeah, it's a crime.
Okay, so that's how it would be treated as, okay, that's what I was trying to determine. Okay, thank you very much. Thank you, Chair.
Thank you very much, Councilmember Bonds. I think what has been made clear today is that there's a lot in this bill, more than kind of meets the eye at an initial read, and a lot of continued work and collaboration that's going to need to continue. I heard from a lot of public witnesses who said, without some details, support this bill. I heard similarly from witnesses who said this is an incomplete solution. And I think as we continue to move forward on this committee and in our city, and as I've said many times, we are all on the same team. I have no doubt that everybody is very committed to having a safer city. And there is not going to be one perfect solution that is going to eradicate all crime overnight. We know that. And so looking for that one is, I worry, going to stop any progress. We have to keep moving, and we have to keep moving in a direction that is going to improve public safety, do so fairly and justly, and to do so in a proportionate manner, as we, seek not to make the mistakes of our past. And so I really appreciate all of my colleagues who are here today, the over 80 public witnesses who testified and continue to be great partners in this work, our wonderful government witnesses, for being here, and to Mayor Bowser for putting forward this package of recommendations and proposals. As I said, I think you've got to put these ideas out there so we can have these discussions and you can have these debates. It's not going to benefit anyone to wait until you have the perfect thing before you put it out. So I thank her for her partnership. I thank you all for being here and your continued efforts. And as a reminder, the record will be open until December 13th. So if anyone wasn't able to testify today, please feel free to submit your testimony to judiciary@dccouncil.gov now through December 13th. With that, the time is now 9:05 p.m. on Wednesday, November 20th.